Good morning, Texas. Okay, thank everybody for being here. I'm glad that you guys are all here. Y'all give me, if you're watching, I know it's early, and I gave a little bit more time today than what I said everyone I'll be back at 7. Well, I'm back at 7:30. Took a little bit of time for me to get everything started. Okay, guys, so let me know. Give me a 5x5 if you're watching, if you can hear me. I know my voice is a little bit deep right now. I haven't spoken since I ended the stream yesterday. I might have said like a couple of things, but I've been sort of just hiding in a hole for a while, just trying to pretend like things aren't as bad as they are. You know how sometimes you have to do that. So thank you guys for watching. We're going to cover once again this excellent piece from Dolcefino. And we have a couple other things that I want to look through so that you guys can understand what Nate Paul was dealing with, what was actually happening, because it does appear as though there is, and this is just from observation, just a conspiracy theory, and it's not mine, so don't sue me. It does appear that there's a deep state operation to usurp Nate Paul's power by taking his real estate kingdom from him bit by bit, inch by inch. As you'll see in this Dolcefino video, which I've played several times because I want to make sure people understand it. If you have any questions about this, feel free to leave them in the comments on Pilled or Foxhole or Rumble, and I'll try to answer them. But as we see in this video, at one point in one day, Nate Paul had 9 of his properties foreclosed upon. And these are commercial properties that he's invested a lot of money into and that he didn't owe very much on. But during COVID, because he wasn't able to make some payments on some of his properties, of which he owns many, when I should describe Nate Paul as a young real estate tycoon. Okay, he's like a Texas Trump, but I don't know about his politics. I'm only referring to him as that based on his real estate empire. Because during COVID, he fell behind paying some of his property taxes, as all of us did, right? Or paying his mortgage on some of these properties. They foreclosed on 9 of his properties in one day. And there were halts that were established that, hey, y'all can't foreclose on anyone's properties, not whether it's zoned commercial or residential, whether it's white collar or blue collar. Foreclosure sales were frozen during COVID. Thank God. That was Governor Abbott's position. That was President Trump's position. And that was a position that Attorney General Paxton took. And this video will help you understand why so many of the articles are BS, that he was doing all of this to benefit Nate Paul. No, he was doing this because it was the right thing to do. And it was not just for Nate Paul. This was statewide, nationwide. But this video will also depict the mechanisms of the deep state, as how they're doing this, how they're getting people's property from them. And I'm going to go ahead and play this for you guys. I'm going to try to make sure it's not too loud. And give me a 5x5 if you can hear me. I've had many, many supportive comments and some complaints. Of course, there's always people who complain because they want for me to have mainstream media quality coverage, but they don't want to donate and they don't want to help and they don't want to, some people just, no matter what, they just comment on bad service and they're silent for good service. So it's fine.
I'm now opening the bidding.
Please tell me if this is too loud for you.
It's auction day in the state capitol. The scheduled foreclosure of some of Austin's priciest pieces of real estate, all owned by one of Austin's most famous real estate developers, Nate Paul.
$11,750,000 right here.
More than $11 million being bid. That's big money. And among the bidders is a familiar face, despite the mask, to us here at Dolcefino Consulting. His name is Ali Chowdhury. Why do you think so many people accuse you of fraud? Chowdhury's facing a mountain of accusations of real estate fraud here in Houston, accused of owing millions to folks across town.
He always tell you a lie, promise you a law, and never make it happen.
Even the lawyer who helps Chowdhury a lot is caught on tape critiquing the Houston real estate investor.
No, he thinks he's so slick, he can everybody.
Chowdhury's latest trouble here at home, this failed condo project up in the Heights. Yet there he is, Houston's accused real estate racketeer with money to burn in Austin's frenzied real estate wars.
Going once, going twice, sold.
When the bidding was over, it looked like Chowdhury had won. But now he's gone to court, claiming the auction guy, Houston attorney Mark Riley, was conspiring with another bidder to rig the result. It's the guy standing next to Chowdhury, Will Hardiman, son of Austin car dealer Brian Hardiman. If you buy a car in the state capital, chances are you got it from a Hardiman car dealership. But that fight between Chowdhury and Hardiman, it pales in comparison to the real estate war going on between Nate Paul and Hardiman.
We are tendering funds and you to full pay the loan. You're not accepting it, right? Yeah. So you're refusing to accept the funds, right?
Go around and go find you a court in this building to come and stop this.
Paul's company, World Class Property, had fallen behind on the payments on some of their biggest properties in Austin. And companies linked to Hardiman had swooped in to buy some of the debt. On video, you can clearly see Paul is trying to pay the debt off on the properties before the auction even starts. And the law says he can.
We've delivered funds to pay off.
Funds are here, cashier's check.
By redeeming the amount, the deed is ours.
But the lender helping Paul pay off those loans said in a sworn affidavit, quote, "In my 30 years of experience, I've never encountered a situation such as this." But the trustee holding the auction, he doesn't seem to care. We'll talk about him a little more later, but you can tell it got ugly.
Amount due, mother. We've tendered the amount due.
The real estate battles in Austin are making headlines across the state, and that nasty confrontation is captured from all kinds of angles. Everyone seems to want to document what happened for the courtroom.
Go around and go find you a court in this building to come and stop this.
Okay.
Why don't you try that?
Okay.
Wonder why Hardiman seems so confident of the results he'll get in a Travis County courtroom. This is the following month, June, protesters trying to shut the auction down. And yes, you heard right, they're chanting F you. The Austin American-Statesman reported that Paul's company, World Class Properties, had 9 properties foreclosed on that day. The largest portion, a $100 million property, the 3M campus. A California company called Carlin bought properties at that foreclosure supposedly worth, wait for it, $139 million. The July auction was even uglier. There's a photo of Ali Chowdhury being escorted away by Travis County Sheriff's deputies. That auction fight over another Nate Paul property, the building that houses the famed Capitol Grill in Austin. No dispute Paul's World Class Property company had fallen behind on the loan payments. They owed less than $8 million on a property worth upwards of $25 million. But before you say too bad or it is what it is, look what Dolcefino Consulting has uncovered. On April 14th of 2020, Brian Hardiman got U.S. taxpayers to bail his car dealerships out during the COVID crisis. A lot of car dealers did that. More than $41 billion of your money was handed out in loans across Texas to save jobs during the pandemic. But there was a catch. You had to promise you were getting the money to support ongoing operations. Government records show Mr. Hardiman needed a lot of your tax money to keep his folks working. More than $10 million in PPP loans. $3.7 million to Austin Infinity, $2.6 million to Continental Cars, $3.9 million to Continental Imports. On the very same day that Hardiman's companies got that government bailout, records of the Texas Secretary of State show a company was created, Colorado Third Street LLC. On paper, the company is owned by this guy, Justin Bain. 2 weeks later, that same company, Colorado Third Street, it bought one of the big loans owed by Paul's companies, Capital Grill. But where did Justin Bain get the money to pull the trigger? Records obtained by Dolcefino Consulting show the funding for Colorado Third Street LLC was provided by Austin Infinity and Continental Cars. Those are Brian Hardiman's companies. We now know from those court documents that Hardiman's entities don't just fund Colorado Third Street, they own 80% of it, kicking in $7.6 million. That's a lot of money for car dealerships that said they needed a government bailout just 2 weeks before. Good thing money is fungible, right, IRS? The Capitol Grill isn't the only Nate Paul property that Hardiman entities have foreclosed on. And in each and every one of those foreclosure sales, it's the same trustee, the guy you met earlier, Houston-based attorney Mark Riley, the guy you saw get into it with Nate Paul. I wonder if Paul's lawyers know what we do. Mark Riley has a history of alleged fraud. He was sued in 2004 for misusing trust funds of the family of a Houston multimillionaire Robert Alpert. Riley was ordered to pay back more than $1 million. 8 years later, the debt still hasn't been paid in full. In that same lawsuit, we found that handwritten notes were discovered showing that Riley was developing an alleged embezzlement scheme for $10 million and that he planned to steal some average Joe's identity, move abroad, and live off his stolen wealth.
11,750,000 right here.
Well, that must not have happened because there's Mark Riley working in Austin, accused in ongoing lawsuits of fraud with Brian Hardiman to stage the curious real estate foreclosures we've seen at the Travis County Courthouse. Those lawsuits, they also include Justin Bain, that Austin real estate broker whose company went after Nate Paul's Capitol Grill building. And guess what? He's Mark Riley's nephew. What a small world. And when you look up Justin Bain's office address in Austin, look what else you find. Carlin, that California company looking to reimagine Austin. They don't just share the same cool view of Austin from the 2nd Street district, they share the same suite. What a coincidence. Last October, Nate Paul warned of a conspiracy to take his Austin real estate empire away. But few listen. Maybe Ali Chowdhury is just the tip of the iceberg in the Texas real estate investigations to come.
And I hope that helped you guys understand a little bit more. Thank you so much for that. We're going to do just a little bit of a recap from yesterday or the day. But let's see. What should we do? I guess I want to show you Busby, but other attorneys are excellent too. So I think what we might do is go to day 3 and show you Ken Paxton's young attorney, Anthony Osco, and how well he was doing. Because the case was so weak against Paxton that even this young gun, he's very, very good. Okay, I'm going to go ahead and share this one and turn this volume up. Y'all give me a 5x5 if you can hear me.
Yes, sir, I understand. And I'm not any longer trying to ask that question. I do want the record to reflect that neither yesterday nor today has the Attorney General graced us with his appearance. That's all. I wanted to make that statement, please, for the record.
And the rules were voted on. The Attorney General does not have to be present for
Thank
anything
you very much, Your Honor.
other than his initial pleading.
I'll pass the witness.
Judge, may I have a moment to just prepare my exhibits up on the bench or the podium?
So this is Anthony Osco, I believe that is his name, and he is a young attorney. He's going to do very well, as you'll see. I'm going to mute myself for today, but you will hear me speaking a little bit from the day that this was recorded. Okay? And I'm working on the audio. I don't have a mainstream media professional studio, so I'm taking the comments and adjusting them as we go, trying to make all of this work so that you understand what's happening to our Attorney General. We can break down all of these impeachment articles soon. I'm a little disappointed.
You may proceed.
It looks like we're.
Mr. Banger, we heard a lot about your background. Obviously,
We'll
you have
see
a
how
very
this guy
esteemed
does.
career and resume, correct?
My resume is what it is.
Okay. Mine's not like yours, and so I'm just going to try and do a courtesy to you and ask you short and simple questions, okay? And I'd ask that if I ask you a yes or no question, that you simply respond yes or no, all right?
Understand.
Now,
I have
you are
adjusted the
currently
volume, so
represented by an
hopefully it'll
attorney,
work
correct?
well for you.
I am.
Okay. That attorney is Johnny Sutton.
Yes.
That is the same attorney that represents Jeff Mateer, correct?
It is my understanding that he also represents Jeff Mateer. Yes.
So you and Jeff Mateer both have the same attorney.
We do.
Please like and share, guys.
Um,
Thank you for being here.
As a
Please.
matter of fact, Mr. Sutton is here today in the building, right?
Yes.
He's probably watching your testimony.
I assume so.
Okay. And as a matter of fact, the two of you were just in the restroom together about 15 minutes ago.
You would know that because you were there too.
I know, right? But that's a yes, correct?
That is a yes.
Okay. So you guys have been in contact
all y'all.
during your testimony in this trial.
We have.
All right. Now, you stated on direct examination that you did not provide any statements with regard to what you've testified in court today, right?
Could you please reframe? I don't understand the question.
Sure. And I think the record reflects when Mr. Harden asked if you made any statements in this case, and when Judge clarified if you had made any statements before this testimony, you said that you hadn't.
I do not recall testifying to that effect.
Okay. So you've made statements previous to your testimony today, right?
Again, when you say statements, have I spoken to anyone?
I mean,
This
you have
attorney
made
is
an
good,
out-of-court
too.
statement, Mr. Bangert.
Are you talking about under oath?
I'm asking you yes or no. Have you made statements about this case to anyone?
This is a good attorney, too.
You may answer the question. What's your objection?
My objection, Your Honor, is if he would just please express what he means by statements. That has a legal significance and a practical one.
Overruled.
This witness is not aware of the issue.
Overruled. Answer
Yes.
the question.
So
That's very
Yes
clear.
or no question.
it's not a yes or no question.
Well, then
sir.
let me ask you a more specific
Yes, it
question.
is.
Were you interviewed by the House Board of Managers in their preparation investigation of this case?
Yes, I was.
Okay. Were you interviewed by Mr. Harden and Mr. DeGuerin prior to your testimony for this case?
Prior
Who
to
is
my
this
testimony
attorney?
today,
Yes.
I was. Yes.
Okay. So those are two statements that
Young
you've made
and
to people about
handsome.
your testimony in this case, right?
I'm not trying to fight with you, counsel. I'm simply pointing out that the word statement carries legal significance,
Well,
typically
hearsay-
under oath.
Well, hearsay is
Those are
any
not under oath.
Yes.
Witness,
Yes,
answer the question. Not argue with the counsel.
You've made two interviews prior to testifying today, right?
I have given interviews. Yes.
Okay. Two of them.
I have spoken both with the House Managers Council and I've spoken with Mr. Harden and Mr. DeGuerin.
Yes or no, Mr. Banger? Were either of those interviews recorded?
No.
Did you ask that those interviews not be recorded?
No.
Did your lawyer ask that those interviews not be recorded?
Not to my recollection. No.
So you don't know why they were recorded? Why they were not recorded?
I do not.
Okay. If Mr. Harden or Mr. DeGuerin had had any objection to you being recorded during your interviews, would that have been a problem? Yes or no?
I don't understand the import of the question. Would that have been a problem for me?
My question is, if Mr. Harden or Mr. DeGuerin had said, Mr. Banger, you're giving an interview with regard to testimony in an impeachment trial. Can we record you? Would that have been a problem for you or Mr. Sutton?
I can speak for myself. I would have no problem with that.
Okay. And despite your lack of objection to that, Mr. Harden and Mr. DeGuerin chose not to interview you during your interviews with regard to this case?
Chose not to record me.
Yes.
I assume that was their choice, but I was not recorded.
Okay. And additionally, prior to that interview, when you met with the House Board of Managers, safe to say you wouldn't have had an objection to them recording you either, correct?
I can't think of any at the time, no.
Okay. And it just so happens that the House Board of Managers, the investigators in this case, chose not to record your statement either.
As far as I know, they did not.
Okay. So you would have to agree that there are a lot of things that you testified to when Mr. Hardin was directing you that we were hearing for the first time on this side of the trial, correct?
I honestly cannot answer that question. I do not know what you know and what you do not know.
Okay. Well, you had
Well, you know that
information
they
that you
don't have a
produced
recording of
actually to
your
both sides of this
testimony.
trial within the last 2 days, correct?
There was a text chain that was produced by my counsel.
Okay. We didn't see Mr. Hardin produce those text messages during his direct, did we?
Mr. Hardin producing his text messages to whom?
During his direct examination of you, he did not ask you about text messages that you produced yesterday during this trial. Yes or no?
No, he did not.
Okay. Your Honor, may I approach the witness?
Yes.
This attorney is young and he's handsome. I like his suit and everything. But I do kind of want Busby. Oh, there's Busby. Okay, so it's okay. Let this young gun cut his teeth on this because this is.
Don't speak to him now. Just give it to him and then speak from the microphone. Thank you, Counselor.
I'm handing you.
Hold on. Everyone wants to hear you.
Can we not afford mics to be
I'm
clipped on
handing
the
you what has
suit?
been pre-marked as Attorney General's Exhibit 1000 and I believe 3, correct?
It is marked AG 1003, yes.
Okay. Now, you recognize this document, do you not?
I do.
These are text messages from your cell phone, right?
Yes.
You produced these to both sides in court yesterday.
Mr. Sutton, my attorney, produced them yesterday.
Okay. And you would agree that these
Good
are
morning,
fair
Hunter
and
Sabo.
Excuse me. We do not have a copy of
Yes,
what you
Judge.
have.
As well as Big Bad Black Conservative. Good morning. Thank you for being here. All right. Let's see if this helps. I turned it up just a little bit.
Continue.
Yes, Judge. You would agree that these are a fair and accurate reflection.
Pardon me.
Give me
Your
a
Honor,
5x5
we
if
were
you can
not
hear
given a
me,
copy of
and if
this.
you
Do
can
we
hear
have a
the
copy of
background
it?
audio. They have a cop. They have and have had.
They gave it to us, so whatever.
Thank you.
I know they're the ones that he produced it for. They have it. They're just another way to stall.
I'd ask the record reflect that I've tendered to opposing counsel a copy of their witnesses' text messages.
Let the record reflect.
Now, Mr. Banger, you would agree that these are a fair and accurate reflection of
Guys,
the text messages
when we
between you
reread
and
this
Ken
transcript,
Paxton
it's going to be so funny.
in July and August of 2020, correct?
Give me a moment.
Thank you to Hunter Sabo and Big Bad Black Conservative for being here and letting me know about the audio.
With the only
I appreciate
modification that the
you.
first text message is in June.
Okay. Well,
It goes through
your
August.
attorney produced these, so presumably he got them from you, right?
Yes.
Okay. Otherwise, fair and accurate reflection?
Yes, they appear to be.
Judge, at this time, I would move to admit AG Exhibit 1003.
Any objection?
No objection, Your Honor.
Show the exhibit being entered into the record.
Okay.
Admitted to evidence.
This
excuse
is
me.
a
Thank you,
second
Judge.
piece of evidence that the House attorneys say they don't
Mr.
have,
Banger,
but that
you
Paxton's
talked
attorneys say they
about
got from the House attorneys.
Two very, very,
It's the
very
second
specific
time.
conversations that you had with Mr. Paxton that I think stood out during your testimony. The first one of those was a conversation at Polvo's, correct?
We did, well, Nate Paul was part of that, but
Right.
we were at Polvo's at lunch together with Mr. Paxton, Drew Wicker, and Nate Paul.
And the second conversation was essentially a conversation that you overheard Jeff Mateer was having, right?
The conversation at the Raga meeting in Atlanta, yes.
Okay. Two separate conversations.
Yes.
Did you provide, I don't recall, did you provide dates of those, specific dates of those conversations during your direct examination?
I do not believe I did.
Okay. Now, you talked a lot about your experience in your resume. I think you've clerked, you've worked at, was it Baker Botts as a partner, right?
I have both clerked and worked at Baker Botts as a partner, yes.
You've worked at executive level positions in 2 attorney general's offices?
Yes.
You didn't get there because you don't have an attention to detail, right, Mr. Banger?
I'd like to think that I
Mr.
pay
Also.
sufficient attention to detail.
Right.
too.
And you
I like his
document
suit
things
too,
that are
guys.
important to you, do you not?
Not always.
Not always? Okay. Well, let's talk about that. You had documented in this case something that you thought was very important, the foreclosure opinion, did you not?
I made a document that outlined my concerns about, oh, sorry, you said the foreclosure letter?
Yes, the foreclosure letter.
Well, I was shown the foreclosure letter today, yes.
At this time, I would ask
I'm not
Eric
sure that's
if you
what he
could
asked.
publish the House Board of Managers Exhibit 119. Mr. Banger, this is an email that you sent to Ryan Vassar on September 30th.
Counselor, has this been entered into evidence?
My understanding is it has. If not, Judge, I'll ask to enter. It's the House Board of Managers exhibit. At this time, I would offer.
We do not object, Your Honor.
Okay.
Oh man,
Admitted
I
into
was
evidence.
Thank you, Judge.
I was half expecting them
Now,
to object to their
Mr.
own
Banger,
exhibit.
this is an email that you wrote to Ryan Vassar on September 30th of 2020. True?
That's how bad this is going for them.
Yes.
September 30th of 2020 is after you had the meeting with the other executives about going to the FBI with regard to Ken Paxton. True?
This is at 9:29 a.m. that morning. We had not visited the FBI at that point.
Okay. It's the same day that you had a conversation with the other executive level AGs about going to the FBI, right?
We did on that day.
Okay. And September 29th, or excuse me, September 30th, that's 2 months after you ever drafted the foreclosure opinion that you talked about during your direct examination, correct?
Slightly under, but about 2 months later, yes.
Do you typically write memorandums about things that happened 2 months ago? Yes or no?
No.
Ooh,
Does it
yeah.
stand out to you, or does it seem odd to you to wait until the day that you go to the FBI or the day before you go to the FBI to write a memorandum about something that happened 2 months ago?
Seems
No.
odd to
Not
me.
odd at all?
No.
Okay.
That's weird.
Now, to be clear,
That's suspicious.
yesterday during Mr. Hardin's testimony, he at one point said, I think by the end of July, beginning of August, you had been a part of 3 issues that related to Nate Paul, right?
Well, depending upon how you count the open records issues as 1 or 2.
Okay. Well, you have the open records issue, correct?
Yes.
Your involvement in MIDI.
I was involved in MIDI as well, yes.
Okay. And then you've got your foreclosure opinion involvement.
Yes, that is correct. I was involved in all.
And as a matter of fact, a lot of those
3.
almost overlapped each other, true?
At the edges and at the margins, they did overlap.
Okay. Now, yesterday you testified to the jury that you had a boiling concern about this, correct?
I did have boiling concern about this.
Now, to be clear, House Boards 119, your email to Ryan Vassar, is the only memorandum and summary that you drafted with regard to any of your involvement with MIDI, open records request, or the foreclosure opinion. Yes or no?
I can't recall.
You can't recall. Okay. Well, we didn't see any other memorandums, have we?
I haven't seen any in the trial today.
Okay. Well, you would have produced it, so you'd know about it, wouldn't you?
Surely you have them.
I produced everything I had.
Okay, so
And
they
all
don't
we got
exist.
was this email.
I produced far more than this email.
Okay.
Interesting.
Now, I want to backtrack a little bit, and we'll go back to that correspondence between
But as
you
far
and
as
Mr.
memorandums, this
Vassar.
is the only one.
You talked a little bit about the time from when you guys came out to the FBI and what happened to you after, okay? I want to talk about that. Eric, would you mind pulling up Article 6 of the Articles of Impeachment? Article 6 accuses Mr. Paxton essentially of terminating or taking adverse personal action against employees for making a good faith report to law enforcement. Would you agree with that, Mr. Banger?
It says he violated his duties of his office by terminating and taking adverse personnel action against employees of his office in violation of the state's whistleblower law.
Okay. So kind of what I just said, right?
I defer to the document.
Okay. Well, if we read from it, it talks about terminating or taking adverse personal action. So I would like to talk
Can't even
about what
agree that
happened
it
to
says
you.
what it says.
Now, at no point after you reported to law enforcement were you terminated from your position. It's a yes or no question, Mr. Banger.
No, he
were you
left
fired or were you
willingly.
not fired?
Come on.
I was constructively discharged.
No. I asked you whether you were fired or not fired, yes or no.
Answer the question.
I was constructively
No,
discharged.
you resigned. He said he resigned.
Did Ken
Fucking
Paxton say
liar.
you are no longer an employee of the Office of Attorney General?
He did not say that.
He
Okay.
resigned
Thank you.
because all of his
As a matter of fact,
duties
you
were
left,
taken
you
from him.
resigned from the Office of Attorney General as the Deputy First Assistant Attorney General. Did you not?
I did resign.
You see how he
And
lies.
you
See?
resigned under the title Deputy First Assistant Attorney General.
That was my title at the time I resigned.
Sir, you are under oath.
So you were not demoted from your position as First Assistant Attorney General.
I did not lose my title.
Okay. And as a matter of fact, you were never suspended after you reported to the FBI, were you?
I was not.
Okay.
Perjury.
You talked about Mr. I think maybe Webster, but certainly Ken Paxton stripping you of some of your responsibilities, right?
Yes.
One of those responsibilities was the fact that you were in charge of the Special Litigation Division, true?
I was.
Now, that role was actually moved out from underneath you, correct?
That is correct.
And they put it in charge of the division chief that was running that division at the time, right?
My understanding was that Patrick Sweeten was put in charge of that division, yes.
So essentially, Brent Webster promoted an under-level assistant attorney general? Yes or no?
I do not know if he promoted Patrick or not.
He certainly added some responsibility for Patrick, correct?
That was my impression, yes.
And that bothered you? Yes or no?
It came without explanation or warning, so yes, it was troubling to me.
It's possible that Mr. Webster just was promoting somebody that had been, I don't know, giving an exceptional performance at their job.
That was the excuse that he attempted to give me.
That's not what I asked you. I asked you if it was possible.
Wow.
I don't think so.
Wow.
Certainly they wouldn't take a job from Ryan Banger, right?
That's slander.
That's not exactly what I said.
Okay.
This
Sounds
guy
like
is
it.
so, this is, oh my gosh. Oh my gosh.
You said that the environment, did you describe it as being hostile after you reported to the FBI?
Yes, it was.
Toxic, right?
It was.
Affecting
Was it
the
toxic?
ability for people to get their work done?
It was.
Okay. Now, you left and you
Well,
went
according
to
to you,
work
you
for
had
the
no more
Alliance
work.
Defending Freedom, didn't you?
I did.
And in your time, well, that would have been 2020,
What is this Alliance
true?
Defending Freedom?
Say again?
When you left the Office of Attorney General and you went to Alliance Defending Freedom.
Counselor, can you raise that mic up a little bit closer
Sure.
to you? Okay.
Is that better, Judge?
That's much better for
Okay, I'm gonna
all
lean
the
in.
jurors.
That's much better.
When you left the Office of Attorney General and went to Alliance Defending Freedom, that was in October, November of 2020.
November of 2020.
November of 2020. And since your time in November 2020, all the way up until, I believe, 2023, isn't it true that you have brought cases from the...
Okay, so just to address some of the audio, I am on a laptop with a headset. I don't have any mixing capabilities. I can turn down some of the video. I can turn up some of the video. I can pull the microphone way away from my face like that, if that helps. But I don't have a whole studio, guys. I don't have a studio to be able to add all of these bells and whistles or to be able to adjust different audio and volumes. I can only turn up or down the videos, or I could move the mic closer to my face, or I could move the mic way far away from my face. But that's about all that I can do to adjust the volume. But donations would be appreciated. I understand a lot of Americans are accustomed to mainstream media quality, and a lot of streamers have risen to meet that. They'll spend their money that they should be spending on rent on equipment in order to produce, because we get a lot of comments, oh, this is not perfect. I'm used to CNN. I'm used to Fox News where everything is perfect and on time. And I'm not saying that you guys are saying that, because I've gotten a lot of very positive comments over the last few days, but yeah, the critiques on how I should do things, I'll be able to do things better when more people donate and I'm able to actually afford this equipment, because this is something I do in my spare time. I'm actually working right now as I'm doing this. I have been every day that I've been streaming this. I've also been working. So that's something that I think that you guys need to consider. Mainstream media is not covering this with any commentary or any context for a reason. And of course, they mean to convince you that with all of their fancy bells and whistles and their fancy studio, that they are a higher quality reporting organization. And it's just not necessarily so. But Americans have sort of been conditioned to believe that this must not be official news because this isn't coming from a professional quality studio. So maybe it's not professional quality news. Well, professional quality news is extremely expensive to conduct. I already do everything at takingbacktexas.org. All of those 30 plus reports I've handwritten by myself. Everything on that website I've done by myself. And it is like pulling teeth trying to get people to focus and to appreciate the information for what it is. I have reformatted in so many different ways this information about election integrity. This is a courtesy that I'm doing so that you guys might understand more about what's actually happening to our Attorney General, because no one else that's reporting on this, even if they go a little bit more in depth, no one else has this inside baseball about who was doing what. So that's why I'm doing this. I don't have a fancy studio. I do not have a mixing board. I don't have an airwave. I don't have a big fancy area. I am in an efficiency apartment with a small old laptop, and I was just recently given by a friend of mine a headset that has a microphone so that I might be able to do slightly better audio than what's available on my laptop. That's where I'm at, guys. I'm unable to do any mixing of any audio, all right? I don't know how to add fun things to the chat so that people can put fun stickers or, have fun GIFs to share in the chat. But I've had comments on across social media platforms, talking about, oh, I don't like the talking, I don't like hearing people talk. Oh, that's not very professional looking. And so I'm just trying to, it's difficult to address them all at once because I don't want to focus on the critiques when there are so many positive comments. But I will just remind everybody that I am a grassroots election integrity investigative reporter, okay? I'm not a live streamer. I'm not a professional streamer. I'm not a YouTube star. I'm not a social media star. I've been massively shadow banned heavily and have lost so many social media accounts since probably 2018 or 2019. I do not focus on being a star on social media. I focus on the information and getting it out to the people so that y'all understand what's going on and so that y'all know what to say when you approach your representatives. So that's the focus here. Now, that being said, big bad black conservative, yeah, I appreciate you letting me know some stuff, and you say it in a very polite way, and I very much appreciate that because other people don't say things in a very polite way. They're very harsh, they're very critical, and when they do that and they say it to where other people can hear, it's sort of like slander and discouraging people from even tuning in to people like me. And so I get a little bit sensitive about that. Like just this morning before I even started, I had another critical comment about how, well, I'll just have to watch it with someone who isn't going to talk over the entire thing. And I'm 100,000% not talking over the entire thing. I will give commentary every now and then, but there are sometimes 45 minutes to an hour where I go without saying anything because I'm just listening. Or because I'm working, because this is not how I make my money. In fact, I lose money focusing on this stuff. I lose money doing the election integrity work. I lose money doing this. So donations are greatly appreciated. We have gotten a few, and I really appreciate you guys. We've gotten a lot of positive comments. So I appreciate Hunter Saba, Big Black Conservative. Thank you guys for being here so early. And thank you for being constructive instead of destructive. I really appreciate that. I can't tell you how much that means because the critical comments, though there aren't anywhere near as many as supportive comments, I have much more supportive things being said. than negative things. But the negative comments are doing the devil's work. They are serving the deep state. If people really don't appreciate my commentary, there are other streams where the people hosting the stream have no idea what's going on and couldn't tell you who's who or who's done what or what means what. That's the benefit of watching with Taking Back Texas. We actually know what's going on around here, and we can tell you most things. Okay, there's some things that are confusing, and in just a little while we'll go over what happened at the end of the hearing yesterday, because it was pretty strange. It was unexpected. It was it was weird, and then it got reversed. So we'll go over that in just a little bit. So thank you guys. Thank you so much. I appreciate you guys. Let me see it, and that's over on the Rumble chat. We've already got Hunter Sabo and Big Bad Black Conservative and 31 other people lurking. Y'all can all feel free to say hello. Over on the Pilled chat, we've got Fact Finder, Toxic Masculinity, Ew, and all these whistlers look and act like sissies.
The Alliance Defending Freedom to be co-handled with the Office of Attorney General?
We have.
Okay. And some of those cases you have worked directly with Brent Webster, have you not?
There have been some, yes.
Specifically, state of Texas versus Xavier Becerra.
I believe that's the title of the case in Lubbock, Texas.
Okay. And that was one of a few cases, true?
Yes.
And all the while that you were bringing cases from Alliance Defending Freedom back to the Office of Attorney General, Brent Webster was acting as first assistant, true?
That is my understanding,
Okay.
yes.
And Ken Paxton was acting as Attorney General?
Yes.
I want to talk to you about the open records request, okay? You kind of gave us an explanation of how the process works, so I just want to rehash that out. My understanding is that if an individual makes a request to a state agency, that state agency has a certain time period to go to the Office of Attorney General and make a request for a ruling, right?
There is a statutory time period to request a ruling, yes.
We have
Right.
this
So in this
document on
case, the statutory time
takingbacktexas.org
period,
that
well,
explains all of this
for example, when Nate Paul went to the Department of Public Services in March of 2020, if that was March 3rd, they had till March 13th essentially to request your office give an opinion. True?
I do not recall the specific dates, nor do I recall whether it was Nate Paul or one of his attorneys who made that request.
Okay. I just want to clarify, you do not recall the specific dates in which the DPS request by Nate Paul's attorney was made?
It was in the spring of 2020, but I don't recall the precise dates. I'd have to see some documents around
that. Eric, would you mind pulling up Article 3? And while we're doing that, just for a little background, Mr. Bangert, the requests by Nate Paul's attorneys for the records involved in the investigation, it was for initially the Texas State Securities Board, right?
Yes, the initial request went to SSB.
That was in 2019.
Is that a question?
Yeah, that was in 2019.
Yes, it was.
Then you've got DPS. That request was made in the spring of 2020.
That is correct.
And sometime later, arguably end of May, there was a request made for FBI's comment or brief on the DPS request that was originally filed in the spring, right?
I believe that was part of the second request.
Okay, so we're talking about 3 different records requests, correct?
I would classify it as 2 with a secondary request attached to the second.
Okay. And then you also have to throw in the request for reconsideration, right, on the Texas State Securities Board?
Yeah. That was part of the first file.
So essentially, the Office of Attorney General makes 4 separate decisions about records relating to Nate Paul.
We made at least 3. I don't know if it was 4.
Okay. Well, let's go back to fall of 2019. Texas State Securities Board. At that time, was Ken Paxton the office of it? He was the AG of the Attorney General's office, right?
Yes, he was.
Now, when Nate Paul made that request through Aaron Borden, his attorney, in fall of 2019, that initial request was denied by the Office of Attorney General, was it not?
Yes, the ORD did, well, when you say denied, it sustained the request for exemptions and exceptions by the board.
Sure, meaning that the Texas State Securities Board, while Ken Paxton was AG, was not required to turn over records to Nate Paul.
That's right. The November request did not require turnover of records.
Let's move forward to 2020. You had a conversation with Justin Gordon about a request for reconsideration of the Texas State Security Board records. True?
I did.
And ultimately, you ended up having conversations with Ken Paxton about that request for reconsideration.
I did.
And ultimately, the Office of Attorney General again did not rule that the Texas State Board, the Texas State Securities Board, was going to have to turn their records over to Nate Paul, did they?
We did not require them to turn their records over.
Okay. So up until, that puts us in February or March of 2020, would you agree?
We're ballpark in that area, yes.
Right, ballparking it because yesterday you stated it was right around the time COVID started.
Yes.
That's a whole nother convo we'll get into in a little bit. Okay, so Texas State Securities Board records are not given to Nate Paul. Let's move on to DPS. Now, to be clear, the ultimate decision by the Office of Attorney General with regard to the DPS records was that they refused to rule in that situation.
It was a no decision.
Okay. Now, I want to talk to you about what that means. If the Office of Attorney General refuses to rule on a records request, that means that the state agency that was requested does not have to turn their records over to the individual, right?
We did not require disclosure based on that ruling.
Okay. And so, as a result of that ruling, the Department of Public Safety did not turn their records over to Nate Paul or his attorneys, true?
That ruling did not require disclosure.
Okay. Well, you're aware that there was a writ of mandamus filed by Nate Paul's attorney for those records they were trying to get from you, correct?
You're going to have to, the writ of mandamus, I believe, occurred with respect to the initial request. I don't recall one on the second request, but it may have happened.
You would agree there was a writ of mandamus filed?
At some point, it was my understanding that a writ had been filed.
Okay, and you're not going to tell this jury when that suit was resolved, are you?
No.
For a matter of fact, it could have been pending into the winter of the next year, true?
As far as I know, and it's, for clarity, when you say writ of mandamus, I'm assuming you're talking about federal practice.
No, I'm talking about writ of mandamus in the district court for the Department of Public Safety records.
You're talking about the second issue then. Okay. No, yeah, there was a pending action in the district court.
Okay, so they weren't just going to Office of Attorney General to try and get these records that they were after, right?
Could you repeat one more time?
They weren't just going to the Office of Attorney General, Nate Paul and his lawyers. They were also going to the district court to try and get the records they were after, correct?
That was my understanding.
Okay. Now, DPS was not required to disclose records after this refusal to rule, right?
Our refusal to rule did not require them to disclose.
You stated that that was contrary to precedent at the Attorney General's office, true?
I did.
But you would have to admit that this specific request made by Nate Paul and his attorney, Joe Larson, had some unique circumstances, true?
I don't recall any unique circumstances.
Well, you worked with Justin Gordon pretty closely on this case, didn't you?
I worked with him very closely on the first file for SSB and somewhat, but less closely on the second file.
Okay. Could you kind of, so you really delegated it to Justin Gordon to handle, right?
No.
He was the man in charge of this decision, was he not?
He was the head of Open Records, answering to Ryan Vassar, the deputy for legal counsel at the time.
And he drafted opinions, and he drafted the opinion to refuse to rule that you edited, true?
I did edit the opinion.
Okay. Your Honor, may I approach the witness?
Yes, you may. Just don't talk on your way up or back.
Yes, Judge. I guess the point I'm getting at, Mr. Bangert, is that not every, like you said yesterday, you said that pretty much all of these requests are kind of the same. They're easy to rule on when it comes to law enforcement material, true?
They're not all easy, but we get a lot of them.
Right. You referenced the opinion, the law enforcement exception, true?
Yeah, so
yes,
he looks
I
like
believe that's
he
correct.
looks like Tim
Doesn't you
McGraw.
say the opinion? Which one are you referring to, though? I want to make sure
I
I'm
can tell
answering
some of y'all are from
accurately.
Texas
Well, the
that are
DPS
watching
opinion.
this. Some of you commenters are.
I believe
from
that's
Texas.
correct. I need to see it again.
And the FBI comment.
Again, I need to see the document.
To be clear, there was an initial request for DPS records in March of or spring of 2020, true?
That is my understanding, yes.
Okay. There was a later, you're aware that DPS did not notify the FBI about the records, true?
I don't recall that. You'd have to refresh my memory on it.
So it sounds like you don't know every little detail about the records request, do you?
No, and that's perfectly normal for a senior executive not to know every detail.
So yesterday, when you said that the decision was not consistent with precedent, you didn't know every little fact about what was going on within this request, did you?
I knew enough to make that determination.
Well, you didn't know everything, did you, Mr. Bangert?
I am not omniscient, so no, I did not know everything, but I knew enough to make that determination.
And it's fair that maybe Mr. Gordon had a different opinion about what went on with regard to those records requests.
Mr. Gordon was working on that. I do not recall what his opinion was.
Okay. Are you aware that ultimately the Office of Attorney General did disclose the FBI comment?
I do not recall that.
Okay. Are you familiar with June Haddon?
June Haddon, the name is familiar. I believe she worked in the Open Records Division.
Okay. Would it surprise you to find out that she ruled that the FBI's brief on the DPS record should be disclosed to Nate Paul and his attorneys?
I'm not aware of that, but I'd have to see the ruling.
Okay. You hadn't heard her name with regard to this litigation or case today, have you?
No, not until today.
Okay. And you have no opinion as to whether Ken Paxton prodded June Haddon to turn those records over to Nate Paul, do you?
You'll have to ask the question again. It was coming fast.
There's no evidence, you don't know of any evidence, or you have no opinion that Ken Paxton told June Haddon to turn the FBI comment over.
I'm not aware of any conversation to that effect.
Safe to say that in conclusion, every single request for records from Nate Paul's lawyers, none of those resulted in him getting the records with regard to DPS and Texas State Securities Boards, right?
I'm not aware of any disclosures that were made.
Okay.
At least by our office formally.
So essentially every ruling that was made with regard to those records was the same, had the same effect as if you refused to require DPS or Texas State Securities Boards to turn those records over.
The net result was they did not have to disclose the documents.
Okay. You were involved with Biddy as well, right?
Yes.
Now, you talked about the fact that Ken Paxton directly ordered you to intervene into the lawsuit, true?
Yes.
Now, you would agree that if you thought something was illegal, you wouldn't want to delegate it to a lower level attorney, true?
That I don't even know how, no, that does not.
Yes or no? Would you delegate illegal activity to a lower ranking attorney?
The question doesn't make sense because I wouldn't carry out illegal activity.
Judge, I'd asked a non-responsive. I've asked him a question.
Answer the question.
Yes or no?
I would not instruct anyone to carry out illegal activity.
Right. That's why you didn't have Ryan Vassar sign that opinion in July of 2020.
I did not have him sign that opinion because I had a very bad feeling of where that was headed.
Okay. Well, let's talk about what you did in the Biddy case. You had no problem instructing, well, let me rephrase that. You did instruct Josh Godby to intervene into the Biddy case, did you not?
I did.
And when Ken Paxton asked you to file a motion to stay, you told the jury that you were opposed to filing that motion to stay, did you not?
I did.
But you turned around and you asked Joshua Godby to file a motion to stay in that case, did you not?
I don't recall that.
Okay. He filed a motion to stay, didn't he?
That is my understanding. Eventually, a motion to stay was filed.
Okay. You didn't walk up to Ken Paxton and say, Ken, I don't agree with what you're doing, and so I'm not going to do it.
I did not have that conversation with him, no.
And at no point did Ken Paxton say to you that if you do not intervene into the Mitty case, that you're going to be fired.
No, we never had that conversation.
You are aware that Mitty has been previously of interest to the Office of Attorney General, true?
You'll have to refresh my recollection.
Okay, well, when Greg Abbott was the Attorney General, you're aware that the Office of Attorney General filed suit against Mitty.
Yes, that did happen.
Okay, so you are aware that their background isn't necessarily squeaky clean.
I wouldn't put it that way.
You would not tell, you've got no knowledge that Ken Paxton was entering into the Mitty litigation for the purposes of benefiting Nate Paul, would you?
Well, I disagree with that.
Okay, do you have personal knowledge? Yes or no?
I do.
You do?
Yes.
Well, Jeff Mateer made you aware of the fact that Jeff Mateer made you aware that World Class was disgruntled and not happy with Joshua Godby's performance in the intervention in Mitty. True?
That was sometime later, but I received an email. I was copied on an email in which Jeff responded to current counsel for World Class, complaining about Joshua Godby.
Okay. So World Class was complaining about Joshua Godby. True?
They were.
Now, at some point, you stopped talking to Joshua Godby. I want to say that was, excuse me, let me back up. You stopped talking to Justin Gordon about the open records request. True?
At some point, the issue came to a rest,
Right,
so I would have no occasion to talk to him after.
Probably when you made the final ruling not to disclose the records in the Department of Public Safety request.
When the no decision was issued, yes, that's when it would have terminated.
Now, about 1 or 2 days after that, it might have been June 2nd, you started talking to Joshua Godby about the Mitty Foundation case. True?
That sounds about right, yes.
And Ryan Vassar has his hands in the open records request at that time too. True?
He was overseeing the open records division.
Because he took your position, right?
He did when I was promoted.
Okay. So Ryan Vassar is also probably aware of these different interactions with Nate Paul between the Office of Attorney General and Nate Paul, correct?
You'll have to ask him that question.
Okay. Well, safe to say that he worked on the open records request with you, right?
He worked on it, yes.
And he worked on the foreclosure opinion with you, true?
He did.
Okay, so those are two different scenarios where you and him both worked on Nate Paul issues, true?
At least those two.
Okay, and it's fair to say that you and Mr. Vassar were discussing the fact that you both had been involved with Nate Paul.
At what time?
At some point when you were working on these cases.
We had discussion around those two instances. We discussed the work that we were doing.
Okay, so you would not tell our jury, the senators, that the executive level attorney generals did not know that different divisions or facets of the office were involved with or working on cases regarding Nate Paul, would you?
We began to piece together the linkages between these matters over time.
Okay. But you didn't do anything about it until September, I want to say 30th of 2020, true?
That's false.
Well, you didn't go to the FBI until September 30th of 2020?
We didn't go to the FBI.
Let's talk about that foreclosure guidance.
So snarky.
Eric, would you mind pulling up Article 2? And to be clear, Ken Paxton is allowed to intervene into a lawsuit if he thinks it's appropriate, true?
Our office has authority to intervene.
Okay. And he's in charge of the office, is he not?
He is the elected attorney general.
Okay. So if he wants to intervene in a lawsuit, he is allowed to do so.
He has authority to do so.
Okay. Looking at Article 2, it alleges that Mr. Paxton misused his power to issue written legal opinions under Subchapter C, Chapter 402 of the Texas Government Code. You're aware of this, right?
Yes, I see the article on my screen. Yes.
Okay. Now, we actually looked at a copy of that exhibit. Eric, would you mind entering exhibit 192, AG 192? And Judge, for the record, I believe it is an exact copy of a House Board Manager exhibit that they've already published. Would you scroll to the second page, Eric? And just to be clear, Mr. Banger, when we talk about that very last paragraph, you actually signed this opinion, right?
Yes.
Okay. And by signing it, you would agree that you have adopted the statements within it, true?
Not necessarily.
Okay. So you just sign things at will?
No.
No? Okay. And you signed this document, right?
I did sign this
And
document.
the very last sentence or paragraph in that document says, it is not a formal opinion under subchapter C, chapter 402 of the Texas Government Code, true?
Could you scroll down to the last paragraph?
Well, you wrote the opinion and you read it a minute ago. You would
I'd like
agree
to
with
see
that.
I'd like to see the document. Ah, there it is.
Got it. You wrote, we trust this letter provides you with the advice you were seeking. Please note this letter is not a formal Attorney General opinion under section 402.042 of the Texas Government Code. Rather, it is intended only to convey informal legal guidance.
Yes.
You wrote that, right?
I did.
That was on this letter when you issued it in 2020, right?
It was.
Okay. So the very face of the document that you signed specifically states that it is not an opinion under 402, true?
No, that's not correct.
Specifically says it's not a formal Attorney General opinion under section 402.042 of the Texas Government Code.
It is not a formal Attorney General opinion.
Okay.
Under section 402. It's very different.
Okay. Let's talk about formal opinions. There's a specific place on the Attorney General website for a formal opinion, is there not?
Opinions that are issued are listed on our website, yes. They were signed KP numbers and they are accessible by the public.
They are signed KP numbers. This time, Judge, I would move to offer AG Exhibit 6 after I provide a copy to opposing counsel.
If you have one more copy for us, we'd appreciate it.
I've got one more copy for the court.
I have no objection, Your Honor.
We'd still like to see it.
Yes, Judge.
Just so we can follow along. All right. Thank you, sir. Admit this exhibit into evidence. No objection.
And Eric, if you would publish and just stay on the first page. So up here in the top left corner, we've got opinion number KP 0322. True?
Yes, it says opinion number KP 0322.
Okay. And that is an opinion number that is associated with a formal opinion.
I have not seen the rest of this document, but I'm assuming that this has the form and shape of an informal opinion.
Okay. Did you state yesterday during direct examination that Ken Paxton doesn't have a hand in signing or dealing with formal opinions?
I don't believe I said that, no.
Okay. So you would agree that he does pay attention to what he signs and what he issues on his office letterhead, correct?
He is required, or, well, I should say, he has a practice of signing formal opinions himself.
Okay. And that opinion has his name on it, true?
I cannot see it, but I would be welcome to look at the signature block.
Eric, would you flip back to the signature line? Okay. You see Ken Paxton's signature on that opinion, right?
Yes.
Okay. He has to sign these formal opinions, does he not?
I believe that is the practice of the office.
Unless he's been recused, in which event Jeff Mateer would sign the formal opinions, true?
That was the practice of the office.
Now, I want to talk to you about the opinions in this case. Originally, Ryan Vassar drafted the the informal guidance letter with regard to foreclosure sales, correct?
Yes, the informal opinion that was issued on August 1st, he did draft the initial draft, yes.
Now, the way that that letter ruled was essentially that you didn't attack the 10-person restriction from the executive order, right? You just said that judicial foreclosure sales were accepted from the rule and could go on with that restriction.
I would need to see the document to refresh my recollection on the precise contours of the opinion.
Eric, would you pull up Exhibit 192?
Okay, everybody. I would like to, at this point, I want to say thank you to everybody that's commenting. I'm going to pull the microphone. I have a very loud voice. I was gifted with I don't know what. I'm trying not to scream or to holler in your ears. So if it seems as though I am speaking more calmly than normal, that's just because my normal voice is very loud. Even my whispers can be stage whispers if I don't watch it. But what I'd like to do now is to break down the articles of impeachment. And if you hear rain in the background, yes, Texas has been blessed with rain. I'm not sure if this is some sort of, maybe, if somebody might see something of value in this, sort of a good omen for Texans. Rain can be a very good omen. So I'm pleased, and I do also apologize if there is a lot of background noise. So I've got some very kind and constructive patriots listening. Big Bad Black Conservative, let me know if this audio is sounding right, if I'm a little bit loud, or if I'm doing all right. And especially let me know if you can hear the rain in the background and the cars driving through it, because I'm in an efficiency apartment in a downtown city area, so it's not necessarily the best for audio, but I appreciate you guys. And at least I know that Big Bad Black Conservative, you're going to be very polite and constructive about it, and I very much appreciate that. So I am at this point soliciting critiques, though about 30 minutes ago I was nitpicking about critiques. I'm soliciting constructive critiques in case there are issues with the audio. So thank you so much. And what I want to do is show you guys how to find this stuff. Okay, so I'm going to go ahead and add this to the page so you can see. Okay, this is where I'm at. This is just where I'm at. Home screen search. I use Brave. Okay, but it doesn't matter too much. So you're going to go to house.texas. And this is filling it in already, but I'm going to just show you where to go. You're going to go to house.texas.gov. And this is what you're going to pull up. Then you'll go over to committees. See this area up at the top right here? Committees. You're going to click on that. And these committees are listed alphabetically. We're going to go down to the General Investigating Committee because that is the committee that's right down here. Again, these are alphabetical, the committees are. Scroll down to General Investigating Committee and click on that one. All right, are y'all following so far? Now we're going to do a breakdown of these articles. We're going to show you which ones have been debunked, how they've been debunked, and it's going to be relatively informative. Now, if you've been watching for a few days, you've experienced this. We've broken down these before. So now, I forgot to tell you what to do. So what you're going to do is when you're on this General Investigating Committee page, you're going to come, excuse me, over to the right side, right over here. See the quick links in this little right-hand column? So under quick links is basically everything that this House committee has done. All right, and Paxton's impeachment is here among the very few things that this General Investigating Committee actually investigated. Okay, here looks like they've done something against Brian Slayton. Okay, and here's something against Paxton. So what it appears this House Investigating Committee has done has they've only investigated representatives, Texas representatives, which could be a beneficial thing. But you're going to click on HR 2377 Warren Kenneth Paxton. This is the impeachment. These are the articles, and you're going to click on that, and I'm going to share this with you. Okay, so now you can see that, and give me a 5x5 if y'all can see that. Hello, Fact Finder and Grain of Salt, Carrie Lake, welcome. Over on Pilled and Foxhole, you guys are up and at 'em early this morning. Good job. Fact Finder says this witness reminds me of the demon Peter Strzok. You know what? Thank you, Fact Finder. I was trying to identify which vibes am I getting from this guy, from this particular witness, and I think I agree with you. I think I totally agree with you. He's giving Peter Strzok vibes. Isn't that crazy? Okay. So give me a 5x5 if you guys can hear me. And if this is looking good. And I will zoom in on these articles so that you can see them a little bit better. Oh. Well. Not too much. Alright. Is that enough? This is good, I think. And this is enough for all of you all to read. Yes. Okay, guys. Thank you so much. Miss Firecracker, thank you. Big Bad Black Conservative says you're doing the work. You're doing good work here. I'm working and can't stream it myself. Doing us a service. I'm glad to help. Thank you so much. Hunter Sabo says you do a wonderful job. So glad I found you on Rumble. I'm glad y'all found me too. Thank you, Miss Firecracker, for the 5x5. All right. And I appreciate all of y'all's constructive comments. So now over here, these are obviously these are the impeachment articles. There are 20 of them. In my opinion, some of them are a bit redundant, but we'll see what you guys think. Article 1 was thoroughly debunked right away from Paxton's team. Immediately, as soon as Busby began his cross-examination of the first witness, which was, what was his name? I can't remember his name. He was the Dwight Schrute of this entire impeachment. He was the assistant to the manager. The very first witness was absolutely destroyed, and in the process, it totally debunked multiple articles. So, Article 1 says that specifically Paxton caused employees of his office to intervene in a lawsuit brought by the Roy F. and Joanne Cole Mitty Foundation against several corporate entities controlled by Nate Paul. Paxton harmed the Mitty Foundation in an effort to benefit Paul. None of this is true. The Mitty Foundation has not lost a single dime. In fact, they have profited $20 million off of this lawsuit with Nate Paul. Mitty Foundation has not been hurt in any means. The Mitty Foundation invested $3 million into Nate Paul's properties, and before this, they had several successful business deals with Nate Paul. But during COVID, when Nate Paul was unable to make his payments on his properties, like everybody was unable to make their payments on their properties during COVID, during the government mandated lockdown, the Mitty Foundation decided to sue in an attempt to obtain the properties for themselves, and they were successful in doing that. Ken Paxton, on referral from the Travis County DA, opened up an investigation, and all of the employees, I should call them mutineers, all of the mutineers, being referred to as whistleblowers, they all signed off on this investigation because it was a lawful investigation. There were multiple agencies that were looking into this, and it ended up at the Attorney General's office, these complaints from Nate Paul. Okay, so not only did he cause employees of it, not only did he not cause employees of his office to intervene in the lawsuit, okay, they all approved of it and signed off on it. Not one of them said, hey, this is something we shouldn't be looking into. Okay, not one of them said that. They all agreed to allow it to be looked into, okay, at least on its face. And we'll get to what they actually wanted to do in just a minute. So Article 1's been thoroughly debunked. Article 2, specifically, Paxton caused employees of his office to prepare an opinion in an attempt to avoid the impending foreclosure sales of properties belonging to Nate Paul or business entities controlled by Paul. Paxton concealed his actions by soliciting the chair of a Senate committee to serve as a straw requester. Furthermore, Paxton directed employees of his office to reverse their legal conclusion for the benefit of Paul. Again, foreclosures were halted statewide and nationwide. That was the position of Governor Abbott, to halt all foreclosure sales. That's what was being discussed because people weren't able to make their payments. The only foreclosure sales that I believe were allowed to happen were foreclosures on properties that had been processed prior to the lockdown. Those foreclosures, some foreclosures were allowed to go through. But if the foreclosures were filed in the middle of the lockdown, the position of Governor Abbott, of President Trump, and of the Attorney General was that we're not going to allow or authorize foreclosure sales to happen and making people lose their property when they're unable to pay their bills because of a government-mandated lockdown. So this did not benefit Nate Paul. This was the position of the governor, of the president, of President Trump, and of the Attorney General's office. So he did not cause employees to prepare an opinion in an attempt to avoid the impending foreclosure sales of properties belonging to Nate Paul. The employees took that opinion because the office took that opinion. This was a collective thing because the governor took that opinion and the president took that opinion. And the only people that were mad about this are the mutineers and the leftists that have wormed their way into the OAG. And this is exactly why Paxton hired outside counsel, because he did not trust these fools. And we see that he should not have trusted them. We see that very clearly. He was right. Imagine that. We all agree with the duly elected Attorney General. Imagine that, guys. That we agree with the person we sent up there to do this job. Okay. Paxton concealed his actions. I don't know that he concealed his actions at all, but I think that having a legitimate request for a ruling on this thing being sent in, or an opinion to be issued being sent in by a representative is not a problem. Not a problem at all. This was to prevent people from losing their properties. And then it says Paxton directed employees of his office to reverse their legal conclusion for the benefit of Paul. This very well may have happened, and I'm glad if it did. I'm glad if it did happen. If the OAG is gone rogue and his little underlings that Paxton brought on are deciding to act against the will of the duly elected Attorney General, the governor, and our president, I'm glad that Paxton saw what they did and said, what is this? This is not the opinion. This is not the position we're taking. You need to correct that and fall in line. So if Paxton did direct employees of his office to reverse their legal conclusion for the benefit of Paul, that was the right thing to do. I'm glad he did it. I'm glad he stood up for Nate Paul. You know, I don't know. Nate Paul as we know, you can have all of the money in the world, all of the influence, and all of the respect of the people in the world, as Trump does. But as we see, that's not going to protect you from the deep state when the deep state decides to get you. All right. So Nate Paul having the Attorney General there to help him, that's just a good thing. It's all good things. I'm not seeing any issues. Let me know when y'all spot the issue, because I'm not spotting the issue yet. Article 3. Anyways, Articles 1 and 2 have been totally debunked. Article 3. Specifically, Paxton directed employees of his office to act contrary to law by refusing to render a proper decision relating to a public information request for records held by the Department of Public Safety, and by issuing a decision involving another public information request that was contrary to law and applicable legal precedent. Okay. We're going to start from the bottom and go backwards. Issuing a decision involving another public information request that was contrary to law and applicable legal precedent. When he issues a decision, that is an opinion, a legal opinion. So that's not an impeachable offense. That if he issues an opinion that's contrary, I doubt it's contrary to law, but probably, and you'll see how more and more of these are so blatantly false that they'll just flat out lie in these articles. though applicable legal precedent, probably, he did say something that went against the grain. Say, hey, I think that these people should have access to this information. And that went against the grain. And let me tell you, the deep state does not like that. When they decide, let's just use election records as an example. When they decide they don't want us to have access to what the law says are publicly available public records, then they will do everything in their power, including suing the Attorney General himself, to try to prevent those records from being released, which is what they've done, which we've watched them do over the several years. So, contrary to law and applicable legal precedent, an Attorney General opinion that's contrary to applicable legal precedent, not a problem for me. If it was contrary to law, we could talk about that, though they've been unable to make this case on the stand under oath. It's so easy to say whatever you want when you're not under oath. But once you're under oath, it becomes much more difficult. You have to be very specific, and you've got to, cover your ass, right? Okay. Act contrary to law by refusing to render a proper decision relating to a public information request. So they wanted Paxton to deny a request. Paxton said, I don't think I want to deny the request. I think that he should have access to this info. There was a little civil war internally about that. And so Paxton said, we don't have an opinion on that. That's going to have to go to, I guess, take that to court and see if there's any way for a judge to make a ruling. Okay, because Attorney General opinions are one thing, and then a judge's ruling is a different thing. So this is just not an impeachable offense. Okay, so Article 3 debunked, because issuing opinions is what he's there for, whether you agree with them or not. Okay, that's just what he's there for. If he issues an opinion and then a lot of things happen based on his opinion that his office is responsible for, then that's a little bit different if they're breaking laws. No laws have been broken. Nobody's been able to make that claim. You know what I mean? So Article 4. So Article 3 debunked. Article 4. Specifically, Paxton improperly obtained access to information held by his office that had not been publicly disclosed for the purpose of providing the information to the benefit of Nate Paul. I don't know that that's necessarily true. It looks as though Nate Paul was asking Paxton to confirm that these warrants were legitimate. These warrants from the FBI were legitimate, because apparently raids were conducted on Nate Paul's properties, and Nate Paul was not left with copies of the warrants, which is very suspicious. And admittedly, under oath, they said, yeah, it's usually best practice. Usually procedure is you have to leave a copy with them. And I imagine the reason why you'd want to leave a copy with them is so that they have the evidence that you served a lawful warrant. Why would they not leave a copy of the warrant with Nate Paul? Well, Nate Paul is concerned that the warrants were modified afterwards to authorize what actually happened in the raids. And hang on, let me turn my phone down. I need to change my notification sound too, because that's very triggering. When Paxton was investigating the complaints by Nate Paul that there were potential unlawful warrants, and Paxton begins to look into this, that's not an impeachable offense. In fact, it was recommended from the Travis County DA that Paxton's office handle this investigation. So Paxton handling the investigation and providing information to Nate Paul that Nate Paul requested, and that Paxton had no legal right to deny him, or that Paxton felt like Paul should have access to, like the warrants. Paul should have had access to those warrants. He absolutely should have a copy of the warrants that were served in raids conducted on his property. So Article 4 debunked, because no, Paxton did not improperly obtain access to information. And how do you improperly obtain access to information held by his own office? He is the duly elected Attorney General of the great state of Texas. If it is in his office, he can obtain that information however he wants. What are you talking about? Paxton improperly obtained access to information. He has total access, does he not? Is there somebody above General Paxton in the Attorney General's office, guys? Are they ready to admit that there is a shadow government secretly attempting to control this place? Is that what they're... Are we there yet? Are we ready to talk about that? Article 4, debunked. You don't improperly obtain access to information held by your own office. So he says Paxton improperly obtained access to information held by his office. So what's the improperly obtained improper access, you know? Improper access? What? How did he obtain improper access? Debunked. Article 5. Specifically, Paxton engaged in Brandon Kamick, a licensed attorney. And did y'all see Brandon Kamick's testimony yesterday? I thought it was great. I thought he did a great job. Again, whenever an issue is spotted, I think we should talk about it. We just haven't been able to spot any yet. Other than this affair, which they're only using because they just have nothing. They have nothing. But Paxton dealt with his affair, and that's between him and his wife and God. Okay? And she's a good woman if she chose to preserve the marriage because she loves him. You know, and he's a good man for coming clean and admitting it and asking for forgiveness. So what more can we do, you know? So here, you know, so every time they bring up that affair, it's just know that it's because all of these articles are weak and they have nothing. So Brandon Kamick was wonderful. And later we'll do a recap. Maybe during the lunch break, we'll do a little recap of Brandon Kamick's testimony. It looks as though we're about to start. We'll go back through later. We stopped off on Article 5. So, a licensed attorney. Anyways, let's just debunk Article 5 really quick. Specifically, Paxton engaged Brandon Kamick, a licensed attorney, to conduct an investigation into a baseless complaint during which Kamick issued more than 30 grand jury subpoenas in an effort to benefit Nate Paul or Paul's business entities. Paxton has every right to hire outside counsel. He is the duly elected attorney general. He does not need anybody's permission. And of course he hired outside counsel because the people, the mutineers, the whistleblowers who have tried to impeach Attorney General Paxton over helping with this issue already labeled this complaint as baseless. Why would he assign somebody that's already made up their mind on the case to investigate it? Why would he do that when they've already made up their mind without an investigation? So of course Paxton engaged Brandon Kamick. So Article 5, debunked. He has every right to hire an outside investigator. He has every right to conduct an investigation. The complaint was not baseless. Paxton did not agree that the complaint was baseless. So he hired Brandon Kamick to look into it because all of the mutineers in his own office had overplayed their hand and had shown their ass. The line was drawn and they picked their side. And did Attorney General fire them over it? No, he did not. No, he did not. Okay. It does appear that we're about to get started any moment now. Let's see. There we go.
Well, let's go to the Lord in prayer.
In prayer.
Heavenly Father, when we consider who you are, the one who has always existed before time, way back into eternity, who always was and always will be. When we consider that you made everything we see, things we cannot see, us, every molecule, every particle of each of us, just because of who you are, we owe you everything. We owe you our lives. And Father, when we consider on top of that all that you've done for us, the gifts that you lavish upon us, that you heap upon us, our very lives, and especially those of us in this country and this state, the special blessings we enjoy of liberty and opportunity and justice, unknown in the history of the world, uniquely given to us here from your hand. We know we each have a responsibility in preserving those things as stewards, each one of us, whatever our role. So, Father, we thank you. Thank you for who you are, for what you've done. We confess our failure to acknowledge you as we ought, to look to you, to humble ourselves before you. And we just thank you for loving us, the ultimate expression of your love for us, that Jesus Christ, God's Son, God himself, would humble himself and come to this earth and take on human form and live that beautiful life and then pay the penalty for all of our sins on the cross and then raised from the dead on the third day. We thank you for him. Your word says that since you gave him for us, there's nothing you'll hold back. So, Father, we ask you for wisdom that you've promised to give. We ask you to be honored in these proceedings today by everyone here, whatever their role. Thank you for loving us so much. In Jesus' name we pray. Amen.
Thank you, Senator. You may be seated.
Amen, and thank you guys for being here over on Pill. Yes. Mateer. Thank you, Truitt. The first witness's name was Mateer. Jeff Mateer. Good morning, Truitt. Carrie Lake. Grain of Salt. Fact Finder, of course. And everybody else that's watching, feel free to comment. Let's go and check over on the Rumble chat.
Members, can we have a little quiet in the
It was a
courtroom? Can I
good
have both
prayer,
parties
wasn't
come
it,
forward?
Mark? Yes, it was. Hunter Sabo says, prayers to all from Ohio. Thank you, thank you. And Big Bad Black Conservative, you were a delegate? That's awesome. I wonder if we met. I wonder if we said hi. Which, hey, we're nerds, so we're about to get into it. Which Senate district were you from? And you can send it to me in the private, in the DMs on that we have going on Telegram now. I don't know how I missed you. And I see that you are also in the Texans, the state delegates, whatever that Telegram group is called. So you saw my little rant this morning, and I appreciate it if you took that down. I just, the negative comments, they sometimes trigger me, but I think that that's sort of weak. And I think that I should be more empowered by positive comments as opposed
Is the defense ready to call their first witness?
Thank you so much for your positive comments.
And who would that be?
Justin Gordon.
Bailiff will bring in Justin Gordon.
Now, let's review yesterday at the end of the
Counselor,
day.
state your name for the record.
Of course, Allison Collins.
I always give you the time check. Members, House, you have 2 hours, 34 minutes, and 49 seconds remaining. A respondent, 8 hours, 38 minutes, and no seconds remaining.
Now, at the end of the day yesterday, the House impeachment managers were doing their prosecution, right? And they accidentally rested, and Busby immediately jumped on it. And it was definitely an accident. Tony Hardin accidentally rested his prosecution case. Now the defense is calling their witnesses. Both chances will have so here's the issue. When the House impeachment managers rested, it was a pretty big deal, and Busby motioned to force a vote on the the sufficiency of the evidence, saying that this is not anything. These are not impeachable offenses, and there's no evidence for anything that they're even alleging. That accidental rest and Busby filing that motion literally threw everything into chaos. They both of them reversed the motions that they made. So at this point, we'll see how this goes.
Could you please turn on your microphone and go ahead and adjust it pretty close? The acoustics in here can be a little difficult.
Is that okay?
Yes, that's much better. Could you please state your name for the court?
My name is Justin Gordon.
And where are you currently employed?
I'm employed in the Open Records Division of the Texas Attorney General's office.
And what is your position there?
I'm the Open Records Division Chief.
How long have you been the chief of the Open Records Division?
I began in 2015 at the beginning of General Paxton's term.
Good morning, Ms. Firecracker.
Excuse me, I think you're going to have to speak louder and a little closer. Okay.
I began in 2015, in January of 2015.
Says, good morning from North Carolina.
What does the Open Records Division do?
Our division handles a number of responsibilities regarding the Texas Public Information Act. That includes enforcement and review of public information decision requests. We also provide training for governmental bodies on the Public Information Act.
Okay, I'm going to ask you just to slow down a little bit while you're talking, okay, to help the court reporter out. Can you tell us how many public information ruling requests your division handles a year?
Last year we did over 40,000. In the previous fiscal year we did just under 40,000.
And does your division maintain a record for each ruling request?
Yes, we maintain both an internal record of our ruling requests. We also post all of our letter rulings on our website after they are issued.
Do you recall a request for ruling from the Texas State Securities Board in the fall of 2019 for some records related to Nate Paul?
Yes.
Do you recall if any records were released as a result of that ruling request?
I do not believe any records were released in response to that ruling request.
Do you recall if there was a request for reconsideration of that ruling?
Yes, there was.
How frequently does the Open Records Division receive requests for reconsideration or complaints about a ruling?
That's very common. I don't have an exact number to provide you, but that's something that we see certainly on a monthly basis, if not weekly.
Were you also involved in deciding a request for ruling from DPS, the Department of Public Safety, in the spring of 2020, which we're going to call the big request for ease of reference? Do you recall that one?
Yes, I do.
This is the big request that Nate
was that
Paul put
also
in
related
for
to Nate Paul,
information.
if you recall?
It was.
At some point, as one of your duties, as part of your employment, did you make a summary of that file?
I did.
Your Honor, if I may approach the witness.
Yes, you may.
I'm going to approach with what is marked as AG.
Hold on one second. Yes, Senator Whitmire? Okay. Allison, you're going to have to speak louder as well.
Even louder. Okay.
That'll do it. That'll do it.
I'm going to approach with what has been marked as AG 205, and it is be pre-admitted.
Members, do you need for us to review with the court reporter what has already been said? You're okay? Everyone's okay? You do? Okay. Okay, so let's go back to where you began the question on DPS, Senator West. Securities. Okay, let's start over.
No problem. Do you recall receiving a request for ruling from the Texas State Securities Board in fall of 2019 for some records related to Nate Paul?
Yes.
Do you recall if any records were released as a result of ORD's ruling?
No, I do not believe any records were released in that ruling.
Do you recall if there was a request for reconsideration of that ruling?
Yes, there was a request for reconsideration.
How frequently does ORD receive requests for reconsideration or complaints about a ruling?
That's very frequent. I don't have an exact number to provide to you, but it's something that we see, if not on a weekly basis, then certainly monthly, several times a month, we receive reconsiderations.
Do you also recall being involved with a request from DPS in the spring of 2020 related to Nate Paul?
Yes.
Now, we've been calling that the big request to help distinguish them. Will you understand what I'm saying if I call it the big request?
Yes.
Thank you. And at one point, as part of your employment, did you create a summary of this file?
Yes.
Your Honor, I'm going to approach the witness with what has already been admitted as AG 205. Mr. Gordon, do you recognize this document?
I do.
Is it a fair and accurate depiction of the summary that you created for this file?
Yes, it is the summary I provided for the file.
Well, let's talk about it. Let's walk through it together, okay?
Okay.
First, how would you describe this particular request, the big request?
It started off as what I would have characterized as a relatively routine request from the Department of Public Safety. Department of Public Safety routinely briefs our office on law enforcement matters. They, again, very commonly submit rulings to our office. However, as the ruling was being reviewed, it took a turn procedurally, and then there was a number of procedural irregularities that occurred with the file that made it that made it unique.
And Eric, if you could please pull up AG Exhibit 205 and highlight the first paragraph, please. And Mr. Gordon, I think it's consistent with what you just said that there were procedural issues that made this file unique. Is that correct?
That's correct.
Okay, and when was the request received by your office?
On March 13th.
Okay, and at this point, this is when you're talking about it was very routine?
Correct.
Do you recall what exception DPS was asserting?
They sought to withhold the information under the law enforcement exception. That's Government Code Section 552.108.
Is that, there are generally two types of exceptions under the PIA, is that right?
That's correct. There are two, we characterize them as two separate types of exceptions. There's an exception for confidentiality provisions that we would also call mandatory exceptions. And there's a type of exception that is just a normal exception to disclosure that we would call a permissive exception to disclosure.
And which type is the law enforcement exception?
Section 552.108 is a permissive exception. The governmental body has the option to raise it or not to raise it.
What happens if they do not raise it?
Nothing happens if they do not raise it. We won't address it if they do not raise it.
So if they don't raise it and you don't address it, what's the end result as it relates to the request? Are those records released or are they withheld under the law enforcement exception?
Oh, they would be released. They would not be withheld under the law enforcement exception.
So let's talk about some of the procedural irregularities in this file. I'm now in the second paragraph, Eric, if you could blow that up for the senators. Where did this file first start to take a turn towards the unique?
Where you have it highlighted, I described that.
Excuse me one second. I'm very sorry. I'm very understanding with 8 grandchildren and a lot of little ones, but we really can't have a distraction. I'm sorry. Might have to step out. I really apologize, but I don't want to distract the jurors. Very sorry for that.
May we continue? Thank you. I believe you were about to point out to us where the procedural issues started to arise in this file.
Sure. So we have a statutory 45-day deadline by which we have to issue all of our rulings. That's from the government code. And as we were approaching that deadline, the DPS submitted a follow-up correspondence to our office explaining that the requested information may implicate the interests of the FBI. And at that time, they also submitted additional records. So in the initial submission, they only submitted a representative sample, which they are permitted to do. In fact, the PIA requires them to do that if the records are voluminous, and they had done that in the initial submission.
Impeachment proceedings.
However, when they submitted the subsequent submission, they submitted additional documents, not the same representative sample that they had submitted earlier. And the new documents were substantially different than the documents that had been originally submitted and were of a different character. So they
and I'm going to stop you. I think that's a great spot. And just to summarize, so essentially the original representative sample that DPS sent in did not match with the sample that they later sent to your office in May of 2020. Is that right?
That's correct.
And they sent that second sample at the time that they were notifying the FBI that they might have an interest in the file, in the information being sought by the request?
That's correct.
Is that considered a procedural violation under the Public Information Act?
Yes, governmental bodies are required to submit all of the records that they want a ruling on or a proper representative sample by the 15th business day after receiving the request, which had been substantially before this time period.
Well.
So this sample was also late. Yes. Is that correct?
That's right. That's correct.
What
now is when we get to see
for a procedural violation of this nature?
perspective.
Under the Public Information Act, failure to comply with the procedural requirements in requesting decision from our office results in a presumption that the information is released unless the exception that they're raising constitutes a compelling exception. And our office has concluded that Section 552.108 does not constitute a compelling reason. That's a fancy way of saying that they waive that exception, and they would waive it for the information that they had the procedural violation on.
And that would be all the information that they provided as the second sample in May of 2020?
Correct. Anything in that representative sample, the second set of documents that was not in the first set.
And is it your understanding that that second set of documents had also been provided to the FBI?
Oh, I'm not sure if they provided that second set of documents to the FBI. I don't remember that.
You all,
Okay,
so this
over on Rumble,
late,
we've
was
got
the
some
notice to the
questions.
FBI also late?
They both
Yes,
reversed the
governmental bodies.
the
There
positions
are
that they took
procedural
yesterday,
requirements, and there
except
are
the House
also
did
due
rest.
process requirements in the Public
But
Information
the
Act.
two motions
And because
that
of those
Busby had,
deadlines,
which was the
there
directive
are
verdict,
certain
that's
notice
been
requirements.
that's been
So
rescinded.
the only notice
And the
requirements in the
House's
Act that applies to
motion
third parties is
has
in
also been
Section
rescinded. But the House did
552.305.
rest.
That section
That was an accident
requires
on their
governmental
part.
bodies to notify third parties if their privacy or
So
proprietary
the
interests are
directive
at issue,
verdict was
and that notice
rescinded.
is supposed to come within 10
And that's
days
why,
of receiving
they're
the
basically
request.
acting like yesterday did not
Otherwise,
happen, except
there's also
like
the
last
due
part,
process
except
element
for the
of
House did
that notice
rest.
needs to be made in time for those comments to be received by our office before, in time for us to be aware of them, and also in time for the requester to receive notice.
And in this instance, was the notice given close in time to your statutory deadline to issue a ruling?
Yes, we received it just a couple of weeks before our 10-day deadline, or our 45-day
So to
deadline.
answer your questions over on Rumble, Trump Rocker, did the vote even take place by the senators, or are they just not saying what happened? The vote did not take place because the motion for a directive verdict was rescinded by Busby. And the House rescinded their motion as well.
Do you recall?
But the House did
I don't
rest.
recall.
So this is now the
If they were a
defense's team
CD or if they
to
were
make their
if they were a
case.
hard copy.
I hope that makes sense. But please, if you have more questions, go ahead and leave them in
notice
the
went out
comments.
to the FBI and you received a copy of it. What happens next?
So at that point, we were kind of up against it with respect to the timelines. You've got the highlights here with respect to the to kind of what was going on in this file. We had also been notified by the requester in this file that he had filed a lawsuit against DPS in this case, which added a whole nother layer of complexity to it. Because the late notice, because the notice was received so close up against our 45-day deadline, we didn't feel like the third party who was notified, FBI, would have had time to submit comments to our office in time. And so while we were waiting for those comments so that we could receive them and review them from the FBI, we took a 10-day extension on it, and again gave ourselves a 10-day extension, which is permitted under the PIA.
All right, I'm going to ask you just to slow down a little bit, okay? You're doing great. So you extend it for 10 more days. Does the FBI eventually provide your office with comments?
Yes.
And do you know if the FBI also provided the requester with a copy of those comments?
At the time, when we identified the documents, we actually only found the comments because the requester let us know that he had received comments, and so then we went and tracked them down. This is at the beginning of COVID, so our mail intake was kind of thrown off. So when the requester notified that we had received comments, we went and tracked those down. To add another procedural complication to it, at that time, the requester notified us that his copy of the comments had been completely redacted. Our copy did not have any redactions on it. It just had a reference that at the end that the version that had been provided to the requester was redacted.
In your honor, if I may approach with what's been marked as House Managers 46, but has not been admitted into evidence yet.
You may approach the witness.
Yes, guys, so I totally understand the confusion about what happened yesterday. So the House did rest. They were unable to take that back, but both parties did take back their other motions. So now it's just the defense's turn.
Mr. Gordon, do you recognize the document that I placed in front of you?
I do.
What is it?
This appears to be a copy of our internal ruling file pertaining to the DPS file that we've been discussing.
And does it appear to be a complete and accurate copy of the file?
Over on Pilled, we've got a question, grain of salt. Would you please explain the time left Patrick announced when it started today? Yes, each side was given 24 hours to make their case, and it's up to them how they use that time.
Take your time.
Paxton was letting, not Paxton. We're all doing this. We keep implicating Lieutenant Governor Dan Patrick when we mean to say Paxton and vice versa. Patrick was just letting them know how much time they have left for both sides, because each side was given equal amount of time. I believe 24 hours was I think 24 hours plus a couple hours each for a few different items. They were given identical amounts of time, though it's up to them how they want to use it. So it looks as though, one side has used a little more time than the other, and that's totally fine and understandable and strategic. Any time left over, they'll be able to use their time whether or not one side uses all of it or not. So that's why they keep track of that every day, how much time is left. I hope that makes sense.
Yes, it does.
I appreciate your thoroughness.
To the question of how does
we've
somebody
moved to
accidentally
admit
rest
House
their
Managers
case?
46.
Very simple, very quick.
Any objection?
It happens
Mr.
so
President,
fast.
no objection to the admission. However, in this document, it contains a copy of the unredacted FBI brief, which not only contains personal identifying information, but a number of sensitive information of the types of operations plans and other sensitive law enforcement information, which Nate Paul has been trying to get for a
DOJ's
while.
own Aaron
If it comes
Epley.
in, we just ask that it be redacted because that information has not been publicly made available.
And Your Honor, we'll get to that on the next request, but I will represent to this court that that is not the case. As has been discussed by other witnesses, this brief was in fact released publicly.
Okay, so they did not object, and I'll let her go along with her line of questioning, and we'll get back to that issue, but thank you for bringing it up. Go ahead.
Thank you. Eric, if you could pull up towards the back of that Exhibit 46, the Bates number at the bottom is 8803.
Mr.
And
President, I do have to, I'm sorry, before this is shown to the jury, there is personal identifying information
and
that has
sir,
not, may I finish?
Stop not talking over each other.
That has not been released publicly. It may have been released to Nate Paul at General Paxton's direction. However, it has not been made public to the world at large.
Okay.
There's very sensitive law enforcement operation plans, details about search warrants, how investigations are done, and also specific names of individuals that are identified and involved.
Come on up to the bench. Please come up to the bench.
Yes, sir.
And this, everybody, is what Aaron Epley does. She did this multiple times yesterday, attempting to approach the bench to convince Dan Patrick not to allow specific information in, despite her entire case being comprised of hearsay, double hearsay, slander, at this point libel, since they've written some of the lies down. If you say a lie meant to disparage somebody, it's slander, but if you type it out, it's then libel. So we're fighting very hard not to release information. Again, this is what the deep state does when they've decided that they want to take you down, and they will cover their tracks. While they do it, they will look you right in the face and smile, feeling very confident in themselves, in their ability to thoroughly destroy people.
yes, and we can ask Mr. Gordon that right now and he can clear that up.
Oh my. Somebody's microphone came on temporarily. It would be great to be able to hear what they're saying. This is the DOJ in the pink blazer. Oh, I'm very interested to hear this.
Any fall within this and it would be acceptable. It's not a special exception to only that requester. It is public.
Well, we're getting some excellent clips here from a candid mic. The DOJ and CIA's own Aaron Eppley facilitating the political takedown of Texas Attorney General Ken Paxton for his willingness to investigate complaints by a young real estate tycoon named Nate Paul related to potential abuses by the FBI, mishandling of information, fraudulent warrants, and other constitutional violations that Nate Paul has been alleging for years to multiple agencies. That is the CIA and DOJ's own Aaron Eppley facilitating this. Just for some context. But I've got the headphones pressed up against my ear, waiting for another candid mic moment. I'd love to hear more about this. Do you all think that their deliberations at the bench should be public? Shouldn't we be able to hear what they're saying, the ridiculous arguments that they're making for or against this? Now, I sure hope Dan Patrick doesn't allow Aaron Eppley to continue to waste time this way. I think he should make a decision. He is the lieutenant governor, the president of the Senate, and I think that he needs to. Oh, now they're addressing the microphone. Okay, they saw that there are some candid takes that were caught on that microphone. Well, I guess we won't get any more candid mic moments unless somebody accidentally turns theirs back on. I do hope that Dan Patrick puts his foot down and says, you know what, I'll make the determination as to whether something's admissible or not. Let's go and check the chat. Over on Pilled in Foxhole, Carrie Lake asks a great question. How do you accidentally rest your case? Victoria, her mind is blown. Yep. Hollywood lawyer outfit, absolutely. Bubblegum pink, that's what Aaron Eppley is wearing. I guess maybe she thinks that if she wears Pepto Pink, we won't throw up when she presents her case, but no, yes, Karen Aaron is there. Karen Eppley. All right, we're having too much fun now. All right, Carrie Lake, that was a very funny comment. Karen throwing a fit. Yes. Victoria says, I know that's not important, but costumes matter. Oh, gosh. Victoria, did you happen to see what that one senator was wearing when she was sworn in? And I've made several comments about this, and I should probably let it go. But for some reason, it's just stuck in the craw of my mind. Yeah, costumes matter, especially when it appears that your wardrobe came from the Gothic cheerleader section of Spirit Halloween, which is exactly what look, we call her Wednesday Addams, and you'll see her on camera. She's almost every day she's dressed inappropriately for the floor of the Senate. You need to be dressed in a humble and respectable manner, not showing too much leg and too much arm or even too much, body yaddy. And not that she has it. I mean, she's not a complete beached whale. She looks fine, but the way that Wednesday Addams dresses is inappropriate. So your comment on Karen Eppley, her name is Aaron Eppley. She's the CIA and DOJ's own Aaron Eppley, representing the House impeachment managers, is wearing a Pepto-Bismol pink blazer today. And I agree with you, Victoria. That matters. She's wrong for that. She should be impeached for this blazer. Carrie Lake says, I pay attention to the colors they wear as well. I occasionally do. Hardin, I gotta give Hardin a hat tip for his fashion. Remember that cornflower blue tie? It's not every man that can pull that off. Victoria, she's very much gumming up the process. This is the only thing they can do. And look, they've even utilized Bill Nye, the fake science guy, and he's on their team as well. So let's go over and read the Rumble chat. You guys are funny over at Pilled in Foxhole. So, okay, let me scroll up. Thank you guys for being here. Okay, Trump Rocker said, thanks, Seven. I was watching yesterday on RSBN. I saw Rusty make the big mistake. Yeah, that was very funny. We were all so shocked and didn't really know what to think or to say. We're like, did he really? No, surely he did not. But he did. But he did. The bumbling house. Yes. Raging smirk. Welcome. Thank you for being here. The bumbling house. Yep. Oh, he's about to come back. Dan Patrick, you see he's got that gavel. Look, he's about had it. Karen Epley's going to get the gavel if she doesn't fall in line. Melindy says, what I saw is that both motions were withdrawn. Yes, Melindy, exactly. Rescinded, withdrawn. I guess withdrawn's the more proper term. Plus the additional fact that Olson was unavailable for testimony, adding to the mashup. Olson doesn't need to testify. I'm not interested at all in hearing from Laura Olson, guys. Laura Olson is the woman that Ken Paxton admitted to having an extramarital affair with. He came clean. He asked for his entire staff's forgiveness. He asked for his wife's forgiveness. His wife chose to forgive him and preserve their marriage. They are in love. Mistakes happen. This is not an impeachable offense, and it's not something that Ken Paxton hasn't already owned up to. This is merely an attempt to slander and humiliate Ken Paxton and his wife, who is a sitting senator, Texas Senator Angela Paxton. There's a bit of an uproar because she is recused from voting on these articles in the Senate, despite her representing a significant amount of Texans from her area, from her Senate district. She's not allowed to actually vote yes or no in this impeachment process, which has some people quite upset. But she is in this room watching this happen, and this is an attempt for the deep state to humiliate and utterly destroy the Paxtons and anyone who would do what Ken Paxton has dared to do. So yes, they were both withdrawn. I'm not interested in hearing from Laura Olson because she has no information that is relevant to an impeachable offense. Whatever happened between Paxton, Olson, with his wife, that is between Paxton, his wife, Senator Paxton, and God. That is not political fodder to be used against people and to be tossed around and to be chewed on. So, yeah, if Laura Olson's not available to testify, I don't blame her. I don't think she should be forced to testify. She has no relevant info. Brymark says, so when this is over, will any of the witnesses be investigated and or prosecuted for pulling the stunt? Well, several of them have lied and have committed perjury, especially the ones. Let's go and do this. I would like to show you this particular article right here. It's the very next one we are going to get to is actually Article 6, where it says specifically Paxton terminated employees of his office who made good faith reports of his unlawful actions to law enforcement. Paxton and the law enforcement authorities. Paxton terminated the employees without good cause or due process and in retaliation for reporting his illegal acts and improper conduct. No illegal acts or improper conduct has been established. And he did not fire, but he only fired like one person. And nobody blames him for firing that person, okay? This was a mutiny. I would have fired them too. But most of the people resigned. Most of the people complaining that they were fired, they actually resigned and had another job with a lobbying firm lined up. And I'm saying most of them resigned and had another job lined up because most of them went to the same lobbying firm. It was very obviously a mutiny. Says furthermore, Paxton engaged in a public and private campaign to impugn the employees' professional reputations or prejudice their future employment. This absolutely did not happen. No evidence of this has been presented. And none of them have missed a single paycheck. Even throughout COVID, none of these mutineers missed a single paycheck. So this article is totally debunked. Only one of them was terminated. The rest of them resigned. And so to your question as to whether or not any of these witnesses can be investigated, well, I think, Brymark, I think that if they committed perjury on the stand like we witnessed the last few days where people were saying, I was terminated, and then it turns out they actually resigned, and they say, well, I was effectively terminated. That's why I resigned, because I was constructively terminated, because they were taken off tasks that they wanted to be a part of, but they were not fired. They were not told they were going to be fired, and they were not impugned. In fact, they filed their own resignation, but then went on the stand and were saying that they were terminated, repeatedly saying that until they got called out and confronted with their resignation letter. Yeah, I think that perjury is on the table. I think that that option is on the table. So as you see, they're still sort of just milling around. Let's see if they get back to it any moment. Well, it appears that they're still just sort of...
Members, take your seats.
Oh, I spoke too soon.
So we're going to proceed slowly, carefully. You may proceed.
Thank you. Mr. Gordon, as a preliminary matter, if a document is released after a ruling request or a ruling decision, would that be released to a subsequent requester for that same information?
Objection calls for speculation.
Overruled.
Yes, there's a specific section that directly addresses that. Section 552.007 of the government code prohibits the governmental bodies from selectively releasing information and provides that if information has been released to one requester, then it would be released to a subsequent requester unless there's a special right of access that applied to the initial requester.
Absolutely. Which is exactly
Okay.
why we
Sorry.
said
All right.
that the argument that producing
Mr.
CBRs
Gordon,
took too
Mr.
long
Gordon,
was a
repeat
silly
your
argument.
answer. Slow down.
Yes, sir. Yes. There is a specific section of the Public Information Act that addresses that. It is section 552.007. It provides that if information is released to one requester, then it would be released to a subsequent requester. It prohibits the selective release of information to one requester and not to another. So if information has been
Absolutely.
released by a governmental body, then it would be released to subsequent requesters unless there's a special right of access that only applied to the initial requester. For example, if I ask for my driver's license number and receive it, you wouldn't release my driver's license number to the next person because I have a right of access to that.
Thank you for that explanation.
Very interesting. So I
Eric,
have a right of
could
access
you
to
please
my
pull
ballot.
up within House
yes.
Managers
Let's all
46
request our ballots. We
at
can only
page
do that if we're aware of our ballot
8803,
number.
which is
So
page
make a note of your ballot
77
number,
within that
the
PDF.
entire number.
Mr. Gordon, can you see that on your screen?
Yes, I can.
Does this appear to be a fair and accurate picture of the redacted brief the FBI provided to Mr. Larson?
That's correct.
And Eric, if you could scroll to the next page, so to 78, go down. Is this showing an entirely redacted page?
Yes.
And does that continue through the majority of this brief?
Yes.
Is this unusual?
Yes.
Can you explain why?
Under the government code, if a third party submits comments to our office objecting to the release of information, they're required to notify the requester and provide the requester with a copy of those comments. They are permitted to redact the comments, but only to the extent that it reveals the information that is requested. In this case, they've redacted the entirety of the brief, including all of the substantive arguments.
And why does that matter?
That matters because the requester was not put on notice about what arguments the governmental body was making and would have been unable to respond to them to our office in order to refute any statements that were made or directly address the statements that were provided by the briefing third party.
Paxton's team
is
is
this
going to
another
destroy these
procedural
articles.
violation of the PIA?
Yes.
Guys,
so
the
far
PIA
we've
is
talked
binding.
about at least 3 procedural violations or irregularities with this file.
Objection
Yes.
leading.
Restate your question. Sustain.
Can you estimate for us how many procedural irregularities we have discussed related to this
The
file
Public
so far?
Information Act, guys, is binding by 6 months
There
in
was
jail and a
the
$10,000
failure
fine
to
if found
submit
to be in
the
violation of the law.
representative sample, or they submitted the documents late. The representative sample that they submitted the second time was not indicated that the first representative sample was not actually representative. They did not notify the third party in a timely fashion. And then when the third party briefed us, they substantially redacted their briefing to us. Or I'm sorry, they substantially redacted the copy of the briefing that was provided to the requester.
Are you able to tell us how frequently you work on a file that has 4 different procedural irregularities?
We see a lot of procedural irregularities. These are pretty unique, though, in the way that they came in. Ordinarily, what we see are missed deadlines. So it would be pretty rare that we see 4 completely different procedural violations like this.
And again, what can be the consequence of a procedural irregularity of the nature you've been discussing?
If a governmental body fails to comply with the procedural requirements of the Act, then they would waive their discretionary exceptions.
Meaning that any documents that fell within a discretionary exception would be released?
Objection leading.
That's not
rephrase your
leading.
question.
She just had a question.
So what's the consequence of that, of the permissive exceptions being waived?
If a permissive exception is waived, then we would not apply it or review it in the context of those documents. And if that's the only exception that's addressed, then those documents would be released.
And in this particular file, the DPS file in front of you, was the only exception raised the law enforcement exception?
That's correct.
And it is a permissive exception?
That's correct. They did not raise any confidentiality provisions. They only raised the law enforcement exception.
Do you recall meeting with the Attorney General about this file?
Yes.
And I don't want you to go into what anyone said at that meeting, okay? But could you please tell us what topics were discussed?
We discussed this topic, this DPS file.
Did you discuss options for how to proceed?
Yes.
And what were those options?
The primary options were to release the information, to conclude that there had been a procedural violation and a failure to establish that the information was accepted from disclosure. And then the second exception, which was the primary option, was the closed letter that we ended up issuing.
Did you agree with issuing the closed letter?
Yes.
Why?
It was correct. The procedural background of the request put the requester at a significant disadvantage, and allowing the procedural actions that were taken would have really been a detriment to that requester. There was already a pending lawsuit, and courts will give our letter rulings great weight, and rubber stamping the actions in this procedural context would have, or could have, I don't know what the court would have done with our ruling, but it could have tilted the scale in favor of a governmental body who had failed to comply with the procedural requirements.
And I want to make sure I understood your testimony a moment
This
ago.
means that Paxton's
you
office
considered
was fighting
releasing all
for
the
us,
information. What do you
good
call
guys,
that?
not the mutineers,
Within ORD.
not the
Pouring
whistleblowers.
out.
And would that have been supportable under the law, in your opinion?
It would have been pushing it. I agree with the closed letter. I feel like releasing it all would have been pushing it.
To your knowledge, had ORD issued closed letters of this nature in the past?
Yes.
Eric, I'm going to ask you to pull up the closed letter, which is within House Managers 46 at page 2, and please take it off the screen before finding the new page and placing it there.
Counsel, what was the Bates number that you directed him to, please?
It's page 2 of the PDF, which is in front of you.
That OAG 8728?
I don't have it in front of me, but it's the closed letter. Mr. Gordon, does this appear to be a complete and accurate copy of the closed letter?
Yes, it does.
And in that letter, you reference a prior ORD decision, right?
That's correct.
Why? Why did you reference that prior ORD decision?
Well, there were a lot of reasons. The primary reason is that what this open records decision specifies is that if a lawsuit is filed after a ruling request is made, I'm sorry, let me take it back and maybe simplify it. Under the Public Information Act, a requester can sue a governmental body if they believe they're improperly withholding documents. What this open records decision provides is that if a requester files a lawsuit after a governmental body has issued or has requested a decision from our office, then our office should still go on and issue a ruling. Prior to this decision, we routinely closed files and did not issue determinations where the issue that come before us in the decision was in court. So we would demur and close that letter and let the court decide.
And in your opinion, how did this DPS file differ from the closed letter that you issued in this case? How did that differ or was distinguished from that ORD decision?
It was all of the procedural irregularities, especially the redacted FBI brief. That was the primary issue that prevented us from ruling in accordance with due process. It was the heavily redacted FBI brief.
And why did that cause you so much heartburn?
Again, our rulings are given weight or great weight, quote unquote, by the courts. And in the face of those procedural irregularities, giving a rubber stamp of approval to them could have tilted the scales in that court, even despite the procedures being handled incorrectly.
Could it also set bad precedent?
Objection leading.
I'm asking his opinion, Your Honor. It's a yes or no. He can say what he'd like.
Overruled.
I'm sorry, I didn't understand. I didn't hear the question.
Sure. Could it also set bad precedent in PIA requests coming into your office?
Objection, Your Honor. The relevance of this personal witness's opinion is not relevant to any issue in this proceeding. And what he considers a good or bad precedent is purely subjective.
I think that we all agree that it is relevant.
Overruled.
Thank you, Dan Patrick.
I wouldn't characterize it as a precedent. So many of our rulings are fact specific. What I do think it could have resulted in, because DPS and FBI routinely brief our office, it could have again been seen as condoning that type of heavy redaction, which then could have led to that type of action being taken in future requests and for future requesters. Wouldn't have characterized it as a precedent, but it could have indicated that we thought that was okay, and then they would, because they do it routinely. I mean, they request decisions from us routinely. They could have seen that as oh well, now we've got the stamp of approval to do this, and now we'll keep doing it.
And now, while all of this is going on, were you made aware of a request from Mr. Larson for a copy of the FBI brief?
Yes.
How were you made aware of that?
That came in as a Public Information Act request. The Public Information Act request was forwarded to my division for handling. And when I say handling, I mean we collected the documents. So we collected the unredacted brief in processing that Public Information Act request, and we provided it to our Public Information Office.
As to the DPS ruling itself, did that closed letter result in the release of any documents?
It did not.
Okay, so this request from Mr. Larson comes in for a copy of the brief. Do you know what happened after that was received?
I know what happened after the fact. Because it involved open records decision documents, our division does not rule on decision requests for our own documents, so it was handled by another division. But through the process of this whole circumstance, I did become aware of what issued or what happened with that public information request.
And your division maintains those files even if it doesn't necessarily make the decision on the request, correct?
That's correct. Because the FBI submitted the brief to our office, we were the ones who maintained that as part of our work file.
Have you reviewed the ORD file for the FBI brief request before?
So just to clarify, our office or my division does not have a file on that public information request. We have the file that's here before me as this PDF, and yes, I have reviewed that, but I have not seen the opinions file or the public information office file involving that ruling request for that brief.
Now, in the file in front of you, there is a copy of the unredacted FBI brief, correct?
That's correct.
Would you take a look at it, please?
Okay, I'm looking at page.
And what I want you to look for, you're the chief of ORD. I want you to set aside law enforcement exception for a moment. I want you to look at that brief and let me know if you think there are any mandatory exceptions to public disclosure that are flagged within that brief.
I want to say thanks to everybody on the Pilled and Foxhole chats for being here. Hello, Uncensored Abe. Hello, Stax. Thank you for the shades. Thank you, Stax, for the cookie. Welcome, Uncensored Abe. Diddy and I need to come on to your show and give a short rundown. Yep, give them an inch, they'll take a mile. I agree, Carrie Lake. Over on the Rumble chat, hello, Pappy Frost. Welcome. The Johnny Sutton issue, Pappy Frost, I agree with you. He said the Johnny Sutton issue is a big deal as there's no way he's doing this for free. Yes, guys, all of the whistleblowers, or as I refer to them, mutineers, are represented by the same attorney, Johnny Sutton, who has apparently agreed to work for them all for free and represent them for free and do a significant amount of work for them for free. I agree with you, Pappy Frost and PC Amani. That's a very big deal. We've got another comment saying the Bush family is paying Johnny Sutton, in my opinion. That could very well be. Texas is, and Batty Mom of 3, absolutely right. Texas is an at-will state and can fire with or without cause.
Not to nitpick, but there is Mr. Larson's email address is at the end of the brief, but he was the requester. So no, but other than that, I don't see any confidential information on the face of the document.
Thank you. And just one more thing on, forgive me. Your Honor, if I may approach with what's been marked as AG 34.
You may.
I also find it extremely rich that Karen Epley, the DOJ and CIA's own, would object to questions about his opinion on a legal process when she was asking people about their opinion on granite countertops in Ken Paxton's home.
Mr. Gordon, Do you recognize the document I placed in front of you?
I do.
And what is it?
This would appear to be the internal file for the opinions ruling request that we've been discussing. That was Mr. Larson's request for the unredacted FBI brief.
Thank you for the donation. Thank you for the can. Sly
Does
Park.
OAG receive
Welcome, Sly
requests
Park.
for copies of PIA briefing on other occasions?
Yes.
Does that occur with, can you tell us with any sort of frequency how often you receive that type of request for briefing?
If I had to guess, I'd say it would be once a month, probably less than once a month. It's not very common. It's not a weekly occurrence.
And were you familiar with Joe Larson?
Yes.
How?
I've worked with Joe Larson for a long time. He is a well-known open government lawyer. He's also involved with the Freedom of Information Foundation, which our office has partnered with in the past to perform trainings. He's routinely sought after to provide input on Public Information Act requests. I've also observed a number of cases that he's handled because he ends up often handling important Public Information Act cases. So I've known Mr. Larson for a long time.
Was, based on your knowledge of Mr. Larson and working with him, was it surprising or unusual for him to submit a request for a copy of that redacted brief?
No, I wasn't surprised at all that Mr. Larson would ask for that.
And you started to walk us through what OAG does when it receives a request for documents that OAG itself holds. I just want to make sure that's clear for the jurors, okay? So let's walk through it. So what's the first step OAG would do when it receives a request for records that it itself holds?
That would be received and handled by the Attorney General's Public Information Office.
Objection, Your Honor. I apologize to the witness, but at this point, it's clear from the witness's own testimony that once this request that's about to be discussed was made, it went to a different division, not his, that he does not oversee, and he's previously testified that he was not involved. So any information that he has about specifically how it was handled or by whom would be hearsay or speculation.
Your Honor, right now I'm asking him to walk through the general process of how this is handled, which is something that as the chief of ORD, he is intimately familiar with.
The witness can answer. Overruled.
When a request comes into our Public Information Office, the Public Information Officer will identify the divisions that they believe maintain documents, and they will notify those divisions. Those divisions then collect the information. Generally, we collect the information unless there's some issue with the request, like we don't understand it or it would require a cost estimate. Those divisions, my division in that case, will respond back that we maintain documents, and then we'll follow that up by providing those documents. If a decision is required, then the Public Information Officer will prepare that decision, and they will send it to our division. As soon as we see that we've received a request from the Attorney General's office, it gets segregated out, and at this time, it would have been forwarded to the Opinions Division.
So ORD is not deciding decisions on documents held by ORD, is that right?
That's correct.
Leading.
Sustained. You can re-ask the question.
I think the point's been made, Your Honor. I'm gonna move to admit AG 34. It is an internal business record of OAG. It was actually given to us pursuant to a business affidavit that has been on record for more than 14 days.
And Your
Any
Honor,
objection?
as we discussed at the bench, the issue is not the business records affidavit. It is protecting the sensitive information of law enforcement, how they conduct their investigations, and specifically the individuals involved. An exact identical copy of the same brief we just talked to you about at the bench is also contained in this document. And so I have no objections as long as she's willing to protect law enforcement and the integrity of their investigations and redact that sensitive information. With those redactions, no objection.
And Your Honor, the chief of ORD has now looked at this brief and told you that there were no mandatory exceptions and no confidential information within that brief. He's also testified that once a brief is given to once documents are given to one requester, they are given to any subsequent requester. They are considered public. And so I do
Aaron
believe that
Eppley
he is
does not
one
want this
more than
information released.
very highly qualified to speak to this file, and that there are no confidentiality concerns raised within it based on this witness's testimony.
Brief response, Your Honor.
Yes.
This is hitting a nerve.
Everything my
Aaron
colleague said
Karen
misses the
Eppley.
point. All I'm trying to do is make sure that the sensitive law enforcement information, which is in front of you, the identities of the individuals involved in the investigation, how they conducted the investigation,
This is the
their sensitive
CIA and
operations
DOJ's
plans,
own Aaron
their
Eppley
sealed search warrant
pretending to
affidavits,
care
and the
about the
details contained
integrity
within,
of
how they
investigations
communicate with
and
each other,
protecting law
who was
enforcement.
on those communications, and when they were sent. All of that information, I just would ask, would be redacted.
And Your
Otherwise,
Honor,
we have
very
no
quickly-
issue.
Absolutely not.
Don't talk over each
Absolutely
other.
not.
Court reporters have a tough job as it is. Come up for a moment again.
Okay, now Dan Patrick has done this. I think that we need to have this debate because here is something that we've already established with the witness that there's no exceptions to this. This has been released and we have to release it to anyone else who requests it. And Paxton's team is saying there's no sensitive information in here. And Aaron Eppley is foaming at the mouth nearly. So they're going to discuss this. There's very obviously something here. He's making sure we don't get any more hot, candid mic. Dang, I wish they would leave that mic on. I love to watch the body language. Dan Patrick, I do believe Dan Patrick is being very fair so far. Dan Patrick's explaining to Aaron, the DOJ's own Aaron Eppley, the CIA and DOJ's own Aaron Eppley, that, hey, the law is the law, and we're not going to redact all of that. It's going to take a lot of time to redact all of that as well. Let's go over to the Rumble chat and see what y'all are talking about. Okay. Spotzel, welcome. Spotzel says, Angela Paxton can't vote, but it essentially counts as a nay because the Senate left the requirement at 21 yeas needed. Same number as if she were voting. Well, I don't know how to process your comments, Spotzel. Angela Paxton can't vote, but it essentially counts as a nay because the Senate left the requirement at 21 yeas needed, same number as if she were voting. That is not okay. Are you sure, Spotzel? Spotzel, if you can, it's not that I doubt you, Spotzel. You just know how we are. We like to have the sauce and we like to have the citation. If this is true, oh wait, a nay to yeah. You know what? That could benefit us, but in the future, we need to make sure that if 21 so we've got Dan Patrick who could break a tie, right? But that's a really interesting comment, and I'm making a note of that for future impeachment hearings because I'm sure we're not done with this. Trump Rocker says, I don't think Olson matters in this case. They're just trying to make Paxton look bad. Yep, absolutely, I agree. PC Amani says, it's going to be interesting. They should investigate Johnny Sutton, who's actually paying him. I agree. How is Johnny Sutton working for all these mutineers for free? Exactly. Which of the 4 witnesses received the $3.3 million settlement? Vassar, I know. Oh, well, I mean, probably the witnesses who are also representing the Mitty Foundation. They profited greatly off of what they've been doing to Nate Paul, which is what Paxton was looking into, what the abuses that they've been committing on Nate Paul. And we all want to know about that, right? Because if they can do it to Trump, if they can do it to Nate Paul, if they can do it to Ken Paxton, we're going to be easy pickings for them, Linnea says, yeah, I don't think Patrick likes all that hand waving and pointing at him, right? Aaron Eppley is very disrespectful with her body language and the way that she speaks. And people notice that. Linnea says, now I see why we agreed to continue. Yes. Isn't this great fun? Actually, it's very important that we expose the truth for what it is. It's very important that we do that. Rob Maga says no one works for free. Yep, exactly. Karen, that's going by. Karen Epley. Yes, the CIA and DOJ's own Karen Epley. Okay. Big bad black conservative says at least she got her hair done yesterday. Yeah, she must have been hearing some of the comments from multiple live streams. I can't be the only one who noticed that her hair was stringier than mine on a wash day. Okay, it was. Please, woman, you are on the Senate floor. Do not wear your Spirit Halloween Gothic cheerleader outfits, and for God's sake, brush your hair. The CIA and DOJ's own Aaron Epley, representing the House impeachment managers, does seem to have acquired a hairbrush. Level up. She's leveled up. Spotzel, yes. Okay, I understand. Spotzel. Okay, so Spotzel says that this was in the rules. It was an agreement reached pre-trial. Okay, if the Democrats missed that and agreed to that, okay. What an oversight, though, on their part. Well, anyways, I think it's very interesting, Spotzel, the observation you made. I just hadn't, and it's interesting to me because I totally missed that. I missed that. So that's a great catch. Small thing, really, but could have big implications. Melindy says, so everybody has to slow down except Energizer Bunny, Motormouth. Oh, yeah, well, Melindy, I mean, I think Patrick understands that there's kind of no reasoning with the CIA's and DOJ's own Aaron Epley. So, Big Bad Black Conservative says she was monitoring our chat. Yeah, I suppose the attorneys are not prohibited from watching any live streams or any coverage of this. In fact, I think Aaron Epley goes and watches to see how well she's been edited. And in fact, I'm positive that she saw some short video clips of herself, smiling, being very smug yesterday, the way that she does, in the hopes that those are the clips that will be edited and used. She just hadn't realized how stringy she was coming across. C. Paxton's attorneys are frustrated. I wonder if that means that one of the Grim Reapers hovering behind Dan Patrick has determined that the redactions should be made. Paxton's attorney said they don't need to be made. Excellent. Raging Smirk says Ken Paxton will be interviewed by Tucker Carlson in the next 2 weeks. Excellent. High quality television. Finally, we have something good to tune into. Trump Rocker says, how long was that leading? It was more confirmation. How was that leading? It was more confirmation. Exactly. One of the last one wasn't leading. This is just Aaron Epley, the DOJ's own, the CIA's own Aaron Epley, representing the House impeachment managers. She really does not want, she wants most of this redacted. She wants the conversations redacted. She wants way more than just any personal information about whoever is involved. She doesn't want this entered in, and this is what she's doing in order to do it. Big Bad Black Conservative, she was either monitoring our chat where we were kind of chuckling about it. Like, surely George Soros pays her enough to get a Brazilian blowout before the Senate impeachment hearings. Maybe she was just so, she has a hard job. Telling the truth, it's easier because you don't have to keep up with so many lies, right? But when you have a job like Aaron Epley, when you work with the CIA and the DOJ to facilitate the takedown of constitutional representatives elected by their people, by their own constituents, Aaron Epley, it's difficult to keep up with the sheer volume of lies. So Big Bad Black Conservative, I think it just slipped her mind to do her hair yesterday and the day before. I think it totally slipped her mind. Oh, we're back.
Members, we will take a break in a little bit, just a little bit.
Are you sure you don't want to just go ahead and count that last one as a break?
Everybody be seated, please.
And I'd like to ask for
So as we have
15
been going
minutes
through
back
this
from
testimony,
Paxton's team.
slowly continue.
Mr. Gordon, the file placed in front of you marked as AG 34. Is there any search warrant inside this file?
Wait a moment. Has it been redacted or not? The way she's asking the questions, she was told to rephrase, and I believe. Let's see. She's asked him to locate in this file that Aaron Epley did not want entered in whether or not there is a search warrant contained in the file.
There is no search warrant inside this file.
Are there any emails between the FBI and DPS inside this file?
There are no emails between the FBI and DPS in this file.
Did you notice any victim information inside this file?
I did not.
And if the redacted FBI brief had been released to one requester, it would be released to other requesters?
That's correct.
And you've had a chance to look at this file now, correct?
Yes.
And at the back of it, you'll see that, well, let's walk through it. So I think you've testified that based on this file before you, does it appear that OAG sent a notice to the FBI about this request for their redacted version of a brief?
Yes, it does.
Did the FBI respond?
Yes, they did.
And I want you to take a close look at their response brief, and specifically the last page under the signature line. It's the last page of the file. Are you there?
Yes, that's page 6 of the draft.
Witness needs
We've
to stay
got
close to the mic
some
and speak up.
commenters saying that
Does
that's
it
actually
indicate
someone
that
named Leah
the version
and not
sent to
Aaron,
Mr. Larson
and that
was redacted?
explains the
Objection, Your
significant
Honor.
improvement in the hair.
Counsel is mischaracterizing the evidence and honestly misleading the witness. The document that she
Overruled.
is.
You may answer the question.
They look
On this
similar enough
brief,
to me.
it does not say redacted after
Thank you, Truitt, for
the
this. Let's
CC
see.
list to Mr. Larson.
And this brief was filed by Mr.
give me 1
McPhillips
second.
from the FBI, is that right?
Pulling this up
That's
right
correct.
now, Truitt, to confirm.
And from the front of this brief, was it filed, and it's actually marked as received by Open Records on or about June 18th, 2020? Do you see that?
Yes.
And then I want you to look immediately in front of this brief is a copy of the redacted brief at issue. Do you see that?
I'm sorry, would you repeat the question?
Yeah, if you keep flipping forward in the file, the next thing you see is a copy of the blacked out brief that the FBI
Okay,
had filed
guys,
first.
I'm going to show you this. That is
Oh,
apparently
I
not
believe
Aaron
that's,
Epley, but someone named Leah Graham. So I'm going to show you. This is Leah Graham, who works for Rusty Hardin, the House impeachment manager. She is the one that's been gumming up the process today. I did think that was Aaron Epley because this is what Aaron Epley looks like. They look like just alike, and they're both absolute CNX Tuesdays, okay? But apparently the woman in the Pepto-Bismol pink is Leah Graham and works for Rusty Hardin, okay? So just a clarification about that, okay?
No redacted version here.
However, this
and when you
is
look under the
Paxton's
signature,
attorney right
first,
here. This is
who
Paxton's
signed this brief from May 2020 for the FBI?
Matthew Phillips.
So the same
And I'd
Mr.
like to know
McPhillips.
Yes.
if we can see Aaron
And
Epley and Leah
underneath his
Graham in the
signature
same
line,
order.
what does it
I'm not
indicate
convinced
next to
that they're
Mr.
different
Larson's
people.
signature? I mean, next to Mr. Larson's name on the copy list.
Next to Mr. Larson's name on the copy list, it says it was redacted.
So the first brief was sent to Mr. Larson, redacted.
We
Is
got to
that
give
what
it to
that represents
Leah
to
Graham
you?
for the hair. She has better
Yes.
hair.
And so the second brief, the June 2021, based on the documents before you, was that
Correction.
redacted when it was sent to Mr. Larson?
It does not indicate that it was redacted.
Does that indicate
you
to
so
you
much,
that the
Pruitt. Thank
FBI
you so much.
provided a
Everybody
copy
over
of
on
this
field for
brief
that.
directly
Carrie
to
Lake.
Mr. Larson?
Thank
Objection,
you.
leading.
Victoria, thank you. Grain of salt.
Sustain, rephrase your question.
What does that indicate to you?
That indicates that they provided the same copy of this brief that they provided to DPS, not unredacted.
And I want you to take a look at this June 2020 brief and tell me how it compares to the May 2020 brief.
Yeah, if we can get Leah Graham and Aaron Epley in the same room to confirm they're different people, that would be great. But thank you so much to everybody on Pilled that caught that. One of you guys said, yeah, thank you, Truett. One of you guys said, there's no way that's Aaron Epley. That hair is way too nice. That surely is a different woman, because those are different genes that produce better hair. And we say, wait, what? So we go and look. Yeah. So that's one thing. If they're the same person, she got a better wig. Because Aaron Epley's hair, maybe it's like just her hair just can't be styled, you know? Some people have hair that's just unruly, you know? Whether it's long and straight, but like won't do anything at all. That's my hair. Well, now my hair curls when it gets humid outside, but when I try to curl it, it looks a total mess. It's totally unruly.
They look very similar. There is some different language certainly at the beginning, but they look very similar.
Other than the first paragraph, they are very similar.
Yes, that's correct.
So based on the documents in this file, does it appear that Mr. Larson that the FBI provided this information itself to Mr. Larson?
Yes.
And the very front of this file is the decision issued in this case. It starts with Bates 49954.
She just debunked another article.
I do.
Excellent.
And you just looked at the FBI's June 2020 brief addressing whether or not
very well done. She just
that
debunked
blacked out
another
brief should be released to the public, right? You just looked at it?
I did.
Did it anywhere in there argue that their redacted brief should be withheld from public disclosure?
No, it looked like the arguments applied to the documents that were issued in the underlying DPS file.
And so when that happens, when the comments don't address the information being sought, what, in your experience in ORD, happens in a file like that?
In that case, we would not apply the exception to the documents that are submitted. We ordinarily, because this opinion was done by opinions, they use slightly different language than us, but we've got boilerplate for that type of circumstance. Either that the entity that submitted the arguments is arguing against the release of information that was not submitted to our office, or that the arguments that they've submitted don't apply to the information that is at issue. Because we have a presumption of openness, there has to be an exception to disclosure in order to withhold the information. And if it's a discretionary exception, it wouldn't be applied to information that they don't seek to withhold. If it's a discretionary exception, they have to seek to withhold it in order for the exception to be applied to it.
And the FBI, so the FBI just didn't address their redacted brief at all, based on this file, is that right?
That's right.
Which would result in what, ultimately, for the requester?
That would result in the information, that would result in the arguments that are raised not being addressed to the information for which there are no arguments. And if there are no other arguments, then the information would be released.
Okay, so I want to make sure we all understand what your testimony has been here today. So we had the first request to TSSB in the fall of 2019. Was any information disclosed to Nate Paul as a result of OAG's ruling?
No.
Then we move on to the big request to DPS in the spring of 2020. Was any information released to Nate Paul as a result of that ruling?
No.
And then we get to this third request. And what we see is that the FBI provided a copy of the brief directly to the requester itself. Is that right?
Objection leading.
Overruled. Repeat the question and answer.
We get to this FBI request for their blacked out brief. And what we see is that the FBI directly gives a copy of the brief to the requester,
Objection.
to Nate Paul. Is that correct?
Objection, Your Honor. It should be made clear for the record that we are talking about two different briefs, one in May and one in June. And the one in June, yes, there's no dispute. The FBI provided that to Nate Paul's counsel. That is not the one that contains the sensitive information that we have been discussing.
Clarify.
Of course.
I sustain the objection. Clarify.
What we're seeing from this file is that the FBI provided a copy of its June 2020 brief directly to Mr. Larson. Is that right?
Yes, that's correct.
And you've also testified that that June 2020 brief is very similar to the May 2020 redacted brief, right?
Yes, that is correct.
And that ultimately, because the FBI did not address why their redacted brief should not be released to the public, it was released.
Objection, leading.
Sustain, rephrase your question.
What was the ultimate outcome of the opinion on this FBI request related to its redacted brief?
The opinion concluded that the unredacted brief could be released to the requester.
And you reviewed that brief?
Yes.
And you did not see any mandatory exceptions within that brief that would require OAG to apply its own redactions before release?
That's
Objection,
correct.
leading.
Overruled.
That's correct.
And after this ruling in August of 2020 on the FBI brief, do you recall one way or another if Joe Larson, on behalf of Nate Paul, continued to seek information from public safety agencies through public information requests?
Yes, he did.
And how do you know that?
He continued to pursue complaints against the Texas State Securities Board all the way through September of that year, seeking to obtain documents that TSSB was withholding from him in the context of Public Information Act requests. And then that continued, throughout the summer and into the fall.
And after ORD rules on a request, what does ORD do with the documents that the governmental agency provided to you to make your ruling?
We send the documents back to the governmental body.
You don't keep a copy?
No.
Those are all my questions for this time. Thank you.
Thank you, Ms. Collins.
She did very well. She demolished Articles 3 and 4. That was very good. She sounded sweet, and sorry, let me talk quieter.
So sorry, one thing, we are moving for admission of HM 46 and AG 34 based on this witness's testimony.
Your Honor, same objection. All we're trying to do is protect the sensitive law enforcement operations, who was involved, when emails were sent, what the subject of those emails were, what the
They
FBI's
established there were no
operations plans were,
emails.
how they work with the State Securities Board, the FBI, the DPS. If that information be redacted, no objection.
Hold on. We've discussed this at length. He testified there was nothing confidential. The FBI could be here. They could be called.
Yes.
I love how he
Your Honor,
gestures
or
to her.
Mr. President, yes, that's correct.
Either one, doesn't matter.
Okay. Yes, sir.
But they're not here.
They're not. However, I would like to, for the record, remind the court that it was Mr. Bangert's testimony opposite to Mr. Gordon's.
Your Honor, I'm going to insist that she not say testimony of another witness in front of this witness.
Okay.
Wow.
Both of you,
Okay, I'm sorry,
just
Leah.
stop for a moment. Okay.
Leah's the Karen. Again, this is she's apparently not Aaron Epley. This is here, let me show you. This is Aaron Epley right here. Okay, this is the DOJ and CIA's own Aaron Epley, but her hair does not actually look like that in real life. This is Leah Graham. Apparently, they look just alike. But this woman works for the House impeachment manager Hardin. Okay, but she has a very similar, just say, bouquet as Aaron, the DOJ's own Aaron Epley. But that is Leah. What? Graham. I don't know why I cannot keep her name in my head. Leah Graham, who continues to object to this, even though the witness established that there is none of the information that she's objecting to, as and insinuating is in the document. This witness already testified. None of that stuff's in this document. Dan Patrick was absolutely right. Dan Patrick's really looking pretty good here because he was like, look, how are you going to object on behalf of the FBI? First of all, it was the DOJ who sent you, right? No, I'm just kidding. But how's she going to object on behalf of the FBI when they could have been here to testify on the evidence that they released this evidence. The FBI did. And so the OAG is going off of the Public Information Act, which is binding. You cannot just violate the Public Information Act because, I mean, it is binding. If somebody sues, so say I want my records. And
Your Honor, if I could, I just want to make sure that there's no misunderstanding or misstatement here.
Jurors, please take your seats again.
I just want to make sure that there's no misunderstanding here, that you have a complete copy of those files in front of you, and you can see for yourself that there are no copies of search warrants, there are no copies of the actual emails within those files, which appear to be the documents that counsel is concerned about. And I just want to make sure that's clear for the record, that those documents are not in those files.
And the witness testified to that.
We have reviewed them while up here going through this testimony. Is it your representation as an officer of the court that this document has already been released to the public?
Yes.
Both documents?
Yes.
And that was the testimony?
It was.
I have to overrule your objection.
Dan Patrick, excellent.
Get into evidence.
They just demolished Articles 3 and 4. Absolutely.
AG 34.
She did a good job. It was.
And OAG Exhibit 46.
That should be HM 46 and AG 34, Your Honor.
HM 46, yes.
Thank you, Your Honor. Those are my questions for now.
Yes.
She was very good. She totally destroyed, and I can show you this right here. Why not? Because I have it right here. This is Article 3, abuse of the open records process. Yes, she just introduced herself as Leah.
Being fact specific.
Excellent.
You recall the testimony?
Thank you.
Yes. So let's talk facts. The requester in this case was Nate Paul's lawyer, correct?
Objection, speculation.
I believe that same testimony was elicited on direct. That
overruled. Go ahead.
Correct.
We did not know that at the time. It's become apparent that that is the case now, but we did not know that at the time.
In your original opinion, as it relates to the request for the full release of the DPS file, was that it should not be released and that the law enforcement exception applied. True?
That's the big DPS file that we're referring to?
Yes, sir.
The original draft on that, I believe, did just address it under the law enforcement exception.
And that was your opinion that it should not be disclosed under the law enforcement exception, correct?
No, that was not my opinion.
That
was just the first draft that was on the ruling.
Who drafted the first draft?
I'm not sure if that was the drafter on the ruling or if that was me. I don't remember.
You had direct conversations with Ken Paxton about this specific request for a full copy of the DPS file, true?
Yes.
He made it clear to you that he wanted to find a way to release the documents that Nate Paul's attorney was requesting, true?
Objection, Your Honor. That's improper testimony through this counsel, assuming facts that have not been addressed with this witness.
Your Honor, this testimony has already been elicited.
Overruled.
True?
No.
Mr. Paxton did not summon you to his office to talk about this file?
Yes, he did.
He did not put pressure on you to either not rule against the requester or to release the information?
No, I would not classify it as pressure. The decision that we made was not.
Sir, I appreciate that. I'm not asking you what the decision was made. I was asking about your conversation with Mr. Paxton. He had one of two things that he wanted to occur. Either release the information or at a minimum, figure out a way not to rule against the requester. True?
Same objection, Your Honor, assuming facts not before this witness.
I'm trying not to laugh because this is very funny.
In your conversation with Ken Paxton about this particular DPS file, can you recall any other time when Mr. Paxton directly came to you and got involved on a DPS open records request?
No.
Ultimately, you did exactly what Mr. Paxton wanted, correct? You did not rule against the requester, Nate Paul's attorney, true?
Again, objection, Your Honor, assuming facts not before this witness.
Overruled.
True.
I'm sorry, could you repeat the question?
Yes, sir. Ultimately, the opinion was not to rule against the requester, which was exactly what Ken Paxton was pressuring you to do, correct?
Again, Your Honor, I'm going to object. She's now mischaracterizing this witness's testimony. He said he was not pressured.
Sustained.
By not ruling, you were not ruling against the requester. By making a no decision, that's not ruling against the requester. True?
That's correct. We didn't rule against either party, the requester or the governmental bodies at issue.
Now, earlier you said that the OAG decision not ruling against Nate Paul's attorney, quote, tilted the scale in terms of how a court would ultimately decide whether or not to rule on the disclosure of that information. True?
No, if I said that, I may have misspoken. We did not want to tilt the scale. We didn't want to tip the scale either way. We wanted to maintain the status quo and allow the court to review it completely de novo without our opinion, which is due great weight, tilting the scale based on the procedural requirements.
Withholding the information would have been detrimental to the requester. That's what you said on direct. Do you remember that?
I'm sorry, could you repeat the question?
You said withholding the requested information would have been detrimental to the requester. Do you recall that testimony?
I'm going to object, Your Honor. I don't recall that testimony either, so mischaracterization of his testimony.
And I'm happy to put her on the stand. I'm asking the witness if he recalls his testimony.
We can check with the court reporter.
I have a quote, it would have been detrimental to the requester.
Okay. I'm going to overrule. You can answer yes or no.
Yes, it would have concluded that the information could be withheld.
Now, on June 8th, after the opinion came out, Joanna Ward, do you know who that is?
John Award?
Yes, sir.
Yes.
Okay. On June 8th, she was asking if you still had the file in your possession. Do you recall that?
Yes.
In the file she was referring to was the entire DPS file, correct?
Yes.
And within that file is one part of it would have been the probable cause affidavit that Nate Paul was looking for, correct?
No, I believe that, if I'm not mistaken, I think that was after the ruling had been issued.
It is, sir, but that's not my question. Included within the DPS file would have been the probable cause affidavit that Nate Paul was looking for, true?
No.
The probable cause affidavit would not have been within the DPS file.
Not after we issued the ruling, we would have sent the documents back to DPS.
But by June 8th, after the decision was released, do you recall Joanna Ward emailing you and specifically asking you if you still had it, it was still checked out to you, and asking when you were going to return it? Do you recall that?
Yes.
We talked a lot about precedent and what should be publicly disclosed. You would agree with me that a search warrant is treated substantially differently than a probable cause affidavit or search warrant affidavit in terms of whether or not that should be released to the public, correct?
There are different exceptions that can apply to those, but I would not characterize anything as what can or should be released to the public. It needs to have an exception that applies to it. But both can be released to the public. A search warrant affidavit is more likely to have an exception that applies. They're not automatically confidential.
Correct. No further questions, Your Honor.
Redirect.
That was dismal.
Very briefly, in any of these requests, could either party have filed a lawsuit challenging the outcome?
Yes.
Did anyone file a lawsuit for the outcome of the FBI brief ruling request?
No.
That's all I have, Your Honor.
And just so the court knows, because it has been unusual, either side can ask questions from the podium or their tables in case anyone's asking. Can the witness?
Requires no redirect, Your Honor.
Pardon?
Witness requires no redirect. Recross.
Can the witness be excused?
Yes, Your Honor. Thank you, Mr. Gordon.
Am I released, Mr. President?
I'm checking with the House. Yes, you can be released. Thank you. Hence, we'll call their next, no, we're going to take a break. Sorry. We'll call your next witness after a break. How about 5 minutes after 10? 20-minute break? 11. Sorry. We passed the 10 hour. 5 minutes after 11.
Well, guys, I think that the House did a terrible job establishing anything at all. The witness refuted their entire narrative. It was great, wonderful to behold. So over on the Rumble chat, we've got, let's see. And I changed my mind. I don't think Leah has better hair. Her chunky highlights made me change my mind. Okay. Over on Rumble, you're saying, let's see. Read some of them. Let's see. Someone says Erin is a cover-up artist. We'll see what she, big bad black conservative. We'll see what she looks like at the end of the day, right? It was a long day yesterday. Oh my gosh. Raging Smirk says, good. Then she heard our feedback on how Erin CIA DOJ is irritating, like nails on a chalkboard. Mm-hmm. maybe her would be super greasy. It might be. It would be if I was her. If she was me, yeah, whatever. Spotzel says, FYI, if you're looking for info on 21 out of 30 votes issue, Angela recusal. It was at the very beginning, the first day's announcements. Yeah, I must have missed that. But that's a pretty interesting catch. Just another clucker in the gaggle. Well, Lindy, that was a funny comment. Sorry. I hadn't read that before I read it aloud. I just read it aloud the first time I was reading it. That made me laugh. Melindy says, just another clucker in the gaggle. Batty mom of 3. Yep. Says, see you next Tuesday. She was they're both real see you next Tuesdays. You know what I mean? So I guess we'll just Big Bad Black Conservative says, well, they say all black people look alike. I guess all white brunettes look alike. Yeah, I think I'm a white brunette, but one time somebody did a report and they said I was a redhead. And I was like, am I a redhead? Yeah. Icky vibes, yeah. They have like an ick factor to them. Raging Smirk says that pink color is gross. Trump Rocker says, thank you for the clarification. Yeah, they do. They look alike, but that was a good catch by Grain of Salt over on Pill. They're like, I think that's not Leah. I think that's not Aaron. I think that's someone named Leah. So I missed that. I'm trying to do like 4 things at once. So thank you for that. I'm glad I caught that comment so we can make that clarification because we're over here, still talking about Aaron, and we're I don't know if she's finished yet with these people, but Leah wanted to try her hand. I don't think it went well for Leah. I don't think it went well for her at all. Hey, B. Perry, how are you? They'll be back soon. Yikes, cleavage on the Senate floor. Woo! Wowza. B. Paris, yep, she demolished Articles 3 and 4. So I would say up till about Article 5 has been demolished, and the ones above that, some of them are redundant, to be honest. They're like, he committed a crime, and just committing the crime was another crime. That's kind of how they read. But it's just a bunch of hocus pocus. Oh, okay. So what we're going to do now is go back to this little recap that we were doing of yesterday. Now, if any of you are new here, let me know. But we're going to do a recap now. This is a young attorney that was on Paxton's team, and he was grilling. This is a witness from the 3rd day, okay? And we just watched one of Paxton's team, a young female attorney, totally destroy Articles 3 and 4, and it didn't take very long at all, to be honest. Even with Leah pulling an Aaron Epley and going up to the bench and having a lot of complaints about the evidence that they really did not want admitted, that evidence got admitted. And but the Paxton's female attorney that we just watched take those articles down, she did such a good job. This is another one, another young attorney. You know about Busby. We've recapped Busby taking apart these witnesses. Now this is one named Osco. I think his name is Anthony Osco. So we're going to get back to this recap for a while. And I'll work on the volume because I'm going to adjust the volume because I will be talking over this one. I was very excited when this first started. Now I'm talking a little bit more calmly just to, preserve my energy and just in case y'all are listening with earbuds in. But so I apologize for my volume on this video, but I'm going to work with the volume a little bit so you can hear everything. Okay. All right. Thank you.
I mean, Mr. Banger, you drafted this opinion, did you not?
Well, Mr. Vassar drafted it and I provided edits and corrections to it.
So you're familiar with the content?
I was 3 years ago.
Okay. Well, if you take a look at it, you would agree that it ruled that foreclosure sales could still go on despite the fact that there was an executive order restricting public gatherings outside to 10 people. True?
What's funny is that he had to have been freshly aware
Go to
of
the next page.
all these articles of impeachment. Now he's acting like, I haven't seen this in 3 years. Really? Really? Look at him pretending to read it for the first time in 3 years. As if this wasn't part of them building.
Let me know if you can hear it
Plugged in.
or if I should turn it
Look at
down.
him pretending to read it for the first time in 3 years, as if this wasn't part of them building the impeachment articles.
There were very limited circumstances under which foreclosure sales
I think
could
it's something
proceed,
quick.
but we were subjecting those to the hard 10-person cap.
I mean, you testified with regard to the subject matter of this yesterday, didn't you?
I did.
Remember the articles I showed y'all about all these foreclosures? This was a statewide
So you would
concern.
agree that you said that despite the fact that 10 people at max can gather in public, foreclosure sales can still occur. True?
That misrepresents the opinion.
Well, if there are, you said that foreclosure sales could still go on, did you not? Is that not what that opinion says?
No.
It doesn't seek to invalidate the 10-person rule, does it?
You need to go to the next page of the opinion.
Go to the next page, Eric. Thank you.
The second full paragraph on page 3 has operative language.
Elaborate on that.
Yeah, tell us
Pardon me?
about that.
Tell us about that.
What's operative language?
If a foreclosure sale is subject to and not exempted from the 10-person attendance limit imposed in Executive Order GA-28, it should not proceed if one or more willing bidders are unable to participate because of the attendance limit.
Executive order, you say?
So, how are you saying that when Ken Paxton asks you to change the opinion, that it is contrary to precedent and the position of the Office of Attorney General at that time?
It made the ability to proceed with those types of sales more restrictive under the COVID limitations than our previous draft would have.
It made it more restrictive?
Yes.
Right. Which means that, in a sense, it benefited people that maybe didn't have their jobs at the time and didn't have money to pay their
See?
mortgages off. True?
I told y'all.
I do not know who this was benefiting, at least at the time I was writing it. I didn't
What
know
an
who it was
idiot.
benefiting.
Did
What
you
an
lose your
idiot.
job during COVID, Mr. Banger?
I told
Say
y'all
again?
this is
Did
exactly.
you lose your job during COVID?
I did not.
Did you
No.
struggle with the ability to pay a mortgage during
No.
COVID?
He didn't miss one
I
pay.
did not.
You would have to agree with me that many people did lose their jobs during COVID. True?
Absolutely, this is a statewide issue.
I understand that that did happen.
Okay. And as a result of losing their jobs, many people probably couldn't afford rent and they couldn't afford their mortgage, right?
I also understand that financial institutions were suffering because of restrictions on their ability to
That's not
foreclose
what
on their
I.
loans.
Objection,
Oh my
non-responsive.
God! Look, he just spoke for the banks. He just spoke for the banks against the
Is that an
against the
objection,
good of the
Or
people.
you're just making a comment?
It is
Just spoke on
objective.
behalf of the bank.
Overruled, but let him
It's true
clearly
colors.
answer the question. Let him
Finally,
answer the question directed.
some truth comes out.
Yes
of
or no? My question was yes or no. Could that affect people and their ability to pay their mortgages and their rent?
Could what affect them?
A ruling that
Oh
foreclosure
my
sales,
God.
or excuse me, that COVID was in existence.
COVID was in existence at that time.
And it caused people not to have money and
Good
not to
Lord.
be able to afford rent and not to be able to pay their mortgages. True?
I believe the economic disruption caused by COVID had some of those effects.
Okay. And the
Look at the
job
way
of the
he's
Office of
dancing
Attorney
around it.
General is in part to protect the public. True?
The Attorney General's office is a sacred trust, and it's always to be used for the public benefit.
They did
Right,
this
now,
because
all of the
people
public.
lost
Eric, could
money.
you publish
This was
Exhibit
a
119
statewide thing.
again?
This was not in benefit of Nate Paul.
This is
Attorney
your
General took the same
memorandum
position
of what
as Abbott.
happened with regard to the foreclosure opinion.
They made sure people weren't being
And you
foreclosed
stated in
upon.
Exhibit
Under
119 that you were not certain
government-mandated
why
lockdown.
Ken Paxton wanted this foreclosure opinion issued. True?
There's no exhibit on my screen.
119, Eric.
May we see it, please?
I think it's been entered, Rusty.
I said, we don't have it.
Oh, I understand. Eric's pulling it up.
Chill out, Rusty.
We don't have a copy.
Jeez.
It's y'all's exhibit.
It's once again. Okay, this is the
Is it in
third time.
evidence?
I'm keeping track.
I don't
This
think it's in evidence.
It's in evidence, Judge. I've
This
already
is the
referenced
third
it during
time.
this examination.
He submitted it earlier. You didn't object, I believe. Oh, I believe that's the case.
If that's
Yes,
the case.
no, this, I
If that's the
recognize.
case for an error, but I don't think we had it marked as in evidence. Thank you very much.
Yes, sir.
Now that I believe.
You stated that you were uncertain why Ken wanted the foreclosure opinion issued. True?
He had provided me a rationale.
It's a yes or no. You said in this memorandum right here, you were uncertain.
I was uncertain.
Okay.
And I believe
Now,
that. This guy's out of touch.
You did not include the fact that Ken Paxton was texting you all the while you were editing it and drafting that report, did you?
Oh, wait.
I don't believe I mentioned text messages in this document, no.
And yesterday you told all the senators that it was contentious between you two on the phone at some points, did you not?
Oh, I don't recall saying that.
Okay. So it was calm and collected the entire time.
It was not calm and collected the entire time.
Okay. Well, you stated to them that you were objecting vehemently over the phone with Ken Paxton, true?
I did not say that.
You were objecting to Ken Paxton, were you not?
Except that you did.
I was having conversations with him in which he was frantically telling me to make edits, corrections,
It's
and
a yes or no
ultimately
question.
changes.
It's a yes or no question, Mr. Bangert. You disagreed with Ken Paxton over the phone, true?
I had conversations with him about the contours of the opinion.
Okay, so you're not saying you
Wow.
disagree with him then, are you?
I was trying to understand what he wanted as his subordinate.
You didn't mention text messages yesterday, did you?
I did not.
All right. Eric, if you would flip to AG 1003 for me.
This is crazy. Crazy. This guy's pretty good. This guy's as good as BuzzFeed. Maybe he works for BuzzFeed.
No,
There's BuzzFeed
Mr.
there.
Bangert, you stated on direct examination yesterday that, quote unquote, Ken Paxton was acting like a man with a gun to his head. Did you not?
I did say that.
Okay. Now, looking at the last set of text messages
Thought he was
here,
going to deny it again.
if you'd flip to the last page, Eric. I'm just going to read from the exhibit.
This is crazy.
Thank you again. I can't express in words how much I appreciate your work, especially over the weekend. I am grateful because I feel like hundreds of people will be protected from harm and maybe devastation. You and Ryan deserve all the credit. Thank you. I hope that your Sunday is relaxing and enjoyable with your family. He texted that to you that day, didn't he?
12:19 on Sunday. Yes.
Okay. Now, did you mention that to the House Board of Managers when you were interviewed about this case?
I don't recall if I mentioned this text message.
Did you mention these text messages in your interviews with Mr. Harden or Mr. DeGuerin when you were preparing for testimony and trial?
Let's see why I would have.
Okay. And did you include it in your memorandum to Ryan Vassar that was produced?
There's no reason why I would have.
No reason to include a text message of him showing gratitude and why he wanted to have this foreclosure opinion worded the way he did?
I don't believe this was what he actually, I don't believe that he was telling the truth.
Well, there's
here.
certainly not a text message from you in these texts objecting or saying that you disagree with Mr. Paxton, is there?
I do not agree. I do not disagree with him here.
You don't disagree with him here.
What?
I do not state it in writing here.
Okay. And you signed the opinion that was ultimately issued in this case, true?
I did sign it.
And that opinion has no binding effect.
It is a persuasive opinion.
Persuasive at best.
Persuasive opinion.
Did you tell the FBI about these documents?
I believe they were provided to the FBI.
Okay. We just didn't get a copy of them until today?
I did not have them in my possession.
Oh, okay.
They were in the possession of my counsel who found them.
Did you delete
recently.
your texts?
No.
So
For some reason, it has paused. Oh, here we go. Okay, that's fine. Sorry about that, guys.
And Judge, At this time, I would offer AG Exhibit 295.
Any objection?
May I have just a second? I'm
Sure.
sorry, Judge. Thank you.
The
No
live
objection.
Senate trial for today should be resuming in about 5
Well,
minutes.
what was the number on that? I don't have the number on that.
295, Judge.
Enter 295 into evidence.
This is a
Would you
recap
mind
of the day 3
publishing
cross-examination.
295? That is a letter from Sheena Paul to the judge regarding the bankruptcy the foreclosure proceeding occurring the next day, dated August 3rd of 2020, correct?
This is executed by Brian Elliott.
Attorney for World Class, right?
I assume so because it has World Class's one of their property names at the top of the letterhead.
You would agree that this document has the letterhead of August 3rd, right?
It is dated August 3rd.
Now, you were not present in the district court when this document was filed, were you?
No.
So you have no idea what impact it had on the district court judge in that proceeding, do you?
I have not talked or spoken with Judge Gamble about this, no.
Now, the very next day, the day that the foreclosures are supposed to occur, you find out that a bunch of Nate Paul properties are world-class properties are put into bankruptcy, right?
That's what the Business Journal reported.
Okay. You've been in civil practice for quite a long time, true?
Over a decade at that point.
You are very, very aware of what happens to properties when you file bankruptcy, are you not?
I was not a bankruptcy practitioner.
Well, you're aware that when you put a document, you file bankruptcy on something, it causes a motion to stay, does it not?
There's an automatic stay that's applied based on my recollection.
There you go, which would prevent any type of foreclosure sale, would it not?
Again, I am not a certified bankruptcy practitioner. I know that there are exceptions to that. I can't even begin to speak to the legalities of these properties or how those would have applied in these cases.
Well, you knew a lot of law, on direct examination with Mr. Harden, and now you don't know about bankruptcy proceedings?
Mr. Harden did not ask me about bankruptcy proceedings.
You had no problem putting in your memorandum that the properties went into bankruptcy.
The properties were going into bankruptcy, that's correct. Okay. I'm sorry, they were going to foreclosure.
It's possible that the bankruptcy filings did not, or those are what prevented the foreclosures, true?
I don't know.
Okay, well.
But I think it's interesting that World Class submitted a copy of our
Objection to non-responsive.
Opinion.
Objection to non-responsive. May I approach the witness, Judge?
Yes, you may.
Objection, narrative, and storytelling, whatever. I don't know all the legal objections, but that was stupid what he just tried to do. You see how defensive this witness is?
Okay, guys, we should be coming back soon. Not sure if we will be. Sometimes they like to take their sweet time. But how did you like Anthony Osco? I'm going to go over to the Pilled chat and read some of your comments over here. Hello, Diddy. Hello, Uncensored Abe. How are you guys? Stax, how are you? Of course, Victoria Truitt. Dondo, uh-oh. Anybody recall how much time both sides had remaining this morning? It was said, and I forgot. We spoke about it like an hour ago. But I have already forgotten about that. I'm so sorry. So this young attorney I think he did a good job. Let's see, what do you say over on the Rumble chat? What's going on over here? Spotzel says, are there any articles that are still in doubt, even from a biased position? Many shot down on day 1 and 3. Most of them were shot down right away. It was remarkable to behold, honestly. I was like, whoa. Paxton's team are so good. And also, there's just no case. So, Rob Mago, remember, she's from Washington. Yeah. So, right, there's no difference in either brief. The FBI released the entire brief publicly, so the brief was publicly available. So when Paxton released it, it was not a violation of anything at all. It had already been released to the public from the position of their office and by, you know, per the law. Okay. Let's see. You're also saying, what? There's cleavage happening. Who's committing cleavage on the Senate floor? Oh, the Motormouth ninny. Oh. Well, I changed my mind about her having better hair than Erin Epley. I changed my mind about it because of her chunky highlights. And it's not that everyone with chunky highlights I have a prejudice against, because I'm from the 90s. I remember when it was cool. But hers, I didn't like them. There was like 2 strips in the middle of her head. I was like, what is that? Anyways. Spotzel says, rule number 1 for lawyers, never ask a question to which you don't already know the answer. Sorry, that was right by the mic. And I thought I turned that down, but it's okay. Excelente. Let's see. So Brymark says, Spotzel, I was thinking the same thing. Peppy Frost says, recap the 21 votes things, please. Oh, so yeah, Spotzel pointed out that apparently in the Senate rules, Angela Paxton, we know she's not allowed to vote in this. You know, Attorney General Paxton's wife is a Texas senator. So Senator Paxton's here. She's watching this, but she's not actually allowed to vote on this. Though they kept the votes necessary to impeach at 21, meaning hers is just going to sort of default to a nay. Are the necessary votes total is at 21? Spotzel, if you want to give a better description of that, he already did that. Okay, there you go. So Spotzel has the description over in the Rumble chat. Let me see. If it's all right, I'm going to do this. I'm going to pop this chat out and I'm going to share this. So, all right, can you all see that? So Spotzel, wait, where is it? Has a really good rundown of this because they caught it. Oh my gosh, I swear that I turned that down. Oh, do more dance? Okay, I'm new to you. Got your link from Seth Keshel's Telegram. Love your commentary. I'm geeking out. You can follow on Telegram if you would like. Okay, Spotzel says with 30, right here, y'all. With 31 members, 21 votes required to impeach, the negotiated agreement reached by the Senate was that Angela Paxton would not vote, but 21 votes would still be required to impeach. So hers is going to sort of default as a nay. That was Spotzel's, that was actually Spotzel's observation. Very, very interesting one. I was like, wow, that's interesting. At first I was like, wait a second, that's not right. But then I was like, oh, wait, it's in our favor? Well, it's still noted that it's not necessary. But if they agreed to those rules, there's nothing I can do about it, you know? I'm not going to, that's not a hill I'm going to go and fight for. I'm doing election integrity. So they decided on these rules, them's the rules. Okay, let's see. How are you guys liking it? How are you liking the impeachment? I think that the House is not making the case that they thought they were going to be able to make. I'm going to be honest. I don't think it's working for them, you know? So let's see. They're still not back yet, so I'm gonna keep going with this until they're back. And you'll hear them hit the gavel because it's not on mute.
He can't even agree to basic stuff. He has to reword everything just to have control where he's losing grip.
I would like to offer AG exhibits that I've handed to both opposing counsel as well as Your Honor. I believe it's 262, 265, 275, and 283.
Hold on, slow down. 283, 275, 265, 262?
Yes.
I can shorten this a little bit. If he represents that these are their exhibit numbers that were originally agreed to, that we said we would not object to any of your exhibits.
Okay.
If they're covered by that objection, I mean, if they're covered by that agreement, then we have no objection.
Are they covered?
They are covered, Judge. Well, take that back. No, they're not. That's why I intend to offer right now. We have not previously agreed to these.
I understand. Just give me a couple more minutes. I don't care. No objection, Your Honor.
Can you just clarify for the record, we have one with a number and what the other numbers are? You may have the copies back.
So for purposes of the record, we're offering 262, 283, 275. I only gave you, and then also 269.
No objection. 269 was a new number from the one you repeated back to me.
Yep.
Just want to be clear.
269, 275, 283, and 262.
I think I said 265. You repeated what I said. I was incorrect. It's 269.
Okay.
There's been no objection? I believe they said no objection. Mr. Hardin, you said no objection, correct? Yeah.
Sorry, Judge.
Please enter those documents into the record.
Just gonna okay. Thank you.
Into evidence, excuse me.
May I approach the witness, Judge?
Yes, you may.
These are all bankruptcy filings by Nate Paul and his attorneys made on.
Yesterday, we had called Professor Michael Gerhardt, who's intended to be one of our expert witnesses. Last night, the court ruled that the expert testimony we were going to provide would not be heard. And so to the extent there was confusion, I just want to make the jurors aware and the public aware that that was the court's ruling, and that's why those witnesses aren't here.
And the court ruling was based on objection from the House under rule such and such.
Yeah, yes.
And we took about an hour to deliberate and look at all the questions.
That's right. I
we
apologize for,
We ruled in favor of the House on that.
just wanted the public to be aware. That's right.
And you were very kind to pull them from your witness list.
Thanks, sir.
Mr. Kinghorn, I believe I already swore you in the group. You may be seated. Speak loudly and closely to the mic. Thank you.
Austin, good morning. Thank you for being here. We both need to speak slowly and loudly into the microphone, I am told. You've testified in this chamber before the Senate, correct?
Yes, I have.
Okay, so you know the acoustics in here can get a bit weird, especially for our folks in the back.
That's correct.
So please just introduce yourself to the jury and tell us about your career.
My name is Austin Kinghorn. I'm the Associate Deputy Attorney General for Legal Counsel at the Office of the Attorney General. Would you like me to go back from the...
Yeah, sure. Why don't, if you could please just start with law school, walk us through what you've done up to the present day.
So I graduated from Baylor Law School in 2010. After that, I did a clerkship on the 14th Court of Appeals for then Justice Jeff Brown. I did a stint in commercial litigation. Yes, sir. I did a stint in commercial litigation after that, primarily doing insurance defense. After that, I went to work for the AG's office in the Civil Medicaid Fraud Division. When Justice Brown was elevated to the Texas Supreme Court, I went to work for him again as a staff attorney. I worked at the court for about 6.5 years in that capacity. for Justices Brown and later Justice Jane Bland, and then came back to the AG's office in the General Counsel Division. From there, I was promoted to General Counsel, and then most recently to the title that I hold now.
Thank you, sir. And tell us a little bit about your work for the Attorney General and your current roles, both as General Counsel, Opinions Committee, and your current title.
Right. So as the Associate Deputy for Legal Counsel, I'm over two divisions. It's a General Counsel Division and the Opinion Committee. In that role, I am both the Division Chief of General Counsel and General Counsel for the agency, and also Chair of the Opinion Committee.
How many employees do you oversee?
19.
And are you proud of your time at the Attorney General's office?
I am very proud.
I think this is a bit of a silly question, but it's come up a lot. Are you a rhino? Do you know what a rhino is?
Yes, I do. I've been called a lot of four-letter words. That's not one of them.
What are your politics? Are you conservative?
Yes, I am.
Again, I think it's a silly question, but it's being asked. On a scale of 1 to 10, how conservative do you think you are?
11.
Fair enough. What I'd like to do today with you is go through these articles of impeachment, see if there's any perspective you can provide as to each. And I appreciate you being here helping explain the work of the agency for the jury. So let's start with Article 1, which relates to the Mitty Foundation and the intervention into that lawsuit. Were you directly involved in that lawsuit or that intervention in any way?
I was not.
Okay. But are you familiar with EAMs?
Yes, I am.
Unfortunately, we've talked a lot about EAMs during this trial. What's your understanding? What is an EAM to you?
An executive approval memorandum is a document that the agency relies on to seek and attain executive approval of various agency actions or engagements.
And do you receive EAMs as part of your work?
I do. I probably receive one or more a day.
What do you do if you have concerns about an EAM?
If I have concerns about an EAM, typically the practice is going to be to reach out to who circulated the EAM and, engage with that person directly, try to flesh out the issues. Sometimes it's simply a matter of correcting something in the EAM and recirculating it. So, the first step is always just get in touch with the folks who are asking for the executive action and connect and make sure you have an understanding of what's going on.
If you get an EAM that you're concerned about, or if you're proposed a course of action that you don't agree with, do you just go ahead and sign the EAM anyway?
No, I do not.
Okay. So what does signing the EAM signify?
That would signify that you have reviewed the EAM, you reviewed the legal authority in it, the explanation of the rationale for the action that's being sought, and that you approve of that action being taken.
So if someone at the Attorney General's office signs an EAM, does that mean they've approved that action?
That's correct.
What about, let me ask you this. Does the Attorney General have to have an EAM that's fully approved by his subordinates before he takes an action?
No, he does not.
Why not?
The Attorney General's authority and the First Assistant's authority flow directly from the Texas Constitution and from statutes, specifically Government Code Chapter 402. The EAM process exists to vet certain proposals, but it is ultimately not binding on the person or persons who actually possess the constitutional executive power to act as Attorney General or on behalf of the Office of the Attorney General.
So just to make that clear, the Attorney General has the legal authority to act without an EAM approved by his subordinates?
Absolutely.
Okay. Does that include the authority to sign a contract?
Yes, it would.
Let's look at an example of an EAM. Can we pull up House Exhibit 62, please, Mr. Arroyo? Your Honor, I believe this has already been admitted into evidence. And I'm going to try and go electronic today. So we'll see if it works. And Mr. Roy, if you could just zoom in on the signatures on the top of this EAM and maybe capture the subject line as well. Have you seen this EAM before, Mr. Kinghorn?
Yes, I have.
And which EAM is this?
This is a EAM requesting approval to intervene in the Mitty Foundation litigation.
You weren't a signatory on this EAM, correct?
No, I was not.
Okay. But let's look at the first signatory. That's Mary Henderson. Who is that?
Mary Henderson at the time was in our financial litigation division, and she held a senior attorney role in that division.
And what does her signature on this EAM indicate?
That would indicate that she has approved of the action described in this EAM, and it looks like she's the one who actually circulated this EAM.
Why do you say she's the one who circulated it?
It says from Mary Henderson, and also she's the first signatory. So typically the first signatory on the document, the lowest signatory would be the person who actually routed the document for approval.
So does this indicate that Mary Henderson and Kat Day actually authored this EAM? Is that what this says to you?
That's likely the case, yeah.
Do you know whether the Attorney General ever spoke with Mary Henderson or Kat Day about this EAM?
I do not know.
Okay. Who's next on the signature line? Who's Josh Godby?
Josh Godby at the time was the division chief for the financial litigation division.
And what does his signature here indicate?
That would also indicate approval of the action that the EAM is seeking.
And who's next up the chain on this EAM?
That's Darren McCarty.
What was his role at this time?
At the time, he was the Deputy Attorney General for Civil Litigation, so you'd see his name a lot on EAMs like this involving requested courses of action in active litigation.
And again, I want to be clear about what his signature means here. When he docu-signed this EAM, what does that indicate to you as General Counsel of the agency?
That indicates approval of the action that is sought by the EAM.
And same question with Mr. Mateer. What was his role and what does his signature here indicate to you?
Jeff Mateer was the first Assistant Attorney General at the time, and his signature would indicate approval of the action that EAM seeks.
And would it be your expectation that all of these people who signed this EAM have read it?
It would. I mean, that is certainly the point.
That's what you normally do within OAG, right?
Correct.
And would it be your expectation that they understood the memorandum before they signed it?
I would not sign an EAM that I did not
Objection, Your Honor.
understand.
Question calls for speculation.
I'll move on. Thank you, Mr. Roy.
Sustained. And
all right, let's move on to talking about Article 2. That's about the foreclosure guidance letter. It's been called a lot of things in this courtroom. That's what I'm going to call it. Do you understand what I'm referring to? Are you familiar with that letter?
I do understand and I am familiar with it.
Okay. Did you work on that guidance letter personally?
In a very limited capacity early on, I performed some very perfunctory research on it. I never participated in the drafting of the letter itself.
Who asked you to do that research?
Ryan Vassar.
And did you form a conclusion as to what was the ultimate outcome in your limited role?
As memory serves, I didn't form any firm conclusions at the time. I performed a couple hours, maybe 3 hours of research, and really just had enough time to kind of come up with some general parameters of what the issues were. And Mr. Vassar and I had a phone conversation about what we had found so far in our respective research. And he took it from there, and I never had another conversation with anyone else about the letter moving forward.
Did you see the letter once it was ultimately issued?
Only when it was issued, yeah, when it went up on the website.
Right, so to be clear, you weren't involved in the drafting process, so you don't know how they got from A to Z on that.
That's right.
Okay, but you saw the final letter.
I did.
Did you agree with the analysis and the conclusion in that letter?
I do.
Objection, Your Honor. Relevance.
overruled.
And just as sitting there as you sit there today, can you briefly explain what that letter does in your view? Well, or rather, let me rephrase. Can you explain the conclusion of the letter?
The legal conclusion?
Yes.
The legal conclusion essentially was that under the circumstances of COVID at the time, with 10-person restrictions on in-person gatherings, that there was a possibility that a public sale, as defined by statute, that necessary element to proceed on a foreclosure wouldn't be satisfied if you didn't have a situation where anyone who wanted to be a bidder on a property that was under foreclosure would have an opportunity to bid on it and thus get the best, most fair value for the property.
Let me make sure I understand each piece of that. So you mentioned the public sale issue. That's a requirement out of statute. Did I understand you?
That's right.
Okay. And you mentioned a bidder being excluded. Why would that be the case?
Sorry, could you repeat that?
I thought you mentioned the 10-person requirement might result in a bidder not being able to participate in a foreclosure sale. Why would that be the case?
Correct. So normally these sales are open to the public. Anyone who wants to go bid on a property can, and that of course has the effect of increasing the price typically. And the COVID restrictions are at the time, the governor's executive orders only permitted 10 people to gather at once in what was considering, I think the nomenclature was at the time, a public gathering.
So to make sure I understand what you're saying, if there were bidders that were excluded, that could drive the price down at the sale?
Yeah, that's certainly a possibility.
Okay. In your view, does that letter shut down foreclosure sales in the state of Texas?
I don't have an opinion on whether it did or didn't. I do know it was non-binding and informal legal guidance.
Did you work on any other COVID-related opinions or guidance documents?
I worked on a great number of them. During my first several months at the agency, starting in June of 2020, COVID-related work was the vast majority of what I was doing.
And if you could just briefly for a minute here, explain to the jury, explain to the public, we're trying to explain the work of the Office of the Attorney General today, so explain what it was like to be working on these issues during COVID.
It was intense. It was a demanding time, as I'm sure it was for a lot of people in this room. We were on the cutting edge of a lot of novel legal issues. A lot of folks were looking to the AG's office for guidance and direction on how to respond, how to navigate the challenges that were coming forward, especially as it pertained to the governor's executive orders, which were coming out. We were often looked to for guidance on how to comply with those, what they meant, construing them, and we fielded those requests from all corners.
Was it unusual during that time to have expedited requests or to be working on short deadlines?
That is never unusual at the OAG, under any circumstances.
Particularly so during COVID?
Sure, particularly so.
Are we to understand
Everyone who
that
came to us with a problem
could
needed an
gather to
answer.
foreclose on
It
property,
wanted an answer,
but not
at least
to
quickly.
work to pay mortgages during COVID?
Let's
And
talk about
the Attorney General's
opinions
office
and
said no
guidance
on that?
documents from the Attorney General's
When they
office
did that?
more broadly. What kinds of guidance can the Attorney General issue?
Well, there's a range of options. A lot of folks in this room are probably familiar with our formal legal opinions. Under Chapter 402 of the Government Code, a authorized statutory requester may request a formal legal opinion from the OAG, and that opinion, while non-binding, is a source of persuasive legal authority that courts typically will look to and consider when resolving a case. But we have other tools in our belt beyond that. Additionally, under Chapter...
Before we go to the next one, I just want to clarify one thing. You mentioned that a lot of folks in this room might be familiar with that formal legal opinion. Why would that be the case? Why would these senators and some of these House members be familiar with that?
Chairs of legislative committees, senators and House members are authorized requesters under the statute.
Okay. Does the Attorney General's office work frequently with those authorized requesters regarding their requests for opinions?
We frequently work with members of the legislature on a host of issues and try to be as solicitous as possible in being helpful and giving the best legal guidance we can.
And I'm sorry I interrupted you. So that was the formal legal opinion process. You're
That's
moving on to the next category. So I apologize for interrupting.
Sure. So under Chapter 418 of the Government Code, which is the Texas Disaster Act, the AG's office has additional authority to provide legal counsel to local political subdivisions during a declared disaster. Authorized requesters include mayors, county judges, county commissioners, emergency management directors. Beyond that, the office has historically operated with the understanding that we have broad legal authority with the Attorney General as the chief legal officer of the state to issue informal guidance of public note, of public interest that would have a wide applicability to the public at large, especially in disaster situations where there's a need to get good information out to the public on pressing issues. And that authority, I think, flows directly from the Attorney General's constitutional and statutory authority as the Attorney General, as the chief legal officer of the state.
Other than the foreclosure guidance letter, can you recall any examples of other COVID-related guidance that was issued that also fell in that third category you described?
We put several guidance documents out on issues that a lot of folks are facing. Churches, private religious schools. I know that we did some opinions on access to vacation homes, and not opinions, letters on access to vacation homes in other states, where golf courses fell in terms of the governor's orders for shutdown purposes. So there were a lot of topics that we put something out there short of a formal opinion that was designed to provide generally applicable informal legal guidance to the public at large.
So it's fair to say, is it fair to say that the foreclosure letter was not unique in that regard? It was not the only informal guidance that was put out.
That's correct.
Let's look at a couple of other examples of guidance from this time. Mr. Arroyo, if you could pull up House Exhibit 105. And I believe this has already been admitted, Your Honor. Are you familiar with this document, Mr. Kinghorn?
Yes, I am.
And just very briefly, what is this document?
Objection, Mr. President. This document is not in evidence.
I apologize. I thought it had been admitted. It's House Manager's Exhibit 105, and I'd offer it if it hasn't been admitted.
We thought it was pre-admitted, Ms. Epley?
No, Mr. President, I don't believe so. We don't object. It's our document to begin with. I just wanted to make sure the record was clear.
Yeah, I apologize. I tried to get this smoothed out with counsel before we started, but yes, I offer it if it hasn't already been admitted.
Okay. It will now be admitted into evidence. That's exhibit, what's the number, 105?
House Exhibit 105, Your Honor.
Okay. Admitted to evidence.
Is that
Mr. Kinghorn, if you could, please just, to the extent that you can, please just describe briefly what this document is.
This was a general guidance document that the agency issued to houses of worship during
the CIA and
COVID
DOJ's own
pandemic.
Aaron Epley.
Is this
The
a
Manila
full-blown opinion
Blazer.
under Chapter
She should
402?
be impeached
It
for
is
the
not.
Manila Blazer.
And
as well.
is this a disaster council letter under Chapter 418?
No, this is not.
Mr. Arroyo, if you could show us the bottom of the page, there's a date next to the exhibit stamp. And when was this letter issued?
It says April 27th of 2020.
Do you think it was any way improper for the agency to issue this guidance?
No, I do not. And in fact, I think this is the kind of guidance a lot of folks were looking to the Attorney General to provide.
Let's look at another example.
May I seek clarification? He was confirming that the guidance in regards to the House of Worship Exhibit 105 is not something he takes issue with, correct? Not the foreclosure letter itself?
Your Honor, she can cross-examine the witness.
No, I'm clarifying.
This is my examination, and
Yes,
she should
you can,
be able
you can
to.
cross-examine on that.
Thank you.
Thank you, Your Honor. Let's briefly look at House Exhibit 104 next. I also thought this one had been pre-admitted. Maybe I'm wrong. To the extent that it wasn't, I'd offer House Exhibit 104.
Thumbs up.
Great. Mr. Kinghorn, have you seen this letter? Or rather, are you familiar with this letter?
Yes, generally speaking, yes.
Okay. This is a letter in response to Chairman Frank.
Yes, this is the one about the golf courses. Okay, I had to read a little bit into it.
Okay, great. Let's look at the last page, please, Mr. Arroyo. If you could just zoom in on that text, please. So this letter, was this a full-blown Chapter 402 opinion?
No, it was not.
And how can you tell that?
It's got some language there caveating that it is not a formal opinion issued pursuant to section 402.042, which is our formal opinion statute.
It says on the letter that it is not a formal opinion under Chapter 402.
That's right.
So if someone were to say that this was a Chapter 402 opinion, they would be wrong. Do you agree?
I do.
Are you aware that the foreclosure guidance letter has substantially similar language in it?
Yes, I am aware of that.
Okay. And who was this letter signed by?
Ryan Vassar.
So Ryan Vassar signed an informal guidance letter.
Yes.
Does that indicate to you whether Mr. Vassar thought he had the authority to sign that letter? Do you think there was an issue with authority for issuing this letter?
I assume that he operated under authority to issue this letter on behalf of the agency.
Did you think a requester was necessary for the foreclosure letter?
No, I did not, personally.
Do you have any personal knowledge as to why one was sought?
I do not.
So you'd have no reason to disagree with me if I were to tell you that a requester was demanded because someone was trying to get out of doing the
Objection,
work.
Mr. President, I'm sorry. Counselors testifying to facts not known to this witness.
Sustained.
You can take that down, Mr. Royal. I think that's enough for Article 2. I think we're going to skip Articles 3 and 4 because I don't think you have any unique responsibility with regard to the PIA. Is that true?
I do not. That's right.
And we've heard plenty about the PIA today. But as an aside, does the Attorney General have the authority to access any case file or file in the agency?
Yes, I believe he does. He's the Attorney General.
Why does that give him the right to access any file he wants?
Well, I guess there's kind of an old saying in the legal profession that his name's on the wall. It's his agency, and he's the duly elected Attorney General. So it's his law firm. He gets to see a file if he wants to see it.
So if someone were to say that the Attorney General improperly accessed a file, would that make sense to you?
That would not compute to me.
Me neither.
Exactly what we were saying earlier. Makes no sense. He has complete access
Can we pull up
to
Article
everything in his agency.
4 briefly, Mr. Royal?
These deep state mutineers are not duly elected, have probably never gotten a single vote in their life. In fact, Mateer wanted to be a federal judge. We really dodged a bullet with that one.
Do you see the allegation here where it says Paxton improperly obtained access to information held by his office? Did I read that correctly?
Yes.
Let's go to Article 5 now. Take that down, Mr. Royal. Are you familiar with the contract with Brandon Kamek?
I am.
Okay. Did you have any involvement with hiring him?
I did not.
Did you have any involvement with drafting the contract or executing it or anything like that on the front end?
I did not.
Okay. When did your involvement with this particular contract begin? When did your familiarity with it begin?
Uh, Sometime later, after the contract had been terminated, I believe Mr. Kamick reached out to our office to inquire about payment on the contract for the outstanding invoices.
And when you say reached out to our office, does that mean he reached out to you as general counsel, someone in your division? Do you recall?
My best recollection is that it was a phone call to the general counsel division. I think he was looking for someone to talk to about it.
Do you remember a date for that phone call?
I don't.
Was that before or after you'd been promoted to general counsel?
I believe it was after.
Okay. And when were you promoted to general counsel?
During the month of November of 2020.
Okay. So sometime after your promotion in November 2020, Mr. Kamick called to inquire about payment on his contract. Is that your testimony? I just want to make sure I understand the timeline.
That's right.
Okay. You were made aware of this phone call. What did you do with that information?
I conferred with Leslie French, our chief of staff, on that, primarily because she had more awareness of these issues and what had been happening at the time. As I said before, I had no involvement with the contract. So she and I recall discussing it.
Objection, Mr. President. Question calls for hearsay, or he's about to get into hearsay at this point.
And let me clarify. Please don't.
Sustained.
Yeah, thank you. Of course, I agree. Please don't relay the contents of any conversation that you had with anyone else. Don't tell me what anyone said. Again, I'm just asking, once you became aware of this request for payment, what happened next? So you said you conferred with Leslie French. Please pick up there.
My best recollection on this is that at some point, a call was made to Mr. Kamick.
Objection. Anything he could state after that is going to be hearsay.
We don't know what he's going to state next, so I don't think that's true.
Overruled.
In that case, anything next is non-responsive. May he ask another question?
You can break it down into questions.
Did you reach out to Mr. Kamick?
Yes.
What was the purpose of reaching out to Mr. Kamick?
To follow up on his inquiry.
What did you want Mr. Kamick to know when you followed up with him?
Objection, Your Honor. Hearsay.
I didn't ask for what he said. I asked for what he wanted Mr. Kamick to know in response to his inquiry.
Overruled.
The purpose of the call was to inform Mr. Kamick of how he might proceed about processing his invoices under the contract.
And what were Mr. Kamick's options to get paid at that point?
There remained work within the scope of services that had not been satisfied before we could issue payment. Specifically, the preparation of a report of his findings hadn't been completed. So what I relayed to him, and I believe this was over a voicemail, was that we couldn't make payment on the contract until that commitment had been made.
If Mr. Kamick had sent you that memo that he had contracted to provide, what would you have done?
Subject to any other clerical reason that we might have to shore up, from my view, it was a payable invoice because it was a valid contract at the time that the services were performed.
Did you ever hear back from Mr. Kamick after you advised him that if he sent you the memo, he could get paid?
I did not.
Mr. Kamick never called you?
Not to my knowledge.
And again, when was this, to the best of your recollection?
My best recollection is it would have been sometime in November or later.
Let's go ahead and skip ahead to Article 7, just briefly. Are you aware of the Attorney General's Office internal report regarding the events underlying this impeachment proceeding?
Yes.
And broadly speaking, what is that report as you understand it?
That report is the findings of a 10-month investigation that was conducted internally at the Office of the Attorney General concerning the allegations that the whistleblowers raised.
Did you ever review that report?
I did.
How many times? What was the nature of your review?
2, no more than 3 times, I was provided a copy and asked for general feedback on the document, proposed edits, revisions, things along those lines.
Were you ever directed by anyone to make sure that the report was a sham?
No.
Were you ever directed to make sure it included false or misleading statements?
Absolutely not.
Are you aware of anyone else receiving such a direction?
Absolutely not.
What would you have done if you had identified a false or misleading statement in that report when you reviewed it?
If I had identified a false and misleading statement, I would have immediately raised that issue to the folks who are working on the report for consideration.
When was that report published?
That was August 24th, I believe, of 21.
And just to be clear, I'm looking at the text of Article 7 here. The allegation is Paxton directed employees of his office to conduct a sham investigation. Are you aware of that occurring?
I'm not aware that that occurred.
And you're one of the employees who, at least to some degree, worked on the report?
That's right.
The report was published in August 2021, you said?
That's right.
And it's been on the has it been on the Attorney General's office website continuously since that time?
Yes, it has.
So, was that before or after November 8th, 2022, that this report was issued to the public?
After. Can you repeat the question?
Sorry.
I
Was
may
the
have misheard
report
date.
made public before or after the Attorney General's election on November 8th, 2022?
Oh, I'm sorry, before.
It's been on the Attorney General's office website continuously since then.
That's right.
Are you aware of whether there was reporting on the issuance of that report?
There's been extensive reporting on the issues that were discussed in that report.
When did that reporting begin, as far as you're aware?
That reporting began pretty much immediately when the whistleblowers reported General Paxton as law enforcement, and it's something we've been dealing with ever since.
And the OAG report also contains the details of those facts?
It does.
And that's been public?
Yes.
On the Attorney General's website?
Yes.
You can take that down, Mr. Roy. Let's move on to discussing Article 8 a little bit. Article 8 deals with the settlement of the Brickman versus Office of Attorney General litigation. Are you generally aware of that litigation and that settlement?
Yes, I am.
As part of the agreed settlement terms in that case, are there any contingencies that must be satisfied before the settlement is fully effective?
Well, the biggest contingency would be funding for the settlement itself. I think there may have been some non-monetary considerations as well, but I think maybe the one you're asking about is the contingency of the legislature funding the requested amount.
That is the one I'm asking about. Why is that legislative appropriation of funding contingency necessary for this settlement?
Like other state agencies, the Office of the Attorney General is prohibited in the General Appropriations Act from settling a case for more than $250,000 without seeking additional funds to do that.
Does state law set out a process for seeking funding for such a settlement?
It does.
Did the Office of the Attorney General follow that process?
Yes, we did.
Do you know whether funding was appropriated?
It has not been appropriated to the state.
Has the Office of the Attorney General paid out a single dime on this settlement?
It has not.
As far as you're aware, has a single dime of taxpayer money been spent funding that settlement?
It has not.
Who decides whether that will ever happen?
At this point, ultimately, the legislature will.
The House and the Senate?
Correct.
It's up to them whether to fund it.
That's right.
The Attorney General can't force them to do that, can he?
He can only ask.
Let's pull up Texas Government Code section 554.010. Your Honor, this is just a statute. I'm not offering it as an exhibit. It's going to be up on all of the screens. Mr. Arroyo, if you could zoom in on that. And I have paper copies for the witness and the court and opposing counsel, if that would be helpful.
Now this will work.
Are you familiar with this provision in the Whistleblower Act?
Yes, I am.
Can you explain in English what the statute means?
So this is essentially a reporting requirement. There's two parts to this. When you pay out on a settlement or judgment in a Whistleblower Act case, the agency is required to essentially put together a report on that case. And following that report, the state auditor's office may initiate an audit or an investigation of basically what went into what happened with the Whistleblower Act complaint. And if the SAO initiates that investigation, then they must follow up with a report to several entities on improvements that can be made, things that can be changed to prevent this from happening again.
So let's break that down. Let's go piece by piece. If the settlement is consummated, the Attorney General's office has to do what?
It has to put together a brief memorandum describing the facts and the disposition of the suit, and it has to provide that to the state auditor's office.
Okay. The Attorney General's office has to prepare a memorandum describing the lawsuit and send it to the state auditor's office. What happens after that? What does the state auditor's office do with it?
The state auditor's office will review the report, and not later than the 90th day after that report is submitted, the SAO has the option to investigate the governmental entity or conduct an audit.
Let's just pause right there.
Mm-hmm.
They have the option. Has the Attorney General's office been contacted by the state auditor's office regarding this provision in connection with the Brickman versus OAG matter?
Yes.
And what's your understanding of that contact from the state auditor's office regarding this statutory audit?
We were made aware of the existence of the statute, and they just wanted to bring it to our attention in light of the settlement road that we were on to make sure that we were aware of this requirement.
The audit's coming.
That's right.
And under this statutory audit, who would have received the state auditor's report?
The Legislative Budget Board and the Legislative Audit Committee, and the governing board of the chief executive officer of the entity involved.
What would that report contain pursuant to the terms of the statute?
The SAO's report would include recommendation on changes that would be necessary to correct the problems that gave rise to the whistleblower suit.
Mr. Arroyo, could you pull up the text of Article 8, please? If I'm understanding your testimony correctly, the OAG has been notified of the statutory audit by the state auditor's office, and those findings and recommendations will be given to the legislature under the terms of the statute, correct?
That's right.
Are audits and cover-ups the same thing?
I'm sorry, could you repeat that?
Is an audit the same thing as a cover-up?
Did you say a cover-up?
A cover-up.
No, it is not. It's kind of the opposite.
If someone's trying to, conceal their wrongful acts, should they subject themselves to an audit, in your opinion, as general counsel of the Attorney General's office?
No.
Do you know whether the state auditor's office likes to conceal facts when it conducts an audit?
I do not believe that is the way they are wired.
I don't believe so either. And of course, we talked earlier, your testimony is that the allegations underlying the facts at issue in this impeachment have been reported since they happened. That's your understanding.
Correct.
You've seen reports in the media frequently about the goings on at the Attorney General's office.
That's right.
Texas Tribune seems to have a story every other day about the Attorney General's office, don't they?
There is a lot of coverage.
Do you have any personal knowledge of Ken Paxton ever forming or forming an agreement with Nate Paul and accepting a bribe?
I have no personal knowledge of that.
And do you have personal knowledge of anything to do with Laura Olson?
I do not.
Okay. Do you have any personal knowledge of any vast criminal conspiracies involving misuse of OAG resources?
I have no such knowledge.
If there were such a conspiracy, would you still be working at the Attorney General's office?
No, I would not. I accepted promotion in this agency at a very critical time, and I assured myself and assured my wife if there were ever anything that I saw that were illegal or unethical, I would step away. And I'm still here. I'm proud of the work we do. I'm proud to serve General Paxton. I'm proud to be part of this agency.
Thank you, Austin. Pass the witness.
Well, that went very well, don't you think? I think this was an excellent witness. Very good. They have no case. The House impeachment managers have no case. Some of them are great attorneys, not you, Aaron Epley, and not you, Leah Graham. So I think we.
Ms. Epley, your witness?
Oh, ew. Okay, it's
Thank you, Mr. President.
CIA and DOJ's own Aaron Epley representing the House impeachment.
Hi, Mr. Kinghorn.
Good afternoon.
Have you and I spoken before?
We are old friends now.
That's right. Is it fair to say that you have been my contact to get documents from the Office of the Attorney General?
That's right.
And that our first conversation went well, but subsequent ones got a little chillier.
That's fair.
Now, we played respectfully with one another, right? No one was rude.
That's right.
Okay. Is it also accurate, though, that right after I would have private conversations with you as an officer of the Office of the Attorney General, particular details of our conversation would show up in Ken Paxton's filings?
Objection, Your Honor. Relevance, hearsay, has nothing to do with these proceedings.
Sustained.
Mr. President, I don't know that I've ever seen a
Nice
lawyer
try,
open up
Karen
a bigger
Epley.
door in regards to the credibility and bias of a particular witness, and I would ask for a little latitude.
Everybody,
Your Honor,
please
this
like
has
and share
nothing
this
to do with
out.
credibility and bias. She's asking about litigation discovery. That has nothing to do
I
with it.
sustain the objection. Try your question a different way.
Did you receive pressure from Chris Hilton or Judge Stone to provide you information in regards to our conversations?
Not at all, and I can answer your question more pointedly.
I'm certain that he will do that, so I don't want to be rude, but I want to make sure we move forward.
She
Did
really
you
does
receive
not want
pressure
the picture.
incoming without a conversation?
Not at all.
Did you receive directives in regards to what position you should take?
None.
So the fact that you and I would have a conversation and it would show up in their filing the next day is completely and totally made up.
Objection, Your Honor. This is totally improper. All parties, all witnesses were free to speak to
absolutely
both
nothing.
sides. That was in the Senate rules that were adopted. And it is only fair that people producing discovery talk to both sides. They certainly talked to people we were talking to. We talked to people they were talking to. That's how the entire litigation of this impeachment has gone. This is completely improper. Nothing improper happened here. And she's not only attacking the witness's character, but my character and my colleague's character. This is completely improper.
Sustained.
To clarify, then maybe it was the subjective use of a word. As opposed to pressure, did you receive incoming communications?
No, it's your
that
entire
inquired
narrative
about
that's
our
a problem.
conversations?
Objection, Your Honor. Same objection, and this is hearsay.
Sustained.
Okay. You talked some about MIDI. Is that correct?
About you?
About MIDI. Sorry,
Sorry.
MITTE.
MIDI, yes.
Yes, sir. You were not directly involved in that litigation?
I was not.
So mostly what you offered for us was the use of the EAM or people's signatures to validate a contract or an action, correct?
Objection, Your Honor. Mischaracterizes testimony. His testimony speaks for itself.
Sustained.
What is the purpose of the EAM?
The purpose of an EAM is to solicit and attain executive approval of an action that's being proposed to be taken or or an engagement that's being proposed within the agency.
Thank you, Mr. Kinghorn. And when you personally sign an EAM, are you signing to say, I believe this is a good idea, we should proceed? Or are you signing to confer, as general counsel, there is legal authority?
You're asking about me personally?
Yes, sir.
And I would be signing generally as to legal authority.
Okay, so when Mr. Hilton asked you and you said you were giving approval, it means consistent with your job, that's an available option that we can justify, not this is my idea, I suggest we do it.
Objection, misstates testimony.
He can answer, Your Honor, if it's within his knowledge. Thank you.
I think that everyone's, depending on their role, their reasonings for going into their signature is a little different. For my role as general counsel, I'm primarily focused on whether the agency has the legal authority to take the action proposed.
And to draw an analogy then, Ryan Vassar, for example, signing Brandon Kamek's contract is approval that it's a legal justified position, not that it's the right one.
Objection, Your Honor. Assumes facts not in evidence with this witness.
Sustained.
But also it builds Ken Paxton's case that he has the legal authority.
Yes or no?
He had the legal authority.
Yes. Okay. I'm going to turn your attention for a moment to the PIA. Are you aware of incoming public information requests as to Ken Paxton's email, Signal, or Proton?
Typically, no. If a PI request you're referring to is directed exclusively toward the Attorney General, that's probably not a request that would come across my desk.
I think I want to be more specific. Are you personally aware of any PIA requests ever for the text messages, Signal account, or Proton of Ken Paxton?
Objection, Your Honor. Relevance.
Overruled.
There's been a great number of PIC requests concerning the Attorney General's personal communication devices. I don't remember with specificity as to the specific types of communication you're referring to.
So you're telling the Senate you do not know if a PIA has ever been requested for his texts?
If you phrase it that way, then yes, I am aware that there have been PIA requests for his text.
Are you aware of PIA requests for his Proton email?
I'm not personally aware of them, or at least do not recollect.
Are you personally aware of PIA requests for his Signal?
I'm not personally aware or don't recollect at this point.
Are you personally aware that he has those accounts?
Again, objection, Your Honor, to the relevance of this. It has nothing to do with anything this witness has testified about. It has nothing to do with anything in his personal knowledge.
It really doesn't.
Nothing to do with any of the articles of impeachment.
Overruled.
I do not have any personal knowledge on the use of a Signal account. In terms of, as I have reviewed the documents in terms of producing to you through subpoena requests, I have seen that there was a Proton email account that wasn't included, I believe.
Are you familiar with the fact that either the Proton or the Signal was set up by Office of the Attorney General IT staff?
I am not familiar with that.
Do you think that you should be if it's true?
Not necessarily.
Okay. Are you aware of the fact, either through a PIA request or the subpoena authority of this Senate, we were not provided any documentation related to Signal or to Proton email for business conducted on behalf of the state of Texas by Ken Paxton?
Objection, Your Honor. Lacks foundation, lacks personal knowledge. The witness has testified that this is not within his scope and that he doesn't know anything about any of these. This is an argumentative question with no foundation.
Sustained.
Did you personally respond to our discovery requests?
Yes, I did.
Did you personally have a conversation with me about Proton email?
Objection, Your Honor. Hearsay.
I don't know what to say to that, Your Honor. We're both here.
I'm going to overrule. You can answer the question.
Thank you.
Can you restate the question for me? I'm sorry.
Did you personally have a conversation with me about Ken Paxton's Proton email?
I do remember that conversation, yes.
Do you remember telling me that you knew it existed, but couldn't provide me any of those documents?
I did not say that.
You didn't tell me that you knew that there was a Proton email account, but you didn't know anything about it.
Objection, Your Honor. Asked and answered. She's attempting to impeach the witness with a conversation that she thinks she recollects. This is improper.
Evidence.
I'm certain I recollected, if that helps.
Overruled. You did ask, he did answer, but overruled.
Okay, so let's try this one last time. Will you tell the ladies and gentlemen of the Senate if you provided us any proton or signal documentation for Ken Paxton?
Sorry, can you ask it just a little bit more slowly, just the echo is...
That's fair, I speak quickly. Will you tell the ladies and gentlemen of the Senate whether you did or did not provide us any document in regards to Ken Paxton's proton or signal account?
We did not provide any documents related to a proton or signal account.
I don't think they would have access to that necessarily.
At one point during the questioning, I think what you had said was the Office of the Attorney General is Ken Paxton's law firm. Did I get that right?
Objection, misstates prior testimony.
It was in court today and a moment ago on the subject of Gross.
Overruled.
Thank you.
I'm analogizing, but yes, I did say that.
But of course, that kind of brings me to my next point. As a prosecutor, your job is to zealously advocate for the, your job is to seek a true and fair, I've forgotten my oath. As a defense attorney, your job is to zealously advocate. But as a civil attorney who works on behalf of the Office of the Attorney General, what is your oath? What are you supposed to do? What's the most important part of being a lawyer for the state of Texas?
Objection, Your Honor. Compound question.
Overruled.
God truly works in mysterious ways, doesn't he, Patriots?
I would say the most important part of my job as a public servant is to faithfully serve my principal and the people of Texas.
Do you believe your principal and the people of Texas to be different? Who do you think your client is, Mr. Kinghorn?
Who is my what?
Who is your client?
My client?
Yes.
Is the Attorney General.
Elected by
Would
the
you
people
believe me
of
if I
Texas.
told you that when you work for the Office of the Attorney General, you work under his authority and for him, but your client is and only ever is the state of Texas?
Objection, Your Honor. Argumentative, contains a legal conclusion.
Sustained.
She is.
Do you believe me when I say that, or do you agree with it now as you sit here?
Slinging mud.
Objection, Your Honor. Same.
Yeah, same question. Sustained.
And her hair is still stringy. Big bad black conservative. Are you seeing this?
You were asked questions about Brandon Kamek, and you relayed a conversation in which he'd called to find out about payment. Do you recall that?
I do.
And can you tell us what month and year that was?
Not with any greater specificity than what I indicated earlier.
I didn't hear you, so would you tell me again?
Sure. I believe it was after I was promoted general counsel, which would have been sometime during the month of November. But it wasn't necessarily during November. It could have been December. I don't remember exactly when it happened.
Okay. So Ryan Vassar was part of bringing you into the Office of the Attorney General, is that correct?
He was.
And Ryan Vassar was a friend of yours, correct?
Everybody
Yes.
on Pilled.
And is it fair to say that you liked and respected Ryan Vassar?
Yes.
And when he was summarily dismissed from the Office of the Attorney General, you rose to his position somewhere around
Are you
November,
saying this
correct?
insensibly?
Objection, Your Honor. Argumentative and assumes facts not in evidence before this witness. Moreover, I don't know what this line of questioning is intended to do other than improperly bolster the character of some witness who's not here. The door has not been open to that, so that aspect of this questioning
Trent
is also
says she
improper.
did open her own law firm the same month she left DOJ and took on this case. Yes, the DOJ's own Aaron Epley.
Were you promoted after Ryan Vassar was fired?
Absolutely. Aaron Epley is a bit of a problem.
Eventually,
Yes or no?
yes.
Thank you. And it was after that that you had a conversation with Brandon Kamek, and Brandon Kamek is asking your office about payment because despite the fact that he's been employed since September, he's never been paid. Is that right?
That's right.
And as of November, there was no contract in place, right?
There was a valid contract.
Then why was he never paid?
At one time. By the time Mr. Kamek reached out, I believe the contract had been closed at that time. Just trying to be specific.
So what I'm asking you is, there's a secret private contract signed only by Ken Paxton, not kept in the Office of the Attorney General at some point in the storyline, correct?
Objection, Your Honor. Argumentative, assumes facts not in evidence before this witness.
Sustained.
I don't know how else to do that. The defense's entire position is that Ken Paxton signed a contract with Brandon Kamek, correct?
That he had the authority to.
Objection. This witness has been subject to the rule and doesn't necessarily, doesn't speak for the defense. It's the same question. It's argumentative. It's a sidebar. You've just sustained the objection.
If I may, he was questioned at length in regards to the OAG report. Any person who's read it once or skimmed through knows that this is their position. It's not a violation of the rule. It's a question he opened.
Objection,
Their position
argumentative,
is that
and
he
lacks
hired him and
foundation.
that
She
he had the
hasn't laid that
authority
he
to
knows
hire him.
anything about that aspect of the OAG report. And if she wants to ask that question, she can do it, but she has to lay the foundation for it and do it properly.
I'm happy to do that.
Dane, go ahead.
Did you read the Office of the Attorney
She already
General
admitted
report?
that she forgot her oath, so we're not surprised.
I have read it, yes.
Okay, so on page 5, it reads, position taken by the Attorney General in this litigation was adverse to Nate Paul and in support of higher settlement amount to be paid by Nate Paul. Do you recall that being their position?
Objection, Your Honor. If she's reading from a document, I don't understand what it is, and I don't have it.
He's testified that he's read the Office of the Attorney General report.
I didn't understand.
He's been questioned in regards to its veracity. I intend to take him through a list of false and misleading statements to get his position and then challenge him with the testimony of the whistleblowers as allowed by the rules.
Objection overruled.
In regards to the Mitty Foundation, on page 5, it says the position taken by the Attorney General in this litigation was adverse to Nate Paul. You understand that's his being Ken Paxton's position, correct?
Objection, Your Honor. There's been no testimony about Ken Paxton's position, and there's no, are we talking about the report or are we talking about Ken Paxton? I'm still confused as to what we're doing here.
Sustained.
Is the Office of the Attorney General report in question published on the AG's website?
I'm sorry, say that again.
Is the Office of the Attorney General report published on the AG website?
Yes, it is.
And do you have to have either title status, meaning Ken Paxton, or the first assistant in order to publish it?
Yes, that's a fair statement.
And therefore, every statement put onto that website is adopted and made on behalf of Ken Paxton, correct?
I believe that the report is issued by the Office of the Attorney General. Whether that extrapolates to a legal position that Ken Paxton holds pursuant to this proceeding, I'm not going to go there.
So as an officer of the court and a government agent, you're not going to honestly say that anything published on the Office of the Attorney General website is the responsibility of Ken Paxton and something he should be held accountable for? That's your position?
Objection, Your Honor. Argumentative. She's demanding that this witness make a legal conclusion that he's justified, that he's just testified that he cannot make.
He is the general, thank you. Is your position that he cannot be held accountable for what he posts on the website?
My position is that I can't speak to the Attorney General's legal positions.
Isn't that your entire job duty?
Objection,
Let
Your
him
Honor.
answer. Let him finish his answer.
Thank you.
No, it is not. My job is to provide advice and counsel to my client, the Attorney General of Texas.
Okay. So if you had to choose between the state of Texas interest and Attorney General's interests, whose do you choose?
I do not see them in conflict.
Okay. Then back to this point. Do you or do you not, as attorney for Ken Paxton, think that he is held accountable for the items that he posts on his website?
I don't know what you mean by held accountable. That's a very vague question.
I'll help. Are you familiar with the Texas Rules of Evidence?
Somewhat. I am general counsel, not a litigator.
Do you understand what an admission by adoption is? Or an admission because it's made by a representative? Or an admission because it's made by an employee?
I'm aware of those rules.
Do you believe that those things would apply in appropriate context to Ken Paxton?
That's not something that I've researched specific to this proceeding. I don't have an answer for you on that.
I think we're all clear on you not wanting to answer this question, so I'll move along. I'm going to give you a series of statements then, and I would like for you and I to discuss them. This investigation revealed the OAG's intervention worked to the foundation's advantage on mediation. If I was telling you, or if that statement's about Mitty, and you have Ryan Bangert, Josh Godby, Darren McCarty, and Ray Chester all disagreeing with this statement, would even them disagreeing change your opinion as to it being valid?
Objection, Your Honor. Assumes facts not in evidence before this witness as to those other folks' positions. I don't have an objection to her questioning the witness about a document that I believe is in evidence, but I think in fairness, he should be provided with a copy of it.
Sustained.
So earlier when Mr. Hilton asked you if you believed in the OAG report, you're not actually saying anything in it is true or not true, or that any of us should really entertain your opinion on it, right?
Objection, argumentative, misstates testimony.
Overruled.
Can you restate the question?
Your opinion on the Office of the Attorney General report being truthful is irrelevant to this proceeding because you will not address the statements within it. Is that accurate?
I don't agree with the question as you phrased it.
Okay. Then let's talk about the foreclosure letter. You went into great detail in regards to the distinctions. You relied on 418. Is it accurate to say that applies to mayors and local subdivisions, but not Senator Hughes?
That's correct.
And so Senator Hughes's authority or name wouldn't be necessary if that was the basis of that letter, correct?
I do not believe it was necessary. That's correct.
That's a different question. If the Attorney General was relying on 418, Senator Hughes's approval would not be necessary, correct?
If I understand yes, that's correct.
In regards to 402.042, that you do need an official requester for, correct?
That's right.
And if it was an informal guidance, then no requester is needed at all, correct?
That would be my position, personally.
So in regards to items 1 and 2, you wouldn't need to involve Senator Hughes at all, let alone use his name to put forth an opinion that he certainly would never have approved of, right?
Objection. Assumes facts not in evidence. Moreover, she's stating a juror's opinion without following the rules.
Sustained.
Okay, last in regards to your credibility and the Attorney General's reliance on you. Is it fair to say that you represented him in a bar grievance relying on in a government filing or a court filing? And you took the position that the Attorney General was not subject to the bar rules or the state Texas ethics rules?
Objection, Your Honor. Assumes facts not in evidence.
I'm asking him, he's on the stand, it was his position.
And you're characterizing that grievance and that litigation. You're mischaracterizing it. You haven't established that any of those things are true with this witness.
That's the purpose of the questioning.
Overruled.
Did you or did you not take the position that the Attorney General of the state of Texas is not beholden to state bar ethics rules?
Objection, relevance. That doesn't have anything to do with an article of impeachment.
Overruled.
Ms. Epley, I'm not sure which, can you be more specific about what complaint you're referring
Please
to?
like and share
I
this
don't
out
have
so
recollection
people
when
can
I sit
understand
here
what's been
as to
happening to our
specific.
Attorney General.
Does it feel appropriate to you that you would ever, for any reason, for any purpose, indicate that the Attorney General of the state of Texas was not beholden to bar ethics rules?
I don't think that's what we said at any point.
Pass the witness.
Mr. Kinghorn,
Well,
do you
that
know if
did
any
not go well
proton mail
for
or signal documents
Aaron Epley.
that would be responsive to their subpoena exist?
I do not.
Did you conduct a diligent search for those documents on behalf of the Office of the Attorney General?
I conducted a diligent search of all documents that we had in our custody and control.
Do you have an obligation to produce documents that don't exist and that aren't in your possession, custody, or control?
I do not.
I have 1 moment, Your Honor.
Exactly. That's how the Public Information Act works. The Public Information Act does not compel governmental agencies, bodies, or individuals or
Pass the
persons
witness, Your Honor.
to create documents.
Ms.
It
Epley,
only
are you
compels
coming
them
back?
to supply the
No,
documents
I have
and
no
access.
further questions for Mr. Kinghorn. Thank you.
May he be excused.
May we approach on a quick housekeeping matter? It's just the admission of some records I left at the podium, frankly.
May I excuse the witness? Yes.
That's fine with us, Your Honor.
Okay. Yes, you can approach.
Once again, the DOJ and CIA's own Aaron Epley, representing the House impeachment managers, has asked to approach the bench to enter more evidence in that she claims she just forgot to enter on the podium, wasting more time. And of course, nobody trusts her. Everyone's up there. The Paxton team is up there looking at what they're trying to enter in. Bill Nye, the fake science guy, is over there. Do you see? He's got the bow tie. He looks so silly. He looks so silly with the bow tie. He's a tall and lanky man. And just, the bow tie is not my thing. Let's go and see what you're saying over on the Pilled chat. Over on Pilled and Foxhole, let's see. Stack says they never say no when asked if they're a rhino. You mean they never say yes? Yep. Oh, you mean they don't just come right out and say no? I understand what you're saying, Stacks. Absolutely. Cisco Kid says, I'm learning more and more each day that the laws are like statistics, easily manipulated to support a narrative. Not so much the laws, but the procedures based on the interpretation of those laws. That's the administrative state in action, right? That's just how it works. That's how that's why we need to make sure that the administrative agencies don't have too much power and that we can deal with legislatively. Cisco Kid, how are you? Welcome. So she reminds me of Marsha Clark, just the nagging voice. Cisco Kid says, that's going back in time. Truett says, Cisco Kid, that's going back in time. I had all but forgotten that name. Carrie Lake says, pretty soon she's going to be in Dan Patrick's lap. Well, careful. Let's go see what's going on over on the Rumble chat. Please like and share this out. They'll be back to the podium in just a moment. This is, once again, the CIA and DOJ's own Erin Epley, representing the House impeachment managers, has asked to approach the bench. She likes to do this. She likes to waste our time, gum up the process. This is the strategy because they have absolutely no case. Paxton's team has destroyed these articles and their witnesses. The House accidentally rested when it meant to pass the witness yesterday. That was hilarious. And now it's the defense's turn, and these are all Paxton's witnesses. And the House impeachment managers are very particular about the type of evidence they want admitted, despite their entire case being built off of hearsay and double hearsay and a literal mutiny inside the Attorney General's office. Yes, Cactus Blossom. Erin Epley sounds like Kamala. Rob Maga agrees that she's annoying. I hope you're talking about Erin Epley and not about me. I'm just kidding. Hunter Sabo says, did they say when lunch break? Don't want to miss anything. Well, they're not at lunch break right now. They just have asked to approach the bench, but I wouldn't be surprised if they stay at the bench for a while and then declare lunch break after wasting a lot of time at the bench. So we shall see what they want to do. What time is it? Is it time for lunch? Yeah, it's about time for lunch. So I wouldn't be surprised if they announce lunch break soon. In fact, it would be polite for them to if they're going to argue about all of this. Thank you guys for being here. Thank you everybody over on Pilled and Foxhole and Rumble. I'm heavily shadow banned on YouTube. So hello, Akira. How are you? And
Members,
just one.
we will take our lunch break now
Until
1:30.
Okay,
yes,
guys.
and there's a short meeting before that.
Alrighty, they're going to take their lunch break from 12:30 to 1:30. It looks like they're going to have a meeting before their lunch, before some people go to lunch. All right, so we will also go to lunch, and while we're at lunch, I'm just going to do another recap. I'll probably let this one finish up with Mr. Osco because I think he was doing a good job. Mr. Osco from day 3 of the impeachment, questioning some of the House impeachment managers team witnesses. So I'm going to go back to this. We were playing this earlier, just a short recap. Okay, so let me go ahead and put that on there, letting y'all know this is a recap of the day 3 cross-examination. And I'm going to also let you guys know that we will be back at 1:30 Central Standard Time. Okay. Thank you guys so much for being here. Donations are accepted, but they are not required. Visit our website at takingbacktexas.org to see what we're all about. You can get signed up for a few different things at our website, our email address, our Substack, And you can sign up to start duplicating our work in your county. You can get connected with us, and we'll get you trained up on how to do what we've done. All of our reports on this website, all of our presentations are done by myself with the help of a lot of excellent Patriot poll watchers who have taken our courses and have helped us follow through. Our follow through game is pretty strong whenever we have teamwork. It's hard for one person to do everything, but when you have people helping, you can really get a lot done. So just putting this in. And there we go. Now I'm going to go ahead and start this. Let's make sure we have any other comments. Akira, hey, what's up? Hello, Diddy. I know Diddy's been here. Diddy, Crisco Truitt. Cisco Kid says her middle name is Time Bandit. So I thought it would be very polite of them to go ahead and announce lunch break, since they're going to waste more of our time, with Erin Epley and her protege, Leah Graham. Protege or genetic clone? Was Leah Graham, was she grown in a petri dish? We have no confirmation that she wasn't. And no offense to anybody out there that might be a test tube baby. God made you too, even if you went through man to do it, okay? But we gotta just make sure we're not playing God, okay? We need to be careful, okay? We need to be careful. So I'm gonna go ahead and get this going. I hope y'all enjoy.
On August 4th and August 5th, okay? Say so. All right. Now, if these bankruptcy filings were filed on August 4th, the date that the foreclosures were supposed to occur, that would stay the foreclosure sale, would it not?
I don't know.
You don't know.
Perhaps.
So it's possible that Ken's issuance of the informal guidance letter didn't cause the foreclosure sales to go away. It's possible.
I do not know what effect that letter had on the foreclosure sales.
Are you a Trump fan?
I'm sorry?
Are you a fan of Donald Trump?
I voted for President Trump.
Okay. You're a staunch conservative, are you not?
I am.
Are you aware that only a week after you guys issued this opinion, he issued an executive order that basically mimicked the attitude towards foreclosure sales?
I'm not familiar with that executive order.
Okay. And so that brings us into the fall of 2020, right? August, September?
September is the beginning of fall.
Okay. And you didn't really have any contact with issues regarding Nate Paul from August of 2020
Keep
up
answering
until
questions nobody's asking.
September 28th, right?
Oh, I disagree with that.
Well, you weren't working on the foreclosure
The witness,
opinion.
please speak up when you're.
Yes, I disagree with that.
You were not working on the foreclosure opinion.
That was completed on August 1st.
Okay. You weren't working on MIDI.
Mr. McCarty had assumed responsibility for that.
You were not working on MIDI.
I was not working on MIDI at that time in August.
And you were not working on the open records request, true?
Those were finished.
Okay. So you were not personally working on any matters that involved Nate Paul at that time.
I was actively speaking with other members of the executive team about what was happening at that time, which was the desire to hire outside counsel.
So everybody, I assume, is on the 8th floor at this time, right?
We had COVID orders were still in place. I don't recall who was there every day. I was there every day the office was open.
And let's talk about that, because the OAG's position at that time was that everything should open up, was it not?
We wanted everything to be as open as possible, consistent with public safety and the governor's orders.
Even after you left the Office of Attorney General, your employees at the Office of Attorney General weren't even present.
There were some who were not present.
There were some. There were most of them that were not present.
My recollection was there were periods of time where large majorities of them were not working from the office.
Periods of time that postdated your employment at the Office of Attorney General.
I cannot speak to that.
Because you weren't there.
Because I was not there.
So that's not really inconsistent with the situation that was going on at the Office of Attorney General, was it? Yes or no?
That the attorneys were
Yes
not
or-
present?
Yes or no?
Oh, that had nothing to do with our policy.
Okay.
Nothing.
So you were not personally a part of the hiring of Kamek, were you?
No.
You found this out on September 29th of 2020.
That he had been retained by the Attorney General directly?
No, that he was filing subpoenas with Michael Wynn.
Yes, I learned about that on the 29th.
And you're saying that that is the very point that it kind of stood out to you all what was going on, right? That was the tipping point.
That crystallized a number of things.
Okay. Now, when you say it crystallized a number of things, you did not have all the facts with regard to that investigation, did you?
I personally did not.
Okay. You didn't investigate that case, did you?
Was I? What do you mean by I wasn't investigating that case?
You didn't investigate the referral that was given by the Travis County District Attorney's Office, did you?
I was not the primary responsibility for that.
Everything that you took with regard to that investigation came from Mr. Penley or Mr. Maxwell.
No.
Those were the people responsible for investigating it, were they not?
They were responsible.
Okay. You were not responsible.
That was not part of my responsibility at that time.
Okay, so you weren't responsible. Now, despite that fact, you went to the FBI on September 30th, correct?
I did go to the FBI on September 30th, yes.
You went to the FBI without talking to Ken Paxton first, true?
Oh, I talked to him many times prior to that.
You didn't talk to him about the fact that you were going to go to the FBI, did you?
We did not talk to him. We did not tell him we were going to the FBI immediately prior to going.
Right. So when you and Mr. Harden were talking about the conversations you had with Ken Paxton about the fact that you wanted to talk to him, that was all after you had already gone and reported your boss to law enforcement, true?
The text messages that we reviewed today were sent after we made our good faith report.
Okay. So you did not take the time to hear his side of things out before you went to law enforcement?
I disagree.
And at that point, you took it upon yourself to send a letter to Brandon Kamek as well, did you not?
If I can recall correctly, I was the one who did send the email containing Jeff's letter. Again, I'm stretching my memory, but I think I was the one who sent it.
Okay. Now, prior to doing that, you talked earlier about a set of text messages. I would ask to admit to publish House Board Managers 225. Eric, would you? It's been admitted, Judge.
And Council, we're going to be going to the lunch break. I've gone a little longer, a few more minutes. Do you want to break now, or do you want to continue for
I'm
a few
fine
more
right
minutes?
now, Judge.
Is good for you now?
Yep.
Okay, we'll break for lunch now.
Your Honor, I apologize. Can I raise one issue? I apologize, Your Honor. Can I raise one issue before we break for lunch?
Yes.
That may just help speed things along with this witness. You admonished Mr. Harden at the beginning of the day that if there were any statements that Mr. Bangert had provided that we haven't seen, that he was to turn them over to us. The witness has testified that there were actually 2 interviews that he gave to the House. We still don't have any information related to those. To the extent that there's work product mixed with that, I think they can redact that and provide us the statements. But I just request that we get those over the lunch break, and that may allow us to not have to recall the witness later.
Just continue to look during lunch break for those documents if you have those.
Thank you very
And
much.
if you do, turn those over by the end of lunch.
Sir, we do not have, but I'll continue to be sure. Thank you.
We will return at 1:10.
Okay, guys, so this is when they went on break from day 3. So what I'm going to do is, let's see, we're going to fit through some of this.
They're going to go to lunch. They said they'll be back at 1:10. So we'll.
That informal guidance was issued. And to be clear, Eric, would you?
Okay, we're back with the recap. We'll be back at 1:30 p.m. for the live impeachment trial for day 8 of the impeachment of Ken Paxton, the political takedown of our Attorney General of the great state of Texas. The deep state is exposed. The articles are destroyed. At this point,
exhibit number again.
just having
It's not
fun.
an exhibit. I don't intend to offer it as an exhibit. It's just a statute. I'd be happy to if you'd like me to.
I'm I'm not sure I'm going to object, but I can understand what the purpose. I mean, you're going to ask the witness about it, or
I do intend to ask the witness about the law on non-judicial foreclosures.
are you perhaps having it here for him to refer to in case he doesn't know it?
I have a copy in case he's going
Counselor, if
to
you
need
can
to.
address the court.
Sure.
Both of you can address the court.
I'd be happy, yes, Rusty, and I'd be happy to offer it as AG 1005.
If it's not being introduced to evidence, I don't have any objection to what we're doing. I don't think. I just don't know what the statute. If the court has it. I don't know whether the court has it.
Okay, we do have it. I thought I heard you just say if it's not being offered as evidence, you have no objection.
That's correct. That's correct.
Okay. So,
at this time, I don't intend to offer it into evidence. Mr. Banger, are you
we're on the same
aware?
page?
Yeah. Okay. All right. So, did you just say now that you are offering it?
No,
You're not offering it.
I wasn't offering it at this time.
Thank you.
I might change my mind here in a second. We'll see.
All right. Fair enough.
Mr. Banger, you are somewhat familiar with non-judicial foreclosure law, correct?
Did you ask, am I familiar with non-judicial foreclosure law?
Yes, I asked you if you were familiar with non-judicial foreclosure law.
It's been a while.
Okay. Well, you did write a memorandum about it and issue an informal legal opinion on the matter, correct?
If you're referring to the August 1st letter, I did assist Mr. Vassar in putting that together.
Okay. And in doing so, you probably had to research the law on non-judicial foreclosure opinions, true?
Not necessarily.
Okay. You're aware of when non-judicial foreclosures take place, correct?
Based on the document that I prepared, I believe it was the first Monday or Tuesday of every month, but that's my recollection.
Okay. If we said it was Tuesday, would you agree with that?
I would have no reason to disagree.
Okay. Now, the fact that that occurs every single Tuesday, that singular Tuesday of every month, that's a reason that Ken Paxton could have said, Mr. Banger, we need to get these done this weekend. True?
Yes, that could have been a reason.
Okay. And to be fair, Nate Paul is not the only person that had properties that were subject to potential foreclosures on that date, was he?
I don't know for a fact, but it seems reasonable to assume there would be other properties that would have been subject to foreclosure.
Okay. Potential homeowners, correct?
Again, I don't know of any particulars, but it's entirely possible.
So it's safe to say that it could have been someone that
You can't
didn't
think
have a
of
job
one
and
person.
didn't have money to pay their home loan, correct?
I have no reason to agree or disagree with that. I don't know.
Okay.
He has to agree with that. We saw that that's what was happening, but he has no reason to agree that people were threatened with losing their home.
After that informal guidance was issued, and to be clear, Eric, would you mind pulling up House Boards 119? That was not issued like a legal opinion was.
Okay, you guys want to see some more? Something you've seen
I'm asking.
what you will of Mr. Osco. So let's jump over here and see if this guy impresses you.
Complaint. Yes?
This testimony was hilarious the other day. I think it was the day before yesterday.
I'm sorry?
Again, these are our good faith beliefs that a crime had occurred.
Respectfully, sir, we are not here in this historic event for your good faith beliefs. So if you could just tell these senators who are taking up their time and all of Texas's time with this impeachment.
Excuse me. These sidebar testifying comments are an inappropriate form of cross. If you just asked a question, I have no objection.
I will throttle it down. I withdraw it.
Pull that back.
Yes.
Ask a question.
Mr. Vassar, we got a lot of people whose time is invested in this impeachment proceeding. Did you gain any evidence after you went to the FBI?
I'm not sure what evidence that I can recall.
You had a good faith belief. We've heard those words a lot in this trial, a good faith belief, but without any evidence, correct?
The evidence that we provided.
Why didn't you talk to Ken Paxton? I'm sorry.
Please let him finish his answer.
Overruled. He was finished.
Mr. Vassar, when you worked for Ken Paxton, was he gentle?
As far as I knew, yes,
Be
sir.
kind.
Yes, sir.
Ever yell at you, scream at you?
No, sir.
Don't you think you owed him the courtesy of at least a phone call before you reported a man to the FBI without a shred of evidence?
But that's not how the reporting structure worked.
Oh, please tell these senators how it works.
Well, all of my interactions were directly with Jeff Mateer and Ryan Bangert. General Paxton would call me with questions like the open records issue or the foreclosure letter, or I'm sorry, not the foreclosure letter, that was through Ryan Bangert, outside counsel. So every other instance was my weekly meetings with Jeff Mateer and Ryan Bangert. And I never called the Attorney General. He always called me.
I appreciate your answer, but that was not really what I asked. So let me try again. Don't you think you owed the Attorney General of the state of Texas at least a phone call before you reported him to the FBI without any evidence? Yes or no? That's not the way it worked? Yes or no?
Would you like me to answer?
Yes, I would.
Based on our conversations with Mr. Mateer and Mr. Bangert, they were having conversations directly with General Paxton. I was not part of those conversations. So any concerns that they had raised with him would have been in their conversations. I had no reason to call him directly.
Object non-responsive.
Sustain.
Let me try this again, Mr. Vassar. Don't you think you personally, Ryan Vassar, don't you think you owed the Attorney General of the state of Texas, elected by over 4 million voters, a phone call before you reported him to the FBI without any evidence, sir?
I was appalled at the time. So
object non-responsive.
Sustain.
I object to the contingent interruption.
We're all
of the
appalled
answer. If he
now.
doesn't like the answers he's getting, he can then object to it being non-responsive. But jumping in the middle of this, man, is totally unfair, and I object.
I will listen more closely, Counselor. I have not heard him interrupt him. I will listen more closely so the witness can finish his answer and you can do a follow-up question.
Vassar, my question was, don't you think you personally owed Attorney General Ken Paxton, elected by over 4 million voters, a phone call before you reported him to the FBI without any evidence? Yes or no? No, I don't? Yes, I do.
Well, I would disagree that we didn't have any evidence just based on our beliefs, but I don't think I owed General Paxton anything.
I've turned up the volume, but please forgive my loud voice from this is a recap, so I might not have been speaking as quietly here.
Correct?
He did. And promotion.
And a promotion, huh? Not enough to warrant a phone call before you report him to the FBI, though. True?
Like I said.
Do you wish you could go back and call him?
I'm sorry, say.
Do you wish you could go back in time and call Ken Paxton and talk to him before you reported him to the FBI without any evidence?
I wouldn't do anything else differently.
Interesting. Okay. You don't know anything about Ken Paxton's campaign donations from 2018, do you?
No, sir, I don't.
You didn't work on the Mitty Foundation case, did you?
No, sir.
When you went to the FBI, did you have Ken Paxton's phone number, at least? Could you call him on his cell phone? Did you have the number?
I believe I had his phone number in my phone. Yes, sir.
How'd you get it?
I think he gave it to me.
Why?
Just based on working with him and questions that he would call me with.
So you could call him if you needed something, so he could call you if you needed something, right?
That could be an option, just based on a cell phone use.
You even had his secret email address, didn't you?
I'm not sure which one is.
Well, there is an email that's already entered into evidence in this case. It's ag.wkp@protonmail.com. Have you seen it?
Yes.
He gave it to you, right?
Yes.
Did you email him on his secret email address? Tell him that you were going to go and report him to the FBI without any evidence?
No, sir.
Why not?
It didn't occur to me.
Didn't occur to you. At some point since then, has it occurred to you that maybe you should have done that?
No, sir.
How secret could this email address have really been, Mr. Vassar, if you had it?
I don't know exactly.
Do you consider yourself a close confidant of the Attorney General?
No, sir.
Do you think you're the only person that had that email address?
I have no reason to believe that I was the only one.
So this gentle, kind man, was he attentive to your concerns when you talked to him in the office? Talked to him on the phone?
Sure.
Gentle, he's kind, he's attentive. And at what point in time did the weight of what you were doing in reporting this gentle, kind, attentive man to the FBI become apparent to you?
On September 29th.
When you walked in there?
Walked in where?
To the FBI.
No, that was September 30th.
Okay. So what happened on September 29th when the great weight of having to report this gentle, kind, attentive boss struck you? What was going on?
September 29th, I was in a meeting, just a division meeting with Lacey Mays, and she received a text message on her phone from an individual that I did not recognize, and the individual asked if a Brandon Kamek was working for our office.
And you knew exactly who that was, didn't you?
Yes, I recognized the name.
And what happened in your mind was you realized this contract didn't work its way all the way through the executive action memorandum process. True?
Among other things, yes. That's a thought that went through my mind.
Yes, and the rest of that thought is, if that process has not been completed, he has no authority to work on behalf of the Office of the Attorney General, correct?
Yes.
And that was alarming to you, true?
In addition to the fact that he was acting in a capacity that he didn't have, even if a contract had existed at the time.
And in that moment, did you call General Paxton and say, Brandon Kamek's working, what's going on?
No, sir.
Do you think it's possible? Is there room in your mind for the possibility that if you had called Ken Paxton and told him that information, Ken Paxton would have said, yeah, Ryan, I signed the contract with my own hand, with my own pen. Is there room in your mind for the possibility that that would have happened?
Well, it is possible, but he was out of the state at that time. So I wouldn't have been connected to him or had a reason to call him.
You had his phone number. So what if he was out of the state? Cell phone works out of the state, surely, right?
Yes, sir.
You didn't think to call him?
Well, as I explained, because he was out of state, Jeff Mateer was running the office.
That's another thing we're going to get to, okay? My understanding is your belief was that while Ken Paxton was in Ohio working on the Google case, the biggest case that the Office of the Attorney General had, Jeff Mateer was the acting Attorney General, right?
That's correct, although my understanding, in addition to...
Object is non-responsive to the remainder of this answer.
Sustained.
Mr. Vassar, can it possibly be in a state with as many millions of people as Texas has, that it is the belief of the upper echelon of the Attorney General's office that anytime the Attorney General gets on the plane, Jeff Mateer is the real Attorney General?
Only to the extent the government code is triggered. That's what deputizes the first assistant to act under the authority of the Attorney General.
And your belief was that on September 29th and 30th, when Ken Paxton was in Ohio doing business on behalf of the people of the great state of Texas, litigation business, very important litigation business, that someone else was the Attorney General, and that's what the government code says. Is that right?
Well, it was my understanding it was a political event. It was a campaign event. I had no knowledge that he was working on the Google case.
He was doing a campaign event in Ohio?
That was my understanding at the time.
Where on earth did you get that?
Just conversations at the time with Mr. Mateer.
So if he was on, let's say he was in Ohio on a campaign event, Jeff Mateer's the Attorney General while he's there?
I was just clarifying my understanding based on your question. Your next question of whether Jeff Mateer is the acting Attorney General, again, that would depend on the statute. The statute provides if the Attorney General is absent or unable to act, the first assistant shall perform the duties.
Tell the senators what absent means.
The statute doesn't define it.
Tell me what you think it means.
Well,
out of the state?
It would mean the ordinary meaning of the word under a statutory interpretation approach.
Tell these senators, many of whom are very accomplished attorneys, what the word absent means to your understanding, please.
I am not advised of what the dictionary definition would be. That would be an interpretive guide. Absent could mean out of state. Absent or unable to act could mean incapacitated.
Like if Ken Paxton was on life support in a hospital somewhere, for example.
I presume so.
But he wasn't. He was in Ohio, which I guess is debatable one way or the other.
I'm not aware if that statute has ever been interpreted by a court. So I could not be able to say.
But in any event, it provides the perfect cover for someone in your office to remove Ken Paxton's name for the letterhead and begin sending out letters on behalf of the Attorney General of the state of Texas. True?
No, nobody removed his name from letterhead.
You don't think so?
No, sir.
Have you ever seen Attorney General's office letterhead without Ken Paxton's name on it?
All the time.
All the time?
Yes, sir.
How did correspondence in September of 2020 come to be sent to parties outside of the Attorney General's office without Ken Paxton's name on it? Tell us.
Well, the agency has different letterhead. There probably even today, letterhead that's available on the Attorney General's website that does not have his name on it.
So,
letterhead that he signed.
I see. So when the Attorney General is absent in Ohio, someone at the office goes, grab me the letterhead without Ken Paxton's name on it. He's in Ohio today. Is that right?
I don't recall any decision about using this letterhead or who instructed the use of the letterhead.
No one decided, it just happened, right?
Like I said, I don't recall any decision about it. The agency has different letterhead that exists today.
You're familiar with the Mitty Foundation now, right?
I've heard of it, yes, but
You've been an attorney how long?
I was licensed in 2012, so 11 years.
You said your family goes to a Baptist church, right?
Yes, sir.
Okay, that Baptist church is organized as a nonprofit, right?
Yes, sir.
And at some point in time, I'm sure you've given money to a charity, correct?
Yes, sir.
I got to ask you something that's just been really bothering me, and I know I'm not the only one. What in the heck is a charity doing making a multi-million-dollar private equity investment with Nate Paul with charitable funds? Any thoughts on that?
I'm not sure. I don't know.
You ever ask anybody?
No, I was not involved in the Mitty case, was never consulted on it or provided any advice for it.
Do you know, maybe you do you know of any charities that make multi-million-dollar private equity real estate deals with charitable funds?
I have no personal knowledge.
Okay. Do you recall giving testimony to the House Board of Managers and being questioned on video by Aaron Epley, Brian Benkin, and Therese Buse?
Yes, sir, I remember.
But they never put you under oath, did they?
Not that I recall.
Did that kind of surprise you?
I didn't think anything of it.
Did you ask why not?
I don't know. I don't think I did.
Well, just because you weren't, you are an attorney, obviously. Just because you weren't under oath doesn't mean that you didn't tell them the truth, the whole truth, and nothing but the truth, so help you God. True?
That's right.
Did you review your statement in preparation for this historic trial?
No, I consulted with my attorneys, and that was it.
Did anyone give you a copy of it?
A copy of my
Your
statement?
statement, yes.
No, sir.
So anything that you said in that testimony, I guess we can call it testimony, anything you said in that testimony that's recorded, we can take as a gospel truth, right? Yes?
Just based on my telling the truth, is that what you're asking?
Yes.
Yes, sir.
We can take it as being true, yes?
Yes, sir.
Okay. Have you ever, before today, have you ever in your life been asked to give testimony as a witness without being sworn?
I don't recall. I've been a resource witness to many Senate and committee hearings, but I don't recall if there is an oath administered to a resource witness. So I apologize.
Have you ever given sworn testimony anywhere before today?
No, I don't think so.
It's a tough first outing, isn't it? Mr. Arroyo, if you would, Article 1 of impeachment, please. Can you see Article 1 on your screen, sir?
Yes, sir.
You don't know anything about this, do you?
No, this would be the MIDI Foundation matter.
And just to be clear, have you looked at Chapter 123 of the Property Code to determine what the Office of the Attorney General's obligations are with regard to charities in the state?
No, no, sir.
Don't know anything about that, do you?
No, sir.
All right. Mr. Arroyo, Article 2, if you would. Now, Mr. Vassar, you've given some testimony about what we'll call the foreclosure opinion, right? It was issued August 1?
Yes, sir.
Issued August 1 of 2020? Yes?
Yes, I believe that's right. It was a Sunday.
That opinion was not a legal opinion under Subchapter C, Chapter 402 of the Government Code, was it?
Yes, it was a legal opinion under Subchapter 402.
It was?
Yes, sir.
That's not what you told the House Board of Managers. What did you tell them?
I don't recall.
We'll get to that later, but that's not what you told them, is it?
I don't recall. I may have misstated.
You may have misstated.
If you're saying that's not what I said, and my testimony today is that there's no other statutory authority except for Chapter 418 of the Disaster Act to issue a legal authority, to issue a legal opinion by the Office of the Attorney General. So it either has to be Chapter 402 or it has to be Chapter 418.
But we know this is not 402 because it says on the face of the foreclosure opinion that it is not under 402, correct?
It does say that it's not, but that doesn't mean it doesn't fall under the authority of that chapter. It just means it wasn't written in accordance with the typical legal opinion process.
I was hoping that we would be able to have a chance to discuss this. Mr. Arroyo, please bring up Section 402.042 of the Texas Government Code. No, we're looking for 042. That's .212. We'll get to that later. Thank you. While Mr. Arroyo is bringing this up, I've got a couple questions for you about that. In order for the foreclosure opinion to have been authorized under Chapter 402 of the Government Code, Mr. Vassar, certain criteria need to be met. Is that correct?
I believe so.
There first needs to be an authorized requester, correct?
That's correct.
Who are the types of persons who are authorized to make that request?
The governor, the lieutenant governor, the speaker, chairman and chair people of committees of the House and of the Senate, executive heads of agencies, and county and district attorneys.
Did any of those people request the foreclosure opinion?
Yes, sir.
Okay. What is the next criteria to satisfy for Chapter 402 of the Government Code?
You're going to have to refresh my recollection.
All right, Mr. Arroyo, if you would move to the second page of that PDF that you just had up. There you go. If you could just highlight the text at the top, that big chunk of text there. A little bit lower. Thank you so much, and just blow that up for us. Let's look at item C, okay? You're a lawyer. We can read this together, right? Right?
Yes, sir.
Okay, guys.
It says a request for an opinion must be in writing.
Get started with what they're doing. I'm not sure if
4th, 2020 was the first
All
Tuesday
right,
of the
guys.
month. Would you believe me?
Now we are live.
That
This
sounds
is
right.
not a recap. Let me take this recap thing off. We are live. This is happening.
Let's go
as
back to
we
Exhibit
speak.
AG 170, which is this text thread here, if you would. Let's continue on.
This
Blake
is
Brickman
live
responds
coverage.
to you. Mr. Arroyo, can you bring that back up for me? We're at page Brickman 198 for the ladies and gentlemen.
Now,
of the jury.
I will very likely switch over because I have to go to work here for a couple of hours. So I will very likely switch over to RSBN's live stream so as to avoid any interruptions. Because, every time they take a break, they actually
And
stop
if
the
you look,
feed.
Mr. Arroyo, if you can zoom in on the blue text at the very bottom.
RSBN will allow me to continue streaming without any stops to the feed.
Blake Brickman responds, obviously just a coincidence, right? LOL. And then he had the audacity to thank the office publicly at deputies meeting later that week for stopping foreclosure on individual homes. The man is a pathological liar. You see that?
Yes, sir. I see that.
Next page.
So thank
Mr.
you guys for
McCarty
being here.
responds, all about the people. And David Maxwell responds, all about himself. Then there are a series of additional articles that are being posted to this group chat. Why are you on a group chat in October of 2020?
Because
anyway?
they're gossip queens.
We were all friends. We were all colleagues.
Bunch of mean girls.
We all enjoyed working together. So this was just a group thread where we talked.
Are mutinies fun? Tell us.
If you would, Mr. Arroyo, would you bring it forward to page Brickman 200? In the middle of the page.
Counselor, hold on one second. You're a little ahead of the.
Oh, I am.
Okay,
I'm
it's
sorry.
up now. I want to be sure it's up for the jurors to read when you're quoting it.
Thank you, Mr. President. Mr. Arroyo, if you could zoom in on Ryan Vassar's text at the middle of that page. Yes, Mr. Vassar, thank you. Not quite so close, Eric, if you would. Just capture those two texts from
Eric,
Ryan
you
Vassar
zoomed
in the
in
middle
too
of the page,
much.
the one above that too. Thank you, Mr. Arroyo. Now, Mr. Vassar, you linked to a tweet from Lauren McGaughy on, it looks like October 25. Is that right?
I don't. Yes, it's a link to a tweet. I don't see anything about an October date, but oh, you're talking about the date that it was sent.
Yeah, it may be October 26 because
Yeah,
we're on that same thread.
yeah. If it's chronologically just with the pages, the page before Brickman 199 ends on 10/26, so it could have been 10/26 earlier in the day.
And you write hashtag Soul Survivor. What does that mean?
I'm not sure if it was referring to the tweet that I was referencing. It could have been an indication that I was the last remaining whistleblower who was still employed by the office.
I see. And if we can continue on in that thread, Mr. Arroyo, zoom in on the next three texts in that thread, please. Not Mr. Arroyo, just right under the date stamp, if you would, please. Good man, thank you. All right. On October 26th at about 5:55 p.m., Ryan Bangert writes, yep, And Ryan Banger writes, BW, that's Brent Webster, right?
Yes, sir.
BW just dropped by and just to be clear for ladies and gentlemen of the jury, hopefully everyone knows, but Brent Webster is the then current First Assistant Attorney General, true?
Yes, sir.
It says, Brent Webster just dropped by my office to inform me of an org chart change. I will no longer be overseeing special litigation because it will now report directly to him. And you respond, what a joke, right?
Yes, sir.
And David Maxwell responds, that's a train wreck waiting to happen. Ryan Bangert says, let him have it. And Blake Brickman writes, he is a joke. Yes?
Yes, sir.
Let's continue to the next page. If you can give me, Mr. Arroyo, maybe the gray text at the top, we'll go piece by piece. No, maybe the first 6 gray texts so we can just all see them together, if you could. Thank you. Ryan Banger says, it will run itself. My fear is that he will force them to do crazy expletive. Is that typically how Ryan Banger would talk?
No, sir.
Lacey Mace says, I find that absolutely hilarious. Darren McCarty says, perfect. I've been trying to figure out how to get Patrick and Disher to join my new law firm. Is Darren McCarty one of the so-called whistleblowers?
Yes, sir.
Has he filed a lawsuit with you?
No, sir.
Hello, everybody on Pilled,
He
Truett,
just got out of the
Victoria.
OAG's
Thank you for the
office and
can,
hung out a
Victoria.
shingle, it sounds like,
Stax
right?
Osru.
That's my understanding.
Okay.
Good morning.
Ryan Banger says,
Lord
maybe Aaron
Tay.
can help. I'm
How
sure
are you?
Patrick and Dish
Uncensored
will love
A.
being managed by a failed prosecutor and a third-year lawyer.
Whoa.
That's what Ryan Banger wrote about his coworkers. Yes?
Whoa.
I'm sorry, say that again. Ryan Banger.
That's what Ryan Banger wrote about his coworkers. Yes? His colleagues. Yes?
Yes.
Good morning,
And there's a
Vicky.
like
Good morning,
from
Hunter
Ryan
Sabo
Banger,
over on
and you
Rumble.
write, Patrick and Dish will need to start using smaller words in their pleadings. That's what you wrote, right?
Yes, sir.
Wow.
You're
These
insulting
people-
your colleagues on this familiar group chat. Yes? Among friends. Yes?
It was a very...
Object non-responsive.
Witness shall answer yes or no.
You are I'm sorry, I'll ask it again. You are insulting your colleagues on this group chat among friends. True?
I wouldn't describe it as insulting.
Well, I would.
Witness will answer yes or no.
The way that you phrased it, no, sir.
Okay, he's lying. It's very obvious.
What did you mean?
Seriously, guys?
First of all, just tell the ladies and gentlemen of the jury, who are Patrick and Dish?
Patrick Sweeten was in the Special Litigation Division, and Todd Disher was also in the Special Litigation Division.
And so I may want to make sure the jury understands the implication of what you're saying. The implication is that Patrick and, is it Todd?
Yes, sir.
Patrick and Todd are going to need to use smaller words because their new colleagues at the Attorney General's office wouldn't understand it if they use big words, right?
That's the implication.
That is, as they say, the joke, right?
Yes, sir.
You were being funny, right?
Yes, sir.
At their expense.
If we could move down to the remainder of the page, Mr.
Insulting
Arroyo.
and belittling them. But no, he wasn't insulting them. No, not the way you say it. Why
Blake
would you
Brickman
say it like
says
that?
the agency is going to fall apart, and that is one person's fault and one person only, KP, right?
Yes, I see that.
In point of fact, the agency did not fall apart.
I see they were scapegoating Paxton,
I haven't followed it.
the duly elected Attorney
wouldn't
General,
know.
their boss.
Lacey Mace laughs and says, or she laughs at your joke. And she says, I would love to be a fly in the wall during the special lit meetings. Can you even imagine? 4 laughing emojis, right?
Yes, sir.
And you deleted all these texts, I guess, by just a policy on your personal phone, true?
Sure.
The way that you phrased it, no, sir, I did not delete them.
Well, you had a setting on your phone that deleted them, yes?
That's right.
You didn't think they might be necessary or needed later, right?
That's not true.
Wait,
You post a link to Amazon below that. And what is that link to?
The title is a coloring book, it looks like.
Oh my gosh, is it mine?
And the text below that says, from you, they might need some activities to keep the kids entertained, right?
Yes, sir.
You are suggesting, are you not, Mr. Vassar, that your colleagues, professional lawyers at the Office of Attorney General, might need a coloring book to stay entertained? That's what you're suggesting?
I would describe them as colleagues. I had no professional experience with them other than just the knowledge that they were new lawyers.
You didn't have any experience with the people that you are saying that might need coloring books to keep themselves entertained at the Office of Attorney General. Is that true?
That's correct. It was a joke.
I believe you when
was
you
a
say
joke.
that. I believe when he says he has no experience with them, but he still ran his mouth
I
about
believe
him.
earlier your testimony was that being called a rogue employee was very upsetting to you, right?
Yes, sir.
But this is how you talk about your coworkers.
It's true. It's true.
Again, it was lighthearted. It was among friends.
That was not
that
was not
made
lighthearted.
public to millions of people.
No one was ever supposed
You
to
never
see
thought it would,
and
did you?
certainly not the people of Texas who are watching this impeachment proceeding, right? No one was ever supposed to see this.
No one was hiding
private.
it. I'm sorry.
It was private, right?
Well, it was a conversation among friends, but I wouldn't say that any of us are concerned that it's being discussed here today.
Really?
Are you proud of this?
No, sir. That's not what I said.
No, I'm asking you now. Are you proud of this?
No. No, sir.
Let's turn the page.
Because there's more.
You could give me all the gray ones at the top, Mr. Arroyo, or just the first 6 texts so we can see it in context.
Destruction of records.
Lacey Mace says, ha 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 ha, in response to your text, and David Maxwell posts a laughing emoji, right? This is,
We're
everyone's
all
joking,
laughing
having
here.
a good time on this text thread.
We're all having
right?
a good time now.
Sure.
Nobody's appreciating the somber moment of being FBI whistleblowers at least at this time on October 26th, right?
Well, we had all been through a lot by that point, and I suppose people process things in different ways.
Gallows humor, perhaps, right?
Yes, sir.
Okay. David Maxwell says, my phone conference with Margaret Moore and her team went well
Brian,
today.
yes, this
they
is
are
live.
excited about pursuing this
Earlier was a
investigation
recap. This is
and will
live.
coordinate their efforts with the U.S. Attorney's Office so that both pursuits complement each other. Who's Margaret Moore?
She was the previous Travis County District Attorney.
So David Maxwell is calling the Travis County District Attorney at the time and the U.S. Attorney's Office, and everybody is getting fired up. They're getting excited about prosecuting Ken Paxton, right?
That appears to be what he is saying.
Next sentence says, they obviously want to move quickly as they have time constraints. They are not going to wait on the feds. What does that mean?
Wow.
You have to ask Director Maxwell.
Oh
I'm
my
not sure what
gosh.
that means.
What do you think it means?
Objection to him being asked to speculate what it means, Your Honor.
Good objection.
He doesn't know. He doesn't know.
Sustained.
Thank you. I withdraw it. Now, if you look down in the rest of the thread, it says, so you know, this is Ryan Banger, so you know I tender my resignation today, effective November 4th. Darren McCarty says, thanks for letting us know. David Maxwell says, no, I didn't. Just got done at FBI. Went great. I'm staying until he fires me. We'll keep y'all posted on progress, right?
Wow.
Yes, sir. See that?
At this time, are you hoping to retain your job?
Yes, sir. I was still on investigative leave at the time.
Yes. And you're hoping to retain your job?
Yes, sir.
And ultimately, you came back to the office and talked to Brent Webster, yes?
That's right.
And you said to Brent Webster in that meeting that you still trusted the Attorney General, correct?
I believe so. I don't recall exactly what I said to Mr. Webster about trusting the Attorney General. I think what Mr. Webster asked.
Can you hold 1 moment? We will stand at ease for 30 minutes.
Yes, Your Honor.
Okay, you guys. So they're going to take a break real quick. So let's go and see what's going on in the chats. Pilled and Foxhole chats are lit up. Is it low? Is the volume low? Let me turn the volume up if I can. Hang on. Let me see if I can. Volume's as high as it's going here. Y'all give me a 5x5. If the volume's low, I'll try to fix that. I'm not sure if I can. Yes, he does look like he's about to cry. Over on Rumble, Brian says he's gonna cry. He does look like he's gonna cry. RSBN is not live in my town. Thanks for broadcasting, Mexico Audit Force. Yeah, absolutely. So I'm gonna pull up RSBN because I've got to go to work soon. And like I said, RSBN, to my knowledge, is the only other one streaming this. Well, there's KHOU 11, but they're not Patriot run. Let's see if they're going to be doing this. Day 3. I mean, if KHOU 11 is the only one streaming it, then I'll do that. I'll watch that, but let's see. Oh, so okay, so RSBN is going to be streaming a Trump rally, or no, it's a football game, a college football game, and they're going to be streaming that. So I think what I will do is actually have to go with the KHOU 11, which is a Houston-based thing. Let me see if this is going to work. All right, guys. Thank you guys for being here. If you'll please like and share this out and leave comments if you have any questions. Also, you can check out our website, takingbacktexas.org. We've been live streaming the Paxton impeachment with some commentary. In the evenings, I've had to go, so I've been recapping the last hour to 2 hours in the mornings the past 2 days. So I did that again today, and I will have to go to work, so I'm going to be broadcasting. I'm going to be connecting another live stream of this to mine, so y'all don't have to go everywhere to try to find it. You can still watch it here, even though I won't be able to give commentary for a couple of hours, probably from about 10:30 until about 2:30. A few hours I won't be able to give commentary, but I'll be able to watch and listen a little bit. So y'all feel free to light up the chat over on Rumble and over on Till and Foxhole. Okay, thank you so much for the 5x5. Okay, good. Now I can't adjust the volume on the Senate broadcast. I can adjust it on this KHOU 11 broadcast. So as soon as they come back, now it's a 30-minute break at this point. So what we can do is we can go over all of the articles that have been debunked so far. So we can do that. So these are all of the articles, and we went over a few of these yesterday as they were debunking them. Paxton's team is badass. I've rarely been actually impressed by attorneys, but good Lord, Busby was devastating to the first witness. The young man that they had questioning the second witness yesterday, very dashing. I loved his suit. We all thought he was very handsome. And he was good. He was much younger than Busby, and I don't mean that by any offense. I think Busby's amazing. He was younger, and I actually kind of underestimate young attorneys. I tend to, which I shouldn't do, but he was amazing. He did great. This attorney, at the end of the day yesterday, this attorney is doing a really good job too. They're all good. So Article 1, can y'all see this? Y'all can see. Oh wait, maybe if I put it on screen, y'all can see it. Sorry, I'm not as good. Diddy is the one that learned how to do all of this, and I'm still catching up on this. My priority is securing Texas, is taking Texas back. All right, so that's why we're taking back Texas, takingbacktexas.org. That's why we trained so many poll watchers in so many counties. That's why we have so many reports. Actually, I have to call somebody back here. Just a moment ago, I missed a call from a very important patriot. And if you're watching, I will call you right back. I just had to get this going because I had not the best series of events this morning, so I got pulled away from the live stream, so just trying to maintain this. Anywho, Article 1, which by my account and by honestly, like the accounts of most people watching, Article 1's been debunked because the whole concept was that they say, oh, disregard of official duty, protection of charitable organization. They say specifically Paxton caused employees of his office to intervene in a lawsuit brought by the Roy F. and Joanne Cole Mitty Foundation against, can y'all see that? Go away, y'all. Do y'all mind stop not showing my emails to everybody? Can y'all see that as it's popping up? Oh, good. Okay, never mind. Y'all can't see my pop-ups. I'm still learning how computers work. This is why we can't have computers running our election. The average American should be able to explain to their child how our ballots are cast, counted, tabulated, and stored and reported. We should be able to understand all of that. All right. I can't even figure StreamYard out half the time. So they say that Paxton caused employees of his office to intervene in a lawsuit. The intervention was signed off on and approved by the very whistleblowers who helped draft these articles of impeachment. Everybody signed off on this. This was not something that Paxton did rogue, and this was not something that Paxton forced upon any of his employees. It's just something that they did. So the truth is that the deep state's been going against this man, Nate Paul. And as we learned yesterday, Nate Paul is a young real estate tycoon who's snagged up a bunch of very valuable properties down in Austin. Now, there's some sort of, and a high quality question was asked earlier, there's some sort of involvement between this charitable organization, and I'm using air quotes, the Mitty Foundation, and Nate Paul's multi-billion dollar investment, real estate investments. There's a really high quality question asked earlier. What is the connection there? What is this charitable organization that y'all are alleging Ken Paxton failed to protect? What is their interest in this, in these multi-billion dollar real estate investments with Nate Paul? Why is there even a lawsuit going on here? Okay, let's look into that. Maybe we should look into what they've been doing to Nate Paul, because they're very obviously trying to build a connection between Paxton and Nate Paul and use this to bring them both down. Anyways, Article 1 was debunked because everyone in the office signed off on the intervention, including the whistleblowers. Very funny. Article 2, abuse of the opinion process. Specifically, Paxton caused employees of his office to prepare an opinion in an attempt to avoid the impending foreclosure sales of properties belonging to Nate Paul or businesses controlled by Paul. Again, we reviewed this, as did the young attorney yesterday, in detail, and he did a very good job pointing out that this was a statewide and nationwide issue. Governor Abbott was involved in halting foreclosure sales. Trump was talking about halting foreclosure sales. Everybody halted foreclosure sales because so many people lost our jobs and our money. So many people were unable to pay their rent. I can't even imagine how difficult it was. Because if I was in the financial position that I'm in right now during COVID, I would have been on the street. I would have been so screwed. I would have had to have left the apartment and moved in with somebody that would have let me stay there for almost nothing, me and my child. So it was extremely important for them to protect people that lost their money due to a government mandate, right? But they're trying to make this connection that Paxton issued an opinion which was congruent with Abbott's opinion, which was congruent with Trump's opinion, which was congruent with policies that were being enacted by the executive branch in both state and federal governments. Everybody was talking about this. So this is not something that he did for Nate Paul. Absolutely ridiculous that they would put that into an article of impeachment. Absolutely not. They benefited, I'll tell you, more people than Nate Paul were benefited by this foreclosure sales halt. Everyday blue collar Americans benefited from this. Okay. Bastards. So they put this in there. Article 3. They say specifically, Paxton directed employees of his office to act contrary to law by refusing to render a proper decision relating to a public information request for records held by the Department of Public Safety, and by issuing a decision involving another public information request that was contrary to law and applicable legal precedent. It's not contrary to law. None of this was contrary to law, what he did. When someone asks for open records, the Attorney General usually will give them to them. They have to make a ruling. If the county or whoever the entity that the citizen has requested records from thinks that these records are not covered by the Public Information Act, they're not allowed to deny you. They can't tell you, no, I'm not giving you those records until they talk to the attorney general, and the attorney general has to back them up and say, yeah, those records are not covered by the Public Information Act. Those are protected from disclosure. If, however, the attorney general says those are public records, you better give them to them, then the entity has a certain time frame in which to produce the records and make them available to the requester. So this is just them being mad at the way that Paxton handled some of these open records requests that his underlings wanted to deny people. Paxton's the duly elected attorney general, not these little rats underneath him organizing a fucking mutiny. Article 4 says specifically Paxton improperly obtained access to information held by his office that had not been publicly disclosed for the purpose of providing the information to the benefit of Nate Paul. Again, not a crime. Nate Paul asked for public records. Paxton grabbed the records and provided them to him. Now they're saying he shouldn't have given them that because there's sensitive information in those records. Okay, a probable cause warrant, which is what Paxton was asking for, which is what Paul was asking for. The warrant, which he should have been presented at the, initially, right? Article 5. So Article 4 has been debunked. Article 5. Specifically, Paxton engaged Brandon Kamek, a licensed attorney, to conduct an investigation into a baseless complaint during which Kamek issued more than 30 grand jury subpoenas in an effort to benefit Nate Paul or Paul's business entities. Okay, as we see, these attorneys are big mad that Paxton hired Brandon Kamek to investigate what they are now saying is a baseless complaint, but which they initially signed off on the intervention. So that the baseless complaint is part of the intervention. They're looking into stuff that's going on. They're saying that he engaged Brandon Kamek and that he didn't have the authority to do that. He absolutely has the authority to do that. He's the attorney general. He's the duly elected attorney general. There's no statute that says that he doesn't have the ability to do that. This is actually inherently in his power. They're just mad because once they approved to look into this baseless complaint, he didn't assign them to do it. These people that are already calling this complaint baseless, can you imagine why Paxton didn't want to assign them to look into it? Because they'd already made up their minds. It's no question at all. If you've been watching the past few days impeachment with these whistleblowers, I'm using air quotes, because these are not Assange whistleblowers. These are like Vindman whistleblowers. Real pieces of shit, right? They were mad because they wanted to be assigned to investigate this. They're very mad that Brandon Kamek was there. Because I don't know, I can only assume that they wanted to run the investigation their way to come to their conclusion, which they'd reached before the investigation. It's no mystery to anybody why Paxton decided to hire outside counsel to conduct this investigation into this complaint. Was not the complaint dealing with how the lawsuit was being handled by the OAG? I bet it was. But Article 6. Specifically, Paxton terminated employees of his office who made good faith reports on his unlawful actions to law enforcement authorities. Good faith reports. Paxton terminated the employees without good cause or due process. In Texas, you don't need a reason to fire somebody. I can fire you because I don't like how you look. I don't like how you smell. I don't like how you tap your pencil on the desk. Get out of my business. You don't need a reason in Texas to fire somebody. But let me tell you, organizing a mutiny is going to get you fired even at the Costco. Look, try this at Costco and see if you keep your job there. Paxton terminated the employees without good cause or due process and in retaliation for reporting his illegal acts and improper conduct. Let's talk about a good faith report, because they say employees of his office who made a good faith report were fired. How can you make a good faith report with no evidence and without talking to the attorney general? I think if they know that if they spoke to the attorney general, they wouldn't be able to say that they weren't aware of this exculpatory information. So it's better for them that they just don't talk to the AG at all, play stupid, and they can all take care of everything in post-production. You know what I'm saying? So Article 7. So anyways, this has been debunked because it also says Paxton engaged in a public and private campaign to impugn the employees' professional reputations or prejudice their future employment. None of them have had any jobs finding employment. None of them. They're all employed, and so this whole thing has been debunked yesterday. Paxton did not engage in a public or private campaign. And he did not terminate any of them. It says Paxton terminated employees. Absolutely not. We proved yesterday these fools all resigned. They all admitted to it. And this one idiot on the stand, the second witness, y'all all saw that yesterday, was saying that, yeah, he resigned, but he was also fired. It's like, no, no, no. Did you resign or were you fired? I was constructively dismissed, is what he was saying, because he said that Paxton took away some of his responsibilities. So he chose to resign. Paxton did not tell him you're going to be fired, did not say good luck getting another job. Paxton didn't say anything. He just took some responsibilities away from that guy, some things that he was handling. And I don't blame Paxton one bit. Right? I don't think anybody blames Paxton for taking that away from him. So they weren't fired. None of them were. None of them were fired. But they put this into the articles of impeachment. They also lied on stage. They would say in one breath, they would say, yeah, I resigned. And in the very next breath, I resigned because he fired me. That's not how any of this works. Okay? I unfriend you. All right? So Article 7 says specifically Paxton directed employees of his office to conduct a sham investigation into whistleblower complaints. So the investigation was a sham? Made by employees whom Paxton had terminated, and to create and publish a lengthy written report containing false or misleading statements in Paxton's defense. No, he looked into the mutiny. All right. And he wrote a report about it. That's not an impeachable offense either. Sham investigation into whistleblower complaints? No. A real investigation into an actual mutiny against the duly elected Attorney General. Article 8. Specifically, Paxton entered into a settlement agreement with the whistleblowers that provides for payment of the settlement from public funds. Settlement agreement stayed the wrongful termination suit, conspicuously delayed the discovery of facts, blah, 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 which deprived the electorate of its opportunity to make an informed decision when voting for Attorney General. I don't know. We'll see about all of this. We'll see about all this. How many mutinies were actually happening in his office? How many times has the deep state come in and tried to screw stuff up? I wonder how many times. So they entered into a settlement, which the whistleblowers accepted. What was he supposed to do? They're mad because they're mad because they entered into a settlement agreement, which delayed what they really wanted, which was a conviction, but they couldn't get that since those whistleblowers settled. They accepted the settlement agreement. Ken Paxton asks for it to be funded through public funds because it was, what is he supposed to pay it himself? That's not what it was. It was the office of the OAG settled with the whistleblowers. The office of the OAG is funded with tax dollars. Ken Paxton's not propping that whole thing up on his own. That's absolutely nuts. He's money mover, but he's not propping that whole office up with his own bank account. There's money allocated to them. So, oh my gosh, he asked for it to be for public funds to be allocated for the payment that they agreed to. So, anyways, Article 9. So all of these. We're going to debunk all of these one by one, but basically I would say everything between, I would say Articles 1 through 6. I would say at least 1 through 5 definitely have been solidly debunked. Also is the young attorney's name. Right. So I would say so far, five articles, in my opinion, have been thoroughly debunked. I think they're going to continue to debunk them with every single witness. So that's good. C-SPAN was covering it, but they probably, I mean, so here's the issue with the Senate. It's really annoying because when they cut the feed, when the Senate goes on break, they're like cutting the feed. And every time they come back, we have to start the feed up again, which is a pain in the butt, which is why I'm going to just be streaming like KHOU. Because I'm just hoping that they won't have and we're not going to be streaming on KHOU. That was only for a couple of hours when I had to leave the house for work. a couple of days ago, so this is just another recap of the other day. It looks as though we should be getting started any time now. So let me change some of these. Okay. We should be getting started again any minute. Looks like, and we don't have everybody back in the chambers yet, though. What time is it? It's 1:36. We've got people slowly filing back in. Let's go and read some of the comments over on Rumble live chat. So, Hunter Sabo says, guys, see y'all in a bit. Okay, yep, should be back right around now. Linnea says, I'm wondering about this meeting and the amendment concerning Paxton being banned from public office referred to yesterday. Yes, Linnea, that's a great point you just made. That should be, I think they either said 24 or 48 hours it was needed before they could actually bring that up, so that both sides had enough time to prepare for it. I think it's absolutely ridiculous, and I don't think that there can be a rule passed like that. I don't think that the Senate impeachment hearings is the proper the proper jurisdiction to bring up banning Paxton from holding any other state office. I think that would have to be an act of Congress, and they're not convened in session. All of the House isn't here to vote on this or anything, so this is a strange rule that I don't actually understand how it would even work. So we'll see about that if they end up getting to it. Brian Mark wanted to see some Busby magic, but he did I see, Brian Mark, you enjoyed Attorney Little. He was very good as well on Paxton's team. He really made that witness look like an idiot, didn't he? Let's see. TR Byte 307 says, I called all the senators, spoke with 4 people live, left messages to others. One of the offices, Senator Sparks, had a phone answerer named Tripp, and he was dismissive. Yes, their office staff can be very dismissive. They forget that the only reason they have a job is because we elected their boss. They forget that they work for us. And feel free to remind them about that if they get an attitude with you. Feel free to remind them that your vote is the only reason they're able to pay their bills. Also, your tax dollars. Your vote and your tax dollars are the only reason that Tripp is able to make his bill payments on time. Otherwise, he'd be slinging coffees at the local diner like the rest of us, okay? And then TR Byte also says, I was respectful, but told him that my purpose in calling was to let the senator know my position and concern, not to debate him. That's good. That's a good position that you took. And that's good. Just stay calm even if they're not. Motkey A says, wrote into my senator telling him he must vote against impeachment. He switched sides shortly after. Our rep also voted against the impeachment. Okay, very good. Motkey A, do you mean that your senator has agreed to vote against impeachment due to lack of evidence? That would be wonderful. Hunter Sabo said, let's see, hi everybody from Ohio. Don't let them do this to your attorney general if you have a good one. Is your attorney general in Ohio a good one? Spotzel says, despite having evidence on his side, I suspect Paxton will be convicted due to too many Republicans actually uniparty Democrats. What would the process be for replacing him? Appointment by Abbott? No, the attorney, well, there's already an appointed temporary attorney general. Oopsies. And I imagine that John Scott would just remain the temporarily appointed attorney general until the next election. We would likely call either a special election or just add it to the next November election. He's an elected representative here, and John Scott is currently who Abbott has named as the interim attorney general. Everybody please like and share this out. We should be getting started again any moment now. I have faith that our senators are not going to vote to impeach him. But I've been wrong before. Though I don't think there's any evidence at all. It's more than just Paxton having evidence on his side. All of the facts are on his side, and the House impeachment managers have absolutely no case. These articles are shaky and have been totally destroyed. So And, and it's not a matter of how much evidence does Paxton have to prove his innocence, because you can't prove a negative. You can't prove that you weren't part of a conspiracy necessarily, unless all of the evidence shows that you weren't, and there's no evidence showing that you were, which is the situation we have here. So I have faith that our senators will not vote to convict him. He will be returned as the duly elected attorney general. It's a very big deal to impeach a duly elected representative. But Paxton is very popular, very well respected in Texas. The only people that have a problem with him seem to be the administrative deep state and the Democrats. So thank everybody for being here. What's going on over on the Pilled chat? We've got Subpack Bet, welcome. Subpack Bet says fraud vitiates everything. Yeah, something the bar doesn't want you to know. Yes, Subpack Vet, it won't be a good thing if they vote to impeach him, but I don't there has to be evidence, and there's just none. There's just no evidence at all that he was doing this specifically to benefit Nate Paul, to harm anybody else. It was to conduct an investigation that was referred to his office and that he felt had merit, and said, well, we need to look into this and make sure that nothing strange is going on. And we can replay the Dolcefino report again later. Probably people who've been watching us for a few days are tired of seeing it, but it's a great little mini report by Dolcefino Consulting. An excellent, apparently one of Harris County's finest independent investigative reporters, Dolcefino, Dolcefino.com. We'll play that we'll play that again soon, maybe on the next break. So please stick around for as long as you can today, and please like and share this out. And we will replay the Dolcefino Consulting video that will show you exactly what Nate Paul was dealing with and why he was asking for multiple law enforcement agencies to help look into what was happening to him, because he didn't feel like it was right. He felt as though the FBI was abusing him. They did not leave him copies of warrants that they executed on his properties. He felt as though they were modifying warrants after the fact, and it was a real concern. And Paxton felt as though it was worth investigating, and for that he's being impeached. The articles are shaky. They're made up of mostly hearsay and double hearsay. It was an absolute mutiny inside the Attorney General's office, and Paxton is the only one that is brave enough to investigate the administrative deep state. And I mean that about the administrative deep state in Texas and in the federal government. He's the only one that's been willing to take them on and to challenge them, to challenge their authority and the legality of the processes they're enacting against the people. So it's no mystery to people in Texas, especially the grassroots, especially those that are aware of the abuses of the FBI, the DOJ, the CIA, etc. It's no mystery to us why this is happening to Ken Paxton. It's very clear. I appreciate all of you being here. Please like and share this out so that everyone on this planet will know what's been happening to our Attorney General Paxton, what they're doing and why they're doing it. And it is to cover their tracks, to stop him and to stop him from learning more, and to discourage anyone else from thinking that they're brave and thinking that they're going to do the right thing and follow the Constitution, or even follow the Public Information Act for that matter. We know the deep state does not appreciate solid state legislation that would make it difficult for them to run their little treacherous mutinies, because that's exactly what's happened here. This was a mutiny inside the Attorney General's office from people who resigned from the Attorney General's office after they testified, not under oath, to the House impeachment managers that they were fired. They weren't fired, they resigned. And most of these whistleblowers, who I like to call mutineers, Most of these whistleblowers have all gone to work for the same lobbying firm. This is a complete setup. House impeachment managers have brought on DOJ attorneys, Erin Eppley, and she's the CIA and DOJ's own Erin Eppley, representing the House impeachment managers, among some other attorneys. But it does appear that the DOJ was sent down to facilitate the impeachment of Ken Paxton. And like I said, it does appear that they're attempting to take out two birds with one stone. Nate Paul, the young real estate tycoon in Travis County, Texas, which is where Austin is, the capital. He has an empire of real estate. And Attorney General Paxton. It seems like they're trying to take both of them out at the same time. They appear to have used COVID emergencies to foreclose on many Nate Paul properties. The Mitty Foundation, and when I say they, I mean the banks, and the Mitty Foundation sued Nate Paul, ended up obtaining properties that they a property that they invested $3 million in, now worth $23 million. So they're going to profit $20 million off their initial $3 million investment. All having to do with the COVID emergencies, and that's stalling everybody's business and halting funds. There's no forgiveness from the Mitty Foundation, an alleged charitable foundation that no one can really tell what they were doing, investing in Nate Paul's world-class properties companies. But Mitty Foundation and Nate Paul had multiple successful business deals and still had several pending when they decided to sue during COVID to obtain Nate Paul's properties, which they were successful in doing. Very strange what's been happening here. Very strange. It does appear that the deep state has been trying to take Nate Paul's properties from him by any means possible, and that when Nate Paul asked for it to be investigated, the deep state tried to reach out, extend its arm, and cover its ass. And when Paxton hired outside counsel, that just totally ruined the cover-up. That's why they're doing this to him. Absolutely, you guys. Thank you for being here. Please like and share this out. We'll be starting any moment now. A lot more people have been filing in back into the room. And we've seen multiple articles completely destroyed. That young female attorney earlier this morning did a very good job. She was concise. She was clean about it. She did a very good job destroying Articles 3 and 4, which have already been debunked, but she absolutely leveled them. There's nothing left to Articles 3 and 4. There's nothing left. It's totally debunked. So far, Articles 1 through 5, and I've got them right here. I suppose we could go through them again. Article 1, debunked. He did not cause any of his employees to intervene. He was asked to conduct an investigation. They all signed off on the investigation. It was a group effort. They all agreed to do it. Okay, Article 1, debunked. Article 2, Paxton caused employees of his office to prepare opinions that they didn't like. No, and for the benefit of Nate Paul, and to reverse legal conclusion for the benefit of Paul. No, the rogue mutineers in the office were issuing opinions that were not congruent with the opinion of Governor Abbott, of General Paxton, of President Trump, that foreclosure sales should be halted or slowed down. Okay, and they said, oh, well, you trying to stop us from foreclosing on Nate Paul's property was a direct benefit to Nate Paul. No, but it actually also helped a lot of blue-collar families that were facing foreclosure for not being able to pay their bills due to the government-mandated lockdown. Okay, so this was the position to stall foreclosure sales, as a position of Trump, of Abbott, and of Attorney General Paxton. Okay, so that's why he had them reverse their decision when they were trying to say, yeah, that you can take his properties. Okay, debunked. Article 2, debunked. Article 3, we saw this debunked this morning very swiftly, saying Paxton directed employees of his office to act contrary to law by refusing to render a proper decision relating to a public information request for records held by the Department of Public Safety by issuing a decision involving another public information request that was contrary to law and applicable legal precedent. No. Totally destroyed today. Nothing about the public information that was requested was controversial, except that the mutineers were trying to stop it from being released to the public. But the FBI had already released this information to the public. Once information's been released to the public, the Attorney General's office just says, hey, this is technically already public info. And we're not going to be selective as to who we give it to. If we give all of this public information to one person, that's now been made publicly available. We can give it to the very next requester. This is the same argument that we use with the CVRs. When people would say, oh, if we all request CVRs, it's going to slow them all down trying to fulfill all of our requests. No. They have one request for CVR. They for specific elections records, they produce that record. The next 10 people that come in and ask for those CVRs, the record's already been produced. It's just a simple matter of sending the records out in the emails. There's no you don't start from scratch every time, right? So once something's been released to the public, it's very easy and it's typical to just release it to the next person who requests it. Okay, and she established that. Article 3 totally destroyed. Okay, absolutely not. Article 4, misuse of official information. This was totally destroyed as well. This was really funny. We saw this destroyed earlier where the witness was asked, so it says, Paxton improperly obtained access to information held by his office that had not been publicly disclosed for the purpose of providing the information to the benefit of Nate Paul. First of all, we saw this destroyed earlier because Paxton, there's no improper access for Paxton. Paxton has access to everything in his office. He's the duly elected Attorney General. His name's on the wall. That's what the witness says. He's the one that got all the votes. There's nothing in his office that someone has access to that Paxton doesn't. Paxton is the guy. He's the guy that we elected and sent up there. He's like top dog. So the witness confirmed that it makes absolutely no sense that someone would insinuate that Paxton improperly obtained access to information held by his own office that had not been publicly disclosed for the purpose of providing the information to the benefit of Nate Paul. This was destroyed because it had been publicly disclosed, as we see. If it's the same public information that they're referring to, that had been disclosed by the FBI themselves, and there's no way for Paxton to get information from his own office in an improper way. He is the top dog. So we saw these two absolutely destroyed today. Those are Articles 3 and 4. Now Article 5 is engaging Brandon Kamek. We even heard from Brandon Kamek. And he seems to be, fine man, thought he was doing a good job. This has been debunked because it's saying into a baseless complaint. Ken Paxton did not believe that Nate Paul's complaints were baseless. Neither did the Travis County DA who referred it to the Attorney General's office for investigation. They did not think that they were totally baseless. We did hear from the Travis County DA, and she said that she thought that they were ridiculous, but she was willing and attempted to entertain an investigation into this. But what do you guys think? If you go to an investigator and you say, hey, something really weird is happening, you give them some sort of thing, and they tell you that it's totally baseless, would you trust them to conduct a thorough investigation if before they've looked into anything, they're already telling you that your claim is baseless? No, none of us would trust that person would do a proper investigation. We'd probably go to somebody who would take us seriously and who would agree that this needs to be looked into, because we would have faith that they would do a better job, right? So the Attorney General mutineers, and then the mutineers in the office of the Attorney General were saying, yeah, this is totally baseless. Sure, we'll look into it, but it's totally baseless. And Paxton says, never mind, I'm going to get this guy to look into it. They got so upset about that, and that's why they're building these impeachment articles, is because they wanted to be the one. They wanted to make it look like they looked into it, and it was nothing. Here's what the nothing was, and I should really get this from the other day, because the nothing was that Nate Paul thought that the FBI was modifying the search warrants after they were conducted. There was metadata that was thrown in there saying this metadata doesn't match this metadata, so that shows that there's a change in the file. And one of the cursory investigations revealed that there would be a change in the file whether they modified the text or whether they redacted the information. And they're saying, well, the modified file is because they redacted information. Well, what information needs to be redacted from a search warrant? That's very strange. Also, saying that the metadata would change if it was redacted does not debunk or relieve any concerns that the actual text of the warrant was changed. All that does is establish that we won't know what changes were made because it's been redacted. That would also change the metadata. We can't necessarily be sure without seeing the original wet ink copy, which is what Paxton was pursuing. The wet ink copies of these search warrants to compare to the current digital file. Okay, to make sure there weren't any changes. And those wet ink copies should have been left with Nate Paul. Anyways, that was the complaint, was that it was baseless. They're saying it was baseless because the metadata of those files would have changed if it was just redacted. We don't know why it was redacted, and basically that's just like a cover your ass type of thing where they say, oh, redact all this stuff so that we can explain away the metadata changes. The hash value, right, Hyder? You taught me all about the hash value and the hash value of these files. So where it says baseless complaint right here, Paxton did not agree that that was baseless. Okay, and that's why we trust him. He did not agree when the FBI came back and said, oh, that's just been changed because we redacted it.
Report all the proceedings of the trial of Warren Kenneth Paxton Jr., only impeachment, so help me God.
And
Welcome.
we are back. Thank you, everybody.
Give her a moment, and then when you see she's ready, proceed.
Good afternoon, Mr. De La Garza. Could you please introduce yourself to the jury?
Sorry about that.
Uh,
Yes. My name is Henry De La Garza.
and I'd like to just have you take a minute and a half or so and give us a little of your background, where you're employed, and what you do there.
I work at the Office of the Attorney General, an agency of the state of Texas, and I am the HR director, the chief employment counsel, and the ethics advisor.
And how long have you held the position as HR director?
HR director, interim director, November 2nd of 2020, and then became permanent HR director December 1st of 2020.
How long have you worked for the Office of Attorney General?
I started in 1995 as an assistant attorney general 1 and worked my way up.
And what division did you start in? Have you always been in human resources?
No, I started in habeas corpus division and then went to transportation division and then human resources.
How many attorneys general have you worked for at the agency?
Well, let's see. I guess it would have been Dan Morales and then John Cornyn, now Senator Cornyn, Greg Abbott, now Governor Greg Abbott, and then Ken Paxton, and then also the provisional AG John Scott and provisional AG Angela Colmenero.
How many years have you been working in human resources?
I started in May of 2008.
You've testified that you've been at the agency for a couple of decades. How would you describe your experience working at the Office of Attorney General?
The agency is an outstanding state agency. It's a great place to work. This is as a lawyer, it's an ideal place to practice law, whether you do civil, criminal, trial, appellate, transactional, plaintiff, defense, whatever. We have it, and as an agency, we're number 1 in child support enforcement. This is an agency of lawyers, of child support officers, peace officers, and a lot of hardworking employees.
And as the HR director, how many employees at the Office of Attorney General are you responsible for, enforcing agency policy and procedure?
Well, the approximately 4,000 employees that we have throughout the state of Texas. And we also handle human resources work for the State Office of Risk Management, SORM.
And just generally, what are your responsibilities as both the ethics advisor, the HR director, and the chief employment counsel?
Well, it's quite a bit. As HR director, I oversee the HR operations for our state agency, 4,000 employees throughout the state of Texas. I lead a team of 22 talented and dedicated employees. We handle all sorts of HR functions, from hiring, posting, classifications, onboarding, benefits, leave, training, development. We have a wonderful wellness program, and we also have a robust law clerk program. And as Chief Employment Counsel, I, along with the other attorney in the division, excellent Deputy Chief, we provide legal guidance to the managers and supervisors of the agency, and we make sure EEO compliance, the rare EEOC charge of discrimination, and workers' compensation and unemployment benefits. And then as ethics advisor, I provide guidance to approximately 700 lawyers of our agency, mostly on the Texas disciplinary rules of professional conduct, other ethical issues. And then I oversee the agency's fraud, waste, and abuse prevention program. I think I have it all.
I started as a law clerk at the office, and so I certainly appreciate everything that you do for the office. Outside of working in HR, do you have any other experience with employment law?
Yes, before starting in HR, I worked in the transportation division, where I managed the employment law matters for TxDOT, another outstanding state agency, and handled the trials, appeals, hearings for state and federal law, for all different types of employment laws. Title VII, Chapter 21 of the Labor Code, FMLA, FLSA, ADA, First Amendment retaliation, whistleblower retaliation, USERRA retaliation, workers' comp retaliation, all that.
And so you mentioned the Whistleblower Act. Have you ever taken a Whistleblower Act case to trial?
I actually have.
And does the Whistleblower Act, does that have certain requirements in order to state a claim?
It does.
And does it also provide specific remedies?
It does.
Is one of those remedies removal from office?
It is not.
And who is a proper defendant under the Texas Whistleblower Act?
The government entity.
Is an elected official a proper defendant under the Texas Whistleblower Act?
No.
Where are Whistleblower Act claims usually adjudicated?
It's a state law claim, so it would be in state district court.
Are you aware of a Whistleblower Act claim ever being litigated outside of the state district court?
Not under the Texas Whistleblower Act.
Are you aware, Mr. De La Garza, that in 2020, a group of high-level staffers made reports to law enforcement about the Attorney General?
I am.
And are you aware that some of those staffers subsequently filed a Texas Whistleblower Act lawsuit against the Office of Attorney General?
I am.
And to your knowledge, is that case still pending?
Yes, in Travis County.
You mentioned that you've worked under a number of attorneys general, and so I just want to ask you a few brief questions about how the agency works. How do most employees of the Office of Attorney General obtain their positions?
Most employees, we're talking about, just about everyone, would apply through a competitive posting, and then the hiring manager would select the best qualified candidate.
And how did the former staffers who made those complaints to law enforcement, How did they obtain their positions?
They were appointed by Attorney General Ken Paxton.
And so, and to be clear, I think you said there are about 4,000 OAG employees?
Yes, about 4,000.
And about how many are appointed?
We're talking about half of 1%, maybe 0.2% or 0.02%.
Is it your understanding, Mr. De La Garza, that the Attorney General has authority to appoint certain high-level policymakers?
Yes.
And what is that understanding based on?
Well, it's a well-established concept and tradition in the United States of political patronage. This has been affirmed in Supreme Court law, U.S. Supreme Court law, federal law, state law, that elected officials, whether you are the governor or the attorney general or the elected sheriff of a county, that you have the right to hand select people who are going to help you reach the goals and the vision that you've presented to the electorate and who voted you in.
And for those appointed officials at the Office of Attorney General, are those appointed officials still required to comply with agency policies, just like every other OAG employee?
Yes.
At this time, Your Honor, I'm going to move to admit Attorney General Exhibit 431. Counsel and I discussed this during the break, and I understand that there is no objection.
No objection. Admit AG 431 into evidence.
Mr. Arroyo, could you please pull up AG 431? And could you turn to the second page, please, Mr. Arroyo? Mr. De La Garza, is Exhibit 431, do you recognize this as a copy of OAG policies and procedures?
On the screen, there's nothing on the screen.
Oh.
Hold on one moment. We'll stop the clock for a moment.
Pardon? Camera plugged.
Members, return to your seats, please. Hold on one second, Amy. You start the clock again. Proceed.
Mr. De La Garza, can you see Attorney General Exhibit 431 on your screen?
Yes.
And you recognize that as a copy of the Attorney General Office of Attorney General Policies and Procedures?
Manual? Yes.
And what is your role, if any, with respect to drafting and creating policies for the office?
Well, since May 2008, I've been pretty active in making sure that our policies are up to date, revising policies with new laws. For example, I know that we've got the new Crown Act and military performance and paid parental leave, things like that. So we make sure that we're always keeping up, and we make changes to the manual.
Do these policies provide that Office of the Attorney General employees are at-will employees?
Yes.
And can you just briefly explain what that means?
Well, the state of Texas is an at-will state since, I think, 1877 or something like that. And it just means that in Texas, you don't have a property right in their job. You can be fired for any reason. A little more? This? Oh. Oh, perfect. Thank you. Thank you.
Mr. De La Garza, are members of the executive administration at-will employees?
Yes.
Does OAG have an unacceptable conduct policy?
Yes.
Mr. Arroyo, could you please flip to page 43 of Exhibit 431? At the bottom, the bait stamp should end in 535. Mr. De La Garza, is this the unacceptable conduct policy we're just talking about?
Yes.
And Mr. Arroyo, if you could just flip to the next page, please. And about halfway down on those bullet points, Mr. De La Garza, one of the things that's listed as unacceptable conduct is use of an insubordinate or unprofessional tone towards management. Do you see that?
Yes.
Is that a policy that you wrote?
Yes.
And when did you write that policy?
Based on the date that I saw, it looked like it was in 2013.
And can you explain for the jury why you included that policy in the office's policies and procedures handbook?
It just seems typical that most manuals for employers would include something about, conduct and what's appropriate and what's not.
What are the potential consequences for failing to comply with agency policies?
Well, it depends. We look at every situation individually. It could be corrective action, such as a counseling session, a reprimand. But if it's, depending on the situation, it could be disciplinary action, including involuntary separation.
As the Chief Employment Counsel, the Ethics Advisor, the Director of Human Resources, do you provide advice to executive management on matters on employment issues?
I do.
And do you provide advice related to the application of the policies that are contained in AG Exhibit 431?
I do.
I'd like to switch gears a little bit here, Mr. De La Garza, and talk about the ex-staffers, the former staffers that left the Office of Attorney General in 2020. Who was Jeff Mateer?
Jeff Mateer was the first Assistant Attorney General.
And how did his employment at the OAG conclude?
Jeff Mateer resigned on October 2nd, 2020.
And who succeeded him as first assistant?
Because Jeff Mateer resigned and Attorney General Ken Paxton had, a right to then select someone. And, under the Texas government code, every state agency needs to have an executive head. And at the Attorney General's office, that executive head is the first assistant. And so they pretty much manage the division day to day. And so Attorney General Paxton appointed Brent Webster, and then he began that same Monday, I believe, October 5th, 2020.
At the time that Mr. Mateer resigned, were the other former staffers still employed at Office of Attorney General?
Yes.
And so at that time, they reported to Mr. Webster, is that right?
Yes. Starting on October 5th, 2020, they would have been reporting to First Assistant Brent Webster.
And would those staffers be required to comport with OAG policies in their interactions and their work for First Assistant Webster?
Yes.
And that would be a reasonable expectation that Mr. Webster would have of them?
Yes.
Let's talk about Ryan Bangert. Do you recall what his title was?
Ryan Bangert was the Deputy First Assistant Attorney General.
And how did his employment at OAG conclude?
Mr. Bangert submitted a letter of resignation on approximately, I think it was October 28th, 2020, and then left the agency as identified in the letter on November 4th, 2020.
And what about Darren McCarty? How did his employment at OAG conclude?
Darren McCarty was the Deputy Attorney General for Civil Litigation, and Mr. McCarty submitted a letter of resignation on, I believe, October 26th, 2020, and then left the agency pursuant to the letter he left on November 4th, 2020.
And what about Blake Brickman? Do you remember his title?
Mr. Brickman was Deputy Attorney General for Policy and Strategy.
And how did his employment at the office conclude?
Mr. Brickman was involuntarily separated.
Mr. Arroyo, could you please pull up AG Exhibit 224? And Your Honor, I'm going to move to admit this exhibit. I understand from counsel during the break that there is no objection.
No objection.
The exhibit shall be, what was the number again?
AG 224.
224, admitted to evidence.
Mr. De La Garza, is this memo a memo that you drafted related to Mr. Brickman's employment with the Attorney General's office?
Yes.
And does this memo reflect advice that you provided to the office related to Mr. Brickman's continued employment and ultimate termination?
Yes, it was advice about if we wanted to write a justification, this could be a draft of a justification.
And is this justification, was this the result of an independent analysis that you made with respect to his employment at the office?
Yes.
Were you instructed by anybody to come to any conclusions regarding his employment?
No.
Could you please explain the conclusion of this memo for the jury?
I only see page 1. I'm not sure.
Your Honor, may I approach the witness, please, with a hard copy?
Yes, you may.
Thank you. Just the conclusion was that involuntary separation, that he could be allowed to resign.
Looking at the memo, at the bottom of page 1, you write that Mr. Brickman has engaged in the following misconduct as identified in the agency's unacceptable conduct policy. Do you see that?
Yes.
And you list a number of violations. Is that correct?
Yes.
And is it true that in this memo, you indicate that regardless of Mr. Brickman's report to law enforcement, there are violations of agency policy that justify termination?
Yes. I mean, in many ways, it was a situation of an employee with a new boss and having an insubordinate or unprofessional tone towards the new boss, and not following orders, directives of the new boss.
And based on the information that you were aware of at the time, was it your opinion that Mr. Brickman's had some job performance issues in the workplace following his report to law enforcement?
Yes.
And was part of that misconduct creating an atmosphere that was untenable for the agency?
Yes.
And can you just describe a little bit what that is? I'm looking at page 2 of your memo, talking about the working relationship being strained and inefficient. Could you describe what you were aware of at the time that you made this memo?
Yes. I mean, overall, it appeared that there were some pretty egregious violations of the, kind of the insubordinate tone of that policy that you had mentioned earlier. And the insubordinate tone, the demeanor, the language, the refusal to perform directives from the Mr. Brickman's new boss, new supervisor. Just overall, there were those issues really stood out. And then overall, just based on the, everything applicable state law, federal law, the facts presented, there was no reasonable expectation that he wanted to work for the new boss, the new first assistant, or no reasonable expectation that.
Objection. Narrative. We just asked for a question and answer, Your Honor.
Sustained.
Mr. De La Garza, you mentioned that Mr. Brickman's behavior was egregious. Did I hear that correctly?
Yes.
And is it your understanding that part of the egregious nature of his behavior was his refusal to meet with his supervisors?
Objection, leading.
I'll rephrase.
Rephrase. Sustained.
Mr. De La Garza, what was egregious about Mr. Brickman's behavior?
I mean, based on the facts presented to me, that type of insubordinate tone and demeanor is pretty rare in our agency.
Who did you provide this memo to?
I believe I would have probably sent it to my boss at the time, the human resource director at the time, and probably Brent Webster, the new first assistant.
Who, to your understanding, who made the decision to terminate Mr. Brickman's employment?
It would have been, his supervisor was the first assistant.
And did you support the decision to terminate Mr. Brickman's employment?
I mean, based on the facts as presented to me and the applicable state law and federal law, especially about, political patronage, yes, there didn't seem to be a reasonable expectation that he could continue working with or for Brent Webster or continue serving as a high-level policymaker for the Attorney General.
And do you stand by the advice in this memo today?
I do.
Okay, let's talk about Mr. Ryan Vassar. Was he the Deputy Attorney General for Legal Counsel?
Yes.
And his employment at the office was terminated, is that correct?
Yes, involuntary separation. Yes,
And who made that decision?
that also would have been the first assistant.
Did you support the decision to terminate his employment with the office?
Based on all the facts presented to me and the applicable state and federal law, yes, there was a variety of reasons. There was a lack of confidence in his...
Objection, Your Honor. Hearsay. The witness just testified based on information he received.
Sustained.
Mr. De La Garza, did you provide any recommendations concerning Mr. Vassar's the involuntary separation?
Yes, I mean, as a HR director, I have to rely on information that is presented to me.
Okay, and sorry, I didn't mean to talk over you. When you were providing those recommendations, were you advised by management of some issues, some job performance issues that they were experiencing with Mr. Vassar?
Objection, hearsay, advised by management, out of court statement, Your Honor.
Your Honor, if I may, I'm asking about the facts that inform his recommendation. I'm not offering them for the truth of the matter, but rather for just the things that he was aware of at the time he made his recommendation and why he made that recommendation.
So
I'm going to sustain your objection. Find another way to ask the question.
Thank you, Your Honor. Did agency policy support the decision to terminate Mr. Vassar's employment with the agency?
Yes.
And was it your understanding that Mr. Vassar had violated agency policy by sharing confidential grand jury subpoenas outside of the agency?
Objection, Your Honor. I need to interrupt. This is knowledge gains through hearsay and leading.
Sustained.
Could you please describe what the violations of agency policy were that supported termination?
Well, just overall, as far as the reasons presented to me for separating him were, there's a combination of...
Objection, Your Honor. Reasons stated to me is an out-of-court statement, hearsay.
Your Honor, again, this goes to the basis
Thank you
for his
guys for being
recommendation.
here. Please
This
like
is
and share this
not
out.
He's not testifying as to the truth of it, but
Visit
rather
our
the
website,
information, his understanding of the
takingbacktexas.org.
information and what informed his advice to the agency.
We'll overrule your objection this time.
You can answer the question, Mr. Delegate.
Yes, I mean, I have to rely on the facts presented to me. I mean, we have 4,000 employees. So with respect to Mr. Vassar, I had to rely on the facts presented to me on what he had done or had not done. And so as far as the overall reasons, there was a variety of reasons, a lack of confidence. There were some issues about his performance, some issues about the handling of grants or mishandling of grants. Overall, there was some insubordinate tone and demeanor, and overall, there was, my understanding, there was one last meeting to see if there was any reasonable expectation that Mr. Vassar could or wanted to work with or for his new boss,
Objection, Your Honor. I apologize for interrupting. Can we keep this question and answer? My objection is narrative.
Sustained.
Mr. De La Garza, let me ask you about that meeting. You mentioned that there was one last meeting before there was a decision made to separate Mr. Vassar from his employment at the office. Were you present at that meeting?
No.
Were you later requested to provide counsel as a result of what had happened in that meeting?
Yes,
And sorry, I'm going to stop you right there just because I want to make sure that we're keeping this question and answer. But I appreciate your testimony. When you were asked for advice, did you ultimately recommend separation?
Yes.
And do you agree with that decision today?
Yes.
Let's talk about Mr. Maxwell. Was he the director for law enforcement?
Yes.
And was his employment also terminated from the Office of Attorney General?
He was involuntarily separated on, yes.
And who made that decision?
First Assistant Brown Webster.
Did you advise Mr. Webster with respect to that decision to terminate Mr. Maxwell's employment from the agency?
I recommended that it could be done, that it was reasonable based on the facts presented to me.
And did you personally have prior experience with Mr. Maxwell and some violations of agency policy in the past?
Yes.
And how would you recommend, or excuse me, how would you describe your experience working with Mr. Maxwell?
I mean, I admire all that he's done, but with respect to HR issues in HR, certainly it was a developing pattern of not going to HR for guidance on some very sensitive HR matters.
And did the failure to go to HR for guidance on very sensitive matters, did that ultimately expose the agency to liability?
It could have.
And about how many instances?
Well, there was one case where a Hispanic peace officer, a female, who had been subject to sexual harassment.
Objection, Your Honor. This is knowledge gains through hearsay. Presumably, he did an interview with this woman who will not come in to testify. All of the information he gathered and he's relaying to us is hearsay.
Your Honor, I'll move on.
Sustained. Continue.
I'd like to offer what's going to be marked as AG Exhibit 1055. I understand counsel does not have an objection to this either.
No objection, Your Honor.
Admit 1055.
And Your Honor, may I approach the witness with a hard copy? Thank you. Mr. Arroyo, could you please pull up AG Exhibit 1055? Mr. De La Garza, do you recognize AG Exhibit 1055 as an email that you drafted to Brent Webster and Aaron Reitz?
Yes.
And does this memo provide your legal advice regarding the continued employment of these staff members?
Yes.
What prompted this email?
Mr. Maxwell and Mr. Penley, Mr. Maxwell and Mr. Penley had been on investigative leave, and they wanted to have a meeting to see if there was any reasonable expectation that they could work with or for Brent Webster.
And I'm sorry, Mr. De La Garza, just for the record and for clarification, when you say they wanted to have a meeting, who is they?
Well, primarily the first assistant, Brent Webster.
Thank you, and I'm sorry to interrupt. Please go on.
And there was this kind of a sort of a last ditch, let's see if there's any reasonable expectation that they could work with or for Brent Webster, the new first assistant, and whether there was any reasonable expectation that they could continue as high-level policymakers with Attorney General Ken Paxton.
And so is this email your suggestions of things to ask in those meetings?
Yes.
Why did you pick these particular questions? Like, do you trust me? Do you trust the Attorney General? Are you committed to the vision? Why did those questions make it into this memo?
Well, based on the case law, Elrod v. Burns, Branty v. Finkel, and its progeny, that's what you focus on: the loyalty, trust. Can the elected official, trust the people that he's or she is chosen to support their vision, their goals?
And why would that be important to the agency?
Well, it's definitely a question about efficiency. I mean, you want the everything to move along. And if his deputies aren't, if they're not seeing eye to eye, it's going to break down, and then it eventually starts trickling down, and we start losing, efficiency, and there could be worse problems.
Mr. Arroyo, could you please pull up House Manager's Exhibit 383? And Your Honor, this is already in evidence. May I approach the witness with a hard copy? Thank you. Mr. De La Garza, do you recognize this email that was sent by Greg Simpson, your former boss, to Brent Webster copying you related to the CID division?
Yes.
And I don't want to go through this whole thing, but I just want to ask you, on the second page, could you please read aloud the last two sentences on the last page of this document?
It reads, overall, HRD has had difficulty getting CID to work with us on matters that are appropriately and exclusively within HRD's authority. Maxwell's actions have exposed the agency to potential liability.
And what does HRD and CID, what does that mean?
HRD would be the Human Resources Division, and CID would be the Criminal Investigations Division.
And the Criminal Investigations Division, that was the division that Mr. Maxwell was chief of, correct?
Yes, that's one of the primary divisions under law enforcement, under his purview.
And so does this email identify a number of issues with Mr. Maxwell's management of his division?
Yes, Mr. Simpson explained that there were some challenges that HR had faced.
Did you agree with the decision to terminate Mr. Maxwell's employment with the agency?
Yes, based on the facts presented to me and the applicable law, it seemed reasonable.
And, okay, you can set that aside. Thank you. Do you agree with that decision today, Mr. De La Garza?
I do.
And who made that decision?
That would also have been the first assistant, Brent Webster.
I'd like to talk to you about Mr. Penley. Do you recall that he was the Deputy Attorney General for Criminal Justice?
Yes.
And he was also involuntarily separated?
Yes.
Was he offered the option to resign?
Yes, he was.
And to your knowledge, before Mr. Penley was let go, did he meet with Brent Webster?
Yes.
And did he have the meeting that you suggested or that you mentioned earlier about whether there could be a reasonable expectation that Mr. Penley could work effectively with the new first assistant?
Yes, that meeting took place.
And what was your understanding about the prospect of Mr. Penley being able to effectively work with Mr. Webster following that meeting?
My understanding from that meeting, it was that there was no reasonable expectation that Mr. Penley wanted to work with or for his new boss, First Assistant Brent Webster, that he could in the future, and that he could serve as a high-level policymaker for Attorney General Ken Paxton.
Did agency policy support Mr. Penley's involuntary separation?
Yes.
How so?
Well, just based on the lack of confidence, there was some evidence of questionable decision making, just the breakdown in the working relationship. There may have also been, from what I recall, some insubordinate tone or demeanor towards Brent Webster. And so just overall, based on the applicable state and federal law and the facts presented to me, it seemed reasonable, and the policy supported that.
Was it also your understanding at the time that Mr. Penley had omitted some material information in a court filing?
Yes, that had been also presented to me as far as some, wrongdoing, whether it was misconduct.
I apologize for interrupting. This had been presented to me as hearsay, out of court statement. We object to hearsay.
Your Honor, this is the same ruling that you made earlier to overrule the objection. This is the facts that were presented to him that informed his advice to the agency, and that was subsequently conveyed to Mr. Webster, who determined what the employment decisions would be going forward.
Your Honor, if I may.
Overruled.
You
Yes,
may continue.
I'm sorry. What was the question again? I'm sorry.
Yes, the question was whether it was, you know what, I think you answered it. Thank you, Mr. De La Garza. I will ask you a follow-up question. You said it was your understanding that facts had been presented to you that Mr. Penley had omitted material information from a court filing. Is that right?
Yes, that was the facts presented to me.
And do you know whether that constitutes a violation of the agency's policy on handling confidential and privileged information?
Yes, we have a specific policy on that.
And did you agree with Mr. Webster's decision to terminate Mr. Penley's employment?
Yes, based on the law and the facts presented to me, it was a reasonable decision.
And sitting here today, do you stand by that support, that recommendation?
I do.
Mr. Arroyo, could you please pull up AG Exhibit 120? And Your Honor, this is not in evidence, so I'm going to offer it now. I understand that counsel does not have an objection.
No objection.
Admit AG 120 into evidence.
And Your Honor, may I also approach the witness with a hard copy?
Yes, you may.
Thank you. Mr. De La Garza, do you recognize this email?
Yes.
And does this email reflect some of the legal advice that you provided to the agency, including to Mr. Webster, about the application of the Whistleblower Act?
Yes, I provided some what I considered privileged and confidential advice regarding the petition that had been filed.
Understood. Mr. De La Garza, looking at the first paragraph of this email, you write, "Here is my list of why Vassar, Maxwell, Penley, Brickman should be considered high-level policymakers who are exempt from whistleblower protection." Do you see that?
I do.
And I want to ask you about that term, high-level policymakers. What does that, why was that important?
That is the term used in sort of the political patronage case law about that elected officials can appoint. They have to be high-level policymakers for them to be appointed.
I'm sorry, I just want to, they have to be high-level policymakers to be appointed. Is that what you said? Thank you. And all of the former staffers who made reports to law enforcement, in your view, fell under the category of high-level policymakers.
Objection, leading.
Your Honor, I'm just clarifying his testimony, but I can restate.
Sustained, just restate it.
Mr. De La Garza, is it your opinion that the former staffers who made reports to law enforcement were all high-level policymakers?
They were high-level policymakers.
And could you just summarize for the jury some of the points that were important to you here that led you to your conclusion that they constitute high-level policymakers that are exempt from the Whistleblower Act?
Well, based on the list that I have here, and it was supported by case law, they required more than simple ministerial competence. They created or implemented, agency goals, policy. They controlled or exercised a role in the decision-making process as to the goals and general operating procedures of the agency. They ensured that policies which the electorate had sanctioned by electing the Attorney General were effectively implemented. They all had access to confidential documents or other materials that embody policymaking deliberations and determinations. Party affiliation was an appropriate requirement. They served as
Sorry, Mr. De La Garza, if I could, I just want to stop you there. At the bullet point about party affiliation. You write here that party affiliation was an appropriate requirement for effective performance of the public office involved. Is party affiliation something that the agency would look for in the employees who apply for competitive jobs in regular postings?
No.
Mr. De La Garza, do you stand by this advice in AG Exhibit 120 today?
I do.
Thank you. You can set that aside. Mr. De La Garza, did the Office of Attorney General have legitimate, non-retaliatory reasons for terminating these staffers' employment?
In my opinion, yes.
And under the Texas Whistleblower Act, can the Office of Attorney General or any state agency terminate a whistleblower based on information or evidence that is not related to their whistleblower report?
Yes.
And do you agree that that for the agency to be effective, that high-level policymakers need to be able to collaborate effectively with the first assistant and with the attorney general?
Yes.
Did you believe that there was any reasonable possibility that any of these former staffers could do that?
Well, Darren McCarty resigned. There could have been Ryan Bangert. So, I would say that there was possibly with them, but
For the ones that resigned, but for the ones that were terminated, was there a reasonable expectation that they could work with the new first assistant and with the attorney general?
yes. For the ones who were involuntarily separated, no, in my opinion, there was no reasonable expectation.
Did Ken Paxton ever indicate expressly or implicitly that these former staffers needed to be fired because they made a report to law enforcement?
Not to my knowledge.
Do you have any knowledge that Brent Webster ever indicated expressly or implicitly that these former staffers needed to be fired because they made a report to law enforcement?
Not to my knowledge.
Did anyone at the Office of Attorney General determine what your recommendations would be with respect to the legal advice you provided for these former staffers who were involuntarily terminated?
Not to my knowledge.
Was your analysis of whether the former staffers had violated agency policy, was your analysis an independent analysis?
Yes. I mean, at times I consulted with the other lawyer, my boss, before he left.
Mr. Arroyo, could you please pull up Article of Impeachment 6? And could you turn to the next paragraph of Article 6, please, Mr. Arroyo? Mr. De La Garza, Article 6 accuses the Attorney General of terminating the employees without good cause or due process and in retaliation for reporting his illegal acts and improper conduct. Do you see that?
I do.
Is good cause required to terminate an employee in Texas?
No, it's not. But at the Attorney General's office, we ensure that there are good reasons and that it's fair.
And did good reasons and fair reasons exist for each of the former staffers that were involuntarily terminated?
In my opinion, yes.
Is due process required to terminate an employee in Texas?
No, there's no property right to our jobs since we're at will. So due process, there's no constitutional right. And but we ensure that it's fair.
So, okay, thank you. And were any of the former executive administration staffers terminated in retaliation for making a report to law enforcement?
In my opinion, no.
Thank you, Mr. De La Garza. I pass the witness, Your Honor.
Thank you. Your witness. Please state your name for the record.
Yes, Your Honor. Yes, Your Honor. Daniel Duco. Yes, Your Honor. Yes, Your Honor.
That was very
Mr. De La
good.
Garza, how are you?
Fine, thank you. How are
Mr.
you?
De La Garza, you testified a moment ago that you are familiar with the Texas Whistleblower Act, correct?
Yes, I did.
And you understand that the Texas Whistleblower Act affords protection to people that go to law enforcement so they can go to law enforcement without retribution, right?
Yes.
And as part of the Texas Whistleblower Act, that protection only extends to people who still have their job.
Yes, they are, yes.
Right. So what I mean is, if you report someone to law enforcement and they still have their job and then they're retaliated against, they are protected by whistleblower, correct?
If they, yes, if they comply
Does
with the
that mean Ken
retaliatory,
Paxton's
the
also
requirements
protected
in
by
the
the
Texas
Whistleblower Act?
Whistleblower Act, yes.
But if they get fired before they go to law enforcement, they're not afforded the protection of the Whistleblower Act, correct?
Right, it has to be, right.
Right. So before you go to law enforcement, you don't want to tell your boss, I'm going to law enforcement.
Objection, speculation.
Sustained.
Under the Whistleblower Act, if you tell your boss you're going to law enforcement, you get terminated, then you go to law enforcement, you're not entitled to the whistleblower protection, correct?
Objection, speculation. It's the same question, Your Honor.
Just said he knew this.
You can answer if you know.
All right, could you just repeat the question, please?
Sure. Under the whistleblower statute that you said you're familiar with, if
This
you
isn't
tell
really
your
making a
boss,
great
I'm
point.
about to go to law enforcement, then you go to, before you go to law enforcement, you get fired, then you go to law enforcement, you're not entitled to the protections of the whistleblower statute, are you?
I guess you could make the argument in court. I'm not sure how successful you'd be.
But you agree with my statement, correct?
Probably wouldn't be the best way to do it.
So if someone were to stand up here over and over.
Witness needs to speak up when you speak.
Oh, excuse me.
If someone were to stand up here over and over and say, why didn't you just call your boss? Before you went to law enforcement, why didn't you just call your boss? Under the Whistleblower Act, that wouldn't be a good idea, would it?
I mean, if your plan was to file a lawsuit, then yes,
Exactly.
you shouldn't do that.
You should not go to your boss first.
If you were planning to
They
file a
could have gone
lawsuit,
to
I mean, it
Paxton to
depends on
get more
the
information to
situation.
realize it
I'm
wasn't
not talking
a
about a
crime.
lawsuit. I'm talking about whistleblower protection. It would not be a good idea to call your boss
If your
first, right?
plan was to
Objection,
market
asked and
yourself as a
answered.
whistleblower as opposed to getting all of the facts before
Right.
you go to law enforcement.
You're asking me to speculate. I'm not sure what a plaintiff should or shouldn't do.
You don't want to answer that, do you?
I'm
Well, it's a
I'm
very
not
stupid question because
I'm
the
not
House
here
has
to,
absolutely no
speculate
case.
as to what a potential plaintiff under the
They've stood up
Whistleblower
there and
Act should
asked about
do
it for
or
a
could
reason.
do.
Just so we're clear, you're not here now. A moment ago, you were okay with it, right?
Objection, Your Honor. It's argumentative.
Sustained.
All right, let's put up AG 120, please.
Right. So if your plan was to market yourself as a whistleblower, then
Can you
yeah,
see AG
you would want to tell
120?
them first. And their plan was clearly
Yes.
to market themselves as
This is
whistleblowers.
a document that you created, an email, right?
Yes.
And in this email, it
It
says,
was a
here are
meeting.
my list of why Vassar, Maxwell, Penley, Brickman should be considered high-level policymakers who are exempt from whistleblower protection, correct?
Yes.
This is your analysis.
This was a privileged and confidential document that we are brainstorming.
I appreciate that, but I think I wrote down your words, and what you said was, this is my analysis. You still stand by
Yes,
that?
sure.
And you said, I stand by that today.
Yes.
And you said to the senators here, this is the correct analysis, right?
At the time, I believed it was the correct analysis. So
This argument, this exact argument that's in this document right here was made in the court, right?
I'm not sure. I wasn't involved in that.
You're not familiar with the Court of Appeals case, Office of the Attorney General versus Blake Brickman, Mark Penley, David Maxwell, and Ryan Vassar? You're not familiar with that?
I'm familiar, but I wasn't involved. I didn't work on that appeal.
Are you familiar with the decision that came out in that appeal?
I would have to read it and
You don't remember?
To be honest, I'm not sure if I carefully, that was not something that I needed to read.
Well, if you had read it, you would know that the Court of Appeals said all of your analysis in AG 120 was wrong.
Objection argumentative.
No, nobody agrees with that.
Overruled.
Right?
And if the whistleblowers had gone to the Attorney General, they would have known that
as
there was no
lawyers,
crime.
we make arguments and courts don't agree with them. And so, there's always going to be a winning side and a losing side. And at the time, I was just coming up with potential arguments. That's what, we do.
Right. So when the senators are deciding whether or not this is a valid argument, they can disregard it because the Court of Appeals already decided it was not.
Objection, this misstates testimony and is going outside of direct. This also is talking about a document that is not in evidence, and there's been no testimony before this witness about.
Overruled.
Right?
I defer to the Senate to do the right thing.
We would
You
hope
spent
that
a
they
lot of
would do
time
that.
telling us about how people were involuntarily separated. That means fired, right?
Yeah, we
The Court
just
of
like to
Appeals
use
can get things wrong
involuntary
too, guys.
separation.
Okay, I just
That's
want
why
to
we
make sure we're on
have
the same
Yes.
page. That means fired.
It does.
You also spent a lot of time using the phrase based on facts presented to me, right?
Yes,
And those facts were presented to you by Brett Webster.
for the most part, yes.
Doesn't it seem like you had a Brett Webster problem?
Well, he was the new first assistant, and these employees were reporting to him.
I mean, you've heard the term garbage in, garbage out, right?
I've heard the expression.
So if Brett Webster is giving you information that's not true, then your analysis is wrong, correct?
I have to rely on the information given to me.
I appreciate that. My question is a little bit different. If Brett Webster's not telling you accurate information, then all the analysis you gave on direct examination is all incorrect.
Objection, speculation.
He knows,
Overruled.
correct?
I have to rely on the facts presented to me, and so
Is my question difficult?
it's you're saying that if he presented false false information to me, and I'm using that false, yes, it could affect my analysis.
Well, let's talk about the real reason why these people got fired. Stacey, can you put the timeline up, please? I'm going to use this for demonstrative purposes. So,
Your Honor, I'm going to object. I've never seen whatever this is before. Counsel and I discussed exhibits during the break. This was not provided to me, so I would request that we get a copy of whatever this is to quickly review.
not an exhibit, Your Honor. Simply demonstrative purposes, not going back based on dates that this witness provided on direct examination. If the dates are wrong, counsel can correct me.
Well, Your Honor, I mean, we might have an objection to whatever, whatever he's going to put on this timeline. I don't know what it is, and I don't have an opportunity to verify it, and it's being published to this jury as if it's fact. So I'm going to object to displaying this to the jury.
Your Honor, they're making evidentiary arguments. I'm not offering this into evidence. It's purely demonstrative.
Your Honor, this...
Hold on. Don't talk over each other. I think you can provide the counsel with what you're about to show. Yes.
Thank you.
It was very interesting. I'm glad that the House accidentally rested yesterday, because this is good. These witnesses are very important. Thank you guys for being here. Please comment, like, share. I'm going to read your
Your Honor, I
comments
might have
in just a little
objections
while.
as this goes along, because I don't think there's any foundation that he's laid yet, at least, to ask to publish these as something that's within this witness's personal knowledge. But subject to that, I appreciate counsel providing this copy, and we can move along.
Move along.
Mr. De La Garza, on September 30th, and just before we get started, I want to point out this timeline is a...
Yes.
Stay at the microphone.
Yes. I want to point out, Mr. De La Garza, that this timeline is roughly a month and a half, less than a month and a half. Do you see that?
Yes.
And as you are familiar with the whistleblower statute, as you testified in direct examination, I'm sure you're familiar with 554.004, right?
Is that, could you remind me?
Sure. It says, in an adverse action, if within 90 days of reporting to law enforcement, there's a presumption of retaliatory conduct.
There is a presumption that can be rebutted.
And so the law says, if within 90 days of reporting something to law enforcement, you're terminated or have an adverse action, we are to presume that was retaliatory, right?
There's a presumption.
So September 30th, the whistleblowers go to the FBI, right?
I'm not sure. I have no personal knowledge of what they did.
But like,
head of HR, you don't know?
What if within
that's what I
those
heard.
90
That's
days,
what
these
they presented
whistleblowers
to
physically
my
assaulted
boss, a
Ken
letter
Paxton
saying
and
that
they
they
got
had gone
fired for
there.
that? You
Let's
would
start
still
over.
presume
You're
it
the
was
head of
because
HR,
before
right?
that
Now,
they went to the
yes.
FBI
You know
about
that they
him?
went to FBI on September 30th, right?
I have received information that they did. I have no reason to
The position the
disbelieve
House
that.
impeachment
You also
managers
know
are
on
taking is
October
ridiculous.
1st, the
As usual.
whistleblowers notified HR and the AG Paxton of the FBI report, correct?
Yes, I believe it was the first.
The next day, Mark Penley and David Maxwell were placed on administrative leave.
That's correct.
On October 13th, David Maxwell made his formal complaint against Ken Paxton.
I'm not aware of exactly when he did. Formal complaints go to the formal complaint officer. So if you say it was the 13th, but
You spent a lot of time telling us about David Maxwell. You reviewed all the file. You're telling me you don't know when David Maxwell made his formal complaint?
I don't have personal knowledge of that because formal complaints go to the formal complaint officer. They don't go to HR.
Well, we can assume by the fact that your lawyer hasn't stood up and objected that that's the day he made his formal complaint, okay?
No reason to disbelieve that.
October 15th, Brickman, Vassar, Bangert, McCartley, and Penley all file formal complaints. You know that as well, right?
I understood that they all filed formal complaints.
October 20th, so 20 days after going to the FBI, 19 days after the whistleblowers notify of the fact that they went to the FBI, Blake Brickman was fired, right?
Yes.
Lacey Mace was fired.
Yes.
November 2nd, a month after going to the FBI, David Maxwell was fired.
Yes.
November 2nd, a month after going to the FBI, Mark Penley was fired.
Yes.
November 17th, 6 weeks after going to the FBI, Ryan Vassar is fired.
Yes.
Have you ever heard of the expression, there's no coincidences in Austin?
We've all heard that expression multiple
Pass the
times
witness.
this hearing. You're not
Redirect.
clever, you're not original, and you're not Mr. Rogers, so take off that tie.
Just briefly, Your Honor. Mr. De La Garza, did agency policy support the termination of Lacey Mace?
Yes,
And did you recommend that termination?
I did.
Do you stand by that recommendation today?
I do.
No further questions, Your Honor.
The House
Are
once
you-
again
No need for
established
it.
almost
We can
nothing
excuse the witness?
other
Yes, Your
than
Honor.
if
Yes.
the whistleblowers went to the
Please step down.
FBI
Thank you.
and then
Little
committed
housekeeping
another
before
crime
the next witness.
or another
I said
policy
that after the
violation.
break, I would admit 702 into evidence. We did not do that, so 702 is admitted into evidence. Mr. Donnelly, I think that was the correct number. Also, if both parties would like to come to the bench for a moment.
Okay, I should have waited till now to start talking. Basically, all the House has established is that they would make the argument that if the whistleblower went to the FBI for 90 days. They're basically protected by the whistleblower protection program from being fired for any other reason at all, including another violation of state law or another policy violation, an OAG policy violation, which is what's alleged actually happened. They were actually fired for their behavior, not because they went to the FBI. But the House managers are saying that no, there's a presumption in the Whistleblower Protection Act that says that if somebody is fired within a certain time frame after they take whistleblower actions, that there's the presumption should be that they were fired because they took whistleblower actions. So I attest that the House managers would say that even if this man went and shot Ken Paxton and then got fired for that, that they would attest that that was Ken Paxton firing him for going to the FBI a week before he shot him. That's just an example. No one's shot Ken Paxton. Nobody shot anybody. It's just an example that if they committed another crime or policy violation after they went to the FBI, that they are still protected from the Whistleblower Protection Act for that. No. I don't think that any of us agree with that. I think the House is alone in that position, in taking that position. What do you guys think? Over on Rumble, Big Bad Black Conservative says agreed, but I can't see what he's agreeing with. Sorry, the chat has timed out on that. Rob Maga said these people's behavior in the workplace, unbelievable. Exactly. That's why they were terminated. The ones that were terminated for those reasons. And the ones that resigned and were not terminated. So despite their testimony, they were not actually terminated. And I think that perjury still matters, right? So I don't know.
The court will come to order.
Oh, they're back. Okay.
Members of the jury, there was a motion filed yesterday by the House to amend the rules to collapse a vote into one vote. That motion has been withdrawn. Will the defense call their next witness?
Well, okay. And I'm not sure what exactly that meant just now, but I know that in the House they didn't want to vote
Defense
on all
calls
the
Grant
articles
Dorfman to the witness stand.
Oh, it's Anthony
Please bring in Grant Dorfman.
in a wonderful blue suit that goes well with my high-tech theme. Thank you guys for watching. Please like and share this out so people might understand what's been happening to our Attorney General. Melindy says, slimy tactics. We're swimming in dozens of incorrect Court of Appeals in the country currently. Exactly. So the House impeachment's position that the Court of Appeals disagreed with the prior witness, I mean, it doesn't mean a lot when we know our courts are pretty corrupt too. And it's not difficult to identify those who are fighting for us and those who are fighting against us. It's not difficult to identify them. And Ken Paxton is one who's been fighting for us. So that's part of it. And Melinda says the courts are often very wrong. Exactly. Courts is in quotations, right? So weak line, in my opinion. It was very
Mr.
weak.
Dorfman, if you'd raise your right hand. I do solemnly swear or affirm that the evidence I give upon this hearing by the Senate of Texas of the impeachment charges against Warren Kenneth Paxton Jr. shall be the truth, the whole truth, and nothing but the truth, so help me God. Please have a seat.
Thank you.
Your witness.
May I proceed? And it's Anthony Osso, O-S-S-O, on behalf of Attorney General Paxton. Sir, would you please state and spell your name for the record?
It's Grant Dorfman, G-R-A-N-T. Dorfman is D-O-R, F as in Frank, M-A-N.
Okay, and I understand you're a judge, but just to keep the record clear, I'm going to call you Mr. Dorfman if that's all right.
I appreciate that.
Okay. Mr. Dorfman, could you please tell these senators how you're currently employed?
I'm the Deputy First Assistant at the Office of the Attorney General.
Okay. And I'm going to ask that you lean into that mic and speak loud and clear so that everybody in the courtroom can hear you. Now, before we talk about your role as the Deputy First Assistant, I want to talk to you a little bit about your background and who you are. Can you tell us where you're from?
Grew up in Dallas, Texas.
Okay. And where did you end up going to school?
Brown University in Providence, Rhode Island.
Okay. And then
Dallas,
was that for undergraduate?
the city.
Sorry?
Undergraduate?
That was my undergraduate, yes.
Did you go on to do law school?
I did.
Okay, can you tell us where you went?
Yale Law School.
And what did you do after you completed your time at Yale?
I accepted a clerkship with a federal judge in Houston, Texas, brought me back to Texas after 10 years on the East Coast. I also took 2 years out before law school, got a graduate degree there, not in England as well. And then had a 1-year clerkship opportunity in Houston. Thought I was going back to DC to join the Department of Justice for the second term of the George Herbert Walker Bush administration. That never materialized, so I ended up blessedly staying in Houston.
Okay, so after that didn't work out, what did you end up doing next?
I went to work for a commercial litigation boutique and continued in that line. Went to a second firm where I made partner in, I think, 1999.
Okay, which firm was that?
Ogden, Gibson, White & Brooks, and the first firm was Sussman Godfrey.
Okay, and while you were working as a partner, can you describe to us kind of what type of law you were practicing?
Commercial litigation, generally, that's a big area, but civil trial work and appeals, and a lot of energy work, a lot of employment cases, and just the things that Houston trial practice is made out of.
Understandable. What did you do after you spent your time working as a partner at the law firm?
Well, I had a desire for government service. I'd never really set it out to be a partner at a law firm and continue that for the last 30 or 40 years of my career. So I'd applied to the Department of Justice when the George W. Bush administration came around, went up to interview for 2 vacancies in deputy AGs in the civil division. I ended up withdrawing within 1 week of the interview because my daughter was on the autism spectrum disorder. She was then 4 or 5 years old. And it turns out, to my surprise, but after exhaustive research, the school she was in Houston did not have any counterpart, any comparable service in either the Washington or Baltimore metro area. So I had to withdraw from consideration for that. That lit a fire under me, reminding me that's kind of what drew me to the law in the first place.
Okay.
And so...
let me stop you real quick. So that's back to Houston, right?
I'm still in Houston.
Okay.
Never left. But then I put in for an application to Governor Perry's office for 2 district court vacancies in 2002.
Okay. And can you tell us what happened with that application?
It was successful.
Okay.
I was appointed to the 129th District Court in Harris County. It's a civil district court in May of 2002.
Okay. And can you tell us what happened after that term and farther on in your career?
I'm sorry, I didn't catch that last part.
After you served as a judge, a civil court judge in Houston, what did you do next in your career?
Oh, well, involuntarily, the voters decided in 2008 that they liked President Obama better than the rest of the ticket. I went in-house with Neighbors Drilling as an independent oil and gas contractor, I should say, with worldwide operations based out of Houston with about 25,000 employees, and managed their civil, all their litigation.
Okay. And then at any point, did you serve another term as a judge in Houston?
Got remarried in 2013, wanted to do something different, and reapplied to Governor Perry for a district court bench, and was appointed in November 2013 to the 334th District Court, also in Harris County, same kind of court I'd presided over before.
Okay. And so in total, about how long did you serve as a judge?
I think altogether 10 years,
okay,
not including visiting judge service afterwards.
Okay. And then at some point, you become deputy first assistant at the Attorney General's office. Can you talk to us about what took you from Houston to Austin for that job?
Yeah, not to dwell on bad news, but in 2016, I, along with most of my Republican colleagues on the bench in Harris County, lost. And I went back in private practice for a couple years. My father passed in that time frame, and I stepped into a family business that needed more care than I could give it as a full-time litigator. So I juggled that with having left the law firm, being a mediator, an arbitrator, available to parties to resolve their disputes, and also a visiting judge when the administrative presiding judge in Houston appointed me to service in that capacity.
Okay. So what brings you to the Attorney General's office then? How do you go about applying for that job?
Well, it came sort of out of the blue. I had a call from my friend Austin Kinghorn, who I'd known for several years as a law clerk to one of the justices on the Supreme Court, before that on the Court of Appeals. And he asked if I knew anyone who might be interested in working for the Attorney General. And I said, yeah, me.
Okay. I want to talk to you about that. It's no surprise we're here because there have been a lot of allegations made against Attorney General Paxton. You're aware of this, I assume?
Sure.
So when you get that call from Austin Kinghorn, you're interested in the job. Were you aware of all these allegations at the time?
Yes.
Okay. And can you talk to us a little bit about how you became aware of what was going on?
News reports is
Okay.
probably most others did.
Was that concerning for you?
Yes, it was.
Can you talk to us a little bit about the concerns that you had after reading the news reports?
Well, I knew the reason they were calling and looking for people was because they had openings, and that was the good news. The bad news was these were serious allegations, serious charges that concerned me. And when I did go up to interview in Austin, and for that reason, probably unlike any other interview I've had, I took special time to press, in this case, First Assistant Brent Webster, on these charges.
What were your
normally the interviewee is the one trying to sell him or herself.
You had to cross your T's and dot your I's. Can you talk to us about what your main concerns were coming into the Office of Attorney General?
You might be less interested in this, but I had kids at the time in high school and in junior high. So commuting back and forth to work was a concern. Where to live in Austin, it's not cheap, was a concern as well. So those were, I think you're asking something else.
Well, that's a fair concern, but I am also interested, like legally speaking, you're walking into an office where the Attorney General himself there have been allegations made to the FBI. Right. And so what about that was specifically concerning to you in that situation?
Well, as I said, I spoke with Brent Webster when I interviewed, and I was much more pointed and brusque than I would normally be when I'm trying to get the job. And I knew he was a prosecutor, and by all accounts, a good one. So I pulled no punches. I pressed him, asked what I thought were fairly pointed, direct questions as to, okay, this is the allegations I'm seeing in the paper. What's the answer to that?
Kind of like a cross-examination a little bit?
A little bit. And it had an evidentiary quality to it as well, because he very patiently, I thought, given the busy nature of the office and constraints he was under, took the time with me to walk me through the documents he'd assembled at that point.
Okay. Now, after leaving that conversation, can you talk to us about what your opinion was with regard to taking the job as Deputy First Assistant Attorney General?
Well, I satisfied myself that these charges were, in my opinion, then not well-founded. I knew as part of my job, there were a number of interesting things going on in the office, but I also knew as part of that, like the Google ad tech lawsuit was coming. In addition to that, I'd be in charge of defending, I think it was then pending, the Whistleblower Act lawsuit involving these charges. So that was also a concern.
Right. So I assume you take the job because we're here right now.
I did.
All right. And I want to talk to you about, well, when exactly was it that you started as the Deputy First Assistant?
December 3, 2020.
Okay. So that's after everything kind of went down with regard to October and the reports to the FBI, right?
Yes.
You mentioned that you were a part of ultimately the whistleblower suit. Are you aware of reports that were drafted within the office?
Yes.
How many reports were there?
2.
Can you distinguish the 2 different reports that were drafted on behalf of the Office of Attorney General?
Yes, the first one started almost from the time I was there. The first I remember seeing a draft was sometime in January, I think early January, because I was still working from home right after the holiday. I remember that going through edits of 2021. And that was released by our office in August of 2021, publicly on our website.
Okay.
And that detailed the main whistleblower allegations and what our office, after forensically collecting documents, emails, exhaustively compiling everything, was able to put together to address these allegations.
And can you tell us who actually authored or published that report?
The Office of the Attorney General.
Okay. Now, is it safe to call that the internal report?
Yes.
Was there a secondary report that was drafted?
Yes, and if you have a copy, that would help me be clear and precise, but I believe it is on Louis Brisbois' letterhead or in the format of a memo to the Office of the Attorney General.
Objection, Your Honor. Testifying from a document not in evidence, testifying about a document not in evidence, and hearsay.
Thank you.
Sustained.
There's a report in existence, correct?
Same objection, Your Honor.
There are two reports.
He's not testifying with regard to what is stated in the
Overrule
document.
that. Go ahead.
Okay. There is an existence of a Louis Brisbois report, correct?
Yes.
All right, we'll get there. But before we do, I want to be very clear. You started in December of 2020, right?
Yes.
You've looked at both of these reports, the internal report and the Louis Brisbois report, right?
Objection leading, Your Honor.
Show only to lay a foundation, Judge.
I'm going to sustain. Just,
yes, Judge.
Ask the questions one at a time.
Certainly. Are you aware of...
It's hard for me not to rule, by the way.
Are you aware? It's in their allegation, so I'll talk about it. Are you aware of the two reports?
Yes.
Have you read the two reports?
Yes.
Now, were you present at the Office of Attorney General during any of the subject matter involved in those reports?
I want to answer no, and I think that's right, but I would have to look at the reports to absolutely confirm. But I think everything that was detailed in both reports predates December of 2020.
Sure. Well, let me be more specific. Are you aware that the Office of Attorney General was involved in an open records request involving Nepal?
Historically, I'm aware. I wasn't there at the time.
Are you aware that they were involved in litigation with the Mitty Foundation?
Yes, again, historically.
Are you aware that there was an informal guidance letter with regard to non-judicial foreclosures?
Yes.
Now, were you present at the office during any of those events?
No.
Were you present at the office during the hiring of Brandon Kamek?
No.
So is it safe to say that you don't have personal knowledge of any of those events that are authored in the reports?
Yes.
All right. Give me one sec, Judge. I intend to get an exhibit for the witness.
I like this attorney. I'm just saying. I just think he's a good attorney is all. That's all. Trump Rocker over on Rumble Chat says, I don't call employees that made up a story whistleblowers in the first place. Yeah, like we said, these are not like the Julian Assange whistleblowers. These are more akin to the Vindman type of whistleblower. And the Eric Chiramella, whatever. However you say his made-up name. It's a made-up name.
Mr. Dorfman, would you take a second to look at a copy of
a touching story?
My exhibit numbers got off.
Well, hey, I mean, these are
Attorney General Exhibit 23, and let me know whether you recognize the document.
I have looked at it, and I do recognize it.
What is this document?
This is what you're referring to as referred to as the Louis Brisbois report, the second report in time that our office released on these matters. Well, I say our office, this was outside counsel sending it to the office.
Okay. And is this a fair and accurate copy of the report issued by Louis Brisbois on behalf of the Office of Attorney General?
Near as I can tell.
At this time, Judge, I would offer Attorney General Exhibit 23.
Your Honor, there's so much hearsay in there, I don't know where to begin. The document itself is hearsay. Within this document are conversations between people that are out of court statements that are hearsay. It relies on documents that are out of court statements that are hearsay. It also relies on people talking to other people who talk to other people, which is 3 layers of hearsay. So my objection, Your Honor, is hearsay squared.
That is
sustained.
Judge, may I respond briefly? My understanding, and Mr. Arroyo, if you would pull up Article 7, please. My understanding is that the House Board of Managers allegation in this case is that Ken Paxton and the Office of Attorney General issued a report that basically alleged false and misleading facts. This is a legally operative document in this case.
Your Honor, may I respond?
And the House doesn't want it in evidence? I don't understand how they can argue it's a lie if it's not even in evidence before the jury.
Your Honor, I hope counsel is not trying to mislead this court because this article of impeachment is based on the internal AG report, This report, the Lewis Brisboe report, came out after the article of impeachment. And so I'm sure counsel would like to retract his statement and not mislead this court. Regardless, this is so much levels of hearsay, and this thing up on the screen doesn't get around that.
I don't wish to retract my statement at all. I don't think that the allegation is necessarily clear, and I'm going to continue to argue that this is a legally operative fact.
I would suggest as an officer of the court that he retract it because this report has nothing to do with this article.
Come forward, gentlemen.
Well, now the House impeachment manager team is asserting that this evidence has nothing to do with the article that they're about to mention, which I don't think is really a great position to take, but we'll see what Dan Patrick says. They're going to look at the document now and decide. I suppose they're going to decide whether it's related to a particular article, but I think that it doesn't necessarily need to be related to this one particular article. It can be related to other facts in the case, you know, establishing a foundation, right? Stupid that excuse me. I'm supposed to be more impartial. But no, it's a ridiculous position to take that if their position is that if it's hearsay, that's one thing, but if it's that it has nothing to do with that article, that is not really like a valid point. But he said his objection was hearsay squared. Okay. Well, that's literally what the articles are comprised of, so that's the funny part. Oh, he's arguing hard. He kind of looks like Beto O'Rourke from this angle, doesn't he? What are y'all talking about over on Pilled? Hello, Diddy. Hello, Diddy. What's up? Thank you, Unchained, for the can. Thank you for the donation. What's this guy's name? I think wasn't his name Doug? What's up, Diddy? How are you? Mighty Patriot. Anyone that wants to work under a bush is definitely not a patriot of our republic. I don't know. I mean, some people, it's hard to get into a position of power, even to do good things, without playing a little bit of the game and getting close to deep state actors. It just kind of happens, you know?
For the record, I had sustained that objection and it stands. Go ahead.
May I proceed, Judge?
Pardon?
May I proceed?
You may proceed.
Okay.
Hold on 1 second. Our jurors left the building for a moment. I did not notice. Give a senator a minute and they're gone. We will be taking a break shortly, members, okay? We've just been back 90 minutes, and we normally take a break between 90 minutes and a little bit more. I think we're still missing a few. That was a short meeting at the bench compared to other ones, so they were basing their exit on their experience here the last 2 weeks.
Right, I don't blame them for thinking it was going to take another 15 to 20 minutes. Don't blame them for thinking they had a minute to get some more coffee. Anywho. Let's see. Over on Rumble, Trump Rocker says, let's see.
Good news is the
Prosecution has
cricket
been
also
misleading the
left
court with their
the
entire
chamber.
case.
I just think we're more entertaining, Mr. Dorfman and I, so cricket's out of here.
Okay, let me fix this for you. Give me 1 moment and I will fix that. Y'all said it was glitchy. Here we go. This should be better if it's not glitchy anymore.
I believe all are present and accounted for. You may proceed.
Thank you, Judge. Before we talk about the internal
better
report,
over on Rumble and on
I
Pilled
want to
if
talk to you about your time at the Office of Attorney General in December of 2020. Can you talk to us about what was going on as far as it relates to productivity in the office at that time?
I like it.
It was a very busy time. I think I mentioned the Google ad tech lawsuit that had been years, as I understood it, in the making. We were about to release the complaint at long last in federal court, It
And
was
these are
a
all
huge
Paxton
and
witnesses.
extraordinarily complex case. You're taking on Google. So I was told if I took the job, I would have frontline responsibility for, or at least overseeing that. And we intended to hire outside counsel. So that was a big part of that. At the time, of course, the election was still going on. There were still election challenges. And I know people were talking to the office about that. That ended up resulting in the Texas versus Pennsylvania lawsuits. My first week on the job, I think my first day on the job, we went
I'm
to
going to
lunch.
slow you down. I'm going to break that up, Mr. Dorfman. So you're talking about the election. I assume it's the presidential election, correct?
Yes.
Okay. And can you talk about the effect that that had on the workload of the Office of Attorney General at the very beginning of 2021?
Well, I had nothing to gauge it by, but it was extraordinarily busy time.
And did it appear that the morale, that people were working hard at the Office of Attorney General?
Oh, absolutely.
And despite the allegations that were made against Attorney General Paxton, people were still working at the office?
Yes, in my first 2 weeks there, I don't think I made it home before 8 p.m., certainly.
Did you have
any
any, sorry to cut you off, but did you have any concerns about the work pace and workflow at the office?
No, it was fun. I mean, if that had been for the next 2 years, I would have had concerns.
Okay. As far as burnout goes or things like that, were there any concerns about anything like that?
Specifically December 2020?
More into 2021.
Yes, as 2021 went on, obviously the Biden administration came into office. Day one, people may remember this, a raft of executive orders. We were the first, and I'm proud of this, we were the first state attorney general's office to obtain a preliminary injunction against one of those executive orders. It was the day one immigration order that imposed a 100-day moratorium on deportations, even where congressional statute dictated that removal must take place of a deportable alien within 90 days. And so we challenged that in court, federal court here in Texas, and won. And of course, there were other executive orders that we were challenging and filing lawsuits against. I was a voice in the office from a beginning then, but throughout this time, and as we continue to do the work, that look, it's great to be in court. It's great for our lawyers to go into court at the daytime and spend the whole day and file briefs at night, but you can only do that pace for so long. So I wanted us to be careful, husband our resources, use them wisely, pick the right cases, prioritize appropriately.
Utilize your resources.
To maximize the good work we were doing, I thought.
Now, during that time in fall of 2020, winter 2020, and into spring of 2021, are you guys working in the office or are you working at home at this point? Or is it a mix?
Where I was, everyone was in the office. Now, some of the attorneys in the divisions, the litigation divisions, did a combination.
Okay.
And in a lot of the cases, the courts were shut down due to COVID still in many cases. So even though we had cases all over the state, you might have a hearing in San Antonio on this computer in your office, then you turn and have a Zoom hearing in Midland or El Paso 30 minutes later.
Understood. And
which helped, less travel.
Right. You said that you were Deputy First Assistant Attorney General. Are you aware of who your predecessor in that position was?
I believe it was Ryan Bankert.
Okay. Can you talk to us about your role at the time as the Deputy First Assistant Attorney General?
The core responsibility I had is to oversee the litigating divisions, both criminal and civil. As I'm not a criminal lawyer, never have been, never was a criminal judge for that matter, I rely very heavily on my criminal division deputy, it's Josh Reno, and to manage those responsibilities and report up to me and as needed. But the civil litigation divisions, I feel very comfortable overseeing them. In addition to that, I have overall responsibility at the executive level for policies, procedures. From time to time, I've also had direct report responsibility over human resources, as I do currently, and also over the communications team.
So a wide array of divisions.
Yes.
Now, are you familiar with whether at any point special litigation was under the oversight of your position, Deputy First Assistant Attorney General?
I don't think it has been since I've been there. I think it was at one time. Again, I don't know this personally.
And can you tell us now who oversees the Special Litigation Division?
Ralph Molina.
Okay. And then under Ralph Molina, or at any point in time, was it a Patrick Sweeten?
Yes.
Is he still working that position, moved to a different position?
He's currently our lead counsel in the buoys case and the Rio Grande River, but that's on loan from the governor's office.
Did you have the occasion of working at the Office of Attorney General while he was in charge of special litigation?
Absolutely, yeah. I mean, until I think earlier this year, he joined the governor's office. Up till that point, he was there the entire time I was there.
Okay. Did you feel like you had to help him with his job, or did he appear to be qualified in handling his business in that position?
Patrick?
Patrick.
Very talented lawyer, very experienced, very capable. If I had one criticism of him, it's that he's in court more and managing less. We wanted him to clone Patrick Sweetens. So we had a team of Patrick Sweetens. But Patrick's so good and so natural in the courtroom, I think he longed to be there.
Okay. Do you feel that Patrick is the kind of guy that takes pressure off you if you didn't have to watch the special litigation division?
Certainly. They're the special litigation division for a reason. I think that was a creation of Attorney General Abbott to have the tip of the spear. We have a lot of litigating divisions. We have our general litigation division, which are outstanding. All our divisions are very good, do different things. And special litigation is you need to be at the courthouse in 30 minutes. We just found out the Obama administration's filed doing this. They've issued that executive order. No time, let's go.
Okay.
And so if I had to oversee that as well as everything else, you're right, it would put more pressure on me.
I want to fast forward and talk to you about the internal investigation report. You said you had no personal knowledge of the contents or the subject matter of that report, right?
Say that again, please.
You had no personal knowledge. You weren't personally there for the subject matter that is in the internal report authored by the Office of Attorney General.
I wasn't there at the time these events happened.
Were you present at the Office of Attorney General when the report was being drafted?
Yes.
Can you talk to us about who was responsible for that, and if you know what process went into drafting that report?
I think in the first instance, we relied on an office-wide forensic compilation of documents, emails, et cetera, that were relevant. Brent Webster took the lead in compiling that. And then we had a team, and again, as early as January, I was editing drafts with others, Josh Reno, later Murtaza Sudawala, our deputy for legal policy, Austin Kinghorn, Enrique Varela. There were others, but I may have left them out.
Okay. And can you talk to us about what your role was with regard to the publishing of that report, or at least getting the report ready to be published?
Well, I don't think we published it until August of 2021, and that probably is a reflection, one, of just how busy the office was and how much other stuff there was to attend to. But I'm sure I had revised and edited and redlined at least 5 or 6 times the entire document front to back.
Okay. Now, understandably,
and others did as well.
Right. Understandably, you weren't present for these events that the document summarizes. Did you play a hand in trying to find documentation to support the positions taken in that report?
More oversaw that process.
Can you talk to us about your oversight of that process?
Yeah, I felt very strongly this had to be, it was going out as a report of the office. I believe the Attorney General had said, look, these allegations are baseless, and I will investigate and present the facts and let the voters decide. Words to that effect. I wasn't there. And so this was a fulfillment of that commitment. I took that as a charge to lay it out there. And I think it's fair to say that the document, my emphasis throughout this process of editing was, look, this needs to be the voice of the agency. It's not any one person. It's all of us, and it's objective. It's factual, both in tone and substance. If we make a conclusion or from the facts that we presented from the documents that isn't supported by the document, let's not make that conclusion. Let's take that out and let the people reading it make their own decisions.
And so really, you're just trying to make sure that they're not making allegations that they can't back up.
Objection, leading.
Sustained.
Would you agree that your job was to make sure that the claims were verified?
Same objection, Your Honor.
Sure. Was it your job to make sure that there was evidence or at least something to corroborate statements that were made?
Was there an objection there?
Not to that, Your Honor.
I didn't think so. Okay.
I certainly viewed that as my job, yes.
All right. Now, you mentioned earlier that at some point you get involved into the lawsuit in this case, and I want to talk to you about the lawsuit, okay? Can you tell us your understanding of when the whistleblower lawsuit was first filed against the Office of Attorney General?
I think it was November of 2020.
Can you tell us who the named parties within that lawsuit are?
I'm going to struggle on their first names.
No problem.
Ryan Vassar.
Okay.
Mr. Maxwell's first name is
David Maxwell.
David Maxwell. Thank
right.
you.
Mark Penley, ring a bell?
Mark Penley and Blake Brickman. Sorry.
Okay. And more focused on who is the named party or the named defendant in that lawsuit?
There's just one defendant, the Office of the Attorney General.
Okay. Was Ken Paxton specifically named as the party to the lawsuit?
No.
All right. So it's the Office of Attorney General on the filing.
Yes.
And what is the first thing that you all do? Who all is working on the lawsuit with you at this time?
About the same time I was interviewing, I think they were interviewing for outside counsel, so I knew Louis Brisbois had been hired, and either the first or second week we might have had a phone conference or meeting with them. At that point, I think the lawsuit had been amended at least once. There was later a second amended, and so I was working on it. Austin Kinghorn was working on it. The first assistant would have been involved.
How about Chris Hilton? Was he working on it?
I think that's right. I think Chris Hilton was also from the start there. He certainly was later.
Sure.
Enrique Varela as well, who worked with Austin Kinghorn.
And I'm going to cut you off. You mentioned Louis Brisbois. Can you explain to us what Louis Brisbois' job was with regard to the whistleblower lawsuit against the Office of Attorney General?
To be outside counsel, Bill Helfand is an attorney I've known in Houston for at least 20 years. Very good lawyer, specializing in government work, especially defense like Section 1983, federal court lawsuits, many of which, if not most, have an employment quality to them. The sheriff being sued by his deputy, something like that.
And just without getting into the contents of the document that I showed you earlier, the Louis Brisbois report, was that authored by the attorneys that were outside counsel for the Office of Attorney General?
Yes, Mr. Helfand and others.
Okay. Now, in that litigation, did you all file a plea to the jurisdiction?
Yes, we did.
Okay. Can you explain to us what a plea to jurisdiction is?
A plea to jurisdiction is a document that says to the court, every court must first assess whether it has,
speaking of the microphone.
Every court must first assess, that was too loud, whether it has jurisdiction to entertain a lawsuit. And the state of Texas cannot be sued for money damages without its consent. And this body and the House are the ones that must expressly waive by statute the immunity from lawsuit, the sovereign immunity of the state of Texas, in order for a plaintiff to recover money damages. They argued, the plaintiffs in this case, that
I'm going to stop you and I'm going to break that down. You know, I didn't go to Yale, so you got to make it slow for me. Mr. Arroyo, would you please put up Article 8 onto the overhead screen? So essentially, plea to jurisdiction, well, let me ask you this. Is that something that is commonly filed in lawsuits in your experience as a civil litigator? Or at least with regard to Office of the Attorney General?
I was going to say, at the Office of the Attorney General, I'd say probably 90% of our defensive cases, at least the ones I'm most familiar with, we file plea to jurisdiction. Almost every case challenging the most recent enactments of the legislature arising out of the last session, which have been, all those legal challenges have been brought in the last few months. We filed pleas to jurisdiction, I think, in every one of those, saying this suit can't go forward. The court has no jurisdiction. The state is immune.
Okay. Now, Eric, if you could just blow up the second paragraph specifically all the way down to, well, this part's fine right here. If you could blow that up. Okay, so I'm just going to read the Article 8 to you, Mr. Dorfman, which states that specifically Paxton entered into a settlement agreement with whistleblowers that provides for payment of the settlement from public funds. The settlement agreement stayed the wrongful termination suit and conspicuously delayed the discovery of the facts. The next page goes on to say, and testimony at trial to Paxton's advantage. Sorry.
Let it get up on the screen. Okay, continue.
To Paxton's advantage, which deprived the electorate of its opportunity to make an informed decision when voting for Attorney General. So at what time did we know that the lawsuit was filed in November of 2020. When was it that the Office of Attorney General actually files the plea to jurisdiction?
Not exactly sure, but I believe it was January of 2021.
Okay. And when did the Office of Attorney General engage in settlement agreements with the whistleblower plaintiffs in this case?
Almost exactly 2 years later.
Okay. So when we're talking about the plea to jurisdiction, we are 2 years before settlement discussions even come into play, right?
Right.
Now, I think in your motion for plea to jurisdiction, it was in two parts, correct?
I'd have to see it.
Well, did you talk about sovereign immunity?
Absolutely.
Can you explain to us how sovereign immunity comes into play in your plea to jurisdiction?
Well, I think I covered that. The state is immune from suit unless there's an express statutory waiver from the legislature.
Okay. And then the second part of that was that you talked about separation of powers.
Yes.
Can you talk about that to us?
Well, let me go back and cover the first one, if you don't mind. May I, Your Honor?
If you please go back and cover.
I need to qualify my comments. What you're describing is, you've reminded me and refreshed my memory that the Whistleblower Act is exactly the type of express statutory waiver of sovereign immunity that allows one to sue the state, in this case for money damages. But the case law has been clear, and we argued it, that unless you meet all the elements of a Whistleblower Act claim, there is no waiver of sovereign immunity. There's no jurisdiction for the court to proceed. And we alleged that the plaintiffs in the case had not met their burden of establishing all the elements of the whistleblower claim, and therefore sovereign immunity still applied.
Okay. And was that file in the plea to jurisdiction, was that made in good faith and based on your legal research?
Yes.
All right. Now I want to focus back onto the article that states specifically, if you'd go back to the other page, Eric. It talks about, and you zoom in, the settlement agreement stayed the wrongful termination suit. I just want to be clear, when you all filed the plea to jurisdiction, that had nothing to do with the settlement agreement, right?
We weren't even discussing settlement at that time, no.
Okay. Now, what is the result of a plea to jurisdiction with regard to discovery in a lawsuit?
The plea to jurisdiction, again, every court must first assess whether it has jurisdiction. If it doesn't, it's powerless to order discovery or proceed any further. And the legislature has passed an interlocutory appeal so that even if we lose the plea to jurisdiction, if we win, the case is over and dismissed. If we lose the plea to jurisdiction, we have the right to immediately appeal, when normally you would have to wait till the end of a case to file your appeals.
And
the intermediate appeal stays the court's jurisdiction. It can't proceed further in any capacity until the appeal is resolved.
Okay. Now, was that plea to jurisdiction filed to stop the discovery getting out to the public in this case?
I don't understand your question.
You just said that a plea to jurisdiction essentially stops the discovery from occurring in a lawsuit, right?
It stops anything from occurring in the trial court.
So my question to you is, when you all filed a plea to jurisdiction, did you do so because you felt that the law applied in that situation, or did you do so because you wanted to stop discovery from getting out to the public?
We did it because we thought the state had sovereign immunity, and it was our duty to assert that, as we do in so many of our cases. That does have the effect of stopping discovery from going forward and saving the taxpayers the expense of that discovery, and our lawyers the time. That, discovery really is where the time gets taken in trial cases.
Okay. I want to talk to you about the procedural posture of the plea to jurisdiction. Can you talk to us about the first court that ultimately ruled on you all's plea to jurisdiction in the whistleblower lawsuit?
The first court?
Yes.
That was the Third Court of Appeals here in Austin.
Well, did it go to the district court prior to that
I'm
filing?
sorry. Yes, you're
All
right.
Can you talk to us about that?
We had some discussions back and forth. I don't know how much detail you want to go into, but with the plaintiff's attorneys about scheduling a hearing on two things. They wanted to have a temporary injunction hearing. I think initially they said they needed 4 days. The only purpose of a temporary injunction hearing in this context would be for Mr. Maxwell and Mr. Vassar to seek reinstatement under the Whistleblower Act. So to be reinstated to their position with the Office of the Attorney General.
So are you saying that Mr. Maxwell and Mr. Vassar actually wanted to come back to the Office of Attorney General?
Yes, and I think that's still in their live pleading. Well, they're pleading. I shouldn't say live.
Now, what was the ultimate decision by the district court with regard to that plea to jurisdiction?
Well, so we were trying to schedule the plea to jurisdiction before, 1 week before, something, 1 day, whatever, because the court can't have a temporary injunction hearing until it's heard and ruled on the plea to jurisdiction. The plaintiffs requested and the court agreed to set them on the same day, but that had the effect of meaning before the judge ruled, we were set to a temporary injunction hearing, which got underway and started. And there was even testimony taken, I think, from Mr. Mateer for some time before we got the Court of Appeals to agree that by proceeding with the temporary injunction, she'd implicitly ruled, the judge had implicitly ruled that she had jurisdiction. And
so ultimately, and I'm going to cut you off, ultimately the case goes up to the Third Court of Appeals?
Yes.
Okay. So the district court didn't rule on the plea to jurisdiction necessarily?
I'd have to go back and check. I think she may have written an order expressly denying it, but not until after we had already gone up to the third court and said, we need intervention.
Okay. And can you talk to us about what happened at the Third Court of Appeals?
They said oral argument, and I can't remember exactly when that was, but I believe it was October of 2021 when they issued their opinion, maybe 30 pages.
So almost a year later, while that plea to jurisdiction is still pending, right?
Well, the plea would have been filed in January, I think, and so you're talking 9 months later.
Okay. And can you tell us how the court ruled, the Third Court of Appeals ruled?
Third Court of Appeals agreed with the plaintiffs that the trial court had jurisdiction, that our reading of the Whistleblower Act on the two prongs you mentioned was wrong. Well, they disagreed with it.
Okay. And in response to the Third Court of Appeals ruling in that case, what did you all do on behalf of the Office of Attorney General?
We appealed that to the Supreme Court of Texas by filing a petition for review, asking them to take the case and reverse the Third Court's ruling.
Okay. Now, do you recall when the appeal to the Supreme Court of Texas was filed?
Not exactly. It would have been within 30 days, maybe 45 of that October, I think 2021 opinion from the Third Court.
Okay. And at this point in time, what is going on with the litigation in the whistleblower lawsuit?
Only the appeals process.
Counsel, excuse me, I promised a break about 15 minutes ago for the jurors. They've been in a 2-hour sit down.
Now's an okay time
is
to
this
stop.
a good time?
Sure.
I don't want to interrupt, but it's a good time. Members, it's 5 minutes before 4. Come back at 4:15, 20-minute break.
Okay, you guys. Thank you guys for being here. Any of you are new to watching this, thank you guys. Yeah, I don't think the House has any case at all, so they're just kind of doing whatever they can, honestly. That's what it seems like. They seem over on Pill. Let's see, what are y'all saying over here? Prosecutors have looked like idiots. The other ones, So these prosecutors are just, these are not the prosecutors. This is a defense. All the prosecutors did look stupid. All the House impeachment managers looked so stupid. let's go back to, let's see. Let's see if we can get some Busby action from yesterday. And if you're having trouble, it takes a while to load. If you click on the video and it doesn't load right away, it's because they're like 5 to 12-hour streams sometimes. Like I just have them streaming all day. So it just takes a minute to load when you click on them. I got a comment asking why the videos won't load. They take a minute to load on my computer as well. So Trump Rocker says, interesting that the Texas legislature couldn't pass a bill to protect our borders. It was one of the 8. It was on our. Wasn't it on our platform? Yeah. One of the 8 legislative priorities. Yeah. It is pretty crazy. You know, that's what happens when oh, hang on, wait, sorry, I'm not sharing what I meant to be sharing. Give me 1 minute to change my screen over to this. We're gonna just do like another recap of some of the some Busby action from yesterday, because Busby got a hold of another one of theirs. Actually, you know what we'll do? We'll show everyone. How about that? We'll show everybody when the House accidentally rested, because that was interesting. Let's see if we can find it in the few minutes that we have. I'm going to put this on this screen so you can see what we're doing. Trying to find where the House accidentally rested their case. It was kind of crazy what just happened. Here it is.
469 are admitted evidence.
All right. Now,
you'll hear me from yesterday a little bit as well.
Just to be sure the record's clear, you never participated in a mediated settlement, did you?
I did not.
All right. Now, I want you, if we scroll down and look at the bottom of this, scroll it to it. Number 2 says what?
OAG will permanently remove this press release from its website.
And that press release was what? Is that the one in which you, what was that press release?
This was the press release where Attorney General Ken Paxton called me and my colleagues rogue employees.
Number 3.
Would you like me to read it?
Read it.
A recital in the settlement agreement will state, whereas Attorney General Ken Paxton accepts that plaintiffs acted in a matter that they thought was right and apologizes for referring to them as, quote, rogue employees, end quote.
And then number 4, would you read that?
The parties will not ask that the Third Court of Appeals opinion issued October 21, 2021 be withdrawn.
And that is that the settlement that is now still pending before the House for approval?
It is.
You can take that down. Now, I want to, if
Mr. Hardin, about how long do you expect to go? Mr. Hardin, about how much longer do you expect to go? They've been on the jurors have been sitting for 2 hours.
Was adverse to Nate Paul report or unique to this report?
I'm not sure I understand the question.
Are there other misstatements in this report?
There are many other misstatements in the report. These are just a few samples of the misstatements in this report.
All right.
I apologize. I'm trying to locate where the House accidentally rested their case. I thought it was right around this time. Let's see.
Your Honor, I've got to get a couple of things together. Can I renege and we take a break now? I will be through shortly after you return.
Yes.
Minor, Sutton,
before
and
we break,
50K.
could both parties come up for a second?
I'm not sure. Ali Carver on Rumble. I'm not sure. I know Johnny Sutton is the attorney that's representing everybody that's working for free. Okay, everybody, they're going up to the bench again. giving everybody a few minutes to get organized. Thank you guys for being here. I'm sorry I'm not as attentive as I need to be to some of the chats, but thank you so much. I'm working on a couple of items right now for some of my other work. So thank you guys very much. Give me 1 second. Let me see if I can. Oh, I see. This is one of the times where it was very slow and choppy. I remember. We played this in between some of their breaks. Here's some Busby action. We'll play some Busby action for a little bit. I guess it was closer to the end here. Yeah, this is where I should.
Let's look at
See if I can find it.
What is marked and in evidence, AG 170. And Eric, if you don't mind, go to.
Y'all, please share this out. This guy's being fucking taken
Brickman
apart. Dude.
187.
This is
Let's
awesome.
put it on the screen.
I apologize for my language. That was before I adopted my newscaster
What we're going to look
persona.
at, sir, is a text string that you were on with Brickman and several others. Okay.
Are you saying you're more
Need you to
refined
speak into
now?
the mic. Yes, sir. Okay.
I apologize for going off
All right, let me know
teleprompter.
when you're ready.
How does it sound? Diddy? Does the
Go to
news? Oh my gosh,
187,
that's a cute
Eric.
tiny
We're
little
looking
gun.
at it.
Does
AG.
Okay, guys, let's see if I can find it.
Made an objection. He explained it. You made an objection.
Thank you.
I'm going to sustain the objection.
Is the court ruling? All right, thank you. If I can now, Stacy, would you put up exhibit with debate stamp 6212? The last exhibit was 620.
I'm just trying to find it. It's right around here, I suppose, then, because it was basically the last thing that he did for the day. And as soon as the Senate comes back in session, we will pop that stream back up. But this is just a slight recap.
Did you resume the clock?
Is this it?
Your Honor, these are, just for the record, these have been offered ultimate exhibits, 172 through 185, then 187 through 209, and 218 and 220.
No objection.
You may continue. Let me
Your Honor,
admit these.
may I have
Forgive
just
me.
a moment to see if that's it for us?
Admit 172, 173.
That's the boring part where they start listing off all the numbers, all the exhibits that are listed, that are approved, that are agreed upon. So I guess the senators deserve a bathroom break. And we will recap accordingly. I am attempting to locate, let's see, I'm attempting to locate where he rested. Well, and if you'll remember, for at least the last hour, they were just, you know, at the bench and taking breaks and having arguments. And Erin Epley was throwing her, you know, wrench into the gears of the impeachment, trying to slow it down. So I apologize, and I am attempting to locate the last thing that Mr. Hardin did, because that was basically it. I'm gonna put it right around here because I think this must be it, because for like you guys saw yesterday, big black conservative, the 2:30-40 mark. Hang on. I'm gonna see if this works, because big bad black conservative. I don't know why I have trouble saying it.
Houston,
Wait, are
who,
they
if he had some opinion that the court found relevant.
Okay, hang on. I'm going to
try to get this done. Okay, well, let's see if we can. Well, it's not a, wait, was it? Wait, hang on a second. Let me try to get that link back up, actually. And I apologize for taking that down, but let me try to get that link back up and see if. Here we go. Let's see. Oh, wait, that's just my link. Okay. Well, that doesn't have the clip of it, but I'm about to share the clip of it if I can just find it. Okay, let's add this one back so you guys can see what we're doing. Thank you guys for being here. Please like and share this out so people understand what's been going on.
He should come here and be cross-examined. We can't cross-examine a report from somebody who's not in court. So, Your Honor, there's three.
Let me try to refresh this and get this back to where it's supposed to be. So that's a little jumpy. Thank you guys over on Pilled. Akira, hello, how are you? I apologize. Everything's loading currently, but we'll get to where we need to be. Hopefully. My computer's it's doing a lot of work right now, is what I'll say. Well, I apologize, you all. I don't really, I hope that the Senate comes back soon. Every now and then they go on a break and then they take way too long, and that's not very fun. And it's difficult for us, part-time streamers. We don't have a high-quality studio, so we're operating on what we can. I'm on a laptop and a borrowed headset, so we're doing the best we can. Most of these articles, I can share this at least, so we can talk about these articles. Most of these articles have been totally debunked. A lot of them are redundant, so they sort of they say, oh, well, he committed a crime, and in committing a crime, he committed more crimes, and it's like, we're not in agreement that he committed a crime in the first place. These were legitimate claims, not baseless claims, that were made by Nate Paul, and were referred to the Attorney General's office by the Travis County DA.
Years after the events in question. Two, it's written by a lawyer who's been appointed to be receiver, and it's filled with his opinions about this and opinions about that.
I just got to it, and let's see if this is it. Well, might just have to get through this part. I just got
187,
to it, and I think this will be it.
188, 189, 190, 191.
If we just get through the, what if I just start
192,
saying random
193,
numbers and mess him up when he's counting?
194, 195,
It's
196.
right around this time that the House accidentally rests.
199, 200, 201, 202, 203, 204, 205, 206, 207, 208, 209, 218, 220, and 2 evidence.
Thank you very much.
Yes,
One
sir.
final question. Would it be possible for us to find out what sections the court considers double hearsay? In case in that report later, we could
Thank
come
you, everybody,
back
for
with
being here.
bracketed, not to argue with you about the ruling of double hearsay, but to maybe admit stuff that was not.
With all due respect, we really did spend a lot of time on that, stop the clock, and on the advice of 4 very wise people up here to help me with that issue, I'm going to stay with my ruling.
I appreciate it, Your Honor. If I have just a second,
Yes.
if I could stop the clock to confer, because I think we may be through. I just want to make sure.
Sure.
Your Honor, at this time, the House of Managers rest.
He just rested without a cross exam. I can recall the witness, though. I'm fine with that. We'll recall this man. We will accept the rest. And that's how it works.
He's certainly right. I mean, I want to concede he's absolutely right. I apologize. I think he is entitled to his day in court. Thank you.
So he has given you your cross-examination, if I'm understanding, Mr. Harden?
Certainly.
Your Honor, we have some motion practice we'd like to take up with the court today.
All right.
Now, is he waiving cross or?
Very interesting.
That I would recall this witness in our case in chief. If there is a case in chief needed from us, I'd like to do some motion practice today.
But here's the problem. I messed up and shouldn't have rested until he finished his cross.
And yet you did.
Excuse me. Having this witness come back doesn't make sense. It would seem to me the appropriate thing for him to do is to cross this witness. And then if we had an opportunity or took one to redirect, but it usually should be when both of us have finished with this witness and then we press. The court is having to put up with a screw up by me. I apologize, but I would really respectfully like for him to go and do his cross.
I don't have to do a
So it shows that
On further review with my legal team, it appears, looking at the document, it contains
Okay, you all said it was glitchy, so I'm gonna let that try to load. They're still just milling about. Nobody's back yet, so for that reason we can. What I'm trying to show you guys is where the house accidentally rested, and so it should be loading again. And I hope it's more clear and less glitchy than what's been reported. I apologize for that. I don't have the most sophisticated equipment out there. I'm operating off of one laptop. And I have spilled coffee on this laptop several times, so. But it's doing the best that it can. Donations are appreciated, but they are not required. I also apologize if you can hear the rain outside and many cars driving by. I'm in an efficiency apartment in a downtown area, so I apologize for that. Okay. Here we
the grand jury subpoenas is Exhibit 172. This is very bulky. These were the subpoenas, the grand jury subpoenas that have been mentioned throughout the case. I'll tender it to Mr. Busby, and because of we just have one copy for you.
Did you resume the clock? Did you?
So on my end, it's not glitchy at all, but I see that the Rumble feed is very glitchy when I try to replay another Rumble video. So, oh, an interesting mix-up has occurred. Anyway, so yeah, I'm not sure about that. I will try to see what I can do about that. Let me try one more time. Tell me if this is glitchy. Give me a 5 by 5 if it's not. If it's glitchy, give me a thumbs down.
Ultimate exhibits 172 through 185, then 187 through 209, and 218 and 220.
No objection.
You may continue. Let me admit these.
May I have just a moment to see if that's it for us?
Admit 172,
This
173,
is just prior to
174,
the accidental resting
175,
of the case. Let me
176,
go
177, 170.
No, this is when it happens. Okay, everybody pay attention. Here it is.
Your Honor, at this time, the House of Managers rest.
He just rested without a cross exam. I can recall the witness, though. I'm fine with that. We'll recall this man. We will accept the rest. And that's how it works.
He's certainly right. I mean, I want to concede he's absolutely right. I apologize. I think he is entitled to his day in court. Thank you.
So he has given you your cross-examination, if I'm understanding, Mr. Hardin?
Certainly.
Your Honor, we have some motion practice we'd like to take up with the court today.
All right.
Now, is he waiving cross or?
Very interesting.
That I would recall this witness in our case in chief. If there is a case in chief needed from us, I'd like to do some motion practice today.
But here's the problem. I messed up and shouldn't have rested until he finished his cross.
And yet you did.
Excuse me. Having this witness come back doesn't make sense. It would seem to me the appropriate thing for him to do is to cross this witness, and then if we had an opportunity or took one to redirect, but it usually should be when both of us have finished with this witness, and then we press. The court is having to put up with a screw up by me. I apologize, but I would really respectfully like for him to go and do his cross.
I don't have to do a cross. He rested. I will recall this witness.
Mr. Hardin?
He is waiving his cross for this stage. I understand. If that's the case, there's no problem.
You rested, sir.
Yes.
And I accept that.
Yes, you rested.
That's fine. And if he wants to put on his case now or he wants to argue a motion, what's the court's preference?
Well, it's now up to him. You've rested. It's up to him to either recall the witness or to make a motion, or it's now his call.
All right. May I ask what about this witness? He's caught in the box.
Is he asking for what?
He's asking about this witness. Can he step down at this point?
Subject to recall. Yes, sir.
Okay, you can step down, subject to recall.
Very interesting. I hope the feed is smoother for everybody. Let me know if it's not.
Your Honor,
The House accidentally
we've
rested.
seen, Your Honor, the House is.
Let's wait till the witness is out of the courtroom.
These witnesses walk way too slow. He's still walking. Thank you, everybody, for being here. Thank you, everybody over on Pilled.
Yes, thank you.
Thank you, everybody over on Rumble.
Oh, Mr.
They're still milling about. They're not back yet, but we will flip back over as soon as they're back in. The House accidentally rested their case, and so now it's the ball is in Busby's court, and he's going to pull some.
They rested their whole case?
No, just for the witness.
Oh, okay.
And Busby accepted their arrest and is now going to pull a strategic move, but I don't know what it is. We will find out very soon, I suppose. And the reason I wasn't, I was thinking it was just for the witness is because this witness was subject to recall, so I wasn't quite sure
Yes,
what
Your
was
Honor.
going on.
As I understand from my colleagues, a motion for directed verdict must be filed and in writing. We have done that. We filed a motion for directed verdict on each of the articles, and I think we've also grouped some of the articles. I think those are dispositive. I would ask that the court consider those. I understand that the Senate would.
Sorry about that, guys. So basically what happened is the House accidentally arrested. Paxton's team seized it and filed a motion for a directed verdict.
Bailiff can bring in the witness, please.
Which is where they were going to vote on the sufficiency of the evidence. And they ended up with withdrawing that motion. The House filed another motion after that. They withdrew that motion as well. And then so they're just continuing on now. It's the defense calling their witnesses, but they all still have cross-exam. They can still get evidence in that way through cross-exam if they need to. So it's kind of crazy what happened there. We weren't sure if basically what was going to happen, if the rest was going to remain, if they were going to switch it back.
We have all the jurors. Mr. Asso is the correct pronunciation.
Actually
We'll be sure I
vote
have
on the
that right.
sufficiency. And they didn't do
Thank you, Judge.
any of that. They just accepted the rest.
Mr. Dorfman,
withdrew
we
all
were
the
just
motions
talking about
and started calling
the effect that a plea to jurisdiction actually has on the discovery in the case. Now, I want to focus, Eric, if you wouldn't mind focusing on the next page,
totally
top paragraph, which is the bottom paragraph of Article, bottom paragraph of Article 8. I want to read that to you. Testimony at trial to Paxton's advantage, which deprived the electorate of its opportunity to make an informed decision when voting for Attorney General. Now, throughout the course of the lawsuit that the whistleblowers filed, are you aware of whether specific facts or allegations became public? And could you turn your mic on, sir? Better? Okay, I'm going to re-ask that question.
Please.
Were you aware of whether the specific facts or allegations with regard to the whistleblower suit became public?
Yes.
Can you tell us about in which ways, if you know, they became public?
Well, we talked about that earlier before I came to interview at the office. There were news stories that contained allegations made by the whistleblowers. It was about that same time, maybe a little later, that the lawsuit was filed. That was a news story and a very detailed state court petition that's public record, public filing, covered in the press accounts. And then I think they amended that petition twice between the original filing and early February. So there was a first amended maybe in December, and then in February, just before the plea of the jurisdiction hearing and the temporary injunction hearing, they filed a second amended petition, which I think is the last one. But that's 60 3 pages, very detailed allegations.
And I'm going to
Public
stop
record.
you real quick just to clarify. When you say they filed and amended petitions, can you talk to us a little bit about, well, who filed those petitions?
The 4 plaintiffs through their lawyers.
So David Maxwell, Mark Penley, Ryan Vassar, and Blake Brickman?
Yes.
And did those petitions include specific facts that they were alleging
Yes.
Attorney General Paxton and the Office of Attorney General committed?
Yes.
Okay. And those pleadings were actually available to the public, correct?
Yes.
You can look them up online?
Yes.
So, Eric, if you don't mind going back 1 page to the bottom paragraph, bottom clause. Article 8 alleges that Paxton entered into a settlement agreement with whistleblowers that provides for payment of the settlement from public funds. The settlement agreement stayed the wrongful termination suit and conspicuously delayed the discovery of facts. Is that allegation true?
No. Can I explain?
Please do.
The settlement agreement didn't stay the wrongful termination suit. It was on appeal, and our petition for review was pending with the Supreme Court of Texas. That court doesn't have to take any case it doesn't want to, so you have to convince it to take the case. We had made a case. Filed 2 briefs to do that.
I'm going to stop you because we're going to get there, and I want to break that down.
Sorry.
But with regard to conspicuously delaying the discovery of facts,
the settlement agreement didn't do that.
And weren't the facts available to the public at this point anyway?
More than we discussed. Obviously, the petitions I mentioned, but the Court of Appeals decision is 30 pages and has bullet point block paragraph recitals from the pleadings. So it was restated the most serious allegations that the complaints, the petitions made were restated in the Court of Appeals decision, which also garnered news attention when it came out.
Right. And you had talked about, I think, opposing counsel actually held up a document that was the Third Court of Appeals decision against the Office of Attorney General in this case, correct?
I'm sorry, what was your question?
Essentially that the Third Court of Appeals ruled against the Office of Attorney General.
Correct.
So you filed what with the Supreme Court?
A petition for review, an appeal, notice of appeal of the Third Court's decision with a petition for review asking the Supreme Court to take the case.
Can you explain to us, I deal predominantly with criminal law. Can you explain to us kind of how the process works when you file a petition for review with the Supreme Court of Texas?
It's in the form of a brief, very much like what we would call a merits brief, but it's not. It is simply an argument for why this case is sufficiently important to be one of the 100 or 110 cases that the Supreme Court can take from the entire state and rule on. They only hear so many oral arguments or take so many cases. So you have to convince them this is worthy of their attention. We tried to do just that. Okay. Our opponents filed a brief between our initial and reply brief, explaining to the court they should not. They should let the Third Court of Appeals case stand, in which case the case would have then gone back to the trial court.
Okay. And so the Third Court of Appeals ruling was actually up for appeal, right?
Yes.
Was that ultimately ruled on, that appeal?
Not to this day, no.
Okay. Can you talk to us, are there certain sessions or time periods where the Supreme Court tends to hear cases?
I think that's right. I would defer to people, bless you, who argue in front of the Supreme Court for a living, but yes.
Okay. Do you feel that, I guess at any time, the Supreme Court can pull your case out of a hat to hear it, right?
I think that's right. They usually confer as a body, I think in person, although maybe by remote sometimes too, especially during COVID.
Okay. Does that have an effect on your ability to negotiate or work out a settlement with another party? Or does it affect the other party's maybe goal or them wanting to settle?
I don't know what the what is in your sentence.
The potential for the Supreme Court to pull your issue out of a hat and have it come before them.
Absolutely. It's a significant moment in a case. If they take it, I think the conventional wisdom would be they're not taking the Third Court's case if they decide to take it to affirm it, because they could just do that by denying the petition for review, save themselves time.
So what does that mean to you in the event that they might decide to take your case for
It would have altered our assessment of the case and made it, we would have felt very good about our chances for winning the appeal and dismissing the case outright.
Would that give you the upper hand potentially in settlement negotiations?
So much so that it might make settlement impossible.
Okay. Do you think, if you know, that that had any effect on this case coming to a settlement, or at least settlement discussions starting in this whistleblower lawsuit?
I think that's why settlement negotiations started.
Okay. About what time did settlement negotiations actually begin in this case?
I'm not sure whether it was the very end of December or the first week or so in January of 2021, but about somewhere in that time.
2021 or 2022?
Sorry, 2023.
2023.
December 2022 and January 2023. Thank you.
And just to clarify for the senators, the petition for review probably sat with the Supreme Court for quite a while, did it not?
Yes, I think we filed our initial petition, initial brief in July of 2022.
Okay. Who reached out to who to discuss settling the whistleblower lawsuit?
They reached out to us, my recollection.
And when you say they, you mean the whistleblower's attorneys?
Yes.
And can you talk to us about when, if you know, when that occurred?
Like same time, late December, early January of 2023.
And what did you do in response to them reaching out?
We discussed internally whether we wanted to, as they were requesting, go to mediation with a professional mediator in the Austin area.
What kinds of things were you discussing within your office as to why or why not settle a case?
We certainly wanted to discuss the pending petition for review and when it might be ruled on and what that might do to the party's willingness to mediate at that point if it happened. Whether we could get a professional mediator worth his or her salt on that short of notice, because I think the plaintiffs wanted to mediate in the next 7 to 10 days, maybe 14 at the outset, at the latest, because they were concerned that the Supreme Court might rule, and either way it ruled, the other side would feel good and the other side would feel bad and maybe couldn't. So risk creates settlement potential. So that would take out some of the risk.
Risk for the plaintiffs, right?
Risk to the plaintiffs that the court would grant it, and that might indicate their case was going to be dismissed maybe in a year, maybe in 9 months. They may have assessed it differently. That's how I would have seen it. And risk for us that if the court declined to accept our petition for review, the third court ruling stands, and we're back in trial court, and we have years perhaps of lawsuits and appeals, litigation and appeals, and the accompanying expense and time.
Who found the mediators?
The plaintiff's lawyers did that. I remember clearly because I was very skeptical that on that short a notice we would get any good mediators, and they told us in response to that, I think, that not only they had 2 or 3 who had available dates in the next week or two, which indicated to me, I told people at the office, that's a good sign that they're eager to mediate, because they must have called 10 or 12 people if they could find 2 or 3 available on that short a notice.
Okay, so it appeared to you that they intended to reach a settlement with you.
I think they were highly motivated to settle.
Okay, and that's based on your years of commercial litigation experience, I assume?
And as a mediator and trying to get a mediator on short notice.
Fair enough.
In fact, that was kind of my specialty, is I didn't mediate full time. So if parties couldn't get one of the regular mediators, they knew I was probably available.
Now, I want to zoom out a little bit, just generally speaking, in your years of experience in both a mediator, a judge, and a litigator. Does a party's willingness to settle a case indicate that maybe they think they're liable, or that they think that the other party is correct? Can you talk to me about that?
Sure. In my experience, especially mediating and representing parties who mediate their cases, both sides at least will say they like their case, and they frequently do. Mediation takes place when there's risk and uncertainty, and the only way to control the outcome is for the parties to reach an agreement and take it out of a jury's hands. You never know what a jury's going to do. You don't know who the jurors are. And it may be 2 years from now. It may be, again, 12 people pulled off the street. That's if you want to subordinate your control of your affairs to those people, that's your choice, but that's expensive and risky.
And I'm
not sure I answered your question. Did I answer your question?
You answered my question. I appreciate it. And I want to bring actually your answer and apply it to the fact of this case. Did you have a conversation, without getting into specifics, with other OAG employees about settling or at least go into a mediation with the plaintiffs in this case?
Oh, yes.
Okay. Now, when you entered those discussions, did you have a viewpoint on the strength of your case for the defense, the Office of Attorney General in this case?
Yes.
And what was your viewpoint?
Well, we hadn't probably looked at it in some time since filing the briefing. So we reconvened, revisited, reminded everybody where things were and what the arguments were so we could assess that. I remember being a voice, as I am generally and maybe professionally. Look, let's go to mediation compared to years of trial and discovery and outside counsel on both sides. The expenses, the time is short. We can do it in a day, maybe two. And the expenses, a rounding error in the budget, it's the responsible thing to do, especially in this case. It's one thing if you're a private plaintiff or defendant. It's another when you are dealing with the state's money. I think I felt and articulated that we kind of have a duty to explore settlement. Maybe it can't happen, but we should give it a try.
Right. Your Honor, at this time, may I approach the witness in the court and opposing counsel? Mr. Dorfman, I'm showing you what's been pre-marked as Attorney General Exhibit 335. Do you recognize this document?
Yes.
And what do you recognize this document to be?
This is an internal memo prepared by Chris Hilton, the chief of our General Litigation Division, assessing after we'd received settlement statements from, I think, 3 of the plaintiffs in the Whistleblower Act case, explaining why they thought their case was strong and what they thought they would recover at trial.
And let's not talk about the contents of the document, but could you tell me when this document was authored?
This, on its face, it says February 1st, 2023. I don't have any reason to doubt that's the date. That's the date, by the way, we mediated the case.
Okay.
So whether it was circulated before that date in draft form, I think it was, my recollection. We certainly discussed the contents of it internally before it was put into final form.
Okay, and did the findings, without getting into what the findings were or the subject matter of the document is, did this have an effect on your mindset going into the negotiations?
I don't know if it certainly informed me, and I relied upon it and had, I think it summarized the state of play well.
Okay, and is AG Exhibit 335, is that a fair and accurate copy of the memo that you received from Chris Hilton?
Give me 1 second.
Sure.
Yes.
Your Honor, at this time, I would offer AG Exhibit 335 into evidence.
Any
Mr. Ross,
objection?
I just want to make sure I have the right document. Is this the one with the AOG seal, but with Ken Paxton's name removed?
Yep, that's it.
Then no objection.
Admit
May I proceed?
335 AG exhibit into evidence. You may continue.
Thank you, Judge. Now, I don't want to go line by line in this report, but would you mind just summarizing the kind of what this document is and what you and Mr. Hilton's thought process was with regard to the financial aspect of this mediation in the case?
Sure. It's important to realize the mediation. We were told in no uncertain terms, Blake Brickman would not participate in mediation. He would not come to mediation. He would not be there. He was going to trial come hell or high water. So the opportunity was to settle with 3, not all 4 of the whistleblower plaintiffs. And this, so we received settlement statements from demands, basically. This is what we're going to present the week before, maybe a few days before the mediation date. And this was kind of a summary. I think collectively their attorneys argued for over $5 million in damages if they settled today. Of course, prejudgment interest and attorney's fees, as they said, would go up if the case continued, et cetera. But so for three of them, that was and we didn't want to take their word for it. So we asked one of our top attorneys to read those carefully, review the case law, and report back on what we would consider a more realistic assessment of the case's value was.
And just a brief question. This is just an inter-office memorandum, right?
Yes.
Objection leading.
Was this?
Overruled.
I'm going to ask the question again. Was this an inter-office memorandum?
Yes.
Did you send this out to anybody outside of the Attorney General's office?
No, we would not have done that.
Did you represent that you were the Attorney General or that you had the authority to act without Ken Paxton's, I don't know, authority in this document?
By this memo?
Yeah, by this
No.
memo. No, okay. So can you tell us whether or not you felt that there was an ability to potentially save the state of Texas, the public of Texas, money by engaging in a mediation and potentially a settlement?
Well, I certainly thought that was the case. Otherwise, it wouldn't have been advisable to go to mediation.
Okay. Now, which specific plaintiffs in the whistleblower lawsuit were involved in the initial willingness to settle or request to settle the case?
Ryan Vassar, Mark Penley, and David Maxwell through their attorneys. I don't think we ever talked directly to them during this process.
What about Blake Brickman?
Well, as I said, Mr. Brickman's attorney told us, and actually the attorneys for the other three plaintiffs told us, Blake Brickman will not come to Austin. He will not participate in the mediation. He doesn't care. He wants his day in court.
Did you have a reason or idea as to why Mr. Brickman wanted his day in court?
Yeah, well, this is secondhand. So I understand Mr. Brickman is financially secure.
Objection, hearsay. This is secondhand.
Sustained.
Your Honor, I'd actually argue that it goes towards settlement agreements in this case. And under 408B, it should come into play.
Then my objection is 408. This goes to settlement and it's also hearsay.
Which is if 408B is the exception to the rule. And
we've had this discussion on, I think yesterday or the day before, so I sustain the objection.
Yes, Judge. Needless to say, Brickman's not there, is he?
Wasn't there, wasn't going to be there. Well, and I say wasn't there. We didn't anticipate this or plan this, but February 1st, the date we set for the mediation, ended up being the winter freeze.
Did Mr. Brickman's attorneys come to you with additional demand? Well, we'll get there. Talk to us about how the mediation went. What day do you recall you started mediation?
I believe it was a Wednesday, February 1st. And we had planned to be in Austin in person at the mediator, Patrick Keel's former judge, office. As it happened, with the freeze set in, I stayed in Houston and we were all on a Zoom.
And Mr. Dorfman, it's been a few years. Is it possible that the dates
might not have been a Wednesday?
Fair enough. Judge, may I approach Mr. Dorfman?
I think it was a Wednesday.
Was this a one-day mediation or a two-day mediation?
Ended up being initially planned to be one day, February 1st. We ended up, I think, on February 8th, having a second day by agreement with the plaintiff's attorneys.
Okay. Can you talk to us, and we'll get to the document in a second, but can you talk to us about how the first day mediation went?
It went long. I think we broke sometime around midnight. I want to give Patrick Keel all the credit in the world. We didn't know until it started turning dark that he didn't have power in his house. And at some point, he was on his laptop and lost that power, couldn't recharge. So he's now on his phone on the Zoom call.
This is all happening online, right?
All happening online till midnight. And I think his juice gave out at some point.
Was it a Was it a good day of mediation or was it a bad day of mediation?
I didn't have a whole lot of expectations that this would settle. It didn't, obviously, on that first day, but we got real close. And again, we came in with the expectation that the option today is to settle with 3 plaintiffs. Sometime between 5 and 6 p.m., Mr. Brickman showed up, again, remotely, so I don't know if he was physically present.
Sure. I'm going to stop you real quick. Was this the first day that it got real close and Mr. Brickman showed up, or the second day of mediation?
First day.
All right. So you guys are making headway. You said Mr. Brickman showed up. Can you talk to us about any effect that only 3 of the 4 plaintiffs were present that it had on you? And then what happens when Mr. Brickman shows up?
Well, I think Mr. Hilton's memo, Exhibit 335, speaks of the fact that it's more valuable to us to settle the entire case.
Okay. And why is that?
Because if we're settling with 3 of them, we're paying money out.
Mm-hmm.
Yet we still have to pay our lawyers and outside counsel on top of that to go to trial, to go to discovery, all the expense, maybe less time, maybe less discovery because it's just 1 plaintiff, but still time, resources that we would like to save ideally by getting rid of the whole case at once.
Because what is the point of settling this case to you guys?
We have to be good stewards of the taxpayers' money, of the state fisc. And so we viewed this as any other case. One, that's why I argued for mediation, is we should at least try, if it's cheap and inexpensive to try and settle this and save that money and time and resources. And then settling with 3, I think it would be less valuable, but by the same token, we would offer less money. And I think Mr. Hilton says it in the reverse way in his memo that if Mr. Brickman would come to the table and we could make sure we don't have to expend any money after a settlement, I think his word is that would be worth a premium.
Okay. Talk to us about what happens when Brickman joins the negotiation table. How did that go down? Did you all reach out to Mr. Brickman, or did somebody else reach out to Mr. Brickman? What is your understanding?
I don't recall real clearly. I think it was a surprise to us.
And how did you take that surprise?
Good and bad.
Can you tell us about that?
The good is, look, we've all along preferred to settle with all 4 rather than piecemeal. It's more valuable. It's worth the premium for the reasons Mr. Hilton stated in the memo, the exhibit. So that was good. Bad is, wait a second. You told us all along, all week, maybe 2 weeks now, Blake Brickman's not interested in settlement. Blake Brickman's not going to participate in the mediation. He's not available. He's going to trial. And now that we're talking real dollars and it looks good that we might actually settle, now he's interested. All that, was that posturing? Were we being sold a bill of goods? That the suspicion crossed my mind.
Did you all reach a settlement that night?
No, we got real close, but no.
Now, I want to talk to you about AG Exhibit 423. Do you recognize this document?
Mr. Ross, be sure you speak up and stay on that mic a little bit.
Yes, Judge. Do you recognize AG Exhibit 423?
Yes, I do.
What do you recognize that document to be?
This is General Paxton conferring on me.
Objection, Your Honor. Testifying from a document, not an evidence.
I'm going to lay the predicate right now, Judge, and I'll instruct the witness.
Overruled.
Without getting into the contents of the document, what do you recognize this document to be?
It's a memo from Attorney General Paxton to me and to Chris Hilton, subject line settlement authority dated February 8th.
Okay. And did this email have an effect on your abilities and your thought process when going into the mediation on day 2?
It confirmed what we had discussed internally, yes.
Okay. Did it grant you any form of authority?
Yes.
All right. Is this email that you see in AG 423 affair an accurate copy of the email that you received from Ken Paxton on February 8th of 2023?
Yes.
At this time, Judge, I would offer AG Exhibit 423 into evidence.
Any objection?
Yes, Your Honor, I have 3 objections. First, it was never produced. Second, it was listed on their privilege log, so it was never produced. And 3, it's hearsay, so it is inadmissible.
I can address the objections. I didn't hear your second objection. Could you repeat that?
Yes, this document was identified on your privilege log, so you never gave it to us. And now you're bringing it to court for the first time and showing it to us for the first time.
Let me address the privilege log first. As an attorney for Ken Paxton, I think at this time we'd be willing to waive any privilege.
I appreciate that, but the fact
I'm not done, and if I could just finish my response, then I'd be happy to be quiet and let opposing counsel go. So first and foremost, as Ken Paxton's attorney, I'll waive the privilege. With regard to hearsay, it's not offered for the truth of the matter asserted. It goes towards the effect on the listener and the mediation the next day. We heard Mr. Dorfman just state that on the record. And his first objection with regard to it being not being on the witness list, or excuse me, the exhibit list, Judge, this is a rebuttal case at this point, and arguably we don't even have to put a case on. Most of our exhibits are rebuttal exhibits, but we did give them a list. I am arguing that this is a rebuttal exhibit, and for that reason, it is not covered by the the exhibit list rule, and it should come into evidence.
Your Honor, may I respond?
Yes, you may.
Just so we're clear, the process that occurred was they produced a privilege log, never gave us this document, and now for the first time they're sandbagging us with this document without giving it to us. As the court is aware, you have ruled several times the documents that we did not produce would not come into evidence. They never gave this document to us. This is the first time we're ever seeing it. If they want to take every document off their privilege log and put it into the record, we're good with it. Otherwise, we have a valid objection. Second, Your Honor, it is clear hearsay. There is no business record. The predicate laid was not the standard for hearsay, and so it is inadmissible on all of those grounds.
If I, and just brief, yes, Judge. Well, I'm not aware of a privilege log that we came up with or provided to the House Board of Managers first and foremost. This was on our fourth supplemental notice of the exhibit list. I think the court is aware that the managers have given us plenty of exhibits throughout the course of this trial. I mean, if I remember correctly, Mr. Bangert dumped phone exhibit text messages between him and the Attorney General during the middle of trial. So to say that I'm sandbagging them is just simply not an accurate reflection of what's going on throughout this case or with regard to this exhibit.
Okay. I've heard both arguments. Give us a moment. Jurors, please take your seat.
Sorry, guys. What did
After consultation with my team here, we will sustain the objection on hearsay. Continue.
I guess I missed a
Yes,
lot.
Your
I
Honor.
apologize for that. I had a phone call that I had to take.
Did
Spots all
General
over my
Paxton
window
delegate you the
says
authority to engage in a
defense needed
settlement
to
agreement with the
clarify.
whistleblowers?
Yes.
Okay. Did he do so on February 8th of
Without Paxton's name and
2023?
did, but House will claim it's
On or about that date.
Where was Ken Paxton while the settlement agreement was going on?
I don't recall. I know he wasn't in Austin, and I believe he was traveling, which is in part why we needed to formalize my authority and the scope in case we weren't able to reach him on short notice if it appeared that we had an agreement subject, again, to his confirmation.
But to be clear, you guys formalized that delegation of duty, right?
Yes.
Right. So then you go into the second day of mediation, right?
Yes.
Will you talk to us about the second day of mediation?
I believe it was also remote by Zoom, even though the weather had cleared up. And I can't remember exactly when it was we agreed we had a deal, but the same dynamic had played out. Mr. Brickman was participating from the start on the second day, at least. And so we were now dealing with 4 plaintiffs rather than a settlement for 3, as we had most of the first day of mediation.
And did you all reach a settlement agreement?
We did.
What was the settlement agreement that you all came to?
And to be certain, I think we reached it that day. It may have been the next morning.
Okay.
Before it was finalized.
Fair enough. What was the settlement agreement?
It was in the form of a mediated settlement agreement, payment of $3.3 million to the 4 plaintiffs in exchange for full and complete releases of liability against the Office of the Attorney General. There was other components we had agreed to, and if you have a copy of it, that might help me, but we had agreed to attempt with ERS to reinstate Mr. Vassar in his retirement plan. I think that was the only fringe benefit that was addressed, but I recall that. And then Mr. Maxwell had an separate F5 administrative hearing case in SOA, State Office of Administrative Hearings, which was abated pending the pendency of the whistleblower case. So that stayed, their filing stayed that proceeding, which was an attempt to reclassify him from a plain discharge to an honorable discharge, without which his employment as according to them, as a law enforcement officer in Texas was problematic.
Okay. How did you feel about this agreement on behalf of the Office of Attorney General and the public of Texas?
I felt overall, especially now that it was a settlement of all 4 plaintiffs and the case would not go forward, it was a good assessment of our risk. To be honest, it's more than we would have liked to have settled for. I'm sure it's less than it certainly was less than the plaintiffs' lawyers were telling us they should settle for. So that's probably, again, 95% of mediation settlements fall into that category.
Okay. Now, after this case comes to an agreement, you still have this petition for review in the Supreme Court, right?
It's still pending, yes.
And did you all file any motions with the plaintiff's attorneys in regard to that petition for review?
I think the next day.
Can you tell us what motion you filed with the plaintiff's attorneys in regard to that petition for review?
I believe it was styled as a joint motion to abate in the Supreme Court.
Can you tell us what the joint motion to abate did in this case?
Very short motion. It was simply telling the court, look, we've reached a settlement agreement that's binding and disposes of the case. If the Supreme Court went ahead and conferred and spent time deciding whether to take our case or not and made a decision, they'd be very peeved if they found out later that that was wasted energy on their part. So we didn't want to upset the court. So we let them know, hey, we've reached a settlement. We're going to paper it up and finalize a larger document. It's all the bells and whistles, dot some I's, cross some T's. But you don't need to do anything now, and the parties are jointly asking you to to put it aside for
Give me
now.
a 5x5
Now, I want you to
over on
focus your
Build if
attention
you
on the article of impeachment that is on the screen
are
right
able
now.
to see this.
And it states the settlement agreement stayed the wrongful termination suit and conspicuously delayed the discovery of facts. Is that true?
No.
Why is that not true?
Well, the plea of the jurisdiction stayed the termination suit pending the Supreme Court.
You
At that
guys
point, the
over on
Supreme
Build
Court's
and Console.
consideration, it didn't, whether it's conspicuous or not, it didn't delay
you all
the
for being
discovery
here.
of facts by settling. There was no discovery ongoing at that time. And the way this is written, it's sort of passive voice. But who's doing the delaying? Is the suggestion here that the whistleblowers, by filing a motion to abate with the Supreme Court, are trying to delay the discovery of facts?
Mr. Dorfman, I don't know. I didn't draft the articles of impeachment. Okay, so I want to move on to who pays this lawsuit. Who pays this lawsuit? Who pays the settlement?
Well, the
Well, it
defendant
seems like
is the
Rumble
Office
is
of the
down.
Attorney
Can
General.
anybody
That's
else
the party
reach
that would be
Rumble? Our Rumble
liable
account
and would
seems
pay
to-
any settlement. Obviously, the legislature has to fund that. So those
Rumble's not
And
working
why
anymore,
is
so
that?
can you
Why
double
does the
check if Rumble is
legislature have
working
to
for you
fund
guys
that
to discuss?
settlement?
goes back to our discussion about sovereign immunity. You can't sue the state without its consent. And even if you have a waiver of sovereign immunity, like the Texas Tort Claims Act or the Whistleblower Act, and you go get a judgment from a court, jury, verdict, all the way, hold it up to appeal, you have a final unappealable judgment that entitles you to, let's say, $2 million against any state entity. This legislature, this body can still decline to pay it. They have to agree.
And are you aware of whether that lawsuit has been paid?
No, it has not been paid, not been funded.
Now, did you engage, without getting into specific conversations of what was said, did you engage in discussions with the plaintiff's attorneys about getting the legislature to pay for this lawsuit?
Yes.
Were they for or against that?
For it. For it.
Now, were you a part of any specific discussions with any legislators about getting this lawsuit funded?
Yes, I was.
Can you talk to us, without getting into the specific conversations you had, can you talk to us about who it was that you met with to talk about the settlement?
I think there were two separate meetings that I participated in. Other people in our office had more, both on the House side and the Senate side. I recall a meeting with Senator Hughes where we discussed it, and with Senator Huffman.
And so you also mentioned that other people were meeting, or were other people meeting with other legislators about getting the settlement paid?
I believe our head of government relations at the time, Ryan Fisher, and his deputy, Colleen Tran, were having such meetings, formal or informal. And Mr. Hilton, I think, too, had some meetings.
And if you know, were the plaintiff's attorneys in this case aware of these conversations happening with legislators?
Absolutely. They were adamant. There's email traffic where they're saying we're not doing enough. We need to do more. This person wants to meet with you. That person wants to meet with you. And we said we're doing our best. We agree. We have an obligation to act in good faith and make reasonable efforts. But it's really, you should be highly motivated to do what you can and have the meetings you need to have as well. And we'll show up with you, but let us know.
And just because they haven't agreed to pay it yet doesn't mean they can't at a later date, right?
Of course.
Do you, and you still believe that it is the state of Texas, the public funds that should fund this settlement agreement, right?
I believe that initially. I believe it now if the case goes back to trial, which I think it's settled, but others may feel differently. All the reasons that were there before, again, we'll go back to the Supreme Court presumably. So, but the risk return of time, the certainty of time, litigation, resources, lawyers being devoted to this when they could be doing Biden administration lawsuits or something.
Let me stop you real quick. And just to be clear, you said if the case went back to trial, if the case had gone to trial and there was a judgment entered against the Office of Attorney General, would it still be, should that still be paid from public funds?
That would be up to the legislature to decide.
Okay.
No one can make them.
Would Ken Paxton ever be personally liable for that lawsuit?
No. He's not a defendant.
You were at the Office of Attorney General. You're currently still working there, right?
Yes.
My understanding is you took leave for a little bit of time.
Yes.
Okay. About how
Okay,
long were you
guys,
gone
give
from
me
the
a 5
office?
by 5 if the Rumble chat is
From roughly
if the
early
Rumble feed is good.
May.
Give me a 5 by 5 on build if I could.
I returned to work remotely probably around the July 4th holiday.
So just recently, right?
Just recently.
Okay. I want to talk to you about the time period
You like
from when
going
you
to the tax
started at
farm
the
and getting
Office of
taxed
Attorney
4
General in
times?
December of 2020 up
Some of y'all's
until
comments are
you
so
took
funny.
leave in May of 2023, okay?
Okay.
Can you talk to us about some of the accomplishments made by the Attorney General's office under the leadership of Ken Paxton while you were there?
Well, I've referenced the Google ad tech lawsuit, one of the biggest antitrust
Please
cases,
like and share
not
this
just in the
out if you
country, but
would.
in decades. That's still ongoing. And,
Objection. I apologize for interrupting. Anything after this lawsuit is irrelevant.
Actually, Judge, if I may be heard on the matter. Yesterday, the House Board of Managers elicited testimony from Blake Brickman. I have the transcript here and be happy to show the court, but they've opened the door to the Office of Attorney General's productivity after this whistleblower lawsuit, after these terminations occurred. They talked about the fact that there was not productivity and that the office wasn't functioning well. As a result, they've opened the door. That would leave a misimpression on the jury. And as a result, Mr. Dorfman should be able to talk about how the office is functioning.
Overruled.
So you talked to us about one of the lawsuits. Would you please continue to talk about the other accomplishments and the functioning of the Office of Attorney General?
I should have started with our immigration cases, which I'm probably most proud of.
Would you please tell us about your immigration cases?
Day one, I mentioned this maybe earlier, of the Biden administration, all the executive orders that came out. One was the 100-day moratorium. We were the first to get a nationwide injunction requiring the Biden administration to abide by congressional directive that no, if you have a deportable alien, they must be deported within 90 days, no exceptions. And that we continue to file and challenge and try to hold the Biden administration to the letter of the law and the rule of law on our border. Title 42 is one of those cases. DACA is a continuation of a case then Attorney General Abbott brought years ago against the Obama administration. We just won, I think, in the last week, a ruling out of the federal court in Houston that the revised Biden administration DACA policy is just as illegal, unlawful, I should say, as that in our favor.
Okay. I'm going to bring you talked about big tech already. You talked about the Google case.
That's one of the Google cases. Another Google case we settled before I took leave. We broke away from a multi-state, all the states suing in one location. We broke out of that, filed our own lawsuit in Texas state court. We settled with Google for $8 million when all the other states put together settled for $9 million over the Google Pixel phones, and that was to the relief of Texas consumers who were deceived by misleading advertisements.
Any litigation with regard to opioids?
This is mostly before my time. The money has come in since I've been at the agency, but I can't claim credit. General Paxton himself led the nationwide negotiations on that, worked very hard on that, deserves the credit for that. And it's been billions in money from those manufacturers, distributors, marketers, consultants, pharmacies that were responsible for the opioid crisis that was so devastating.
And so based on what you've seen at the office during your time there, have they been successful in their efforts and their litigation under the leadership of Attorney General Ken Paxton?
I think so. I've been amazed at what we've accomplished. We've worked our lawyers very hard, and they've done very well. They deserve the credit. They're the ones going to court, making the winning arguments and filing the winning briefs, not me. So I don't want to seem like I'm tooting my own horn when I say CNN, no great fan of Attorney General Paxton or our office, had to concede in a news article that Texas had become the legal graveyard for Biden administration policies and executive orders.
Well, thank you, Mr. Dorfman. I'll pass the witness, Your Honor.
Your witness? That sound you're hearing, you have not heard for a long time. It's called rain.
Yes, we were blessed with a lot of rain today.
Hi, Mr. Dorfman.
It may
How are
not
you?
be finished.
I'm very
It looks
good, thank
like
you.
It's not finished. We love this weather.
The mic's not on, Mr.
Can you hear me?
Here we've got.
Yes, sir.
Is this
Dorfman,
Mr.
we
Rogers
were
or is this
looking at Exhibit
Beto O'Rourke?
335 that was introduced by your counsel or counsel for Mr. Paxton. Can you pull that up for me, Stacy? No.
Check your mic one more time. It doesn't sound right.
Is it not working?
No, it is now, but you're tall enough that you're going to have to bend down a little bit.
Yes, Mr. President. Is this the memo that you were talking about on 335 with the council a moment ago?
It's one of them, yes.
And this memo was created by Chris Hilton?
I believe so, yes.
And one of the lawyers standing over there, sitting over there?
Sitting, yes.
Sitting, yes. When you got this memo, were you shocked?
By what?
By the fact that Mr. Hilton was attempting to usurp the power of Ken Paxton by removing his name from the letterhead.
No.
Did it appall you?
No.
Was it simply a matter of Mr. Hilton picking out this letterhead that is available to every employee of the AG's office?
I think you'd have to ask Mr. Hilton about that. I don't know.
You talked about the internal investigation that was conducted by the Attorney General's office, correct?
Yes.
And you talked about the fact that it needed to be fair.
Yes.
It needed to be unbiased.
Well, it needed to be objective, I think is the word I used.
And the subject of that investigation was Ken Paxton.
One of the subjects of that investigation.
It certainly was a big part of it, right?
The allegations against him were a big part of it.
Your Honor, may I approach the witness?
Thank you.
Mr. Dorfman, I am showing you what has been marked as 524, Exhibit 524. Do you recognize this document?
Give me 1 minute to read it quickly. Can you restate your question, please?
Yes, maybe I can make it easier. You see your email address right there, halfway down the page?
I do.
This is an email exchange that you received, you were on?
Yes.
And so as a result, you recognize this document?
Yes.
And, you know, to use a predicate that's being laid by your counsel, this fairly and accurately represents the email as well as the attachment.
I think that's right.
Your Honor, at this time, we offer Exhibit 524.
Any objection?
Yes, Judge. I'd object to hearsay, and they haven't provided a proper foundation for this witness to sponsor this document.
Your Honor, we have a business record affidavit that overcomes hearsay. That gets by that. And the predicate is this witness was part of this email exchange, is a proper sponsoring witness, testified it fairly and accurately represents.
Great. I think part of the rule is that it's got to be provided to counsel. So that would be good.
I will.
Would you provide him a copy?
Yes.
Thank you, everybody, for being here. Sorry, I had a little bit of a glitch up with the Rumble stream.
Judge, if I could just have a moment to look at the business record affidavit.
Please like and comment and share and
Take a
subscribe.
moment.
Thank you so much for being here.
Thank you.
And check out our website at takingbacktexas.org. We recently got our website back up.
Your Honor, I assume we're stopping the clock, respectfully?
Judge, I mean, I don't see why it should. They're offering it.
If it's a minute, we're not stopping the clock, but if it's longer than that, I'll stop it.
Thank you, everybody. Can you hear me over on the Rumble chat? Thank you, everybody.
Judge,
So many comments.
I have to reurge my objection. This business record affidavit is not the
Classical Chip.
correct
Thank you.
affidavit for
Over on
these
the Build and
documents.
Foxhole
It
channels.
references
Hello, Akira,
Office of Attorney
Classical
General
Chick.
numbers that are just not contained on the documents that counsel has
It could be
provided
the
me. And so
storm
I
as to
can't
why I'm
verify
having
that it's
so
the
many
document
issues.
that he's purporting it to be.
But I don't want to say
And
anything bad about
We
the
don't have a
rain.
copy either of the business affidavit.
I can get you a copy.
That would be good. Yeah, it's supposed to be attached so that we know.
And none of this should be given
I
back to them.
appreciate
This
that,
all
Your
should
Honor.
go
It
against
was
their time.
attached to a bigger swath of documents. This is just one of the documents that's part of it.
A little bit frazzled, are they? Do you think they'll be able to find the document that they're trying to submit into evidence? Of course, all of this should count against their time, though they'll probably ask for some of the time back. It should definitely be denied. Is everything looking good over on the Rumble side? Big Bad Black Conservative, can you let me know if everything's good on the Rumble side or if it's glitchy?
We will stop the clock and give you credit for a couple of minutes here.
Oh, that's not quite right. Okay. Well, I was told that it was a little bit glitchy, so what we're going to do is refresh this feed right here. And we do have stormy weather, so that could be one reason why the feed is glitching. But we'll see if this will help. Okay, let me know if this helps at all, okay? Yes, the feed cut out on me there. The Rumble feed cut out on me there for a minute. Okay, let's see if this is better. Sorry about that, guys. I'm not quite sure what happened, but please share this out. Thank you for coming back, even though feed was lost temporarily.
Mr. Dutko, I will say I stopped the clock, but when either side has not been ready to present us what is needed, we have not stopped the clock previously. So I've given you 2 minutes here, but I don't know how long you're going to take.
Yes, Your Honor.
It does not seem you have your paperwork together.
Yes.
So can we continue and get the clock running and come back to that if you'd like?
Yes.
All right. Resume the clock, resume your questioning.
May I proceed? Mr. Dorfman, when you were on direct examination, you spent a lot of time talking about the fact that the quality of attorney that is currently at the Attorney General's office. You remember that?
Yeah, I think so.
And you said how you were proud to walk through the
Okay, let
halls
me
and
know
the
if that's any
lawyers and the
better,
high
okay?
caliber of lawyers.
I don't recall saying that. It's certainly true, but I don't recall saying it.
Yeah,
And you were
I
talking
could
about
not
how
get Rumble
good the
to work
lawyers
for a
are and how
while, and
hard
I'm
they
so sorry
work. Do you
about
remember
that. I'm
that?
not sure why
Yes.
that happened.
Yet, despite the fact that there's the high quality of lawyers that currently exists at the Attorney General's office, Ken Paxton had to hire Louis Brisboe as outside counsel.
Didn't have to, he did.
And it was certainly something that could have been handled internally.
I'm not going to agree with you on that. Now, I have an explanation why.
Okay. Are you aware of the fact that Louis Brisboe has billed the Texas taxpayers $524,000 for the work that was done?
Yes, I am.
And that doesn't bother you?
Okay, excellent. Thank you, Big
I
Bad Black
think I've been very
Conservative. Thank you so
clear that
much.
I view the Texas fisc as
So
a
sorry, I'm not
sacred
sure what
calling
was
for
going on
us.
with the
It's very important for us
feed.
to preserve it and spend it wisely. Again, I had a reason why I supported the hiring of Louis Brisboe as outside counsel. But part of the motivation for settlement was to stop paying Louis Brisboe as outside counsel.
Your Honor, we have the business record affidavit that we were going to present to opposing counsel.
Okay.
Is this for this document? You just got extra copies of BRAs. Again, Judge, I got to re-urge the objection. The document that they've handed me doesn't have a single Bates label on it, and this business record affidavit talks about Bates label documents. No way for me to verify the validity of these documents.
Your Honor, just so we're clear, these are documents that
Could I have a copy of that?
Yes.
And before you answer his objection, let us look at this. We're ready to resume. I'm going to sustain the objection because we don't find a way to identify this affidavit with the document.
Yes, Your Honor. Remember when you talked about the plea to the jurisdiction a little while ago?
Yes.
One thing is clear, a plea to the jurisdiction stays the case.
Once it's denied or granted.
Right. And so when you filed that plea to the jurisdiction, you, as the Attorney General's office, knew that the case would be stayed.
Yes.
That meant there would be no written discovery.
Yes.
That meant there would be no deposition discovery.
Right.
That means that Ken Paxton did not have to testify under oath for the entire time that the jurisdiction was being determined.
No one had to testify, yes.
Right, but Ken
Or
Paxton didn't as well, right?
Yes.
And so when you filed it, you knew that was going to happen.
Once a ruling was made, yes.
Right. And even though you lost at the trial court, instead of going back to the case and conducting discovery, you appealed it to the Court of Appeals.
Well, we didn't lose the case at the trial court. We lost the plea.
Right. You lost the plea to the jurisdiction.
We disagreed with that and we appealed it, yes.
Which means that when you lost that case, that plea to the jurisdiction, that meant if you did not appeal it, you could go back to the trial court and take discovery.
If we chose not to appeal it?
Right.
I suppose that's true.
And then you appealed it.
We did.
And lost.
We lost in the third court.
So then, instead of going back to the trial court to conduct discovery, where Mr. Paxton would have to give his deposition, you took a flyer and took it to the Supreme Court.
I disagree with you that we took a flyer. We urged the constitutional separation of powers, which is a pretty important constitutional doctrine. And we also relied on the sovereign immunity of the state, which this body thinks pretty importantly of as well.
Right. And then while the case was pending at the Supreme Court, there was an appeal. Election, right?
Yes.
And after the election, before the Supreme Court, where you said you had a good faith basis to go, immediately after that's when you guys settled, right?
Not immediately, no.
Shortly thereafter.
We settled 3 months later, a little more than 3 months later.
Your Honor, I was told that the document that was printed for everybody had the Bates label that ran off the bottom. And so now I have a version that has the Bates label that identifies it as a document within the range on the Attorney General's, on the business record affidavit. Since it was a short notice, I have one copy. I would like to show it to opposing counsel and then bring it to the court if that is okay.
Can I see it first?
Yes, Your Honor.
If anybody notices that the House impeachment managers have made a point, please let me know in the comments, either in Pilled or Foxhole, because I'm totally missing it. And I'm not paying any less attention to their cross-examination than I am to the initial examination. I've been paying close attention to all of them. I've yet to hear a point, let alone a statute that he violated, or any wrongdoing on Ken Paxton's part. I've not seen any evidence for anything that they've alleged. In fact, everything that they've alleged has been debunked for the most part. But let me check to see if anyone on the Rumble chat has noticed wrongdoing being proven. What would have come out in discovery? More hearsay. That's all the House impeachment just have right now. Yes. Did he? That's a great question. Did he ask? Does this guy think he's gonna undo the whole?
You can come forward if you like. Come forward if you like.
He might think that. He really might think that. Hang on a second.
Y'all can take a stand-up break, but don't leave because we're moving forward.
Okay, Judy, I'm gonna send over the invite now that I see that you're here. I don't know how well it's gonna work. I'm having some issues with the Rumble. I'm not sure why, but and here we go. Okay, there you go. Now they're not taking a break. This is not really a break. He told them they can stand if they would like, but they're gonna move forward in just a moment. So people are only standing up now to get some blood down to their toes, but they're about to get back to it. So don't you guys go too far. Okay. Over on Rumble, let's make sure. Seems to be going all right. Does anyone have the Foxhole link? Well, you'll have to have an account on Pilled and Foxhole. They take a break on their feet, yes. Hello, White. Oh, hello, White. White has joined the chat over on Pilled and Foxhole. Hello, White. White. That's how you know they don't work. Yeah. Well, I guess they're allowed to have a break every now and then. The senators really have just been sitting there listening to all of this. They don't even get to have commentary. I'm not sure if the stream is any smoother. Diddy, I sent over the invite link by email if you wanted to jump on. I'm not sure if Pilled is smoother. They say 5x5. I'm told on Rumble it's doing all right. And so we've got some people that will let me know if it gets choppy. Usually whenever I close out the link and reopen the Senate link, then it's better. So that's what I've usually been doing. So if you want on Foxhole, you'll need to have a Pilled and Foxhole account. So, and I don't think it's like, I'm not sure if it's like YouTube. I don't think you can watch without having the account. But yes, please like and share out if you would. Had a little bit of a glitch. Apparently our Rumble was down for about 10 minutes. I don't know why that was, and I'm sorry about that. I noticed that it just, it's like I don't know, it just cut out. I had to re-enter the streamer configuration into my streaming service and restart it. So what I don't know is whether or not, all of the chat still seems to be here, so hopefully it's fine. It was just a little disruption. But I don't know if that means that all of the previous footage is lost, but we'll find out. I suppose we'll find out tomorrow. And sometimes I'm unsure if it's, yeah. So.
Members, please take your seats.
Oh, we're back.
Of 2020.
That's a yes.
And when you started, all of the whistleblowers had already been fired or resigned, correct?
Yes.
You didn't interview Mr. Vassar?
No, I did not.
You didn't interview Mr. Bangert?
No.
You didn't determine the veracity of what their testimony is in front of this Senate?
I haven't been allowed to watch their testimony, so I don't know.
Right, but you didn't determine the truthfulness of what they were saying.
To the
That was a
Senate?
silly
No.
question.
As far as
Again, when the
whistleblower
House
allegations.
impeachment managers have no case, they ask
We
silly
took their
questions
pleadings
like
at
this.
face value and addressed those in the report.
I appreciate that, but you didn't make a determination yourself.
I never interviewed them, but the report is I don't know if you call it a determination. It's a report of our office.
Right, but when it comes to determining personal knowledge about the allegations that are made here in the Senate, the allegations that are made before you got there, your testimony would not be helpful as far as personal knowledge goes.
I have no personal knowledge of what happened. I didn't hear any conversations in September or October or prior to that at the agency. That's true.
Pass the witness, Your Honor.
No redirect, Your Honor. Can we excuse the witness, both sides?
Yes, Judge.
Again, I'm not sure that the House made any point at all there.
Mr. Busby, who is the next witness?
Your Honor, Attorney General Ken Paxton, res.
Wow. Okay, they just rested their defense. Alrighty. Look at Busby's suit. Okay, Busby wants to enter in the contest for best fashion. And I think we should allow it. It's a late entry, but I think we should allow it. I like the suit. I like the powder blue suit on Busby. All right. I'm not sure what's after the resting. I think they have maybe statements to give, opening and closing statements. So this will be very interesting. Okay. Both sides have rested. The prosecution and the defense have officially rested. I do love Busby's powder pink suit. Sorry, powder blue suit with a pink satin tie. Powder pink satin tie looks great. All right, I'm gonna have to give it to Busby on this day. When the defense rests, Busby wins the fashion. All right. I assume right now they're just making sure they don't have any loose ends to tie up before they move on to the next stage. They're determining how much time is left for both sides, because I believe whatever time was left over, the sides could use for their arguments, closing arguments, and rebuttals. So thank everybody for being here. Thank you for
The
commenting.
parties approach the bench.
Well, now parties are approaching the bench. Thank you, Truett, Stacks, White, Diddy. If you heard me, I sent the invite link in case you wanted to come on. Melindy says, oh, closing now, bring it on. Yep, they'll be the closing arguments. And I think that however much time they have left they've agreed to a certain amount of this. And I think they were given a certain amount of time for the closing arguments. And if they had any time left over from their presenting their cases, then that could be added to their closing argument time or their rebuttal or something like that. So Melindy's right. Closing is next. Bring it on. She says, heck yeah. Spotzel says, we definitely don't get fashion commentary on RSBN and value added. Thank you. Yes, we thought that, honestly, for a while, we thought Rusty Hardin, the House impeachment manager, was going to pull it out of the bag with the fashion, but Busby's coming on strong.
I apologize. I had a phone call I had to take really quick. Yes, and Anthony also. I think I really liked his suits. There's something about him that I really liked. I'm not sure what it is. Can't put my finger on it. Let's see. Let the managers go first, or is it a predetermined order? Well, I think the managers get to go first, regardless of the ones bringing the case, but I'm not sure that that's the rule. Just speculating. I'm just guessing. I'm just speculating. All right. Watch him wait till tomorrow, says Hunter Sabo, says watch him wait till tomorrow. I think that Dan Patrick wanted it wrapped up by today. That's why he's been allowing this to go from 9 a.m. until 7 p.m. And he wants the senators to have enough time to think about this. And I believe that he wanted the proceedings, this particular area, wrapped up today. I don't know if that's what's going to happen though. So who do y'all vote for best dressed? Because it's definitely between Rusty Hardin and Busby. And if you're gonna factor in charisma and style, we got to give it to Busby. Busby was sharp and efficient, short and sweet, to the point. Anthony Hardin was spinning cotton out of sugar. He was doing something there, but it wasn't a lot. It wasn't much to it. Which made Busby's job easier, though Busby did a great job, but Paxton's entire team did a great job meticulously detailing how each one of these articles were absolute and complete bullshit. They did a really good job. And I love Paxton's team for what they've done. So actually, I want to say it's between Rusty Hardin and Busby and Anthony Osso. Anthony Osso's suits are very well tailored, though I just have to give it to Busby. This final suit that he's worn today, that's it right there. Powder blue and powder pink and white, innocent like an angel. Because Paxton's innocent. And it looks good. With his super tan leather skin. His skin is very tan. And his slicked back hair. He's got the style. He's got the look. Okay, what are y'all saying over on Rumble? Spotzel says... Hunter Sabo says, time to call senators in Texas. Spotzel says, and senators will not be released until a verdict is reached. Will stay through the weekend if needed. Spotzel says, Dick DeGuerin has been pretty sharp dressed. Maybe not as eye catching and not on camera as much, but just sharp, classic. Really? Yeah. Okay. So we've got a vote in from Spetzel for DeGuerin in the fashion league. Okay. This is very very important stuff. So you're gonna want to look good, and we definitely have a best and a worst dressed category. Okay, and I absolutely will go and clip the best and the worst outfits. Okay, and I will rate them. Yeah, and that's just to pass the time that these people waste at the bench, just for entertainment purposes. So, and we can take a vote. Okay, we'll whenever we go and we break down the Senate hearing, we will include a vote on the best and worst dressed. Okay, we'll probably have 3 or 4 candidates for each category. All right. And we'll take a vote. If there's a tie between best and worst dressed, or if there's a tie between worst dressed candidates, I will break the tie. We definitely know the Pepto-Bismol pink blazers in the running. Leah Graham, she should be impeached for that outfit. And, oh gosh, but Wednesday Addams, she's number 1 in my book. I don't know if maybe y'all have to factor in Aaron Epley, the CIA and DOJ's own Aaron Epley, representing the House impeachment managers.
her outfits and you know, her hair. Okay, I shouldn't say too much about it. Shouldn't harp on the woman. But come on. Wednesday Addams is still number one in my book. You wear your gothic cheerleader outfit from Spirit Halloween on the Senate floor, you have earned your crown as the worst dressed on the carpet. This isn't even a red carpet. This is a green carpet. All right. And when you look tackier than green carpet, when you make the green carpet look like a classy touch, that's impressive. That is a skill. To be that remarkably tacky is a skill. Okay. So I want to thank everybody for being here. Thank you. Spotzel says, which one was cleavage in court, woman? Right. Somebody spotted cleavage being committed in on the Senate floor yesterday. Aaron was sloppy looking, hair and in dress code. I agree with you, Trump rocker. Spotzel, I'm not sure which one was committing aggravated cleavage on the Senate floor, but we'll have to review. It may have been Leah Graham. Oh, who's this? Who's this woman with the orange? That actually looks cute. That's Senator Campbell. That looks nice. We're gonna need to get Wednesday Addams' real name. That senator. We're gonna need to get her real name so we can call her out. Anthony also Trump Rocker has cast his vote for Anthony also because, and I'm right there with you because his suits were very well tailored. Okay, a vote for Anthony also, and we'll do this officially too when we go live again and do another breakdown of what happened here. We show some of the best and worst moments in the impeachment hearings. Okay. We got all these votes, okay. So cleavage in court will probably be in the running for worst dressed. I think it's going to be difficult to beat Wednesday Addams, though. Okay. I know that show is popular, but come on, people. When you get elected to the Senate, and it's okay to wear all black, but your skirt needs to be cut just above the knee. It does not need to be shorter than that on the Senate floor. That's madness. That's absolute madness. What are y'all talking about over on the pilled chat? Adam Hugabug says, can I vote for High Seas for best dressed? Yes, you can. I have received one vote for best dressed in the Senate impeachment hearings of Ken Paxton. Thank you, Adam Hugabug. One vote for me. Akira says, it's after 5 p.m. How long do they go till each day? Oh, they might go till 7 p.m. They might go later. I'm not sure what exactly is going to happen right now. I think they have closing arguments, but I don't know if they need to tie some stuff up first. So true, it says that damn green carpet. Diddy says, if that High Seas, bash Epley all you want. Diddy, I sent you the invite link by email. Did you see that? You might have been away from
You can still stand. I just need a little quiet. Both parties come back.
Oh, now Dan Patrick's telling everybody to hush up. Get your butts back over to the bench. Okay, and then on Pilled. Hey, Akira says, hey guys, Texas GOP convention is here in my little town next year. Akira, you live outside of, I don't want to dox you, but you live outside of San Antonio? Because that's where I heard it's going to be, at San Antonio. Which will be great. San Antonio is a romantic little town, isn't it? San Antonio is nice. It doesn't get the credit it deserves because it's not Dallas. Nothing is Dallas. And Dallas is where I'm from. And yeah, it's Democrat run right now. But we're going to take that back. We're well positioned to take Dallas back, actually. So we'll get it. We're going to secure Tarrant, and then we're going to go for Dallas. Because I want Dallas. I don't think the Democrats, they can't have it. I've just decided. They can't have Dallas. I'd like it back. I'm gonna take it like it's Crimea, and I am Putin. Okay, that was a bad joke, and I shouldn't make that joke. Sorry, guys. I don't mean to divide my audience. Just a joke, guys. Except I'm serious about taking Dallas back from the Democrats. I was like half joking, okay? Don't be so sensitive. All right, guys. Over on Pilled.
Curtis Cross says best. I don't even know how to pronounce that. Do you mean congressional correspondent? Thank you, Curtis Cross. When this impeachment hearing is done, I would like to continue to do this with our congressional committee hearings because some of them are so funny. Some of them are so funny. And I will often have them on and just narrate to myself when they're on, whenever I'm working during the day, when I work from home. But I'd like to share my narration with you guys. Thank you so much. Or Fort Worth. I think it's in. I think the next GOP convention for the state is going to be in San Antonio. I think. Could be wrong. That's just word on the street that it's going to be in San Antonio. Diddy Style wants to throw in a vote for Matlock for the worst dressed. Okay, Matlock. Yeah. All right. Look, and the same person can be on the best dressed and the worst dressed list. And I'm talking to you, Rusty Hardin. You can be on both, but we'll see because I think there was someone that was a better representation of Matlock than we've seen in a long time. Aubrey for Congress? Nah. No, I'll just be a correspondent. You do not want me to have any power, be an absolute tyrant. The power goes straight to my head. The lady down there in the red dress wins. Yeah, that dress, that was Senator Campbell. She was looking nice, looking cute with her pixie haircut. That was classy. But you should see some of these other outfits that these senators are wearing. I don't know who is advising them, but it's whack. Melindy, do you remember who it was that was committing cleavage? That was committing aggravated cleavage in court? Let's see what we can do, actually, because the Senate feed, for some reason, the Senate feed is a little bit glitchy, so I'm just going to reconnect again, see if I can get a better one for you guys. And let me know if this is any better. If you would. This should be better. Usually when I just close that out, then it gets better. But we'll see. Maybe it's the deep state throwing off our streaming service. Let's see. Yeah, they're not really supposed to be leaving anywhere, and they're not actually, they're just discussing some stuff, and I'm not sure why they can't just get on with it. I'm going to be honest. I'm getting impatient, I suppose, but please like and share this out, and thank you guys for being here. Both sides have rested their case. The prosecution rested accidentally yesterday. That was hilarious. And the defense has just rested. I believe, as Melindy pointed out, I believe it's closing arguments now. But I don't know for sure. I don't know if there's something else that we need to do in between then. Okay, thank you, Big Bad Black Conservative. Thank you. Oh, I said your name fast that time. That's good. I didn't get tripped up. Been given the 555 over here. Thank you so much. Thank you guys for the compliments. I hope you enjoy my commentary, my correspondence. I guess that's the term that I should use. Should I do this regularly for all of the committee hearings? Congressional committee hearings? Because they're very funny. I have a good time narrating them by myself, but... Okay, actually, before they get started, I'm going to play this one more time, okay?
this one right here. I'm going to play this one more time for you guys. I don't know if I'll need all this time. In fact, let me kind of zoom in right here. Let's see.
Bizarre, you got it from a Hardiman car dealership. But that fight between Chowdhury and Hardiman, it pales in comparison to the real estate war going on between Nate Paul and Hardiman.
We are tendering funds and you to fully pay the loan. You're not accepting it, right? Yeah. So you're refusing to accept the funds, right?
Go around and go find you a court in this building to come and stop this. Paul's company, World Class Property, had fallen behind on the payments on some of their biggest properties in Austin. And companies linked to Hardiman had swooped in to buy some of the debt. On video, you can clearly see Paul is trying to pay the debt off on the properties before the auction even starts. And the law says he can.
We've delivered funds to pay off.
Funds are here, cashier's checks.
By redeeming the amount, the deed is ours.
But the lender helping Paul pay off those loans said in a sworn affidavit, quote, "In my 30 years of experience, I've never encountered a situation such as this." But the trustee holding the auction, he doesn't seem to care. We'll talk about him a little more later, but you can tell it got ugly.
Amount due, mother. We've tendered the amount due.
The real estate battles in Austin are making headlines across the state, and that nasty confrontation is captured from all kinds of angles. Everyone seems to want to document what happened for the courtroom. Go around and go find you a court in this building to come and stop this. Okay. Why don't you try that? Okay. Wonder why Hardiman seems so confident of the result he'll get in a Travis County courtroom. This is the following month, June, protesters trying to shut the auction down. And yes, you heard right, they're chanting F you. The Austin American-Statesman reported that Paul's company, World Class Properties, had 9 properties foreclosed on that day. The largest portion, a $100 million property, the 3M campus. A California company called Carlin bought properties at that foreclosure supposedly worth, wait for it, $139 million. The July auction was even uglier. There's a photo of Ali Chowdhury being escorted away by Travis County Sheriff's deputies. That auction fight over another Nate Paul property, the building that houses the famed Capitol Grill in Austin. No dispute Paul's World Class Property company had fallen behind on the loan payments. They owed less than $8 million on a property worth upwards of $25 million. But before you say too bad or it is what it is, look what Dolcefino Consulting has uncovered. On April 14th of 2020, Brian Hardiman got U.S. taxpayers to bail his car dealerships out during the COVID crisis. A lot of car dealers did that. More than $41 billion of your money was handed out in loans across Texas to save jobs during the pandemic. But there was a catch. You had to promise you were getting the money to support ongoing operations. Government records show Mr. Hardiman needed a lot of your tax money to keep his folks working. More than $10 million in PPP loans. $3.7 million to Austin Infinity, $2.6 million to Continental Cars, $3.9 million to Continental Imports. On the very same day that Hardiman's companies got that government bailout, records of the Texas Secretary of State show a company was created, Colorado 3rd Street LLC. On paper, the company is owned by this guy, Justin Bain. 2 weeks later, that same company, Colorado 3rd Street, it bought one of the big loans owed by Paul's companies, Capitol Grill. But where did Justin Bain get the money to pull the trigger? Records obtained by Dolcefino Consulting show the funding for Colorado 3rd Street LLC was provided by Austin Infinity and Continental Cars. Those are Brian Hardiman's companies. We now know from those court documents that Hardiman's entities don't just fund Colorado 3rd Street, they own 80% of it, kicking in $7.6 million. That's a lot of money for car dealerships that said they needed a government bailout just 2 weeks before. Good thing money is fungible, right, IRS? The Capitol Grill isn't the only Nate Paul property that Hardeman entities have foreclosed on. And in each and every one of those foreclosure sales, it's the same trustee, the guy you met earlier, Houston-based attorney Mark Riley, the guy you saw get into it with Nate Paul. I wonder if Paul's lawyers know what we do. Mark Riley has a history of alleged fraud. He was sued in 2004 for misusing trust funds of the family of a Houston multimillionaire Robert Alpert. Riley was ordered to pay back more than $1 million. 8 years later, the debt still hasn't been paid in full. In that same lawsuit, we found that handwritten notes were discovered showing that Riley was developing an alleged embezzlement scheme for $10 million, and that he planned to steal some average Joe's identity, move abroad, and live off his stolen wealth.
$11,750,000 right here.
Well, that must not have happened because there's Mark Riley working in Austin, accused in ongoing lawsuits of fraud with Brian Hardeman to stage the curious real estate foreclosures we've seen at the Travis County Courthouse. Those lawsuits, they also include Justin Bain, that Austin real estate broker whose company went after Nate Paul's Capitol Grill building. And guess what? He's Mark Riley's nephew. What a small world. And when you look up Justin Bain's office address in Austin, look what else you find. Carlin, that California company looking to reimagine Austin. They don't just share the same cool view of Austin from the 2nd Street district. They share the same suite. What a coincidence. Last October, Nate Paul warned of a conspiracy to take his Austin real estate empire away. But few listen. Maybe Ali Chowdhury is just the tip of the iceberg in the Texas real estate investigations to come.
Okay, guys, so that is what Nate Paul was dealing with. Now, that's the investigation into what Nate Paul has been complaining about is what they're trying to impeach Ken Paxton over. Okay, we've gone through multiple of the articles. They're pretty much all debunked, and a lot of them are redundant. So they're just sort of repetitive, or they're slanderous, you know. So I'm not going to give any attention to the slanderous ones that don't have anything to do with any crime. Okay. But it does appear that they are taking their sweet time. So Trump Rocker over on Rumble chat says land grab on Nate's properties by a slew of fraudsters. Yep. And yes, hearings in D.C. can be quite comical. Melindy says, yes, hearings in D.C. can be quite comical if one can stomach them. There's another special session coming up. It'd be great to cover that. Thank you, thank you. Cleavage person was the one that we thought was Aaron. Oh, that was Leah Graham. She was committing aggravated cleavage on the Senate floor. Okay, excellent. Glad you guys are enjoying the commentary. Some people leave negative comments, but that's okay. Thank you for the positive comments. I appreciate it very much. Absolutely. Well, if they take any more time, I'm going to open a prayer portal again. Okay, guys, should we open the prayer portal? Okay, guys, load up your prayers because we're about to open the prayer portal. All right, we're going to send our thoughts and prayers to Dan Patrick so that they'll hurry up and get this moving, okay? Y'all ready? 3, 2, 1. Prayer portal initiated. Wait, I messed it up. Prayer portal initiated. Okay, guys, if you wouldn't mind, send your prayers now. Okay, to Dan Patrick. And what we will do As they want, give it a moment, and the prayer portal will begin to activate. Okay. Just give it one. Oh, you know what? You know how I gotta do it. Here we go. This is the prayer portal, guys. Okay. Have you sending your prayers and thoughts and prayers? Send them now, so that it will reach the Senate. Send them. Send your prayer portals. Send your prayers to the portal. I have initiated and enacted the prayer portal. Okay, Patriots, now's the time. Send your prayers into the prayer portal. Hurry! That's our prayer. That's our prayer. We pray that the court will hurry the heck up. This is what we pray. This we pray, and we send deep into the prayer portal. Okay? Send your prayers now. They're going deeper and deeper into the web. I'm glad you'll understand what Nate Paul was dealing with and why this is such a ridiculous impeachment hearing, that they're impeaching Ken Paxton for doing his job, for investigating complaints by the people. All right. Okay, guys, send your prayer into the portal. Hurry, that is our prayer. Okay, let's see if they're deciding to hurry back up. It appears they are still milling about. Nate Paul had legitimate complaints. And one of the impeachment articles against Paxton was that he hired outside counsel in order to investigate Nate Paul's complaints. Yeah, because Ken Paxton's office, inside Ken Paxton's office was obviously a mutiny. And they deemed Nate Paul's complaints to be baseless. Without an investigation, they deemed Nate Paul's complaints to be baseless. So I think Attorney General Paxton was right in hiring outside counsel to handle the investigation, because his in-office counsel had already made up their minds without an investigation. Would you guys want somebody who had already decided that your case was totally baseless to be responsible for a thorough investigation of your case? Do you think they'd do a good job if they thought it was stupid from the beginning? Some people might do a really good job at something that they think is stupid. But I personally, I wouldn't want somebody that thought that I was crazy or that my claims were crazy. I wouldn't trust them to do a thorough job looking into them. So I think it was right. And Ken Paxton has every authority to hire outside counsel to look into this kind of stuff. Okay. And the articles of impeachment are easy to debunk, and they were very easily knocked down. So thank you guys for being here. Please like and share this out. Had a slight glitch in the Rumble stream earlier, but I've got it taken care of again. And the great news is our website is back up and running at takingbacktexas.org. If you've never seen any of our work, it's all at takingbacktexas.org. Not all of it is. Our live streams aren't always there. Sometimes we air them. We will be linking everything up to the website so you can rewatch all of this stuff. Trump Rocker says, I thought they were stupid to dismiss Nate's claims. Yes. I think that they knew that they couldn't outright dismiss them, but they wanted to give the illusion of handling them. And there were specific people that were supposed to be handling them. When the investigation into this lawsuit that Nate Paul was complaining about was assigned to outside counsel hired directly by the Attorney General, that's when the administrative deep state actors got very upset and decided to mutiny. And it's unfortunate, but that does appear to be what has happened. And we're not seeing any evidence of any wrongdoing on Ken Paxton's part. There's no law that's been violated. There's no procedure even that's been violated. Even half of what the articles allege is blatantly untrue, demonstrably false, very easy to disprove. The House impeachment managers have no case, which is probably why they didn't swear anybody in the House, because none of this would have passed the House if they had due process in the initial House impeachment hearings. So every single House representative that voted to impeach Ken Paxton with no due process, no evidence, and no sworn witness testimony should be immediately primaried.
And in the breakdown of this, we will be editing everything, and we will have a list of all of the Texas House representatives and the senators who vote to impeach Ken Paxton. We're going to go over all of that. Okay. We don't know about the senators yet, how they're going to vote, but we can very safely say that every single House of Representatives legislator that voted to impeach him did so with no evidence, no sworn witness testimony, and no due process. That alone, in the view of taking back Texas, is grounds for being primaried. So we'll have the list, and we'll have each one of the representatives' districts up. And if you are in their district, you can challenge them. You can primary them. And if you have money, that's a bonus. But if you don't have money, it's not an automatic disqualifier. You may know somebody that will donate the money. Somebody may have the money, but they may not be the best candidate. If you're the right candidate, and you're going to be strong, and you're ready to come out swinging hard, you're ready to learn as much as you can and hold your own against these Democrats, these intellectual Democrats, and I'm using air quotes, okay, then consider primarying these people. Now, if you don't think you can do it, or you don't think you're a great candidate, or you know you're a bad candidate, then try to find somebody in your area that is a good candidate, that will stand up, that will fight. And probably they've already been standing up. Probably you may even know who they are. Okay, so approach them about challenging some of these House reps, and just, you can go 2377. But you can also wait for our breakdown of that if you'd like. And in the breakdown, we'll give you all of the areas covered by these districts, these House and Senate districts, because there's House districts and there's Senate districts. So we'll see. See about the senators. We can safely say about the House reps. Over on Pilled, there's a lot of you guys over there. Thank you so much. And on Rumble, how many people? Yep, got a good amount. Happy Frost says, I'm playing catch up on the Rumble. I paused on my other pad device, so I guess I'm double dipping sort of virtually. That's okay. I'm double dipping virtually too. I've been restreaming my own restreams, recapping my own recaps. All right, just because it's fun to do. So I guess we can, so this is very interesting. The defense has rested, and I believe it's just closing arguments that are coming up next. I believe that's all that we're waiting on. But there appears to be some sort of deliberation going on at the bench once again, and I think it probably has to do with how much time each side is getting, and I'm willing to bet that the House is asking for more time, or to be able to enter in evidence that hasn't been testified to, or, and I'm just saying this, I don't know, or that they would like to be able to speak again after Paxton's team. Like, basically they'll want the last word. I'm not exactly sure if that's what's happening here, or if there's something just simply procedural going down here. But what I do know is that they've wasted quite a lot of time doing stuff like this at the bench, and it would be polite of them to just get on with it. But I'm patient. We're all very patient people. Pappy Frost says, the real tall goofy guy is totally screwing up the clock thing in my virtual world. And now the real world is stalled too. Well, Pappy, I'm not sure what to tell you, Pappy, but I'm sorry about that. Hopefully we'll get started again soon and everything will straighten out for you. Because right now feel free to double dip. I mean, we even may go and restream another one of my restreams. Heck. Why shouldn't we? So we'll do a nice little breakdown of all of this. We'll see, because it's primary season. It sure is. I don't know if I'm streaming still on YouTube. I think so.
Let's see. I was having some issues earlier. Did he say this will be on later at 7? Okay. Later around 7, did he might be able to come on. But they might be done by then, I'm not quite sure. Right? Let's see. Rusty, fact finder over on Pilled and Foxhole, says Rusty has to win for best imitation of a seasonal latte by supporting mutiny. You think he did a great impression of a seasonal latte? Yes. Do you remember his pumpkin tie? That was a very Charlie Brown Thanksgiving themed costume. That was very Americana. Yes, and he definitely came across as a PSL, right? A pumpkin spice latte. So Rusty wins for the best imitation of a seasonal latte by supporting Mutineer. He was pumpkin spice. So the official vote from Taking Back Texas's Diddy says Wednesday Addams and Matlock have to. He's broken it down into male and female categories. I had them all grouped together like a fool. All right, so we'll have male best and worst dressed male and best and worst dressed female. So Diddy's official vote is Wednesday Addams for worst dressed female and Matlock for worst dressed male. So now that we're breaking it down by gender, of which there are 2, and occasionally an anomaly in between, almost never neither. Most of the time, one or the other. Anyways, I digress. I guess I'll have to vote best and worst dressed. I guess I'm gonna have to vote Senator Campbell as best dressed. She's down there in that orange dress that is an appropriate skirt length. I'm gonna have to vote for Senator Campbell and I also like her pixie haircut. And for worst dressed female, ooh, I'm gonna have to give it to Wednesday Addams, you guys. But that's just my vote for now. We need to actually review the outfits, okay? Because there may be a better dressed or a worse dressed woman that we just haven't recognized yet. We haven't thoroughly analyzed their green carpet looks, okay? But so we'll see. We'll do a recap. But that's the official vote from Diddy, Matlock and Wednesday Addams for worst dressed male and female. And they should be coming back any minute now. Both sides have rested. The prosecution accidentally rested yesterday. That was hilarious. And then the defense has rested today. I think the defense did a great job because the prosecution had absolutely no case. They have no evidence of any law being broken. And and Paxton's team had evidence that pretty much everything that they claimed in the articles was inaccurate, untrue, inaccurately represented, a flat out lie, twisted facts. So it's, oh no. I'm getting a double dose. Oh, Pappy Frost. Okay, Pappy Frost says I'm getting a double Aubrey commentary overlap. You are a powerhouse. Your mind will explode with knowledge, and it's just going to be great. So subject yourself to that. It's lovely. Do what few others can. Happy Frost. Okay, you guys. Yeah, they'll be back any minute now. Trump Rocker says, my Senator Springer and my Rep Patterson are duds. I won't vote for them again. Well, let's try to see let's try to cover the entire area that those HD and SD that those House district and Senate districts cover to see if there's anyone in those
parties. I need someone from each side to announce that you're going to have closing arguments in the morning before I adjourn for the day.
Okay. So they're going to do closing arguments in the morning and adjourn for the day. Alrighty.
Mr. President.
Do you close tomorrow?
Yes, Mr. President, the House will have closing argument.
On the record?
Yes, Your Honor. The Attorney General will close tomorrow. Closing argument.
Okay. For the record? (9 a.m. as always. 9 a.m. We are adjourned for today.
Okay, everybody.
Members, before you scatter, talk to your two leaders here.
All right, everybody. Well, that was it for day 8. The prosecution accidentally rested yesterday. The defense rested their case today. The prosecution has absolutely nothing. The defense did a great job establishing that and establishing the majority of the content of the articles to be absolutely baseless at best and flat out lies at the worst. So what do y'all think about that? They are convened for the day and will return again tomorrow morning at 9 a.m. to do closing arguments. Now, I believe that they have a certain amount of time left for closing arguments, and whatever was left over from the time that was allotted to them for their arguments will be added to their closing. Will be adding to their closing arguments time. Over on Rumble chat, Hunter Sabo says, "See y'all tomorrow," and thank you so much. Thank you, Hunter Sabo. Thank you for being here. And yep, you're right. You could hear the Hunter Sabo says, "I could hear their bellies growling." We will see you guys live tomorrow morning at 9 a.m. for the closing arguments. And I don't know about you, but I'm very, very much looking forward to it. Okay. And we've got detailed notes about all of this, and what we're going to be editing. I think we have plenty of content to show how solid Paxton's position was and how weak and shaky the House managers team was. And the CIA and DOJ's own Erin Epley, representing the House impeachment managers, she was beyond unsuccessful today. And I cannot wait to review her attempts at bashing and slandering Paxton's witnesses. Absolutely inappropriate behavior from the DOJ and CIA's own Erin Epley, representing the House impeachment managers. And so we'll review that. We'll highlight that. I think it's pretty important. It was important information to the people who informed me on what was going on. And I agree that it's important information that she's got a CIA and DOJ background. And I mean, up until very recently, before she began facilitating the political takedown of the Attorney General of the great state of Texas, America's Attorney General, the best one we have, hopefully the next U.S. Attorney General, if he's unable to resume his position in his office in Texas, which we would like to see him restored to that position, ideally. But thank you guys very, very much, and I hope you understand what's been going on. And we will see you all bright and early tomorrow morning. Have a great day.